14-day district court of the County of Washington, State of Michigan is now back in session. Jason.
You may be seated. Oh. Good morning, Lee. How are you? You can come out. Court does call the case of the People State of Michigan versus Jerome Burns.
Good morning, Your Honor. Mary Townhouse.
And good morning, Your Honor. Assistant Public Defender Shanazia Carey-Akinrelli on behalf of Mr. Jerome Burns. From take your name for the record.
Jerome Burns.
All right. Date and time set for preliminary examination. Are we ready to proceed?
People are ready, Your Honor. Defense is ready.
Okay. You may call your first witness.
Oh, I'm sorry, Your Honor. Before we start, I was going to approach the court about two things. One, just generally sequestration order. If there's anybody in here that may be a witness in this case, I'd ask them to leave the courtroom. We've had our, I'm sorry, family, just 1 second. There are two things I'm sorry about that. We've asked our witnesses to leave. The OIC is still present. And the people on our side are not going to be testifying.
Okay. So all the witnesses have been sequestered on the people's side.
Your Honor, I do not plan to call any witnesses today to testify.
All right.
And they're not going to be called later on in the case.
Well, I don't know if one could commit to that. I mean, I understand what may be the people's concern, but if they're going to be called later, they certainly could read a transcript. So, but the question would be their testimony today. Counsel approach brief. Go ahead.
One other matter, Your Honor, I've spoken to defense counsel both last time as well as today about defendant's cell phone. He had claimed there was some evidence on there that may be potentially exculpatory. I spoke to counsel. I think we've spoken to Your Honor about how we would approach that if he would like to retrieve that for him. My understanding is, I'm not sure we have a clear answer, but my understanding is that that is not something that he would want for today's purposes.
And Your Honor, I think one of our primary concerns was the cell phone in question was in my client's possession when he was arrested. Our understanding is that U of M PD later came to the jail to take the cell phone. So I'm not sure, my client did not have any conversations with anyone other than counsel about information that he would like to retrieve off of his phone. I'm sorry, I think he may have spoken to his father about information that he wanted to retrieve off of his phone. And when his father went to the jail to go and retrieve the phone, he was told that he had just missed it and that the police had just picked it up. So I'm not really sure where the information about exculpatory evidence came from. I don't have anything in my notes. I don't know if it was something that came from my office. However, it was information that our client wanted us to investigate ourselves. We're not inclined to advise him to give passwords or access to his phone to the people at this time. There may be a motion. I think I informed Sister Counsel that there may be a motion that we may file just to get the phone back, because our position is that if the phone is not evidence in this particular matter, then the people have, or the police have no real reason to hold on to the phone if it's not being used to investigate. If there's information that the police would like to get off the phone, I'm sure that there's a search warrant of some sort that they may be able to get. Other than that, they're really just holding on to the phone, and unless we give them access to the phone, they're not willing to give it back to us.
Go ahead.
Yeah, Your Honor, just in response to that, that's not quite the situation. So, Your Honor, specifically defendant claims there's a video on his phone of the victim consenting, which is a big deal if that is something that's truly on there. With that, our anticipation was that he would want us to retrieve that or somehow get that evidence. And we are willing to be creative in how to go about getting that limited evidence. However, so far, and as we stand here today, we have not been given permission. Now, we could absolutely go through a search warrant, and that's what we're going to do since we're not being given consent. I think there's good reason to believe there's information on there related to this case. But we wanted to present that opportunity anytime something is even close to being potentially exculpatory, whether or not I believe defendant that he has that video. His statement alone that there might be is concerning to me, and I don't want to be in a situation where it's later claimed, and I'm not saying by counsel, just later down in this case, where it's claimed that there was exculpatory information that we somehow didn't share or were in possession of. So, of course, the best way to go about is consent. I completely understand his perspective if he doesn't want to give that consent. So we can just go about it through the traditional search warrant ways.
Anything else?
Nothing else, Your Honor.
Well, correct me if I'm wrong, counsel, I think we had an in-chambers conference about this issue. And my understanding was there was going to be understanding what may be the perils of that and the fact that the people could get a search warrant, that there was going to be a decision made by the defendant prior to preliminary examination about whether or not to try to retrieve that information. Exculpatory. My understanding, Ms. Akinwumi, is that he does not wish that to occur. Is that correct? You may want to that mic. Ms. Akinwumi, before you say anything, you want additional time to try to talk to your client about that.
If I could, Judge.
I figured as much, only because as you were talking to him, I could see your fingers. So that probably needed to be a fuller discussion.
Okay.
So what I will do is I will stand in recess. You let us know when you're ready.
I sure will.
Take that.
All rise.
Thank you.
Take a seat. The District Court for County of Washington State, Michigan, is now back in session. The Honorable Judge Simpsons.
You may be seated. We're back on the record in the case of the People versus Burns. There's been certainly a break. Counsel and I have had a extensive bench conference regarding the issue that was raised. Secondly, it's the court's understanding, and feel free to correct me if I'm wrong, and I will ask your client to acknowledge that there might be some, I guess, different interpretation of what is contained on the phone. Your client may believe that it might be exculpatory for him. However, my understanding is he wishes to proceed today on this understanding that that won't be released. That fashion, and he's not consenting to release.
That is my understanding, Your Honor. I have had an opportunity to speak with my client. I've explained to him where we are and what the people's request is. He states that although he does believe that that information is on his phone, he is not inclined to give consent or permission to the people to access his phone to take that information at this time.
And Mr. Burns, is that a correct statement, sir?
Yes, sir.
All right. And you understand that as far as this proceeding, that we will be proceeding without that information. You understand that, sir?
Yes, sir.
All right, very good.
Thank you, Your Honor. Marie Tanner for the people. People call Madison Burns. Please stand.
Be there, they're gonna back up as well. Thank you, folks. All right, ma'am, if you could please come forward to be sworn.
Please take a seat, raise your right hand. You solemnly swear to affirm the testimony about to give you the truth, the whole truth, and nothing but the truth, so help you God. Yeah, see, please spell your first and last name for the record, please.
Madison Burns, MADISYURNS.
All right, man, Claire.
Thank you, Your Honor. Hi, Madison. Thank you for your patience. I know it took a bit this morning. A few things I want to talk to you about before I start asking you questions. First one is, this is Judge Simpson. I wanted you to kind of know what we're all doing here. We're going to start with, I'm going to ask you some questions. After I'm done asking you questions, if defense counsel has questions, she'll ask you some questions, okay? If it's necessary, I'll come back up and ask some more questions, but that may or may not be necessary, okay? When you're answering questions, if you could say yes or no, as opposed to that'd be really helpful, okay?
She goes, All right, all right. Go ahead.
Okay, thank you. And you're a little soft-spoken, I am too, so we need to be really good about getting close to the microphone when we're speaking, okay? If I ask you a question that you don't understand, it makes no sense to you, please let me know that you don't understand, ask me to ask it differently. That's okay, all right? If you can't hear me, please tell me to repeat myself, okay? Same thing with defense counsel. It's perfectly fine to say that you don't understand or you can't hear or whatever the situation is, okay? If you need a break, with the court's permission, that's okay. You can raise your hand, you can ask for a break, whatever you need, okay? All right. Madison, do you know someone by the name of Jerome Burns? Okay, who's that person to you? And
Let me stop you for a second. Madison, you're gonna have to do me a favor, okay? Yeah, you're gonna have to speak louder. The thing about these microphones is they don't amplify, okay? They will pick up everything that is said, but not everybody can hear it, okay? And so when you're looking at me, I'm an old guy, so I need a voice, okay? All right, thank you.
thank you, Your Honor. Okay, and you said Mr. Burns is your husband. Do you have a child or children in common? Okay, and tell me about that. How many children?
Just one is 5.
5. And what's his name?
Benjamin.
Benjamin. Okay, thank you. Do you see Mr. Burns in the courtroom today? Could you describe something he's wearing? Okay. And which side of me is he seated on? Good. Sometimes that gets confusing. Your Honor, may the record reflect that the witnesses identified the defendant.
Without objection, record shall so reflect.
Thank you. So you said that your son's 5 years old. And how long have you been married to Mr. Burns?
2 to 3 years.
Okay. And were you in a relationship prior to that? Okay. I want to ask you a little bit about that relationship with Mr. Burns, your relationship with him, and then the marriage. During your marriage, could you tell me a little bit about kind of your financial situation?
Really,
Okay. And where was that coming from? Why did you feel like you weren't allowed to have your own bank account? Okay. And who told you you couldn't have your own bank account? And when you say he, I'm sorry, this is really annoying, but who are you talking about? Jerome Burns. Okay, thank you. And did he tell you why you couldn't have your own bank account? Okay, no problem. So you had a joint account with him? Did you work during the marriage? Okay. So how did you and Mr. Burns have income? Okay. At some point, did you come into some money during the marriage? And what happened with that money? Were
Most
you-
of it he. I'm sorry, what'd you say, young lady?
Were you, did he allow you to open an account separate to put that money into? Tell me a little bit about, did he have a vehicle during the marriage? Okay. And who drove that vehicle? Did you drive that vehicle? Why not? And who stopped you from going anywhere by yourself, if anyone?
Judge, I'd like to object to this entire line of questioning. I think that it's relevant to the issue at hand of why we're here today, and the event that occurred on May the 7th of this year.
May I respond, Your Honor?
You may.
Thank you. Your Honor, it's extremely relevant to what's going on. We're here to establish coercion. That is what this has been charged under. Notably, as the court's aware, I'm sure council's aware as well, coercive control is the underlying concern we have in these domestic violence type of situations, which is very much is. As the testimony develops, we'll hear more about that. These are all parts that go into showing that coercion.
Anything else, Ms. Ecken?
No, Your Honor.
Objections overruled. You may
Thank you.
proceed.
Thank you. So I'm sorry, Madison, who, if anyone, indicated to you that you were not allowed to go anywhere by yourself in the car? Were you, if you know, were you listed on the insurance for the car? Did you want to be taken off the insurance? Did you ask to be taken off? In whose name was the car? Jerome Burns. Thank you. I want to ask you a little bit about where you lived with Mr. Burns. We don't need to go all the way back, but let's just look at like 2024, 2025. Where were you living with Mr. Burns? And were you on the lease for that apartment? Who was on the lease for that apartment? Did you ever have a cell phone? You own a cell phone? And did you was that cell phone always in your possession, or would someone else have that cell phone at times?
told me I had to put it on the dresser, and I couldn't touch it. I had to do about check-ins.
Okay. Can you tell the court more about hourly check-ins? What does that mean?
Next, all the big things every hour.
And who asked you to? You said he. Who asked you to do these things? Okay. And what would happen if you missed one or didn't obey that request?
So, Madison, can you describe this check-in? Was that like on a daily basis? And so this hourly check-in, you would have to call him or text him every hour. And so in the text or in the call, what were you supposed to inform him of?
What I was doing.
Okay, so I'm just trying to get, it's okay. So every hour you would have to in some way communicate to him what you were doing. How long did that last? A month or two? Okay, just backing up to something else so that I have a full picture of this. Was that during the period in time at which you had to put the phone on the dresser and weren't allowed to look at it? That you had to shut the phones off? Do you know why that was or why you were told that, or did he tell you? You had to shut your phone off. Go ahead, Ms. Tanner.
Thank you, Your Honor. I'm sorry, Manson, you said that if you didn't obey his directive regarding the texting or calling him, I believe your testimony was that he would yell at you. Is that correct? Okay. Can you please tell the court, if you remember, what kinds of things he would yell about, or what would he explain what that would look like?
That's what I was doing. I couldn't answer.
And how would that make you feel?
Forget it.
And was Benjamin, were you home with Benjamin often? Okay.
This is he won't get home until around 4 with us.
Okay. And when Mr. Burns would ask you what you were doing that you didn't check in with him on an hourly basis, what would be your reaction to that? What would you do? And would that satisfy him and calm him down? And when it didn't, what would that look like?
Saying someone.
Okay. What was his tone and demeanor as he would accuse you of those things? Okay. And how did that make you feel? And I know I'm asking you to kind of think back, so if you don't remember, it's okay. What were you scared that Mr. Burns might do?
Get more aggressive. Take from me.
Okay. I want to talk about Benjamin a little bit. Does Benjamin, because you mentioned the hospital and that's what we're here to ultimately talk about. Does Benjamin have a medical condition or conditions?
Yeah, he has a muscle condition. It's like very rare. It's epilepsy.
And you said that Mr. Burns threatened to take Benjamin away. How often did he threaten to do that?
Several times.
What would lead to him threatening to take Benjamin away? What would kind of happen before that threat came?
And then he was in need of doing some or talking to someone.
So he would accuse you of talking to someone. And then at some point during those accusations and the yelling, is that,
Blah, 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 ever happened, and then.
did you believe him that he might take Benjamin away? What concerns would that cause you? I know it seems like a silly question, but what concerns would that cause you, given Benjamin's condition, if Mr. Burns took him away from you? So Benjamin's kind of medical procedures, talking to the doctors, medications potentially, was that on you, him, or was it a shared responsibility? And during this time when you took care of Benjamin and kind of coordinated his care, was that still going on when Mr. Burns would ask you to do hourly check-ins? Madison, do you have any family locally close by?
Not close. He and I have left his brother and my dad's mom, they live in Boston.
Um, is your father still with us?
January of this year.
January of this year? So when you and Mr. Burns were in the hospital for Benjamin in May for this incident, your father had passed away a few months prior to that.
Celebration of life. He had an attitude that he wasn't gonna be taking me because my parents told him specifically over the phone.
Objection, Your Honor, hearsay.
Okay, hold on.
Sorry, you have to wait a second. Your Honor, it's not offered for the truth of the matter right now. This is to establish her mindset.
I don't think that that establishes any mindset, Judge. If it's something that she's claiming my client was upset about that someone told him, it has nothing to do with her mindset at all.
Well, it would if he then communicates that in some way to her.
I don't think that's what she's saying. She's just telling us that he was upset because.
I can ask it directly, Your Honor, if
Yeah.
that would help.
Well, okay,
That's
then
fine.
I'll sustain that at this point, but go ahead.
Thank you. Did Mr. Burns do anything or say anything to you that that he was to indicate he was upset about him not being the one to take you?
He told me that he wanted to be the one to take me and at least sit in the parking lot if he wasn't allowed in there because he wanted to be there for me. Really hard to get by there because my grandma had told him that he wasn't allowed there and he wasn't allowed even in the parking.
Again, Your Honor, it's not for the truth of the matter, whether or not
I'll
was-
overrule it. I'll accept it. I mean,
it's okay, we can move on.
in accepting the answer, I'm only taking that answer to that last part as it gives context to what she's saying had occurred between her and the defendant. So go ahead.
Thank you. And how often would you be able to see your family? the family you had left?
Maybe once a year or 2 years.
Did Mr. Burns have any, or did he express any opinions about you seeing your family?
That they had to come see me. That have time. Run back and forth.
To have you go see them? Um, So I want to talk a little bit about, I might ask some more questions later, but I want to talk a little bit more about the hospital, the reason we're here today. So on May 5th, were you at Mott's Children's Hospital with Benjamin? I'm sorry, May 5th of this year, 2025. And what were you there for?
Someone's going to be getting a MG too. For them.
And was he admitted for that procedure? Admitted to the hospital, like you had to stay there? And at that time, were you living with Mr. Burns? Okay. When did you stop living with Mr. Burns and his parents? Okay. And what led to you not living there anymore?
Because it was a big chance I had to, you know.
And when you say he, do you mean Mr. Burns? And you said it was your only chance to get out. Was that because Mr. Burns wasn't home? What in your mind would happen if you try to leave when he was at home? So on April 4th, he wasn't home and you decided to leave. Can you tell the court why you decided to leave? What was it you couldn't take any more medicine? It's okay. You need a break?
Madison, you need a break? If you want to take a break, I could use one. Okay. So court standing break.
Thank you, Your Honor. Your Honor, I apologize. Victim just went to the restroom, but she.
Okay, you may be seated, folks. Okay, we'll wait. It's on.
I'm sorry.
I just want to make sure. I don't want her having to yell.
Yeah, see. Like, you know, just like.
Yep, got it. We could wait just one moment. I want her to get back from the restroom and seated and then bring them out. Nope. Okay. Now, if you just say please. Just say please, I can be a much more pleasant person. Okay, good. We can then bring the defendant back in. We're back in the case of the People City, Michigan versus Jerome Burns. Got it? All right, the defendant is present. You may proceed, Ms. Tan.
Thank you, Your Honor. Listen, before we took a break, I asked you, you had made a comment about how you couldn't take That's why you left in April. And I asked you what you couldn't take anymore. You started telling us about that. Could you please tell the court? And for how long was that going on? And how long were you together, counting the dating and the marriage?
6 years.
Okay. Thank you. I don't want to go into too many details, but I do want to ask you a little bit about what the emotional abuse looked like. And did you?
I put them in the trash bag and hid them in the closet.
Were you?
Madison, when did that happen? So, I'm sorry, I just trying to understand. So you had one pair of shoes?
Shoes, but they were old. One of them bought me new shoes, which were slip-on Skechers.
And just because I'm trying to get it, those were the only shoes you had at the time? Oh, well, you're right. You're actually answering my question, but I want to. Those were the only shoes that you were allowed to wear?
Yes.
So you had one pair of shoes that you could wear? Thank you. Go ahead.
Thank you. Madison, you said you hid the other shoes in the closet. Why did you hide them? And what was your concern, if any, would happen if Mr. Burns knew that you intended on keeping the other shoes? You said there were things he wouldn't let you do. We've talked about some of them, like going places by yourself, driving cars, the phone thing. Were there other things? Did you feel like you could hang up on him on the phone and continue your walk? And what would happen if he came rushing home in your mind? Okay. And what would, I'm, s- I'm sorry, I didn't hear that last part. I apologize. Had,
So, I'm sorry,
it's okay.
I just want to be clear. When he FaceTimed you that you had to come back, was he at home? He was at,
And you said that if you didn't obey essentially and go home and you had hung up on him and continued your walk, that he'd lash out, and then you were saying something else. And is that why you did as he told you to?
that a yes.
Oh, sorry.
Sorry.
Okay, and Madison, you had mentioned some sexual assault. I don't want to get into details of those because they're not charged in our jurisdiction. But can you just tell us, generally speaking, when those occurred? So you get body aches. And would this be during the time he would assault you sexually? Okay, in general. And you said you would ask him to stop. And when you say you asked him to stop, you mean you would ask him?
Everyone is, Judge, because this is, again, we're talking about situations that didn't happen in this jurisdiction. I understand that people's attempt to elicit maybe, state of mind or reasonable fear, but I don't.
I'll sustain the objection.
Yeah, it's okay. We can move on. I was asking more for the timeline. I apologize. So around what, how many years ago, months ago? Did it, I'm sorry? Okay, thank you. Okay, so going back to May 5th of 2025, you're at Moss Children's Hospital with Benjamin. He's getting treatment. At some point, did Mr. Burns come to the hospital? Okay. Did he give you a reason as to why he didn't want her to come back?
I said that he just us parents and no one else needed to be in there.
Were there arrangements put in place of how and when you were going to be with Benjamin in his room and when Mr. Burns was going to be in the room? So were you in the room together with Benjamin? Okay. Before, we're gonna get to questions about the assault, but before the assault happened, oh, let me ask this, I'm sorry. So, how long, if you remember, how long had you been in the hospital with Benjamin when the assault happened? Total? Okay. And did the assault happen right when you got there or a couple of days or a few days later?
Few days after.
Leading up to the assault, did Mr. Burns engage in behavior that concerned you? Okay, can you tell the court about that, please?
Told me that he was feeling suicidal. Told me that he took half a bottle of Tylenol.
And was that his first time talking about suicide? Okay, can you tell the court if that's happened previously? And so in the hospital, when he was threatening suicide, did you believe that he might actually kill himself? Do you need a break? Are you doing okay? Okay, all right.
You said you're fine? Okay, just listen. It's okay. If you need a break, it's probably good for me to walk so I can get up at any point in time, okay? So you just tell me, all right? All right, go ahead, Mr.
Thank you, Your Honor. Um, was the threats of suicide before or after the assault? And since Benjamin was there several nights, did Mr. Burns and you stay at the hospital overnight? Okay. Where were you sleeping? Together on the mattress? Did you want to sleep on the mattress with him? Did you end up sleeping on the mattress with him? Did you feel like you could tell him that you didn't want to sleep on the mattress? And when you say attitude, could you describe to the court what you mean by that? And what were his comments? Okay, that's okay. Thank you. Okay. I want to talk a little bit about what more immediately led to the assault, okay? At any point while you were in the hospital room with Benjamin, did Mr. Burns touch you in a way that was against your will? Okay. Can you tell the court how that started, please? Okay. And you said leg and down in that area. I know it's hard, but I need you to tell me what specifically, where on your body did he touch? Okay. Again, I know it's really hard. I need you to be very specific about where he touched you. Did he touch your genital area? Okay. What part of his body did he use? We're talking about initially to touch your genital area. Okay. Did his hand or his fingers at that point ever enter your vagina? Okay. Okay. Did you want him to touch you in your genital area? And you said you were pushing his hand away. And what happened after you pushed his hand away? Was he saying anything? What happened after he was touching your leg and your thighs, your vaginal area? What happened next? Okay. At some point, did he ask you to do anything with him? Okay, can you tell the court about that, please?
Sex.
Did you want to have sex with him? Did he stop asking? Did he ask one time? Okay. Can you tell the court a little bit more about that interaction, how it went? So he was asking you for sex more than one time. Was it more than 2 times? Okay. And did you have a response to that? Okay, it's okay. At some point during his asking you to have sex, did you change your mind and decide you wanted to have sex with him? Okay. Did you end up having sex? Did it occur again that he asked you to have sex?
May 7th.
Okay.
I just want to.
Okay. I want you to, as best you can, describe a little bit to the court how come you gave in. You were worried he might take your son or kill himself. Okay. And we've already talked about his threats in the past to do so. Sorry, just one moment, Your Honor.
Yes.
And did Mr. Burns, and I apologize again, I know this is difficult to talk about. Did Mr. Burns end up penetrating you? Okay. What part of his body did he use to penetrate you? Okay. I need you to please say the word. I know it's hard. And it's okay to say, I know we're in court, but with the court's permission. Okay. And when he used his penis to penetrate you, what part of your body did he penetrate? Okay. And did his penis go into your vagina past what we would call like the lifts of the vagina, the outer parts of the vagina? Okay. And is that something you wanted him to do? Was it against your will? Did Mr. Burns use any other part of his body to touch or penetrate any part of your body? We can go with touch first. Did he use any other part of his body to touch your body? Okay. Did he use any other part of his body to penetrate your body? Thank you. And we've been talking about Mott's, as far as you know, Mott's Children's Hospital, is that in the state of Michigan and Washtenaw County? Thank you. After kind of the sexual penetration and what you've described to the court, do you remember if Mr. Burns said anything to you? Would it refresh your recollection if I showed you a statement you made to police shortly thereafter? Okay. Good. Your Honor, if I may approach before I do so, I'm showing defense counsel page 4 out of 6 of the original police report. It has been shared and discovered.
So how it's gonna work is you're just gonna read through this part.
You're not going to read it to us, just to yourself, okay?
When you're done reading it, just look up.
Okay, thank you. Your Honor, may I retrieve it?
Yeah.
Madison, did that help refresh your recollection? Okay. Could you please tell the court if Mr. Burns made any statements after he penetrated you?
He said, read you the stuff.
Thank you. I do have a couple of questions that I missed. I want to go back to. You said you moved out of his parents' residence on April 4th. Where did you go?
Staying in a hotel for-
And what was that? Was that shelter specific, or what was it a shelter for? And when you left in April, did you, again, I don't want to get into the details, but did you make complaints with other police departments reporting the previous assaults? Okay, thank you. Thank you, Your Honor. Nothing further at this point.
Cross-examination. Madison, are you good? Okay, all right. Cross-examination.
Thank you, Your Honor. Hi, Madison. My name is Chinaza. I'm with the Public Defender's Office. I'm representing Jerome, so I have a few questions for you, okay? All right. So you indicated just now that you and Jerome had been married for about 3 years, you said? Okay. When's your anniversary?
May 7th.
Okay. 23? Okay. And you stated that your son went into the hospital on May the 5th. Is that correct? Okay. So when Jerome came to the hospital, how did he know you were at the hospital or that your son was going in for this procedure?
By the my church.
Okay, so, but you knew he was coming to the hospital, right? Okay, and you guys, you didn't go to the hospital together? Okay. And so if that was May the 5th, that means 2 days later was gonna be your anniversary of your wedding, is that right? Okay, and Jerome bought you a gift. Did he bring a gift to the hospital for your anniversary? You don't remember if he brought you an anniversary gift or any kind of gift to the hospital? Okay. You don't remember accepting a gift and telling him how much you loved the gift that he had bought for you? Okay. So when you all were at the hospital together, and you were both in the room visiting your son, is that right? And both of you stayed there for that entire week with your son, right? And when you were there, you guys, you played games together? Okay. You and Jerome talked a little bit, I assume? You're in the room together? Okay. Um, I want to go back just a little bit. You indicated that your son had to get an NG feeding tube, right? That was the reason for the admission. What was the reason for that? Why did he need a feeding tube? He didn't have one prior to that, right? Okay,
Because he wasn't getting enough calories throughout the day on just food.
okay,
A few days I had him eat just as normal every day when he would eat, just to see how many calories he was getting, so they could adjust for how much he would need to once they.
sure. And that's something that they were doing at the hospital. Okay, no, I mean the monitoring the caloric intake at the hospital. Okay, but isn't it true that part of the arguments or issues with you and Jerome is feeding of the baby?
I'm gonna check, Your Honor. I'm not sure how this is relevant to whether or not the assault happened.
Well, Your Honor, I think that it's gonna go into some of the other allegations about the telephone and the excessive oversight that she alleged that my client had over her. We have a reason, or my client has provided me with some information as to what may have led to some of those things or some of those discussions.
Your Honor, I'm concerned not only that it's not relevant, because it's quite frankly, it's not. I'm also concerned that this is all going towards, defendant has multiple times threatened, talked about taking the child away by whether legal means or unlegal means, but we certainly had discussions about family court. This seems like an attempt to make this victim look like a bad mom, and it's not only not relevant, but it's highly inappropriate for this setting.
I mean, that's by no means what I'm trying to do. I'm just
And I'm
trying
not
to.
putting that on counsel. I believe that's defendant's intent.
So what would I do with what you're attempting to try to? Tell you what, I'll be able to sort it out. I'm gonna overrule the objection. I'm gonna give you a little bit of leeway.
Understood. Okay,
Thank you.
thank you, Your Honor. So Madison, my question was just basically, I guess the bottom line is this issue with caloric intake, it was sparked by weight loss of the child, right? Okay. You know how much weight he lost? Okay. Now, do you recall some of the arguments between or some of the issues that, well, let me just ask it like this. You made some statements stating that my client would force you to put your phone on a dresser or a table of some sort, correct? Okay, and isn't the reason that he did that because he complained you were on your phone too much? Okay. He never complained to you about not feeding the child in the manner in which he was supposed to be fed? Okay. What about the allegations or issues that you guys had in regards to infidelity?
I'm gonna object, Your Honor, that to me, that's not an evidence. So unless there's,
Well, except that it's his accusation that that Madison actually testified to peripherally, but So I'll overrule the objection. Go ahead.
Thank you, Your Honor. You stated earlier that he would always accuse you of cheating on him, right? Or talking to other guys. I think that was what you said. And isn't it true that he has confronted you about talking with other guys and cheating on him? Okay. And isn't it true that you had multiple telephones, cellular phones? Okay, you had 2 cell phones. Okay, and you talked about you having to do these check-ins and having to keep your phone on the dresser, but my client goes to work, right? He would leave the home to go to work. Okay, and you stated that you lived with his parents at their home, and they also go to work. Is that correct? Okay, and you also testified today that your son goes to school. Okay, so at times you'd be at home by yourself or my client wasn't always with you in the house. Is that right? Okay. Um, you also talked a little bit about him not allowing you to see your family who lived in Livonia, but he never told you you couldn't go to their house, right? So
So, or go to the cemetery.
okay, but your testimony today was that he said he wouldn't take you there because he didn't have the time or the money to drive you there. Okay. So what would happen if your family were to come visit?
Mother doesn't have a license and my grandma's got health problems. She doesn't get a car.
Okay, so they just wouldn't come or he wouldn't let them come? You said that he would let them come visit.
He told me that they could.
They did not. Okay, so they did not come visit. All right, and speaking of license, that does bring me to the next question. When you first met my client, you didn't have a license, did you? You did?
And I got suspended for 13 because of traffic tickets.
Okay, all right. And Jerome he took you to go get your license back when you did get it back, right? Okay. And at one point in time, you had a white Dodge Charger.
But he sold it out on me.
Okay. But he had purchased that car. I mean, it was your car to drive.
It was his and he was just giving it to me.
Okay. And what about your online bank accounts? You had some online bank accounts like through Chime and other companies?
We shared one and then I ended up going back on my Chime.
Okay. All right, so I want to go back to the hospital. When you all were in the hospital, you said you guys played Uno together. You talked. Now, when my client, you stated today, or you testified today that he asked you for sex. Okay, and is your testimony today that you did not tell my client that you would do it one last time with him?
But I agreed with him because I was scared.
You agreed, you told my client that you all could have sex one last time, right? Oh, and hold on. The one last time is because you knew that my client was filing for a divorce, right? You did not know that. Okay, but you had left the home and obviously did not have intentions on coming back. Okay. And after you all agreed to the one last time, isn't it true that my client asked you again whether or not this was consensual and that you were sure? Okay, but you said yes when he said that, right? Okay, and inside of this hospital, they've got call buttons next to the beds, is that right? They've got call pull cords in the restroom, is that right? They've got call pull cords in other places inside of the hospital room, right? Okay, so much so that I think you accidentally pulled one of those call cords at one point in the hospital, yeah.
Bathroom without turning the light on first.
And pulled the wrong thing, okay. And my client didn't get upset with you or loud with you in the hospital, right? He did, and what did you do when he got loud with you? Okay, but when you were in the hospital, I'm assuming that doctors and nurses and orderlies or whatever the other titles I may be missing, they came in and out the room regularly, right? Okay, and there's no lock on the door inside of the hospital room, right? Okay. When did you report? You did not report this incident. You said that this happened on the 7th. Did you give us a date? I don't know if I took note of that. I apologize. You indicated on the 7th that this had occurred, but when did you talk to someone about it? On May the 10th. Okay, no, so let's just do this. When I ask you a question, just
Oh,
answer.
what was your statement? It was on May 10th because,
Work, but I finally had a chance to go for a walk. And I was able to help someone.
you were able to go for, go ahead. Okay, so you're at the hospital, you went for a walk, and then that's when you told someone. You were still at Mott's at that point. All right, go ahead, Council.
Thank you, Anna. So based on what you're stating right now, does that mean that you never left the room? You left the room, the hospital room without Jerome, right? Yes or no? Okay, you left the room to go possibly get coffee? Yes? Okay. You left the room to possibly go to the cafeteria, is that right? Okay, so all the food that you ate that day was ordered and brought upstairs to you? Okay. How about this walk that you said you went on the 10th? Had you not gone on a walk from May the 5th all the way to the 10th, the entire time you were there? Okay. You also.
You're saying that, I just want to make sure, I
That's
got-
okay.
when you're answering no to the previous question, that meant you had not prior to that point in time gone on a walk, right? Okay, I got it.
And the entire time you were in the hospital, you had your phone on you, right? Okay, but you had your phone on you. My client didn't confiscate your phone, either of the two phones that you have. You had both of your phones, right? And you talked to people on the phone or you texted people while you were there, right? Okay, but at some point while you were there, were you having conversations with people on your phone? You also reported, you testified today that your father's celebration of life ceremony happened while you were there, correct? Yeah, and you had someone come and pick you up, right? Okay, so how did you were able to arrange that ride with that individual without talking to them, texting them on the phone, or communicating at all? You communicated with her on the phone, okay. And there were times where you and Jerome had left the hospital together, is that right?
If the air mattress. Does he want to let me stay in the hospital by myself?
He wouldn't let you stay at the hospital by yourself. So you and Jerome went to go get the air mattress. He took you to La Casa as well, right? You did not go to the shelter at all during that 5-day period you were in the hospital? You don't remember my client driving you to La Casa and sitting outside for 2.5 hours while you went in there to check in? I can't hear you. Okay. How about, you don't have to do check-ins with La Casa when you're staying in the shelter? You had to do check-ins with them, right? And you were required to report to them to let them know your whereabouts and your well-being and things of that nature, right? Okay, and you did that on your cell phone, right? Okay. Um, So you went to your father's going home or celebration of life ceremony. What day was that? Okay, it was before the 10th. So, but it was after the 7th, right? Okay, so your father's going home ceremony was after the 7th, before the 10th, so maybe the 8th or the 9th, right? Okay, and you went by yourself. That's what you testified to today, right? Someone came and picked you up and they took you to the celebration of life and you were there for however long that took and then you came back. Is that correct? Okay. And there were a number of times that Jerome left the hospital without you. Is that right? Okay, so there were times where you were there by yourself. He wasn't with you the entire time you were there, right? Okay, I don't have any questions. Well, give me 1 second, Judge. I do have a few more questions for you. Now, Jerome has never done anything to your son. Is that right? Okay, he's never abused your son, assaulted your son, or anything like that, right? Okay, and when you said that he tried to, or he told you that he had taken a number of pills, what day was that? Okay, but it was sometime while you were in the hospital, right? And doctors and nurses and CNAs and other people walked into that room, right? And if you were really concerned about the pills that he took, you didn't tell anyone, you didn't report to anyone that he may have. Okay, so you didn't believe that he had done that. Okay, no further questions, Your Honor.
Any redirect?
Oh, you're good. Okay, Madison, how you doing? A few things I wanted to follow up on. Um, So council asked you about essentially telling Mr. Burns that, giving in, saying, I'll do it one last time. And you were saying that you agreed because you were scared. So you did it because you were scared. Can you tell us more about that, about what was going through your mind and what that fear was?
Say if I could. Because we said because it was our anniversary that was the reason that we had to, because we were still married. Sure, it wasn't long.
And you asked if Mr. Burns has ever abused your son directly, Benjamin, and the answer was no. Has he ever assaulted you or done things to you in front of Benjamin? Okay. Please tell
Your
the,
Honor, I want to object to that. I think that this is still leading towards the out-of-county offense.
Well, actually, you raised the issue. I think you've opened the door to that regarding abuse. So if a parent something is happening to a parent in front of a child, that might be considered abuse. But I think you opened the door by your question, so objections overruled, you may continue.
thank you. Please tell the court about that abuse in front of Benjamin.
Did anything sexual. Guess we had to stay home. So, whenever we would do stuff like during the night, it's obviously that. And we would get frustrated and then we would start crying. We were doing stuff.
Okay, and what would that frustration look like?
Get frustrated, I think, calm down, fast, Tell me that I wasn't telling them to quit or something.
So Mr. Burns was telling you that you're not saying no?
Telling them stop telling them to quit. He doesn't comprehend words. He might say a couple words, but he doesn't know like meaning.
Okay, so Mr. Burns wanted you to tell your son to quit crying. Is that what, I'm sorry, I'm not understanding. Okay. Okay, and he was frustrated that you wouldn't say that? And when Mr. Burns would have sexual contact with you, when he would sexually assault you, the times that it was against your will, was Benjamin in the room also? While you were at the hospital between May 5th and May 12th, you started kind of getting into, in response to some of council's questions about the times that so sometimes you were able to leave the immediate hospital room. Could you tell the court more about how that happened? When were you allowed to leave? Were there conditions put on that?
Just one.
And I kind of want to, we're asked a lot of questions about when you were around other people, when you were around from Mr. Burns. And I want to kind of group them all together. Could you tell the court the best you can why during those times, if you felt comfortable telling them and disclosing about the abuse you were going through? You were in the hospital for a few days, but was it your understanding that at some point you would go home or return to the shelter, I believe, at the time? Did you have concerns about what would happen if you had reported the assaults at the hospital?
Say that again.
Sure. With the understanding that you were going to end up having to leave the hospital, did you have concerns about what would happen if you reported to hospital staff about the assaults? You said that on May 10th, you finally did report the assault. Could you tell the court about the circumstances that came about?
He told me that I could stay in the room. I wanted to go for a walk, to make the phone call, just to get like immediately.
Okay.
And then anyway, in the corner, I seen him storm out the other day for the elevator. I'm throwing a fit.
And what did you do, if anything, at that point? Okay. Did you go back to the room? Who did you end up reporting it to? Okay. And how come you felt like you could report it at that point? You testified that he had told you when you got to the hospital to shut your phone or phones off, but at some point you were able to turn them back on to make calls.
I think I told him that I needed to at least do, check-ins. Certain people.
So he let you turn the phones back on. One moment, Your Honor, if I may. Madison, you're asked about having two cell phones. How come you had two phones?
Got another one, because, won't let me touch my phone. So I needed to be able to get hold of somebody in for emergency. So I had another phone stashed that way.
Okay, thank you. Nothing further. Your Honor.
How long had you had the second cell phone? From, well, hang on. When you say a few weeks or months, is that from the April 4th date or from the May date? From which date? April or May?
Back to March.
Somewhere, okay, gotcha. All right. And when you use the word, you said you had it stashed. Where did you keep that phone? Say again? In your desk? That was at the apartment. Okay, so you kept it somewhere around there. So when you talked about, as you testified, that he told you to put your phone up on was it dresser? I think it was. Was that both phones or just the one phone? That's what I was getting at. So the second phone, he did not know. So you wouldn't make calls on that phone? Just had it in case. Pardon?
Service on it, but I wasn't able to yet, because I was trying to figure out a way to.
Say that again for me? Okay. So when you say this other phone, when you're talking about putting a service on it, a plan, okay, that's what you're trying to do. So when you first got the phone, prior to you doing that with Kroger and everything, could you call from that phone? Got it. Okay. So you had to, when you had that phone, you could make a Wi-Fi call, but you couldn't make a cellular call. That makes any sense to you, but it does to me. But you think you could call from that phone as long as you had Wi-Fi access? But what you were trying to do when you were talking about putting a plan on it, you wanted cellular service. Okay, if I'm, I'm probably getting way too technical, but you wanted service like everybody else's phone. Or, right, I mean, you just needed a plan so you could call from any, basically, if you needed to.
I wasn't sure if I was gonna be able to follow it out. But I decided to get it.
The plan, got it. Any questions based on the court's questions? Second.
I have a few, Judge.
Go ahead.
You, your son's on social security disability, right? Okay, and you get money monthly from the government for that? Where does that money go? Into your account? Okay, but you, okay,
Before I had my account, we had to put in his, business account.
okay, but you were receiving money.
I'm gonna.
Hold
And
on.
the reason that I'm asking that, Judge, if I may, is because she just testified that she needed to get out of the house to put money on her card because she didn't have any money on her card. So her testimony is as if the only,
Right, but if you, just my understanding, hang on. My understanding of the time frame is that she doesn't really, she doesn't have this other account of hers until after she leaves on the 4th.
I don't believe that's the case. Is you, I don't.
Go ahead.
If the court can ask.
But I don't think I had, that money at that time. I think it already ran out.
What had run out?
The money that I get per month for vitamin.
Okay, so when did that start going into an account you had?
Past year. Exactly.
Okay, but before then it was placed where? Did you have access to the business account?
Then I don't have any further questions. Judge.
Anything from the people?
No,
All right, Madison, you may step down. Thank you.
Your Honor, may this witness be excused?
Any objection?
Judge, I know that it won't be convenient because I'm sure that, I know the people had inquired earlier about child transportation and childcare. I would love to be able to call her as a witness and depending on what testimony comes out later. I don't want to be unreasonable though and say, no, she can't be excused. So I don't know.
Okay, what's her scheduling like at this point? And here's the reason I'm asking. I've got a docket, as I inform council, that was actually supposed to start at 12. I pushed that back to 1, that portion of the docket to 1. I have to get on that docket and try to do that. So I'm gonna have to take a break if that's gonna work with transport, because I know that here, you gotta get the 3 that I have. Okay. So I'm gonna so here's what time is it? Thank you. Like Alexa. Anyway, what I'm gonna do is we'll reconvene at 2:20. Well, just make it 2:30.
Okay.
To continue this exam, if that will work for everybody.
I'm not sure, Your Honor, I will, if you wouldn't mind checking.
I can check with the social worker and see if
Yeah.
officers can stay.
Yeah.
They were, 10 to 8.
Yeah, Your Honor,
So did I. No, go ahead.
Your Honor's energy is unmatched, I'll say. Your Honor, I would suggest an adjournment at this point. I would like some idea of what potential, I know we can't predict what the testimony may be, but in what scenario we would bring the victim back. We can do it at a different time, but at this point, I think an adjournment would be more appropriate.
I can really. How many more witnesses do you have? I had 5 listed, 5 others listed, but I think you had 1 struck off that. So would I have 4 more?
So Your Honor, yes, we have a social worker and 2 officers, so 3 more.
3 more. Okay. Ms. Akinrelli, how do you feel about the adjournment? I have no
Your
idea.
Honor,
what's
we
gonna happen.
would be objecting to the adjournment. We are ready to proceed. I don't know, again, the line of questioning that may bring rise to having to call her back. But I think that if anything, we could adjourn that portion of it if need be. But I know the court is obviously has to jump on this other docket, but we're here all day and ready to proceed once the court is done with the original, with the other docket.
Well, let me just say this. Part of the reason the court's in the time position that it's in is because the court was out at 9:07 ready to start. There was some delay in terms of talking with the witnesses. I'm not gonna call it a delay. Prosecutor had to talk to some of the witnesses. There then arose an issue. You had to talk,
Absolutely.
and I didn't get started till whenever, trying to give leeway as best I could to the parties so that they could be prepared. Oh, let's do this. There are 2 officers? Is
Yes.
that part of the difficulty is the timing of the officers and their,
I think the officers, we also have to check on the victim regarding childcare.
okay, let's do this. I'm gonna give transport time to go get my people for that docket. I'm gonna have him taken back and then we'll figure out if we're gonna proceed, but I gotta start moving something
Understood, Your Honor.
at this point, okay? So court is standing recess.
Good afternoon, Your Honor. Alexander on behalf of the people. Your Honor, the people raised conflict between this honorable court and the Office of the Public Defender. While the people don't believe such a conflict exists, the people make this waiver in avoidance of all doubt.
Good afternoon, Assistant Public Defender Lauren Perry, the Public Defender's Office likewise does not believe the conflict exists, but if one does, we also wait.
All right, continuing the court for its part. Not believe there's a conflict either in Michigan court rules or the cases decided there. To the extent a conflict does exist, given the waivers, the court will consent to hear matters against.
Yeah.
Okay. Court does call the case of the people versus DeJure Pond Sanders.
And then on behalf of the people, Your Honor.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Bond Sanders. Mr. Bond.
Deja O'Brien, Bond Sanders.
Thank you.
Your Honor, as for the pretrial, we are asking to set this case for final settlement conference, please.
And Your Honor, if I could address Bond. that'd be good.
Jury final settlement conference will be set August 8th, 2025 at 9 a.m. Jury selection, if necessary, August 11th, 2025, 8:30. Both of those proceedings are in person. Yes.
Your Honor, it's coming to my attention, I haven't had a chance to listen to these calls, but this defendant has made 22 calls to the victim, starting exclusively after he was arraigned. So at this point, I'd be asking that his phone privileges be revoked while he's in custody.
Your Honor, Ms. Senna did inform me of this, but given the fact that she nor I have listened to the calls, I would ask that you hold your ruling in abeyance until we can do so. Maybe set like another hearing before final settlement.
Well, why would I, if the calls, they were made to the alleged victim's number
Correct. From different pins in his own.
from different pins other than.
Another inmate did call her.
All right. Was there anything else, Ms. Perry?
No, thank you.
All right. This bond will continue. Defendant's phone privileges are revoked this time. And if, I'll do it this way, if defendant requests a hearing on it, then
I'll get in touch. Thank you.
thank you. Court does call the case of the people of the state of Michigan versus Keith Allen Davis. I can't hear you. I can't hear you. Can't hear.
Hello, on behalf of the people requesting practice under Michigan Court Law 8.120, under the supervision of Assistant Prosecuting Attorney Ali Zenda.
I heard that. Hearing no objection, permission to practice is granted. All right.
My turn?
You gonna ask permission to or what? No.
I just didn't want to interrupt.
I got you. All right.
Yes, Your Honor, Hugo J. Mack, appearing in behalf of Mr. Davis. Mr. Davis. Your Honor, by way of information, I did get this case assigned to me very late last week, received discovery, left a voice message and a text message for Mr. Davis. I've checked the Zoom registry. I don't see him here, so I don't have a reason why Mr. Davis is not with us this afternoon, Your Honor.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $5,000 cash surety. That warrant will issue immediately.
All right, Your Honor.
Thank you. Grisbeck. Court calls the case people versus Stephen Grisbeck.
Ali Zenda on behalf of the people.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Grisbeck. Mr. Grisbeck, please state your name for the record.
Stephen Michael Grisbeck.
Teresa Claire on behalf of probation. Your Honor, Mr. Grisbeck is before the court for a review hearing. At this time, Your Honor, the last report I received from the jail on his domestic violence classes is that he has completed 9 out of the 26 classes to date. There is 26 classes that he would need to complete to finish the first segment of the 52 classes. At this time, probation is recommending that the court have Mr. Grisbeck continue all the terms as previously ordered and setting a new review hearing date for September 8, 2025.
Your Honor, we are renewing our request to allow Mr. Grisbeck to complete his probation on out of custody. He did want the court to know that if he were to be released, he would be able to go back to his job. He was doing heating and cooling. He has a full-time job making $21 an hour. If he were to be released, he could start as early as Wednesday. He also did, per the court's recommendation, he did get in touch with the reentry program regarding his Section 8 housing. And his Section 8 housing, he believes is still valid if he were to be released. So he would have his voucher still, which is great news, as I think we were all concerned about him, the possibility of him losing it. He's also very eager to get out and care for his children. He has 2 children. His son's birthday is actually this Wednesday. As of today, he has done 103 days in custody. He would, as the court knows, he has a 24-month probation term, so he would be under supervision for quite some time. He has completed 9 classes, and if he were to be released, from his understanding, this court could order him to restart the program, which would mean another 52 weeks of the DV case or class, which he is willing to do.
My big question is if I go to September 8th, where's he gonna be class-wise? Because that's
Well,
part of,
I did speak with the class instructor, and he indicated to me that the defendant's participation in work is just okay. He's not going above to get the class done. He has not shown up to class. He just hasn't gone. So if Mr. Grisbeck was interested in getting out so he could do the second half on the outside, it seems that he would put forth the effort to get the first 13 weeks done on the inside. I mean, theoretically, to get 26 classes done, he only has to go for 13 weeks. So, because they do it twice a week on the inside. Now, I don't have an exact number where he didn't do that, but according to Mr. Henderson, who runs the class inside the jail, he's just not putting forth the effort.
I do know, Gunnar, it's hard to say also how many classes or how many weeks in the future, because I do know the class, if the teacher is ill, isn't held, if there's a holiday or a jail lockdown. So, yeah, so the court knows, there are situations where the class isn't even held.
Today, the class is canceled as well. And then there's been times where, like I said, they didn't come get us for class. We were on lockdown. I mean, I've been trying to get this class done, every possible class there is.
all right. What I'm gonna do is, I'm gonna continue all terms as previously ordered. I'll set the next review hearing for September 8th, 2025 at 1 p.m. What I'd like to see is some indication that I think we can probably get from either Mr. Henderson or the jail as to the defendant's attendance. And I'd like to see that laid out for me to see whether or not it's a circumstance where classes are being canceled or the defendant's not going.
Okay, Your Honor, I would like
All
to
right.
report from Mr. Henderson.
All right, thank you. Court does call the case People versus Austin on.
Hello, on behalf of the people.
An Assistant Public Defender Natalie Quaid on behalf of Mr. Austin On, who should be present via Zoom. Sir, could you please unmute and state your name for the court?
Austin On.
Oh, there he is.
Thank you, Your Honor. I'm respectfully requesting a brief adjournment so that I can continue reviewing media discovery and then discuss that with the client. And I do believe Ms. Zenda states that the 911 call is also still on the way.
That's correct, Your Honor. No objection to the adjournment.
It's amazing when they're little and they get their voice. Free trial in this matter will be adjourned to.
August 4th at 1 p.m.
Okay, August 4th, 2025, 1 p.m.
Thank you, Your Honor.
Thank you.
Mr. On, you're all set for today.
Okay, thank you.
Court calls the case People versus James Raggett.
Alexander, on behalf of the people, Your Honor.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Raggett, who is approaching. Mr. Raggett, can you please state your name for the record?
James Patrick Raggett III.
Your Honor, regarding the pretrial, we're asking to set this for final settlement, please.
Jury final settlement conference, August 8th, 2025, 9 a.m. Jury selection, if necessary, August 11th, 2025, 8:30. Both of those proceedings are in person. Bond hearing proceeding.
Thank you.
Thank you. Court does call the case People versus Anita Payne.
Hello, on behalf of the people.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Ms. Payne. Ms. Payne, please state your name for the record.
Good afternoon, Your Honor. My name is Sunita Payne.
Thank you. All right, what are we doing?
Teresa Claire on behalf of probation, Your Honor. Ms. Payne is before the court for hearing. Ms. Payne is compliant with the terms ordered, accepting with her payment. She did have an arrearage of 113. She did indicate to my office that she would have that paid, and I'm just checking right now. By today's hearing. And she has made that payment, Your Honor.
Okay.
Given that she is now compliant with all terms, probation is recommending that she remain compliant with the payment plan of $69 per month, that she continue all other terms as previously ordered, with the next review hearing being set October 6th, 2025 at 1 p.m.
Your Honor, I did speak with my client regarding this. I don't have any objection to any, the majority of it. The only thing we would like to address is the contact order. There is a no contact order with the child and I suppose the child's father. It's been in place since the start of this case. Ms. Payne would like to have contact with, I suppose both of them, as the child is living with the father, but specifically the child. I did look back at my notes when the father was present at sentencing back in April. He did say he had no objection to them having contact. It seems Ms. Payne has been compliant with probation, is attending programming, and that seems to be going well. So we're just asking for the court to consider lifting that no contact order so she can have contact with her son.
And Your Honor, I would defer to the court with that. However, I do believe the reason that was put in place is because there was a circuit court order that directed.
Right. And that's what I recall. And my question is has anything changed regarding the circuit court order?
I have not received anything to the contrary that it's been different.
Is it a PPO?
They have a custody or a court case at circuit court.
Well, Your Honor, I don't know.
Fair.
Yeah, I don't know. I can't answer that, but I'm happy to.
Go
Sure,
ahead.
Ms. Payne, do you know?
Is it okay if I speak real quick?
Yeah, go ahead.
Hi, how's everybody doing today?
Good, thank you.
Wonderful. So right now on custody, there is not parenting time set for my son just yet. I have not applied for that because I was on probation for this case, and I didn't know how that was going to go through with them either awarding it to me or not awarding it to me for me being on probation for the case. So I was hoping to wait until it was over to apply for custody, but I don't have any parenting time implemented. But with the no contact order is only through this court right now. There's nowhere else that says I can't see him. And his dad said that it's fine for that, but it makes it difficult when in the paperwork from probation says that there's a no contact. That's the only place that it says that. And I don't think that personally that me seeing him is going to be a danger. I understand what happened and I just want to see him. He needs to see me as well. And thank you so much.
Ms. Larry, you were going to say something.
Your Honor, I pulled that language from what was last in their custody order. I don't think that anything.
Basically, this did not allow.
It basically allowed for supervised visitation.
Yeah, right.
At his home. Now, there is a no contact order with Mr. Robertson, which would prohibit Ms. Payne from visiting the child with his supervision, which was what was allowed by circuit court.
Got it.
So I do believe, Your Honor, that it would require some motion on Ms. Payne's part to have that order changed.
At circuit.
Correct.
Yeah.
So
I don't think that this was derived, I can stop there because I don't think it was derived out of the blue. I think where it came from was whatever was put in place
at circuit court.
at circuit court. That's where we got it. So if somebody wants to get something to me, Ms. Perrone, that shows me that the circuit court order is something different, I will certainly reconsider that.
Yeah, family law is pulled other bear, so I'll have another conversation with Miss Payne.
I gotta be a bear.
It's a bear, I don't really,
Oh, okay.
us criminal attorneys don't always want to touch, but I'll see if we could do something up there, and Miss Payne and I can get more information to the court.
All right, very good. I will then order that the defendant's payment plan at $69 per month will continue. I'll continue all other terms as previously ordered. I'll set our next review hearing October 6, 2025 at 1 p.m. Thank you.
Thank you, Your Honor. Have a lovely day.
Thank you. You too. Court does call are both on?
Yes.
Cases of the people versus Roman Williams.
Claire Law on behalf of the people.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Williams.
No. State your name, please.
Roman Williams.
Mr. Claire, on behalf of probation, Your Honor, Mr. Williams is before the court for review hearings in two cases, one ending in 1236 and the other ending in 1243. Mr. Williams is non-compliant with the payment plan that's set forth in both cases. The other issue with Mr. Williams, probation is asking that the court give him a warning about attending the domestic violence class weekly. He's still considered compliant, but is really pushing towards his max of absences. So probation is asking that the court give him a warning about attending that DV class weekly without skipping, and that in case ending in 1236, that he pay $77 arrearage today, then remain compliant with his payment plan of $26 a month. As to the case ending in 1243, probation is asking that he make a payment of $997 arrearage today, then remain compliant of his payment plan of $181 per month. And in both cases, have the court have him continue all other conditions as previously ordered, with the next review hearing date being set August 8, 2025 at 1 p.m.
You're right, I don't have really an objection to any of that. I was unable to speak with Mr. Williams prior to today. Mr. Williams, I think the number we have for you is disconnected. So if you've changed your number, please call the public defender's office. And so we can contact you, okay?
Okay.
Did you get my email?
Yes, I received your email.
You can also call my number and my signature. But I'm not sure if Mr. Williams is able to pay that today. But again, no objection to anything else. Mr. Williams, are you able to make a payment today?
I'm able to make a payment towards both of them, but maybe not the entire $977.
How much can you pay?
Probably like 300, 200.
Well, we'll go with the 3 because you're behind. So I'm going to order on the case ending in 1236 that the defendant is to pay a $77 arrearage on or before today's date, then remain compliant with payment plan at $26 per month. I will admonish the defendant that he is to attend his domestic violence classes weekly. And I'm just going to let you know, if you get kicked out of the domestic violence program, that could lead to incarceration for yourself. You understand me?
Yes, sir.
Continue all terms as previously ordered. I'll set the next review hearing for August 18, 2025 at 1 p.m. That's on that case. On the other case ending in 1243, the defendant is to pay $223 arrearage on or before today on that case. How are you gonna get yourself back on track on this case, young man? Because then you're gonna owe about $774 still on that case just to get compliant.
I'll just probably put like $100 every week. Just to try to get myself caught back up. Just because I know it is like $181.
What I'm gonna do is you're to pay $223 today. That comprises the other half of that 300.
Okay,
And then $100 per week thereafter until compliant.
sounds good.
And then you have to remain compliant. On this case, I'll do the same admonishment regarding your attendance at DV classes. I'll continue all terms as previously ordered. I'll set its next review hearing August 18, 2025 at 1 p.m. Thank you. Court does call the case of the people versus Zachary Burlett. Yeah, Mr. Burlett's here.
Mr. Burlett, please state your name for the record.
Zachary Thomas Burlett.
Chris Claire on behalf of probation. Your Honor, Mr. Burlett is before the court for a review hearing. Mr. Burlett did have a relapse. So Mr. Burlett did find himself back into Dawn Farm Sparrow.
Okay.
And he did go in to Sparrow on June 12th. He completed detox on the 15th. Then he went over into the residential portion, which is where he still is. The plan is on the 13th of this month to move back into transitional housing. The one thing that I can say about Mr. Burlett, although he did have that relapse, he's been in communication with my office. At this time, probation would like the court to give him an opportunity. As the court's aware, substance abuse issues is a difficult uphill battle. The biggest part with probation is that Mr. Burlett let me know about it right away, and he is honest about it. Given that he did that at this time, probation's asking that the court order Mr. Burlett to start with payments, resetting them at $133 per month beginning in August on the 11th, that he complete his 30-day inpatient at Dawn Farm, then can comply with the plan for transitional housing and continued outpatient. That plan is for long-term, Your Honor. And that he continue with all other conditions that this court set forth, with the next review hearing date being set August 18, 2025 at 1 p.m.
All right. Mr. Burlett, anything you want to tell the court?
Yes, Your Honor. First of all, I want to thank Agent Blair for being very supportive of my recovery, and I'm grateful that that everyone that is in my corner is not looking for punishment, because that's not what this is about right now. It's just about getting back on the ball of things and going through the level of care here and where the mistakes had happened, where I wouldn't say, not trying to beat myself up, where I take part in my part of everything, if I'm making sense here, and that, just having to redo things in a certain different way, like with employment, we're going to go to part-time. I have my commitments back at certain meetings that I've been having commitments at. Just have to apply myself a little more, not to be so hard on myself. So I really want to thank Agent Polera and the courts for giving me the privilege to continue my sobriety, and more importantly, to really be in my corner of it. It's truly amazing. But again, I take my part in everything. And, again, Agent Players remind me that, she's not here to punish me. She's here to help me as much as that she can possibly, as long as I work with her, but more importantly, be honest with her. And that's the one thing that I have to learn in my recovery, more importantly in life, that I have to be honest within myself and with others, because that's what's going to help me achieve my goals and have achievement in my sobriety. So thank you for letting me speak.
Not a problem. Probably the thing that sums up Ms. Blair is when you said she's amazing, and she is. That's why I'm so proud to have her as my probation agent. It's supposed to work this way when something like this happens. Most important thing for us, quite frankly, is get you back on track. Give you an opportunity to sort of breathe and move forward. Like you said, it's not about punishment at this point, certainly. All right. So
Yes, Your
I'm
Honor.
going to order that. Let's pay $133 per month. Will begin at August 11th, 2025. He's to complete 30-day inpatient at Dawn Farm, then comply with plan for transitional housing and continued outpatient treatment. Continue
Correct.
all other conditions as previously ordered. I'll schedule a review hearing August 18th,
August 18th,
2025, 1 p.m.
1 p.m. Thank you.
Right.
Really quick, Your Honor, I know we're trying to move along here. There has been a situation that came to my attention from one of my peers, and I did bring it to Agent Polera's attention. She was not aware of it, not to throw her under the bus. We did discuss about it. There is an active case that was open on June 4th for a retail fraud.
For you?
And yes, and I'm being very honest about it. I did not receive any type of mail, anything about it. I've asked my roommates if anything have came in.
Hang on a second, Mr. Burlett.
Your Honor, I believe that it will be coming to you. It is not a violation of his probation. It is from June 4th,
It's from June.
before he was placed on.
Before he
I
was-
believe on 24. So it's just coming through now.
It's just coming through now to me. Okay. All right. Well, thank you for that, but we'll deal with it when it gets here. It's not a further violation.
Okay.
You were in the throes of whatever the heck you were trying to do with your life when that happened. Okay. So
Yes,
we take that into consideration.
Yes, Your Honor. Thank you.
All right. We'll see you.
All
Take
right.
care of yourself.
You too. Thank you as well. Thank you, Agent Polera.
Court calls the case. People versus Timothy Riley.
Hello, on behalf of the people, this is Public Defender Natalie Tate, on behalf of Mr. Riley's appearance is waived.
Teresa Clare, on behalf of probation, Your Honor, Mr. Riley was scheduled before the court today for a review hearing. He is compliant with all terms ordered by the court. Mr. Riley has actually completed everything that this court has ordered. At this time, probation is asking that the court discharge him from probation of his case. So, yeah, with improvement, Your Honor.
All right.
No objection.
Thank you. Not hearing an objection. Defendant is discharged from probation with improvement. In this case will close. Court does call the case of People versus Jason Stevens.
Public Defender Natalie Tate, Mr. Stevens, appearance is waived.
Teresa Clare, on behalf of probation, Your Honor, Mr. Stevens was scheduled before the court today for a review hearing. He is compliant with the terms ordered by this court. Probation is recommending that all conditions continue with the 2025 at 1 p.m.
No objection.
So ordered. Court does call the case of the People versus Marco Arizankowski.
Clare, on behalf of probation, Your Honor, Mr. Eric Zinkowski was scheduled before the court today for a review hearing. He is compliant with all terms ordered by the court, and I did waive his appearance. Probation is recommending that all the next review hearing be set October 6th, 2025.
Hearing no objection, so ordered. Court does call the case of the People versus BJ Dandamoody.
Hello, on behalf of the people,
Teresa Clare, on behalf of probation, Your Honor, Mr. Dandamoody was scheduled before the court today for a review hearing. He is compliant with the terms ordered by the court, and I did waive his appearance. Probation is recommending that all conditions continue with the next review hearing being set October 5 at 1 p.m.
Hearing no objection, so ordered. Court does call the case of the People versus Robert Jones.
Teresa Clare, on behalf of probation.
Rise. 14A District Court for County of Washington, David Bishop, back in session. The case subject to preside.
You may be seated. Pardon? Yeah. Court does recall the case, Field State of Michigan versus Jerome Burns.
Good afternoon, Your Honor. Ken House, Assistant Prosecuting Attorney on behalf of the people.
And Assistant Public Defender, Chanel Carey, on behalf of Mr. Jerome Burns, Mr. Burns, state your name.
Thank you. All right, the preliminary examination in this matter has started there in my docket, and then here's what we're gonna do, and I think we've got it more streamlined as to what witnesses will be necessary. But as Mrs. Burns may need to be called back, council is gonna work together to make sure that if she is called back, that arrangements are being made, also allowing certain witnesses at people's choice to also be on call and to try to make sure that that's streamlined and we can streamline the testimony and have this matter headed forward. I will adjourn the preliminary examination in this matter or continue the preliminary examination to July 15th, 2025 at 1 p.m. All right, that's a Tuesday. Correct.
Your Honor, I just want to clarify on one issue.
Yes.
Regarding if Mrs. Burns is going to be called back, could we plan that as a kind of schedule that out and not have her on call because she doesn't have reliable transportation? And
What are your thoughts on that, Ms.?
So, Your Honor, if I'm hoping that she'd be able to at least be on standby, so that if we do need her, she'll be able to get here. I know part of the questions that I may have to ask her may be dependent on what the officers say, and I don't know if it would just be better to call her on direct as a witness, or I'm not sure.
I got you.
there'd also be the additional issue, Your Honor, I apologize, that if we start at 1 o'clock, like today, she had to leave at 2:30 for childcare.
She did. Okay. Okay, I wasn't sure. So let's do it this way. It would seem to me. So it's always is that childcare consistent each day? Like it's at that same time, or we could probably make that assumption that it's going to be right around that time. So, I hate saying this because it doesn't fall to me, it falls to Ann to do. But why don't, instead of having her on call that day, because if I have to start at 1, and the reason I'm saying that is because if I had to start at 1, problem is I won't have my courtroom right away potentially because there'll be exams going on. And so I'm going to have to come in as soon as the other judge clears my bench. So it almost doesn't make sense to have her on call. It might be a waste of everybody's time to do that. What I would do is take what witnesses we can, the other witnesses we can. If after, since Ms. Eckenrode, you've indicated it's contingent upon what testimony you or what other witnesses testify to. If at the end of that proceeding, you determine that you would like her called back, either called back in the prosecutor's case or as a direct witness in your case, I will permit that to happen. We will find time to, on another date, to put something in the morning.
Okay.
Again, I don't know where that's going to be, but and we'll figure it out.
Okay,
Okay.
thank you.
Fair enough. Okay, we'll do it that way. And I would also just remind you, I have not sentenced him on his bond violation as of yet either. So that is continuing along with this.
Okay.
Okay. That being all. No, I spend my life as a mushroom. So I don't like all the sun. What?
I said, I normally say we're vampires. We don't like the sun.
Yeah, vampire, mushroom. Why'd you call me a vampire?
I said we as a group.
We?
We're a coven. Coven.
I don't know about that, Ann. We'll have to talk about that. Okay. Court calls the case of, am I on? I am. Of Lawrence Caro versus Patrick Cox.
Good morning, Your Honor. Dan Troika appearing on behalf of Mr. Carroll.
All right, good morning. Good to
Morning,
see
Your
you.
Honor. Gary Bankson appearing on behalf of the defendants, Patrick and Laura Cox.
All right, very good. All right, I think I set this as a status conference a while back, and
Your Honor, I believe
now
that.
everybody can let me know where we are.
So Your Honor, there is a pending interpleader case in the circuit court. That matter is in discovery as we speak. Since we were last before Your Honor, and at that time it was not me, it was my partner, because for some period of time I was out of commission.
Yes, sir.
The court gave us a decent amount of time to get to where we are today. We're still, I think, needing more time. Mr. Bingston, of course, can speak for himself, but we're actually litigating the case in the circuit court, so we're not just, sitting on our haunches. The case is ongoing. We did mediate, that failed so far, and so we do continue to litigate.
Your Honor, I don't disagree with anything Mr. Troika said. I think we're just going to need some more time. We are in discovery presently. Probably there'll be some competing motions for summary soon in the circuit court matter, but we'll see how it plays out.
All right. With you two, I'm willing to give as much time as you guys need. So how much time do you guys think you need?
Mr. Troika, what do you think?
Oh, I'd say into December. I know that's a ways.
Okay.
But our schedule in the circuit court is, I'm pulling it up. It's dispositive motions. Well, that's I would say December, if Bingston is agreeable, and if your court will allow that.
Okay.
I would agree.
I think we can do that. It's really strange. Before you even said December, I'm thinking, just put it to the end of the year. But didn't want to be presumptuous.
I read your mind.
Yeah. I don't know that people want to do that. But I'm thinking some things sometimes.
Beginning of December or middle of December?
Why don't we do mid-December?
December 16th.
December 16th. All right. I will adjourn this matter to December 16th, 2025 at 9 a.m.
All right.
For status conference regarding the circuit court matter. Okay. Very
Thank you
good.
very much.
Thank you.
Take care, Judge.
Mr. Troika, just
Yes.
on a matter of personal privilege, it's great to see you, sir.
Well, thank you. I'm glad to be here, especially compared to the alternative.
Exactly. All right. Take care of yourself, please.
Thank you.
Court does call the case of Lawrence Vitale versus Connor Vitale.
Good morning, Your Honor. Jillian Engen for plaintiff.
And is that Mr. Vitale?
I honestly think that's Mr. Cox.
Is that?
I think so. I don't know. He won't respond to the check.
All right. On the Vitale matter, where Connor is not here, neither is Mackenzie Ball.
Thank you, Your Honor. This is a case where we filed a notice to quit. I understand that at the last hearing, defendants said that they would be moving out over the weekend. They have not moved out. We sent a notice that we would be seeking an immediate writ under MCL 657-44. Your Honor, the immediate writ would be proper under subsection 3C because defendants are holding possession through force. This is a case where there's not a lease, there is not actually really a tenancy. This is a case where the defendants were essentially guests in plaintiff's home. He was allowing them to stay there for a time, but the relationship has deteriorated and defendants have, acted disrespectfully, threateningly to plaintiff. And so we are asking for an immediate writ, which I do not have with me, but we would be submitting to the court if it's granted.
I had already granted a default as to defendant 2 in this matter. Paul, So I'm going to grant judgment to the plaintiff for possession. There is no redemption. I will issue an immediate writ.
Thank you, Your Honor.
All right. Oh, forget there's some judgment. There we go.
Thank you. Your Honor.
All right. Thank you. That's it. Okay, this is where I get like my cattle dog. If I don't have anything to do, I'm going to get destructive. But what the heck? All right, court stands in recess.
We'll make up for it next Tuesday.
Next. Why are you here?
Good day, Your Honor. Good morrow.
What do you do with parenting?
I'm just doing a expungement right quick.
She should be on Zoom though.
But I was also
Oh, yes, Miss Parney's on the Zoom.
I was also attempting to get
So,
tactical votes, but
Miss Parney? I can't hear you.
this is going well, Your Honor. So,
Why? Really? Why is she here?
I'm helping, Judge. I'm hoping I'm going to get good points with you.
Okay, so here's the deal.
Yes, sir.
Our whole arrangement was I only see you Thursdays. Okay, now I may
So
not,
fortunate, right?
I may not have communicated that to anybody. I may have made that my.
Also, the person in charge of my office, we discussed how much food we ate this weekend. And it did not include brisket or any other smoked products, so we are upset. She knows.
So here's the deal. I don't think I was supposed to feed you either.
Oh, I got confused briefly, Your Honor. My apologies.
So who sent you here? So I
I'm here
can call
today to
them.
do an expungement for Mr. Arima. And he was like, have that Stephanie.
Nope. We'll be doing everybody else's cases but that. Ms. Parony, can you communicate with us yet or? No, can't hear you. Still. This is a bad day. I can't hear Miss Parony, but I can hear Cannon. Obviously, I don't have choices. I think because the PD's office is here, I do need to waiver and the prosecutor.
Good afternoon, Your Honor. Ally Zend on behalf of the people. Your Honor, the people waive any potential conflict between this honorable court and the office of the public defender. While the people don't believe such a conflict exists, the people make this waiver in avoidance of all doubt.
This is Public Defender Natalie Pate, Your Honor, on behalf of the Public Defender's Office. Likewise, Your Honor, our office does not believe a conflict exists between this honorable court and our office, but if one were to arise, we would waive such a conflict.
All right. The court, for its part, also does not believe there's a conflict either, and the Michigan court rules are decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. The court does call the cases of the people versus Maria Phillips.
Ally Zend on behalf of the people.
You know, Lauren Perny, Assistant Public Defender Lauren Perny, not on behalf of Ms. Phillips. We were marked as counsel for this case. I think we represented Ms. Phillips on the underlying case. However, we did not assist her in filing this expungement.
Okay, Ms. Phillips?
Yes.
You could unmute. Oh, there you are. Okay. Who did you file these on your own, or was somebody helping you do this?
No, I went through the down on Washington Street. I forgot her name. I think her name Ali. It started off with Patrick and then I got transferred over to Ally, I think.
So, go ahead.
I had in our file, it was the Michigan Advocacy Program was helping.
Yeah, they're usually here. Okay, Ms. Phillips, let me pass. Does somebody have a phone number or email for? Well, it would be MAP. So, but I don't want to call the legal services hotline.
There was a phone number on their application for, I think for specifically for the person who helped. Or at least in the cover letter that was from that,
Okay, let's see.
for an Ally Ellis.
Yeah, I have, yes, it's Heavy Ellis. Okay, Ms. Phillips,
Yes.
hold on a moment. We're gonna try to see if we can get your attorney signed in here, okay?
Okay.
So I see the return, but I don't see a. Oh, well, who they send it to?
She's a paralegal.
She's a pair.
It says.
Paralegal. All right, can we call over?
Yeah, I can see if I can.
Did you, I mean, you can probably try to get to.
Okay.
What's your name? It left my head.
Did you see that? What's the name?
All right, so hold on, Ms. Phillips. We're gonna try to see if we can get your attorney signed on, okay?
Okay.
All right, thank you. I'll
Thank
pass
you.
that. Court calls the case, People versus Dara Patel.
Ally's another people. This is Joe Simon's case.
Oh, it is. He's not here yet.
Yeah.
Okay, we're doing great. Tried my best to avoid it. Called everything I had, but now I guess Cannon's up.
Right now. So if you wanted to play that game.
Are you ready?
Yes, yes. Always for you, Your Honor.
Wow. Wow. I don't even believe that. Court does call the case, People versus Gamal or Reba.
Ally's on behalf of people.
Stephanie Cannon on behalf of Mr. Arima, who is approaching, Your Honor. Mr. Arima, when you are present, please state your name.
Gamil Arena.
Thank you. All right.
Thank you, Your Honor. We are here today on a motion to set aside a conviction, Your Honor. We are asking that a conviction for Luther Fraud third, the date of conviction would have been October 3rd of 2003. Your Honor, we have received information from the Attorney General's office saying that my client is able to have this expunged. We receive information from the Michigan State Police indicating the same thing. My client has not been convicted of more than 3 felonies. My client has not had any convictions for assault or crime set aside as of today's date, Your Honor. There are not criminal charges pending against him. He has not been convicted of any criminal offenses during the applicable time period required under MCL 780.621. The time period required for the convictions listed has passed for all of the convictions, and the opportunity, or I'm sorry, Your Honor, it is my client's belief in mind that it is consistent with public welfare to allow this to be set aside. I've spoken to my client, Your Honor. He would like to address this court regarding why.
Currently enrolled in my major is cybersecurity, so just having that type of conviction under my record wouldn't help with me, finding my career.
You're enrolled where?
Washington Community College.
Cybersecurity?
Yes.
Why?
I mean, it's the latest thing, so.
It's the latest thing, so I'm gonna do it, right? Okay. What have you been doing since the time of this conviction with your life?
Just working, like that has something to do with it as well. I haven't been able to find the, right jobs. Been a lot of like warehouse and
factory type of work.
All right. Anything else you want to tell me?
No, that's
So if somebody breaks into my computer, I can call you?
it. Hopefully in like 5 years.
5 years. 5 years. So you can't help me?
Not now.
I'm starting. All right, fair enough. All right, very good. The court, having heard the petition and the elocution of Mr. Arima, the court, based upon that petition, would find that after an opportunity has been given for the Attorney General and a prosecuting attorney to contest this application, and neither contesting this application, this court does believe that the circumstances and behavior of the applicant from the date of his convictions to the filing of the application do warrant setting aside the convictions and is consistent with justice and the public welfare. Therefore, the petition is granted. Thank you.
30 days for paperwork.
Is that it for you, Ms. Cannon?
That is. Your
Bye.
Honor. Thank you.
No.
Thank you
I mean-
so much. Your Honor.
All right. Always a pleasure. The court does call the case People versus Dara Patel.
Ally Zend on behalf of the people.
Your Honor, good afternoon. Joe Simon on behalf of Dara Patel. Dr. Patel, will you unmute and turn on your, yeah, there you got your video on. Unmute and state your name, please.
Hello, Your Honor. My name is Dara Patel.
Right. Good afternoon. All right, Mr. Simon, it's your petition. Go ahead.
Thank you, Your Honor. Did the court receive my memorandum in support of our petition?
You had a memorandum in support. I did not see a memorandum.
Then let me just give you a couple of the highlights that were in there, Your Honor.
Yes, sir.
Pardon?
Yes, sir. Go ahead.
Oh, okay. Your Honor, my client has had, this is her only contact with the criminal justice system. She's had no contact since she completed her probation on time. She now is in, I think it's pronounced Duarte, California, where she's participating in a fellowship and at the UCLA Harbor Medical Center. She's planning on returning.
I don't like UCLA. But go ahead. Never mind.
That's why I quickly
quickly
tried that. And she's planning on returning to Michigan. And Your Honor, she's not only eligible, but I also had her and attached it to the memorandum, do an updated assessment with Ms. Geiger. And Ms. Geiger concluded that she does not warrant or need for further treatment or further educational services. In a case like this, sometimes I do that so that the court can have even greater assurance that the setting aside a conviction like this would be in the public welfare and consistent with public welfare. So, Your Honor, we are asking for that privilege of expungement.
Tell anything you want to tell me other than the UCLA thing. Go ahead.
Just that it would be, it was something that happened a very long time ago, and I've learned a very great lesson from it. And it would, if this were to be expunged, help me with my future jobs, as well as multiple medical board licenses, and help me provide care for patients in the future. And I really appreciate anything you guys can do to help. Thank you so much.
All right. Has this kind of hindered you along the way, or?
I'm looking for jobs now, so I'm hoping that with my future prospects and being able to have to apply to many medical boards and different states, hopefully if this gets expunged, it will not hinder me from future jobs. So I'm starting now.
Starting now. Okay, very good. And actually, I have nothing against UCLA. That was Mr. Simon who started that all. All right. Okay. Looking over the petition, hearing the petition by Mr. Simon, as well as the elocution of the defendant in this case, an opportunity haven't been given for the Attorney General and prosecuting attorney to contest this application, and neither contesting, saying the court does believe that the circumstances and behavior of the applicant from the date of the applicant's convictions to the filing of this application do warrant setting aside the convictions, and the court does believe that it is consistent with justice and public welfare. and therefore your petition is granted, and I have signed the order. All right. Thank you. Thank you so much. Best of luck to you in the future.
Thank you. Thank you.
Thank you, Your Honor.
All right. Thank you, Mr. Simon. Court's going to stand in brief recess while we try to figure out.
Through to anyone, but she's still.
All right. There's
Simpson,
yes, Phillips.
I contacted the attorney office. They said I don't have an attorney. I'm here by myself.
Oh, did they?
Yeah.
Okay. Okay, then just give me a second. Let me get your files back because my staff took them, and then I'll come right back out. All right.
Okay.
Court's in recess. Court recalls the case of the people of the state of Michigan versus Maria Phillips.
Allie Zend on behalf of the people.
You there, Miss Phillips? Oh, there she is. Okay. Miss Phillips, they've indicated that you are in pro per and they are not representing you. There have been two petitions to set aside, well, actually on two cases, one being an embezzlement case with the conviction date of December 8th, 2009, and a retail fraud third with the conviction date of March 19th, 2014. Tell me why you think I've reviewed everything here. Tell me why you think I should set this aside.
I haven't got any trouble since those last convictions. I've been trying to get a decent job, but a lot of charges have been hindering me. I'm in school now and I have kids now, and I'm just trying to do the right thing, stay on the right path.
You're in school. Where are you in school?
Oakland Community College.
Okay. And so when you grow up, what are you going to be?
I'm well, I'm already grown though, but I'm trying to go back and get
Yeah,
an
I
associate's
know.
degree
That's what
in
everybody tells
accounting.
me. They're already grown in there before me. So what are you going to be when you grow up?
I'm going to school for accounting.
Okay. You want to be an accountant?
Yeah.
That kind of stuff puts me to sleep, but that's okay. If that's what you want to do. Somebody's got it. Okay. And you said you have kids? How many kids do you have then?
I have 4 little girls.
4 little girls?
Yeah.
Oh, bless you.
I know.
Well, don't look so sad. How old are they?
15, 11, 7, and 6.
Wow. I won't say I feel sorry for you because I'm sure they're a blessing. But in about the next 3 or 4 years,
Right now, it's already
I'll just say
starting.
my prayers for you. Okay.
I know it's starting up already.
Yes. All right. But I noticed when you mentioned them that the greatest thing is that a smile came to your face. So
Yeah.
it's not all bad, right?
Nah.
Okay. Court, having reviewed the petitions, having heard the allocation of the petitioner in this case, and the court acknowledging that an opportunity has been given to the Attorney General and the prosecuting official to contest the application, and this application is not being contested. Court believes that the circumstances and behavior of the applicant from the date of the applicant's convictions to the filing of this application do warrant setting aside the convictions. And the court also finds that it is consistent with justice and the public welfare. Your petitions are granted, and I have signed the orders. All right.
Thank you.
Ms. Phillips, good luck to you in the future.
All right. Thank you.
Thank you.
Bye-bye.
CNA District Court for County of Washington, State of Michigan is now in session. All for the court on here, the Honorable Judge Simpsons presiding.
You may be seated. I don't have a prosecutor here. All right, great. Court does call the case, People versus LaShawn Courtright. Good start. Huh? He's the first one here, but he's not here when I call the case. I figured you were busy. I defended you But you should have heard what these other
Oh,
people. were
Mr.
saying. It
Mr. Allen was supposed to help me
It
out.
was horrible. It was horrible, the things they were saying.
Edward Drugas on behalf of Ms. Courtwright
Especially Mr. Shank.
told me not to say it, but
Yeah.
he did. He warned me. Ms. Courtwright is on her way. She is on the bus.
She's what?
She's on the bus. Mr. Allen told me not to say it, but she is on her way. She's been very cooperating. I gave her the ample warning when the Excel spreadsheet came out that we were number one on the docket. So topped the line and said, get here early. And she talked to her this morning. Her alarm went off
You just
late.
kept talking until like.
So I'd ask
give in,
for
aren't you?
the court to pass it. I also have a 10 o'clock, so I'll be here. So I was hoping that Ms. Courtwright will join us at some point between now and then. That's my gracious request.
She's on the bus.
Yeah. I'm not sure which number, but I could try and locate that.
Do you have proof she's on the bus or she?
I have a text message. So that's pretty good proof. Thanks.
Are you leaving the courtroom now since you caused all this disruption?
Yeah.
Okay, bye. On a bus. Court calls the case People versus Aaron Salazar. Mr. Allen told me not to say it.
Good morning, Your Honor. David Shannon, behalf of Aaron Salazar.
Good morning. Your name, sir?
Aaron Salazar. And we did have an opportunity to go over the pre-sentence report. There's no additions, deletions, or corrections. I think it's an excellent recommendation, and I would just ask the court to follow it.
Sir, is there anything you'd like to say before I impose that?
No, I'm not.
All right. The court does acknowledge this is not a serious misdemeanor as defined by statute, however, believes that there are reasonable grounds to depart from the presumption of a non-probationary sentence. Specifically, the alcohol screening and assessment identifies the benefit of alcohol education, abstinence, or attendance at one AA meeting per week, at least for a month, and the abstinence from all intoxications. I'm gonna, you know what, I'm gonna leave, come back. And hopefully things can get rolling. In abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation with the stated of a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. So therefore, the sentence of the court, I'll place you on 12 months probation. You are to pay $855 fines and costs, $100 prosecution recovery costs, $100 police agency recovery costs, $360 probation oversight fees. When can you pay that, sir?
How much time are you going to need to pay? 30 days, 60 days, something like that?
How much is today?
It's going to be over $1,000.
How much I can?
How much time don't set yourself up to fail. So how much time do you need? Would 90 days be enough?
Yep.
Can we have 90 days, Your Honor?
In jail?
No,
I'm kidding. What is this? July? Pay that by October. Do you have anything today?
Do you have any money with you today?
I have some,
How much could you pay today?
400.
400?
Yeah.
Okay. That means he has 5. Pay $400 today. The balance will be due by September 30th, 2025. There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete an alcohol highway safety education program, or the alcohol highway safety education program. You're to attend one AA meeting per week for a month with verification to probation. You're to provide proof of victims' impact panel attendance to probation. I will continue the sober link for an additional 30 days in lieu of 4 days in jail. I'll order 93 days in jail, credit 1, the balance is suspended. Thank you.
Thank you, Your Honor.
Court has called the case of the People versus Jason Allen.
Public Defender Natalie Pate with and on behalf of Mr. Jason Allen, who stands to my right. Please state your name for the record, sir.
Jason Allen.
Thank you, Your Honor. Today's the date and time set for sentencing. We have had the opportunity to review the pre-sentence investigation report, and we only have one correction, or it's more of an update. As to page 2, under employment income, Mr. Allen was in treatment at Dawn Farm. He did successfully complete it on June 17th and has since moved into transitional housing as planned, where he currently resides. And to that end, now that he is into transitional housing, he has been actively interviewing for jobs, and he has another interview set up for this coming Thursday. So that's the only update or correction as to the body of the report itself we have. And as to the recommendation on all cases, we would ask the court to adopt it.
All right. Sir, is there anything you want to say before I do impose sentence?
No, Your Honor. Thank you.
All right. In the case ending in 0278, the retail fraud 3rd degree, sentence of the court, $125 statutory fees, $47.25 restitution to Costco payable through the court. You're not employed at this time, is that correct, sir?
No, Your Honor.
All right. I will indicate then that that's to be paid by December 31st, 2025. I'll order 93 days in jail, credit 93 served on that case. In the case ending in 328, that also being a retail fraud 3rd degree, it's a sentence of the court, $125 statutory fees, 93 days in jail, credit 93 served. In the case ending in 0696, the retail fraud also. The retail fraud 2nd degree. I will order $125 statutory fees, 289 days in jail, credit 289 days served. In the case ending in 0697, the retail fraud in 3rd degree, $125 statutory fees, 93 days in jail, credit 93 served. In the case ending in 0698, the retail fraud in the 3rd degree, it is the sentence of the court, $125 statutory fees, $199.99 restitution to Meyer, payable through the court. That will also need to be paid by December 31st, 2025. I'll order 93 days in jail, credit 93 served. Thank you.
Thank you, Your Honor.
Good luck to you. Case of the People versus Sarah Orr. Mr. Foster Tucker, you're
Good
here.
morning, Your Honor. Sherilyn Foster Tucker on behalf of Sarah Orr.
Your name?
Sarah Orr, Your Honor.
Mr. Drukas told me, he said you were on a bus. I don't know what that was. Anyway, go ahead.
Thank you, Your Honor. We have reviewed the pre-sentence report. We don't have any additions or corrections. We are just asking that the court follows the recommendation, and Ms. Orr does state that she is able to pay the fines and costs today.
Thank you. Anything else, Ms. Orr, you want to say to the court?
Thank you.
No. All right. Sentence of the court, $425 fines and court costs. You can pay that today. All right. That's payable today. I'll reserve restitution or decision on restitution for a period of 60 days in case there's a claim that comes through. I'll order 90 days in jail that is suspended. You're all set.
Thank you so much. Thank you, Your Honor.
Court calls the case, People versus Angela Walker.
Carolyn Foster Tucker on behalf of Angela Walker.
Your name, ma'am?
Angela Walker.
All right. Thank you. Go ahead.
Thank you, Your Honor. We have reviewed the recommendation and the substance abuse assessment. We don't have any additions or corrections or deletions. I would just like to point out Ms. Walker has taken responsibility in this matter. She has learned a lot from this experience. I know it's been a tough time for her. And she has been on the scram tether since February and has had no violations on that tether. So I did want to point that out. And she also completed the early intervention prior to today. So she is already getting a head start on her probation requirements and believe that she will be successful on her probation. In terms of the costs, she indicates that she'll be able to make her first payment by Friday.
Of how much?
200? 200 by Friday.
Ma'am, is there anything you'd like to say before I impose sentence?
No.
All right. The court does acknowledge this is not a serious misdemeanor as defined by statute. However, it does believe that there are reasonable grounds to depart from the presumption of a non-probationary sentence. Specifically, the alcohol screening and assessment identifies the benefit of early intervention and monitored abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. So therefore, the sentence of the court, I would place you on probation for a period of 18 months. You are to pay $1,055 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs, $540 probation oversight fees. You are to pay $200 by this Friday. And then how do you intend on paying the rest?
I plan on making weekly payments,
Weekly?
Mhm.
How much per week?
probably 200 to 3.
200 to 300 per week?
Yeah.
All right. What I'll do is indicate that the defendant is paid $250 per week. All right. And then you should have that taken care of in rather short order then. All right. There is to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete an early intervention program, which you have already completed, at least as probation indicates. You are to provide proof of the victim's impact panel attendance to probation. I will continue your scram tether for an additional 30 days in lieu of 3 days in jail. I will order 365 days in jail credit to the balance is suspended. All right, thank you.
Thank you, Your Honor.
Court does call the case of the people versus Cedric Blair.
Public Defender Natalie Pay on behalf of Mr. Blair, who should be present via Zoom.
You have him? I don't see him. Cedric Blair.
So, Your Honor, for the record, I will respectfully request an adjournment. I did leave him a couple voicemails and sent him an email and text. He did yesterday respond to my text. We didn't have any further conversation from that. I'm not sure where he may be. I was hopeful that he would be here today. For the record, I respectfully request an adjournment of this sentencing.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $5,000. I'll give a 10% privilege. Because of previous warrants, that warrant will issue immediately. People versus Billy Cobb Gully.
Assistant Public Defender Natalie, on behalf of Mr. Cobb Gully, who stands to my right, please state your name for the record, sir.
Billy Cobb Gully.
Thank you, Your Honor. Today is the date and time set for sentencing. We have had the opportunity to review the alcohol screening and assessment as well as the recommendation, and we would respectfully request that the court adopt the recommendation. And I'm also prepared to address the SoberLink light test when appropriate.
I wanted to address it now. Go ahead.
Okay, I just wanted to update.
Sorry.
The court did receive a community corrections violation report with an additional late test on the scope. Court at that time did issue a bench warrant, so there is an outstanding bench warrant for Mr. Costelli.
Go ahead, why don't you address it now before?
Thank you, Your Honor. Respectfully, we ultimately respectfully requesting the court consider recalling that warrant. I have had the opportunity to discuss that with Mr. Cobb-Gully as well as his mother, who is with him today here in support. They did indicate to me that Mr. Cobb-Gully does have full-time work. He actually works as a receptionist in a role at the Holiday Inn. And he does state to me that sometimes during those windows of time testing, he might even blow into the sober link, not then hit the okay, because then maybe a customer will come up, he'll have to talk to them, or things of that nature happen. Both his mother as well as Mr. Cobb-Gully indicate to me he has been abstaining from all drinking and substances. To my understanding, in reviewing the community corrections report, he's been in complete compliance with his drug testing. There have been no indications of any positive tests on the sober link. I do acknowledge that one, I believe it was in late June, of a 14-minute late test that he did then test, and the test submitted was compliant. Excuse me, frog in my throat. And I do believe he did miss one on June 5th, which I did discuss with him. He does take this matter very seriously. He has stayed in constant contact with me. This is his only pending criminal matter of any kind. And as Your Honor is aware, he has been on bond for some time, and outside of the missed and late test, those have been his only violations. I do believe he will be doing well on probation and is a good candidate. As to the sentencing itself, we're respectfully asking the court to adopt it. He does have full-time work. He also helps the community as a wrestling coach. He's been very successful in that field, and I would ask the court to cancel the warrant today.
Sir, anything you want to tell the court before I impose a sentence?
Yes, I would. Like she kind of explained, I do sometimes work the morning shift, 7:30 to 3:30. Sometimes I work the afternoon shift, 3:30 to 11:30. So in those windows, sometimes I do run into different times where I may test and maybe not necessarily be able to press okay at that exact moment. And then I was kind of instructed that if I don't press okay, then that test actually might not be sent, even though it says compliant test is sent. So once I kind of got that notion from the person who is kind of assigning the criminal corrections, once I kind of got that notion from them, I kind of became more compliant or more receptive to the fact that I'm sorry, I'm a little nervous, but yeah, just a little bit more compliant to the fact that or just conscious that, I have to actually, press okay, be conscious about when I submit my tests and things of that nature. I was telling her one of the reasons I actually did accept the sober length was because I am a wrestling coach. I've been doing that for a couple of years now. I was an all-state wrestler when I was in high school. And so I came back and started coaching at my high school that I went to. And one of the reasons, Ann Arbor Pioneer.
Okay, well, that at least goes in your favor.
Yeah,
If it had been Skyline or Huron.
Yeah. And I help.
If you were a river rat, you'd go today. Just gonna tell you. Go ahead. I'm sorry.
Yeah. But I've done a lot, tried to do a lot for our community, especially help my younger brother. My younger brother was the first state champion from Ann Arbor in 38 years in wrestling. And then he went to Michigan State, became an All-American.
He went where?
He went to Michigan State. But I went to Michigan for grad school. So
You know what? That doesn't help.
So we kind of got the best of both worlds,
It's a hurtful day.
Yeah.
He was doing so well. If he had just stayed with Pioneer. Didn't that talk about his brother?
Yeah, well,
he became a Spartan, whatever that is. And then he's talking about going to
we had.
Go ahead. No,
we had to do them both. We had to get them both. So both degrees at both schools. So
he doesn't get it.
Oh man.
Yeah. Thank you, Miss Pate, for letting him know. He wasn't helping himself.
Yeah.
And he tried to talk his way out of it. He still wasn't helping.
Yeah.
Go ahead.
I got a lot of friends who are Terps, so
don't even try
it.
Nice try to say.
Yeah,
I got a lot of Terp friends.
Okay. But I even wanted to express to you, even the situation that I actually did get in trouble for.
I do take full accountability for my actions. I actually don't really drink, but that in particular day, I was with some of my fraternity brothers. I went to Morehouse College, and some of my fraternity brothers live in
He's
Michigan.
helping himself again. Go ahead.
Yeah. So some of my fraternity brothers live in Michigan. My older fraternity brothers, my prophytes, and they have a bourbon bar in their house, and he was eager for me to come over
See,
and test the bourbon.
I'm sort of asking
So-
what fraternity.
The best one, the greatest, the first and the best.
I'm not even going to see. I'm gonna leave him alone.
Yeah.
Go ahead.
Yeah, but I was testing the bourbons, and over that course of time, yeah, I did consume a little bit too much, and I take full accountability for it. But even the officer, he told me, he was like, I didn't actually pull you over because you were swerving or anything. I pulled you over because you were looking at your phone. I was coming back from Livonia and I was on my GPS. But I do take accountability because you're not supposed to have your phone in your hand or anything like that as well. So I do try to be compliant with the law. I actually wanted to go to law school, but I don't know, it just kind of got discouraged a little bit. So, but I still try to stay focused and keep my eyes on forward and keep moving forward. So I do take accountability, and I do want you to let you know that I really do take my life serious, our community serious, and everything that I have going on and that we have going on too.
Did he finish?
I'm done.
Okay. Mom, when he gets nervous, does he talk that much? Does he? Okay. All right. I was gonna let him go. He's got a right to talk.
He's a fellow Gemini.
Huh?
He's a fellow Gemini, so he's a chatter.
Oh boy. Not helping yourself. The court does acknowledge this is not a serious misdemeanor as defined by statute. However, it does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of educational programming, individual counseling, and abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation with the stated rehabilitative goals to promote change, prevent recidivism, and monitor compliance with recommended treatment. So therefore, the sentence of the court that I'm going to place you on 12 months probation. You are to pay $855 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs, $360 probation oversight fees. When can that be paid?
My client's asking for a payment plan as arranged by probation, Your Honor. He does have full-time work at the
Does
front
he
desk
have
facility.
anything today? If not, why not?
I don't have anything today. I don't get paid until tomorrow though, so I could pay something tomorrow.
Okay, how much can you pay tomorrow?
$150.
Means he had 200.
I'm just gonna be transparent with you. I don't make a lot of money coaching wrestling. A lot of my time is actually kind of for free, and I work at a hotel and I get like $15. So I don't make too much money, just to be transparent with you.
150 by the 11.
Appreciate that.
And then a payment plan as arranged by probation. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete the alcohol highway education program. You're to continue individual counseling with verification to probation. You're to provide proof of the victim's impact panel attendance to probation, which is already is completed. I will continue to sober link for an additional 60 days in lieu of 4 days in jail. I'll order 93 days in jail. Credit 1, the balance is suspended. The bench warrant in this matter is recalled. Thank you. Court does call the case of the people versus Christopher Holt.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Holt. Mr. Holt, please state your name for the record.
Christopher Holt.
Your Honor, regarding the pre-sentence report, we don't have any material changes, additions, or deletion. We do ask that you would adopt probation's recommendation. However, regarding restitution, as the court knows, there are co-defendants in this case. I would like to request a restitution hearing. Ms. Pilar and I have been speaking about this and with Mr. Holt. I think there's a number that we can come Two, I just am wanting a little bit more documentation from the victim regarding the restitution that he's requested.
So are you disputing the amount or the split with the co-defendant?
What we have from the victim is just a sheet of paper that says the amount. If he can provide any receipts or any further documentation, I think it can be worked out. We won't have to have a full-blown restitution hearing. But at this point, there's nothing to show that what he purchased was actually purchased. I think I will say on behalf of Mr. Holt, he knows that there will be restitution to be paid. He is willing to do that. He wants to get paid, start paying on it as soon as quickly and to make this victim whole. But frankly, I need to do my due diligence and make sure that what he is requesting was actually, paid out. The reason I brought up is the co-defendant is because I don't think that co-defendant has pled yet. Obviously, if he does, they will be jointly and severally liable. And I don't know if his counsel is going to dispute the amount. The amount is kind of applicable to both cases in both defendants' situations. So that's why it's a little bit complicated. But I did want to make sure the court knows that I think I'm pretty sure there's a world where we can get to an amount that everyone's comfortable with.
Mr. Holt, anything you want to say before I impose sentence?
No, I do not, Your Honor.
All right. In the case ending in 0189, that's the larceny less than 200. Sentence of the court, I'll place him on 24 months probation. He's to pay $555 fines and court costs. When can you pay that, sir?
I can honestly get that paid in a couple weeks, maximum 3 weeks. I'll
have this one paid. You need to pay this one by July 31st.
Oh yeah, that'll be taken care of.
All right. On that case, I will waive the probation oversight fees as I'll be assessing him in the other case. And then he's comply with all the terms that I will announce that is in case 25F10190. I'll order 93 days jail credit to the balance is suspended on that case. On the other matter ending in 0190, place the defendant on 24 months probation, $555 fines and court costs, $720 probation oversight fees. When can you get that amount paid, sir?
I can start a payment plan this month if that's possible. I'm trying to get us paid as soon as possible. That is for sure. I can try to have most of that paid definitely this month.
Okay. What I will do with the fines and costs and probation oversight fees, I'll make those due and payable by August 29th.
Okay, sweet. That would work.
All right. As to the issue of restitution, I'll set a restitution hearing. I need a Wednesday, please.
Would you like the executed review?
Yes.
We could do August 6th.
Set a restitution hearing in this matter for August 6th, 2025 at, this is a state case or Pittsfield State, 9 a.m. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete a theft class as directed by probation. You're to complete 40 hours of community service with proof to probation. There's no going to Gainsley Electric at the 4571 Washtenaw Avenue address. I'll order 365 days in jail credit to the balance is suspended. Thank you.
Thank you, Your Honor.
Thank you. Court does call the case People versus James Moody.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Moody, who is present via Zoom. Sir, can you please unmute and state your name for the court?
James Moody.
All right, thank you. Go ahead.
Thank you, Your Honor. Today's the date and time set for sentencing. I have had the opportunity to review the pre-sentence investigation report with Mr. Moody. The only addition or correction he is asking me to ask the court to make is that he states that he does now have some contact with his son. I believe the report stated that he was planning on reconnecting with his son after the cases were resolved, but he says he does have some visitation time and contact with him. Outside of that, we have no changes or corrections to the report, and we would be respectfully requesting the court to adopt the recommendation.
All right, Mr. Moody, anything you'd like to say before the court imposes sentence?
I just tell you thank you, and I appreciate you for accepting. I appreciate this. I just thank you. I'm sorry, I said appreciate it. Thank you.
Sentence of the court, 9 months probation, $480 fines and court costs, $270 probation oversight fees. When can you get that paid, sir?
I can start paying something in the next 2 weeks.
Okay, what are you gonna pay in the next 2 weeks?
1 second. 50.
Pay $50 by July 25th. And then a
Okay.
payment plan as arranged by probation.
Yes, sir.
No use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. Continue current outpatient treatment with status. All right. Court does recall the case, People of the State of Michigan versus the Sean Courtright.
Long time no.
Good morning,
Edward Drukas on behalf of LaShawn.
LaShawn Courtright. Good morning.
Good morning. I believed you. I knew you'd get here. All right. Everybody else was a little faith. I knew you'd get here, Ms. Courtright.
Thank you for waiting.
Not a problem. All right, go ahead, Mr.
Your Honor, there is no additions or corrections to the pre-sentence report. I'm just asking the court to follow the recommendation.
All right. Ms. Courtright, is there anything you want to tell the court before I impose sentence?
Only that I just asked for time served, and during that time, I had a brain injury when this occurred.
Okay. All right. I will order $125 statutory fee, and only because I have to. And then I'll order 65 days in jail, credit 64 days in jail, credit 64 served. Be
Thank
all
you.
set. You're
Thank
welcome.
you.
Ms.
Have a great day.
Thank you, Your Honor.
Thank you. Except for that, I'm a little bit behind here, but we got the 10 o'clock block coming up and they're up already.
Yes, they are. Would you like to?
Have we checked everybody? No, have we checked everybody in?
Yes.
Court is taking about a 10 minute break, and then I'll come back and we'll start this one. Court's in recess.
All right. Fourteen A District Court for County of Washington, State of Michigan is now back in session. Now we Judge Simpsons preside.
You may be seated. Court does call the case of the People versus Ryan Atkins.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Atkins. Mr. Atkins, please state your name for the record.
Ryan Atkins.
So, Your Honor, Mr. Atkins and I both didn't really know why this was set. I do know
I
that.
don't either, because I'm looking, I think the last time he was here, I sentenced him.
Right.
Paid his fines and costs payable like 30 days after his release, so I thought we were done.
So I think what happened was because Mr. Atkins wants to go to treatment, he is serving a sentence here and serving a sentence before Judge Slay. So Mr. Atkins and I have kind of been going back and forth about this. I think what's going to happen is, so he was sentenced to 3
365 credit like 18.
Right, so 347, this is a lot of numbers. I did math today, which with good time comes out to 277, which would take him to a release date of August 29th. Judge Slay,
Can I? Go ahead. I'll let you go on.
he was sentenced to 210 days beginning March 13th, which good time comes out to about 168, which would take him to a release date of approximately August 28th. So
So
both,
both Judge Slay and I hit August.
right.
We're brilliant.
So with good time,
Okay, so can I just shortcut this?
yeah,
Maybe. He wants to go to treatment. Right?
yeah.
Is that maybe why we're here? Yeah.
I think because he sent a letter to Your Honor saying, can you release me on treatment, to treatment? But he's got this Judge Slay thing holding him. But once he's done,
No. See, I'm not letting you get away with that. Because Judge Slay, you can't just say that Judge Slay.
the Judge Slay thing,
Sorry.
Judge Slay sentence holding him.
She's already released me to treatment.
She has.
I just
That's
need
the
you to
next
release.
thing I was asking.
Yes.
I
Which I-
know. Go ahead. Fine.
I'm sorry.
I'm gonna tell you, I know what I'm gonna do.
I
I
think
know Mr. Atkins for
Right.
ever.
the thing where Mr. Atkins and I disagree
Okay.
is that he's got to finish that Judge Slay sentence before, even if Your Honor releases him today, he's still got to get to August 28th. He's got to do her sentence, Judge Slay's sentence was 210 days, do the in-jail Don Farm program, release to treatment upon completion of both of those terms.
Okay, I see what you're saying.
Does that make sense?
Well,
It's a lot of numbers.
yes, it does. It makes sense if that's the way her sentence reads. If her sentence indicates that he's got to do that time, and let me ask this. After you do the time, were you going to be on probation?
Yeah.
In Judge Slay's court?
Yes.
Okay. Got it.
And Patrick told me that I needed you to release me to treatment, or I have to wait till your sentence is up to go to treatment. And I sent you a letter with his kite stating that.
And Patrick told me he's got to do the Judge Slay time. So this is where
What now?
he's got to do the full sentence, 210 days on Judge Slay's.
Well, okay, I got you.
So that's where Mr.
I'm
Atkins
just-
and I have a little miscommunication.
Right, and I can't resolve that. What I can do is I can just take outside of the picture of it,
Sure.
because I really believe that Mr. Atkins needs treatment.
And he's been in,
Does well when he's not using,
Right.
and you know it. He does really well. He has a much better demeanor, and he's just, frankly, you're just a much better person. When you're
Yes, sir.
using, I can't say that. I can't call you what I think.
he has been in, Judge, on this case since November. So
I
it's
know.
been some time.
I know. Because when he came back, because he hadn't seen me for a while, when he came back, I could tell he was out there using. And he wasn't looking well. You really weren't. So I will make this real simple for this case. If you prepare an order indicating that I will suspend the balance of his sentence to be released to treatment. However, and this is the important kicker, if he doesn't complete treatment or leaves treatment, then he must return to the Washtenaw County Jail to finish out this sentence.
I will get that to you, Your Honor.
All right. And that'll solve it, takes this case out of it, and then you can deal with what the interpretation of Judge Slay's case is.
Thank you. Appreciate it.
You're welcome. Just do the right thing.
Yeah, I know.
Huh?
Just
I know.
last time.
And
Just
think-
last time.
Right, I know you know. That's my problem with you. I know you know, And I know you're smart enough, and when you think about it and don't do the stuff, you do well. Right. Right? It's just when you get on that path.
Yeah.
Okay.
Thank you.
I'll do that. Get that order to me. I'll sign it. Ryan, best of luck to you.
Appreciate it.
Oh, they were with you?
Yeah.
I'm the wife. Huh? You're really? I'm so sorry. I'm so sorry. No. Oh, I know. Court calls the case, People versus Darien Rhodes.
Public Attorney on behalf of Mr. Rhodes. Mr. Rhodes, please state your name for the record.
I need
Gary
a
Rhodes.
camera.
Yeah, I'm doing it now. I have to go to the settings.
Mr. Rhodes, are you turning on your camera? Because you muted yourself. Passing. Sit there and wait. Figure it out. Court does call the case, People versus Raymond Bowman. Wasn't he right there? Okay.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Bowman, who is approaching the podium. Please state your name for the record, sir.
Raymond William Bowman.
Thank you, sir.
Thank you, Your Honor. Today is the date and time set for sentencing. We only have one very brief correction to the report. Under Mr. Bowman's date of birth / age, the date of birth is correct, but he is only 35 now, but will be turning 36 when his birthday comes. Outside of that, we have no corrections, and as to the recommendation, would respectfully request that the court adopt it.
Sir, anything you want to tell me?
No, sir.
All right. Sentence of the court, $125 statutory fee, 51 days in jail, credit 51 cents.
Thank you, sir.
Thank you, Your Honor.
Case, People versus.
Hey.
How
I'm sorry, Your Honor, was that Mr.
Bilal Howard.
Good morning, Your Honor.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Bilal Howard, who is present via Zoom. Sir, can you please state your name for the court?
Bilal Howard.
All right.
Teresa Claire on behalf of probation. Your Honor, Mr. Howard was scheduled before the court today for a violation of probation hearing, which was set at his review hearing on June 11th. At that time, Your Honor, Mr. Howard was directed to report to probation. Mr. Howard did do that as ordered. Currently, Your Honor, Mr. Howard did make a $135 payment. He did that on July 3rd after we had our meeting and discussed why he was in non-compliance. He does have a balance of $1,120. Mr. Howard indicated to me when I met with him that he was going through some different times. He had recently got custody of his kids and was making a transition and working, trying to take care of his kids. Although no excuse, Mr. Howard does indicate that he would like a chance to complete the prosecutor deferred sentence. At that time, I also, Your Honor, gave Mr. Howard a referral to another class that would not interfere with work schedules. Given that Mr. Howard did report and that he is showing that he wants to complete this program, probation is asking that the court to dismiss the violation of probation hearing, extend the prosecutor deferred sentence for a period of 9 months, that Mr. Howard pay $140 per month beginning August 5th, 2025, that he continue all of the terms as previously ordered, with a review hearing being set April 8th, 2026 at 9 a.m. Thank you, Your Honor. We are asking the court to adopt that recommendation, and Mr. Howard did indicate to me that he would be prepared to resume that payment plan in August as recommended by probation.
All right, very good. I'll dismiss the violation of probation. I'll extend the defendant's prosecutor deferred sentence for a period of 9 months. You're to pay $140 per month beginning August 5th, 2025. I'll continue all other terms as previously ordered. I'll schedule a review hearing April 8th, 2026, 9 a.m. All right. Thank you, Mr. Howard.
Thank you, Your Honor. Have a good one.
Case of the People versus Ashley Fix.
Good morning, Your Honor. Edward Drugas on behalf of Ashley Fix.
Ashley Ian Fitz.
All right.
Your Honor, we've gone through the pre-sentence report. The recommendation is something my client wants to address today. The only correction I have to the face of the pre-sentence report is the attorney should be listed as myself rather than helped.
Okay. Ma'am, anything you want to tell the court before I move sentence?
I was wondering if I could be placed on probation. Since,
You want to be placed on probation?
yeah, since I did a month in the Wayne County last month. I'd rather be on probation than incarcerated.
Your Honor, Teresa Claire on behalf of probation.
Yes.
Ms. Fix was ordered to probation to complete the pre-sentence interview. It took some effort to get that done initially because it was done quite some time ago. And then Ms. Fix has numerous times failed to appear to this court for sentencing. While she has been out on bench warrant status, she's also picked up other cases, one being an OWI out of the 15th District Court, which is holding her in custody. Not to mention, it was brought to my attention, she now has a couple other cases out of
Romulus.
Which are bench warranted now because she has failed to appear, I believe, because she was in county here.
I went to
It was a show cause. I don't think a warrant issue.
I went to court.
Oh, a show cause.
Yeah.
So she is, Your Honor,
I
scheduled for
went to
show
court.
causes in this matters because she failed to appear, because she was in custody here for those Romulus cases. Probation's concern with Ms. Fix is that she does come before this court and indicates that she wants to do things, but she never follows through with any of it. So probation has concerns that if Ms. Fix were to be released on this case, she's not going to do it, and she's not going to contact probation. I know that, and this court knows how I operate. I attempted to reach Ms. Fix multiple times to try to even get her to get in here to get sentenced, because originally, I believe my recommendation was to have a probationary sentence. However, it's getting her here, and if she doesn't come to court, she's not going to report probation.
Well, and the cold hard reality is that May and June she didn't appear, but she just, the simplest of things to complete your pre-sentence interview, she didn't do. Had to issue a bench warrant in her cases, in this case, 1, 2, 3, 1, 2, 3, 4 times before we can get you here.
I promise I'll do it.
You're not a good candidate for probation. I mean, I couldn't even get you to interview with probation initially. You didn't even follow the court's instruction to do that. And then had the bench warrant you didn't appear, had to basically make it an in-person hearing, which I don't specifically recall why, but that typically means there's an issue going on with getting the person there. So, and I'm not sure, in January of this year, you were brought into custody somehow. So even after I'd issued 2 bench warrants, one that I recalled, You did that, and on the recommendation initially on April 24th, 2024 was for a probationary sentence, but that was in April of 2024. You didn't appear. I issued a bench warrant, and then we don't see you until January. The magistrate, I'm not sure why, but granted you a PR in January, on January 16th. On January 29th, you were supposed to appear before me and you didn't show up. You came back again into custody for whatever reason in June, and I'm the magistrate, I don't know why, gave you a PR because you said you'd appear. And that was in 2025. And on the date he gave you, you didn't appear. That's where we are. You don't do what you say you're going to do. And the reality is, when I've seen these in the past, what will actually end up happening is we put you on probation, and then ultimately I'm imposing the jail time because you haven't done anything. Anything else?
Can I be placed on the tether? GPS tether.
Your Honor, the only thing I can express on her behalf is that she does have remorse for missing those dates.
All of them?
Yeah.
And other than that, I discussed with her what her options may be on taking.
My mom, I love my mom's side, transportation.
She just addressed that she had stable housing through her mother, so that's.
Sentence of the court, $125 statutory fee, 93 days in jail, credit 20. The balance, the defendant is to serve the balance. Thank you.
Thank you.
Court does call the case, People versus Norman Reeves.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Reeves. Mr. Reeves, please state your name for the record.
Norman Reeves.
Teresa Claire on behalf of probation, Your Honor. Mr. Reeves is before the court for a violation of probation hearing. Mr. Reeves is non-compliant with the terms ordered by the court in that he owes $1,658. 500 of that balance, Your Honor, is for restitution. He failed to report to probation as directed, failed to complete positive strategies for life program, and failed to provide proof of CMH services. He also, Your Honor, has a new criminal case. That case is on bench warrant status. It is out of the Chelsea location. Mr. Reeves, however, did provide a bench warrant recall request to the court. I believe that he thought that he did it in both cases. The Chelsea case still shows a bench warrant. This court did grant him to be set for a hearing with a PR bond. Since then, since my report to this court, I did have a chance to speak with Mr. Reeves this morning. I do have documentation of his services in lieu of CMH services. He is living between his mother's house and Jackson. His mother is here with him today. Mr. Reeves also has indicated that he can make a payment of the 500 on the restitution today. Given both of those factors, Your Honor, probation is asking that we adjourn the BOP hearing to August 13th, that Mr. Reeves report to me in person on Monday, July 21st at 1 p.m. And that he become compliant with the other terms ordered by this court prior to that date, also including taking care of that outstanding bench warrant out of the Chelsea.
Your Honor, in short, I'd ask that you adopt that recommendation. I also had a chance to speak to Mr. Reeves and discuss, why he wasn't able to complete the terms and the matter or the time that he should have He explained that last year he was going through a pretty hard time. He lost a close family member, was going through a divorce and dealing with a custody battle. Since then, he has stable housing and work. He's working at Taco Bell full-time and was just promoted to shift lead. He did have a second child born just in February, and he is financially supporting his partner and that child with this job. He's also paying approximately $300 every other week for child support. He did provide me with proof of his mental health treatment at the University of Michigan. And I provided that to
So all you're
probation.
asking, Ms. Valera, is that I
Adjourn.
1 and 2 of the recommendation I take off,
Well,
or
Your
1.
Honor, well, and that he make a payment of 500 on the restitution today, so.
Got it, okay.
So that part is corrected, and that he does report to me in person to discuss the other.
On the 21st.
Correct. And that we adjourn the VOP hearing to August 13th. And then I can evaluate where I stand with my recommendation on that date.
And
Do I need his probation extended at this point or not?
Yeah, well, technically, yes, Your Honor.
Yeah,
He was
I
on
do.
bench warrant status for
Since
over
May of last year.
like 14 years or 14 months.
All right.
And Your Honor, I'm not sure if the court does want to hear from Mr. Reeves' mother. She is with him and present today and did want to speak to her.
Okay. Come on.
Mr. Reeves.
Hello,
Hello,
what's your name?
Lavita Johnson.
All right, what do you want to tell me?
I'm just here to ask for a second chance for Norman. He has been battling with this custody hearing for a minute now, and he's finally getting his life back on track. So I'm just asking that you please follow the probation recommendation.
Why are you looking at her? Why do I
I
feel
forgot how to
you
pronounce
two-
her name.
Why do I feel you two worked up something?
I forgot how to pronounce her name, but
Teresa Valera, Miss Valera. Okay, so you want me to do that?
if you could, I would greatly appreciate it.
A mother's plea for mercy for her child. All right,
That's what parents do.
I get it. All right, thank you, ma'am.
You're welcome. Thank you.
You wanted this adjourned to what date, Miss Valera?
I would like the VOP adjourned to August 13th at 9 a.m.
Is at this point, I will extend his probation for a period of 12 months. He's paid $500 today toward the restitution, then 150. I'll order the 150 per month thereafter. Report to probation in person on Monday, the July 21st, 2025 at 1 p.m. and then report as directed. You are to become compliant with all of your other previously ordered terms within the next 30 days. I will adjourn your violation of probation hearing to August 13th, 2025, 9 a.m. Thank you, sir.
And Your Honor, can I ask if I can get Mr. Norman in compliance, am I able to cancel that violation?
Yes, yes,
Given that we did the extension
Yeah.
on record today?
right. Because even if we did that, you and mom are gonna work something. I don't know what you'll do, but yes, you could do that.
Mr. Reeves. Okay, you're gonna see me.
All right. Thank you. Thank you. Court calls the case, People versus Darrell Frederick.
Mr. Public Defender Natalie Pate with and on behalf of Mr. Frederick, who stands to my right, please state your name for the record, sir.
Darrell Frederick.
Thank you, Your Honor. Excuse me. Today's the date and time set for sentencing. I have had the opportunity to review the pre-sentence report with Mr. Frederick. We have no changes or corrections and would respectfully request that the court adopt probation's recommendation. I will just note, as to the restitution, Mr. Frederick is currently being held on other matters, so I would just ask that that be due after his release.
Is there anything you want to say before I impose sentence? No. $125 statutory fee, $76.50 restitution to Kroger payable to the court. That'll be due by December 31st, 2025. I'll order 93 days in jail, credit 93, sir. Thank you.
Your Honor.
Thank you. Court calls case People versus Michael Kyle.
Public Defender Natalie Pate with on behalf of Mr. Kyle, who is present via. Sir, can you please state your name for the record?
Michael Kyle. All right, thank you.
I believe the balance is $360. I was unable to recheck today, but it was days ago, I believe that's what it was. Mr. Kyle was incarcerated at the Washington County Jail from September 2024 until June 4th of this year. So I would ask if the court would consider waiving some of the balance, if not all of it, or in the alternate an adjournment of the show cause so that Mr. Kyle can get some work under his belt and start.
Is he working currently?
I do not believe so, but I think Mr. Kyle can speak more to
Um,
that. Mr.
I'm,
Kyle, are you currently working?
I'm not at the moment.
September 10th.
You have August 13th and August 27th.
September date.
Oh, September, sorry. September 10th or September 20th.
I'll adjourn this matter September 10th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you.
Thank you, Mr. Kyle.
What? Court calls case People versus Brian Gerard. 4 cases.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Gerard. Mr. Gerard, please state your name for the record.
Brian Gerard.
We're here for show causes. Mr. Gerard has been in custody for 89 days at this time. His next court dates in circuit court are in a couple of weeks.
Yeah.
I'd ask that we just adjourn the show cause out. I don't know if you have
Is
any
it
idea of when you're.
anticipated he's going to be released anytime soon or no?
No, I might be going to rehab, but I don't even know what this is for.
This is for money that you owe
Oh,
on old cases.
sorry. I don't have it right now.
Well, when's your next hearing in circuit court?
The 14th.
Of this month.
Yeah, I should
yeah.
be going to rehab here in a couple of weeks.
Okay, so let's do this. It was September what, 10th?
How much?
So I'm gonna adjourn this out to September 10th, all of these out to September 10th, 2025, 9 a.m. And then that way, if he's in rehab, depending on what type, he may have gotten through a part of it. We can figure out where we'll go with it.
So I won't have a warrant out for my arrest?
Pardon?
So I won't have a warrant out for my arrest?
I'm not on these cases. I don't know what else you've done. All right. Court calls case People versus Deanna Galamulski.
Teresa Claire on behalf of probation, Your Honor, Ms. Galamulski was scheduled before the court today for a review hearing on a prosecutor deferred sentence. She did complete all terms ordered by the court, and I did waive her appearance. Probation is recommending that the case pursuant to the prosecutor's deferred and discharged from probation.
Hearing no objection, so ordered. Court does call the case People versus Daniel Sims. Oh, are they out there?
They are not written.
Court does call the case People versus Rachel Lindeman.
Teresa Claire on behalf of probation, Your Honor. Ms. Lindeman was scheduled before the court for a final review hearing on a prosecutor deferred sentence. She did complete all terms ordered by the court, and I did waive her appearance. Probation is recommending that the court dismiss the case pursuant to the prosecutor deferred.
Hearing no objection, so ordered. Court does call the case People versus Daniel Sims.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Sims, who stands to my right. Please state your name for the record, sir.
Daniel Sims.
Thank you, Your Honor. Today's the date and time set for sentencing. I have had the opportunity to review the PSIR with Mr. Sims, and we have no corrections and would ask the court to adopt the recommendation.
Is he expected to be released anytime soon or no?
It's a long, complicated story, but hopefully it's released soon to treatment.
Got it.
Yes.
That's all I need. All right. Is there anything you want to say?
No, not.
Okay. $125 fines and costs, $249.86 restitution to TJ Maxx payable through the court. I will make that payable by the end of the year, December 31st, 2025. I'll order 93 days in jail, credit 93, sir. Okay.
Thank you, Your Honor.
Let's call the case, People versus Joshua Sherry.
Chris Clare on behalf of probation, Your Honor, Mr. Sherry was scheduled before the court for a review hearing on a prosecutor deferred sentence. He did complete all terms ordered by the court and probation is recommending that the court dismiss the case pursuant to the prosecutor deferred and discharged from probation.
Hearing no objection, so ordered. Court recalls the cases of People versus Darien Rhodes.
This is the public defender Lauren Kern on behalf of Mr. Rowe.
Darien Rhodes.
Teresa Clare on behalf of probation, Your Honor. Mr. Rose is scheduled before the court today for a violation of probation hearing. Probation would like to correct the balance owed to the court is $1,055 with the last payment being made to the court on May 8th, 2024. Mr. Rhodes has failed to complete the terms ordered by the court in that he did not complete IOP treatment. He failed to provide proof of his AA meeting attendance, failed to attend the victims impact panel, failed to report to probation as directed. He also failed to appear at 2 prior VOP hearings before this court where bench warrants were issued. In addition to that, Your Honor, Mr. Rhodes has new pending criminal matters. One out of the 34th District Court for domestic violence. Alleged date of offense is May 11th of 2022. That is on bench warrant status. He has 2 cases out of the 14A2 District Court, one being a domestic violence, the other being an attempted R&O. Alleged date of offenses, first being August 4th of 22, the other being November 3rd of 2022. He is scheduled for pretrials in both of those matters. He has another matter out of the 34th District Court for an alleged larceny under 200. That alleged date of offense is November 12th of 2023. He's on bench warrant status in that case. He also has a pending felony, a larceny in a building, alleged date of offense of June 27, 2025. He is scheduled for a PCC in that matter on July 10th. Of 2025. It appears, Your Honor, Mr. Rhodes has continued to pick up criminal cases while on bench warrant status in this case and being in violation of the probation that was ordered by this court. Given all of that, probation is recommending that the court order Mr. Rhodes to serve 93 days in jail with credit for 16 days that he served to date, that he served the balance, that he complete the in-jail on-farm program, waive remaining terms, accepting his financial obligations, and discharging him from probation with them.
Ms. Berman.
Your Honor, I am asking that you sentence Mr. Rhodes to the 16 days serves and close out this case. I did have an opportunity yesterday to speak with Mr. Rhodes for quite some time. I think what his issues really come down to is his finances. He explained to me that he and his family have been homeless all of last year and are just now getting back to a better spot. They were staying at the Red Roof Inn for some time, and then they stayed at the shelter for some time. This is all while they had, at this time, they have 3 kids under 3. His partner just had their newest baby in January. And at the time during last year, she was obviously pregnant with 2 children. So they were dealing with some serious financial issues. Mr. Rhodes says he did not have even a phone or a car to get anywhere. He did say that he was enrolled in the MRT program, which he believed was being used, I suppose, in place of his IOP. So he did complete some of the MRT program, but he did not complete it as it does require money to stay in it. He did just do a week. I think he was picked up on the warrant and did pay bond to get out. He said during that time, he just a week really affected his partner and their living situation because he could not work. He is enrolled in a job program through the Friend of the Court, so he is working now. He also says he did attend some AA meetings, but because of his situation, he wasn't able to continue to those. Do know that the larceny cases, he is being represented by the public defender's office, and he said there is an offer to reduce that felony case down to a misdemeanor. He's asking that the court take all this into consideration and the struggles that he and his family have been going through. But again, he is in stable housing now and is working.
The case ending in 1357, which is a show cause hearing, I'm going to adjourn that to September 10th, 2025 at 9 a.m. On this other matter, sir, is there anything else you want to tell me other than what your counsel's indicated?
Yes, Your Honor, it's just, that's, what she says is exactly correct. It was a hard time, and I admit to the violation. I'm trying to get everything situated. I can make a payment today, and on the 12th, I just have to get rent paid before the 15th. And then I can continue to make payments every month until I can get the balance, dismissed, lower down.
These new cases, not doing it that way. Sentence of the court, 93 days in jail, credit 16 that he served. Defendant is to serve the balance. He's to report to the Washington County Jail by 6 p.m. today. If he fails to report, a bench warrant with no bond will issue. He is while in jail to complete the Dawn Farm in jail program. I will waive all other remaining terms except his financial obligations, discharge him from probation without improvement. Thank you.
Thank you.
Case People versus Gary Thomas.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Thomas. Mr. Thomas, please state your name for the record.
Gary Thomas.
Your Honor, we're here for a show cause. I think Mr. Thomas owes 905 on this case. He has been in custody for quite some time now. I'd ask that we just adjourn this out again.
Is he gonna get out anytime soon, or do we
I don't
know?
know what's going on.
What?
I said, I don't know what's going on. They ping ponging me around, man. Give me the loop around.
Do you know
I've
what-
been here
Where is that? You're in circuit court here?
yeah, Circuit Court and 14B.
Okay, so when's your next date circuit? Just
Tomorrow, I think.
Tomorrow?
Yeah,
Okay,
that
so
one.
subject
That's
to-
drug court though.
What? Right. Okay, what about 14B
I think that's the 28th.
of this month? Okay. Well, we probably won't be able to accomplish anything, but I'll adjourn this out to September 10th, 2025 at 9 a.m. I might as well be part of the ping pong game, right? All right, Ms. Thomas, take care. All right, that's that. Set me up for 11, and then I'll be back out court standing brief recess. Okay, go ahead.
I know you don't like when I speak, but It's a 2017 case. Pete is disabled. He's legally blind. We are trying to help clean up some wreckage from his past. Actually, Teresa Polari is very helpful this morning. I think we're going to apply for an ability to pay application. He's on Social Security disability.
How much does he owe? Do we have? Oh, no, never mind. Take care of Mr. Johnson first, please. No.
Yes, 40 cents.
And
he's on Social Security disability.
How much does he get a month on?
$967 total. He lives with his father. His father's 93 and has dementia. So Peter can't see, and his father's is struggling, and they're kind of helping each other out. Peter's brother is here with him today, just so you know that Peter didn't drive today and brought him to the court. But
you understand? Go ahead. I'm sorry.
So we've known each other a long time. Peter and I have known each other for 15 years. He went to the farm. He was really good friends with Larry Woodard, a guy that I sponsored who died in 2014. And we like to clean this up. He doesn't drink, he doesn't use. He's been doing terrific. Just like clean up the wreckage of his past.
And he was going to fill out an ability to pay for.
Correct. And Teresa actually sent us a form this morning. And I have Social Security disability paperwork with me as well, if the court wants to see it.
Don't worry about the form. Hey, I'll take the representation regarding the disability. This is an old case. And quite frankly, Mr. Shand, if you're telling me that you're working hard to try to clean up his records from the past, that tells me something else in terms of what's going on. So I'm going to waive $957.40. That should leave a balance of $125, which would be the state minimums, and then we're done.
Thank you, Your Honor. So can we get 30 days
to do what?
To pay?
Okay. Okay. The 125, we're not chasing you.
Waiving everything except for $125. So you're going to owe $125 to this court, and then we're done here.
Can we pay it today?
He will take your money gladly today.
Well, then I'm done with the court here.
Good.
He already has.
Yes, so it's $87 of the statements.
It's only $87.
Yeah.
Okay, so here's what we do even better. I was just informed he's already paid part of it's 87 even.
No, I was wrong. It's, yeah, 87.
87 even. So do some math for me. Take 1,000 right, minus 87.
$995.
$995.40.
Yes.
All right. So what I'm going to do is I'm going to waive $995.40, leaving a balance of 87 because he's already paid part of the state minimums. So he only owes 87.
We can pay that today.
Fantastic.
Thank you, Your Honor.
Thank you. Take care. Court calls the case, People versus Diamond Edmonds.
Public Defender Natalie Debate with on behalf of Edmonds, who should be present via Zoom. I do not have an explanation, ability to, excuse me, to appear for the record with respect to the request from Chairman of the Bill. I did provide information for today's hearing. It is my understanding at least that Monday there was still a balance.
Yes. What do you have as a balance?
So in case ending in 922, she owes 440.
Okay.
And the other case, if she owes 465.
Bench warrants in each of these matters will issue. Bond is set in the amount of $5,000, 10% on each case. Those warrants will issue immediately. Court calls the case People versus Muhammad Farha.
On behalf of Mr. Farha, who should be present via Zoom.
You see a name.
Hi, I'm sorry.
Okay, it's okay. All right, your name?
Mohammed Farha.
Okay. All right, where are we on this case?
Yeah, I believe this case is still about $825. And I believe Mr. Farha may be able to better tell the court on where he is on that. He, or yes, go ahead, Mr. Farha.
Yes, I had just completed treatment with the rehab, and I just literally started working. And I called the collections department yesterday to try to set up some type of payment plan with them, so I could get this thing paid off, because it's just I want to take care of it, and I literally just
Okay.
started working. But I mean, is there I mean, it's an old. I did the. I thought I didn't know I owed those fees. I thought I did the time for it, but I it caught me off guard with those fees. I mean, is
Yeah,
there?
no, you still owe it. How are you gonna get it paid, you think?
Okay, I'm working. I'm working with the collection department to get a payment plan set up. So
Well,
that's what
I'll
I'm gonna
set one
do.
up for you. What do you think? How do you think you can get it paid,
Can
Mr. Farr?
I pay like $50 a month? I mean, I just literally started working. I'm trying, I'm trying my best, honestly.
Here's what I'll do. You're gonna pay $50 a month beginning August 1st, 2025. Just get it done.
Okay, thank you, Your Honor. Thank you.
You're welcome. All right, take care of yourself.
All right, thank you.
Court calls the case, People versus Corey Harris. Okay.
Good morning, Assistant Public Defender Lawrence Kearney on behalf of Mr. Harris. Mr. Harris paid the $130 remaining this morning, and I did confirm that via AIS, excuse me.
Did he?
Yes, he did.
He was working. He really didn't want to come, so.
Got it. So I'll cancel the show cause defendant's paid in full. Court calls case, People versus Desmond Jones.
Yes, I'm here. Desmond Jones.
Okay, you're here on a show cause. How much is it?
Mr. Jones owes $644, and he is not represented by counsel.
You paid a bond on this case, it looks like. Do you see a bond? You paid 500.
Yeah.
All right, here's what I'm gonna, is that bond in your name, sir?
Yes, I believe so. If not, it's in my
It is.
girlfriend's name. Yeah.
It is in his name. All right, so here's what I'm gonna do in that case. Although we had to go the hard way, I'm gonna apply the bond. That's $450, right? Because there's an administrative fee taken from it. I'm gonna waive the balance and close that case out. Got it?
Thank you, sir. Appreciate it.
All right, now, having done that good thing, I've got some other bad news for you.
What's that?
I got a new case. A new felony case. And it alleges that on or about April 23rd, 2021, at the location of Boston's Way in Ypsilanti Township, Washington County, State of Michigan, that you did unlawfully use a motor vehicle. Do you understand the nature of that charge, sir?
No, I don't. I didn't even know nothing about that case,
Well,
sir.
I'm not asking you whether you did it or not.
Okay.
I need you to understand if you know what you're charged with.
No, I don't. I'm
All
sorry. I
right, then let me specifically lay it out to you. The
Okay.
complaint alleges that on or about April 23rd, 2021, at the location of 5055 Boston Way,
Yes.
Ypsilanti Township, Washington County, State of Michigan, that you did without authority or without the intent to steal, take, or use, or was a party to such unauthorized taking or using of a motor vehicle, namely an automobile belonging to a Linda Watson's Coleman,
That's my mother.
contrary to Michigan statutes. Okay, but sir, do you understand what you're charged with?
Yes, sir.
All right. That is what's called a high court misdemeanor. It is punishable by up to 2 years incarceration, a $1,500 fine plus court costs. If you are convicted, the Secretary of State would also suspend your driver's license in accord with statute. Do you understand that, sir?
Yes, sir.
All right. I would also know, while this is charged as a felony, that if you are a first-time offender as defined by statute, the court may reduce the sentence to imprisonment not more than 3 months or a fine of not more than $500, making it a misdemeanor. All right, you understand that part, sir?
Yes, sir.
All right. First question I have for you is, do you want to be represented by an attorney?
Yes, if I have to. Yes, that would be the most definite. I don't know what to do and I don't want to
Okay.
represent myself.
All right. So you want to be represented by an attorney?
Yes.
All right. This is a public defender case.
Good morning, Assistant Public Defender Lauren Tierney on behalf of Mr. Jones. We waive further reading standing to the charges as for PCC date. And I would, if I may, Your Honor, ask Mr. Jones to call the court and the public defender office to update your phone number, Mr. Jones. We don't have a way to contact you right now.
Okay.
All
I
right.
definitely will.
Okay. Do you have the number for the public defender's office, sir?
Is it the South? Which one is it? The South? I forgot what they do. Is like the free public defenders.
Okay, let me give you the number because I don't know what you're
Okay.
talking about. Let me
I
just give
thought
it
it
to
was
you.
Southwest thing. I'm sorry. I'm thinking about the when they ask you to represent for the Southwest.
No, it's okay.
Okay, yeah.
You're good. I just want to make sure they can get through to you.
Okay,
So
yeah.
that number is 734
734
222
222
6970.
6970. So 734 222 6970.
Yes, sir.
Okay, thank you.
Okay. And so here's what I'm going to do.
Okay.
And having waived formal reading, standing mute, court will enter a not guilty plea on his behalf. I'll set probable cause for 17th for July 17th, 2025, 9 a.m. I'll set the defendant's bond at a $5,000 personal recognizance bond. Sir, I hesitate in asking you this question. You don't have to answer it, and if counsel doesn't want him to answer it. When I was reading the complaint to you and I got to the name, you said something like, "That's my wife."
No, that's my mother. Yep, that's my
Your
mother.
mother.
Yes.
Got it. Yeah, I'm sorry. So what I will order is I'll order standard conditions, including no assaultive behavior or possession of any weapons. There's to be no use of any alcohol, recreational marijuana, or any illegal drugs. I will order that there is to be no contact with Linda Watkins Coleman.
Okay.
And sir, is the I have an Arlington address for you, but the Boston's Way, is that your mother's address?
Yes, that's it.
Okay, so I'm also gonna order that you're not to go, no go to, 5055 Boston's Way,
Okay.
okay?
Yes, sir.
I'll order that, and then we will see you on the 17th,
Yes, sir.
okay? All right, thank you.
Thank you, sir. Thank you.
Court does call the case, People versus Ladante Knowles. No counsel, Knowles, this is show cause,
Yes,
how much?
1,179.
Bench warrant will issue for defendant's failure to appear, bonds at $10,000. 10% privilege on that, that warrant will issue immediately. Court calls case of People versus Dexter Pillar.
Public defender Natalie Pate for Mr. Fuller. Present via Zoom.
No,
Your Honor, I was unsuccessful in having a conversation with Mr. Pillar prior to today's hearing. I did provide him with the Zoom information. However, I will for the record.
bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $7,500. Give a 10% privilege, that warrant will issue immediately. Court does call the case of the People versus Douglas Robinson.
Under Natalie Pate for Mr. Douglas Robinson, who should be present via Zoom.
Yes, I do see the name. Mr. Robinson? Oh, there he is.
Yes,
All right, state your name.
Douglas Robinson.
Robinson, okay. And this is a show cause.
Your Honor, to be candid, the conversation we had was that I was unable to have a meaningful conversation with Mr. Robinson, but he did successfully get the Zoom and some conversations via text. That being said, it is my understanding that there is still a balance in this case of $849 and I believe 72 cents.
Yes.
I believe Mr. Robinson may be able to provide a better explanation to the court for how he might be able to get that paid.
Go ahead, sir.
Yes, I don't mean to keep making excuses. I just been really struggling. But anyway, nonetheless, I just started working, and I can start making payments. Friday, I get my first check, and so I can start making payments on a regular
Oh.
basis.
Okay, so how much can you pay on Friday, you think?
Can we just say 50, just so I don't
That's fine.
Okay.
You're to pay $50. You're gonna then what? Pay $50 a month or $50 every paycheck?
A month would be very I mean, it would be I could guarantee it'd make things easy for me.
You're to pay $50 a month until that's paid in full. And that begins this July 11th. I'll just make it beginning July 15th. I think I can do that.
Awesome.
All right.
Okay.
Thank you.
Sir. Thank you. Have a good day.
Court calls case People versus Savante Scott.
For Mr. Scott, who should be present via Zoom.
I thought I saw him.
Yeah, he's been dropping in and out, but he's currently not present.
I'll adjourn it out to what's my August day?
August 13th or August 27th?
August 13th, 2025, 9 a.m.
I'm sorry, Your Honor, that was the 13th?
Yes.
Okay, thank you. Sorry. Oh, wait.
What?
Oh, he just popped into the waiting room.
He just what?
Popped into the waiting room. Would you like me to tell him it's adjourned?
Well, if he's here.
Hello?
Savante Scott, you got a
Yes, sir.
camera?
Yes, sir. My phone was
Okay,
acting.
there he is.
My phone was
Okay. No, we realized you were popping in and out, so we actually had adjourned it, but then we saw you pop back in. All right,
All right, I appreciate it.
how much does he owe? I've got 50.
I've got, $1,672.
Okay. You owe $1,672.
All right.
How are you gonna get that paid?
I can do a payment plan, $50 a month. Starting. I just now starting a job at KFC.
Why is everybody just starting the job today?
This is the season.
Yeah, right. When are you gonna make the first payment?
Next week I can. Next Friday.
Next Friday, the 18th.
Yeah.
$50 per month. Beginning July 18th, 2025. All right. Thank you.
All right.
Court calls the case, People versus Chance Stallings.
Public defender Natalie State from Stallings, who made the present via Zoom.
No.
Your Honor, unfortunately, I do not have an explanation for his failure to appear and requested adjournment for the record.
He's got quite a bit. Okay.
$2,070.
Say again.
$2,070.
Bench warrant will issue for defendant's failure to appear, bond is set in the amount of 20. Oh. Miss Sandra.
Good morning, Your Honor.
Where's Londy?
Trial.
She's a trial every time, but go ahead.
On behalf of the people, Your Honor, the people would waive any potential conflict between this honorable court and the office of the public defender. While the people don't believe such conflict exists, the people make this waiver in avoidance of all doubt.
Mike Yankee, Assistant Public Defender. Your Honor, likewise, the Public Defender's Office is not moving this, to the extent that it does, it's waived and, yes, we'll get to that case.
The court, for its part, also does not believe there's a conflict either under the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. The court does call the case of the People versus Jennifer Lindsay.
Andrew Childers appearing on behalf of the people, Your Honor.
And good morning, Your Honor. Lord Yagi, Assistant Public Defender, with and on behalf of Ms. Lindsay. Ms. Lindsay, can you state your name for the court?
Jennifer Lindsay.
Oh, thank you.
And Your Honor, I am asking for an adjournment in this case. I did get an offer, but I need some time to meet with Ms. Lindsay and discuss it.
And she's at Huron Valley.
Yes.
Are you able to get in to meet with her? I mean, I know there were some issues, and I just want to make sure.
So I filled out the application. I don't have a specific meeting confirmed yet, but I'm going to try my best.
All right, I got you. Okay, because of scheduling, it'll be July 31st. Probable cause conference adjourned July 31st, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor. And I do have the sheet. Sorry. Thank you.
Court does call the case of the People versus Anthony Lafredo.
Good morning, Your Honor. Karma Dadush on behalf of Mr. Lafredo. Mr. Lafredo, can you please state your name for the record?
Anthony James Lafredo.
Thank you, sir.
Your Honor, we are going to be binding this case over to circuit court. There is an offer on the record, and we would like to, an offer in circuit court.
Doing what?
We would like to please have this bound over to circuit court. Waiving preliminary examination.
Who told you that? Cannon?
No, it was just
Gaddy?
me. I don't know why I always
Mr.
have
Gaddy? Oh, I
problems
didn't-
with preliminary
I didn't know who you were
examinations.
parroting, but go ahead.
Parroting myself, my own brain. Sorry about that. This is not even the end of it. The end of the issues. Mr. Lafredo is in.
Why do I have to start with you?
You started with Yagi, and
I know, and that was quick. This is not.
this
but
will
go
not
ahead.
be quick, unfortunately. Mr. Lafredo is in Jackson County Jail. I have not been approved yet, even though I submitted that pretty early, to talk to him to be able to get his signature for the preliminary examination waiver. Do we need to adjourn, or am I able to ask him if I can sign on his behalf on the record?
Mr. Lafredo, you're waiving your right to a preliminary examination.
Yes, sir.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
I do understand.
All right. You understand you will not have that hearing and that you'll proceed to circuit court for further proceedings.
Yes, Your Honor, I do.
All right. People also waive the right.
We do, Your Honor.
You can just, she can affix your signature to the form, sir.
Absolutely.
Waiving.
Thank you.
And for the record, Ms. Pirani met with him a couple of days before. So it's
Pardon?
not like someone, another APD met with him regarding this case and went over all of this with him. So this is not, just because I didn't meet with him this week doesn't mean he doesn't understand what is happening today. Because we discussed that with him earlier. I just want to put that on the record.
That is correct.
Understand?
He does, yeah. Thank you, Mr. Lafredo.
Is there anything else?
Nothing further.
All right.
Thank you.
Preliminary examination having been waived. Defendant is bound over to circuit court on the single count.
Thank you, Your Honor.
Thank you. You guys have a good rest of your day.
Hold on.
Oh.
Now you don't want to talk. Your turn.
We were formal reading of the charges in Samuel.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be set for
September 3rd, at 1:30 with Judge Conlon.
September 3rd, 2025, 1:30, Judge Conlon. Bond in this matter will continue. Thank you, Mr. Lafredo.
Thank
Your
you.
Honor. Thank you, Mr. Lafredo.
Court does call the case of the people versus Brandon Kelly.
Assistant Public Defender Chelsea Vergils with and on behalf of Brandon Kelly. Mr. Kelly, please state your name for the record.
Brandon Isaac Kelly.
Thank you.
Your Honor, today we are asking for an adjournment to continue a plea discussion and allow me to do an AIM referral. I am also asking to address bond.
Probable cause conference will be adjourned July 22nd, 2025, 9 a.m. Bond.
Thank you, Your Honor. Regarding bond, his bond is currently a 5,010%. We're asking you to consider a personal bond. Mr. Kelly does stay in Washtenaw County. He has an Ann Arbor mailing address. He reports that prior to being in custody, he was engaged in community service. He does not have a criminal history. He understands the bond conditions not to go back to Target or have contact with the complaining witness. He does have another case open, but it is my understanding, based on the record on JIS, that $100 bond will turn into a personal bond upon his release on this case.
So he's held on another matter.
Yes, but if this were turned into a personal bond, that would automatically turn into a personal bond.
That's the way the bond reads.
On GIS, it does state that Magistrate Garwood said it that way.
People believe that the bond term that is very fair and appropriate in other cases that other unprovoked, most of the cases that has consist of him being in public places and just punching people in the face, either because they looked at him or he looked at them. In this particular case, he had the use of the watch as a makeshift brass knuckles, which escalated into a felony. These cases happened within about 3 weeks of each other in the month of June. I'm not really sure what's going on with Mr. Kelly, but I'm not the most stable at this point. And I would request.
So was he on bond on the other case when this happened? Not yet. All right. Anything else?
No, thank you. Oh,
Court
sorry.
does believe that the bond is set appropriately. Motion for bond reduction is denied. Bond will continue. Thank you. Court does call the case of the people versus Benjamin Hoffman.
Ally Zend on behalf of the people, Your Honor. And Your Honor, maybe in the hall, I'll go grab them.
Case of the people versus Sean Bilodeau.
Good morning, Your Honor. Edward Dugas on behalf of the defendant. Sean Bilodeau? Your Honor, there's an outstanding DVD I need to obtain. I'm asking for just a brief adjournment.
Probable cause conference, July 22nd, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Great. Where are they? Okay, court does call the case people versus Jacqueline Jones Washington, all three cases.
Mackey on behalf of Mrs. Washington, Jones Washington. Mackey requesting permission to practice under Michigan Court Rule 8.120 under Public Defender Brian Bowling.
Permission to practice is granted.
Thank you, Your Honor. Appearing on behalf of Jones Washington, she's in custody.
Yes.
Oh, she's on Zoom.
Could you state your name, please?
Jacqueline Jones Washington.
Thank you.
We are still waiting for a competency report in this matter, Your Honor, so we respectfully request an adjournment.
I have one that is
So I saw in jail.
dated June 17th. You have that one as well?
Our office hasn't had one since May.
Got it.
So this is the report on the 2025 case, so she needs a final one.
Got it. Okay. My staff just reminded me, this was the case where she had been, I think, found incompetent but restorable on two of the matters. We needed a new order for the third case, the 2025 case. This report that just came through, which has the same finding of incompetent but restorable, is the same as the other one. Does that make sense to you? I recall having to do this. We just didn't have an order for the 2025 case.
Okay, so did you need that order? It was sent last time, I believe, right?
Well, we didn't have the order for the forensic exam. So we did that.
Yeah.
This is the report this current report, which is effectively the same as the other reports, is coming from that new order that we sent for the request for the preliminary examination. Ms. Akinwumi, was there something you were going to add?
Absolutely. I'm just taking notes, Judge. I just wanted to make sure I was catching.
What do you mean you're just taking notes? Just gonna.
As far as people go, we would stipulate to the findings of the report that Ms. Jones Washington is
Okay, and I don't know if you're in a position to stipulate to it. It's the same, it's the same finding, but I don't know if you feel that you're gonna need to go through it with your client.
Can I have a 2-week adjournment so I can review that report with my client? Okay.
I'll adjourn all of these matters. I'll adjourn the competency to July 22nd. Well, we're not gonna be able to get it back because that's not 2 weeks. It's gonna have to be July 31st, 2025, 9 a.m. Bond on all of these matters will continue.
Thank you, Judge.
What is that date again? If you can please repeat that.
It's July 31st,
And
9 a.m.
9 a.m. Thank you so much.
All right, got it?
Yeah, thank you.
Thank you. Court does call the case of the people versus Rio Boyd.
So, Mrs.
And then on behalf of the people, Your Honor.
Particular on behalf of Ms. Boyd, would you state your name for the record? Oh, sorry about that.
Riel Boyd.
Judge, I was just appointed, I think yesterday, may we get a short adjournment?
Probable cause conference will be adjourned July 22nd, 2020. 9 a.m. Bond continued.
July 22nd. Thank you,
That's
Judge.
Tuesday. Thank you.
Thank you.
Okay, court does call the case of the people versus Duran Wilburn.
And then on behalf of the people, Your Honor.
Edward Lucas on behalf of Jerome will be approaching.
And good morning, Miss Lowe. Just because you think that you're a small walking past, I could still see. Your name, sir?
Ron Wilburn.
Thank you.
Your Honor, at this time, discovery is complete to my knowledge. I'm asking for a preliminary examination.
Okay. 20 seconds. Would the people have their witnesses available the 22nd?
We'll do our best, Your Honor. And I did want to make clear aware as well, we did request a 911 call on the 9th, so it should be here before exam.
All right. Preliminary examination in person, July 22nd, 2025, 9 a.m. That is before
Judge Barr.
Judge Barr. Bond will continue.
Thank you.
Thank you. Court calls the case people versus Dacia Moore.
I'm here. Good morning, Your Honor. Christina Costantino appearing on behalf of Ms. Moore. Ms. Moore, can you please unmute and state your name for the court? Deja Moore.
Thank you, ma'am. Constantino, you just don't come to like Washtenaw County anymore?
Judge, I love Washtenaw County. I would much rather be there with you than where I've been. Trust me on that one.
Okay. All right. Well, everybody else misses you. I know. All right. What are we doing? What are we doing?
Judge, I did just recently receive some new discovery this week. I would like a chance to review that with my client. So we would be asking for a brief adjournment of the PCC.
All right. We have some strange dates. Would you like Tuesday the 22nd or the 31st?
The 22nd would work.
All right. Probable cause conference will be adjourned July 22nd, 2025, 9 a.m. Bond continued.
Thank you, Judge.
Right. Thank you. It does call the case of the people versus Isaiah Bozeman.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Bozeman. You state your name.
Isaiah Bozeman.
All right. What are we doing?
We're requesting an adjournment to review discovery.
Are you, it's not signed, but are you aware of a character reference letter sent on his behalf?
I don't have that, Your Honor, no.
All right. I'll make sure because since it came to the court. Yeah. That come with it.
Yeah, something to eat somewhere.
I don't know why they're here. There's a number of them sent for whatever reason. There's not going to have an influence on the court, but we'll provide those to both parties.
Thank you, Your Honor.
All right. You're asking for an adjournment of this matter. I'll adjourn this matter. Probable cause conference to July 22nd, 2025, 9 a.m. Bond continued.
Adjourn.
Court calls the case of the people versus Heather Booth.
People.
Mr. Rushing?
I'll grab it.
Good morning, Your Honor. Sydney Rushing, appearing on behalf of Miss Booth. Is that Miss Booth in the Wayne County Jail by chance? That's where she is currently located, Judge.
Do you have her?
We did not know she was in custody.
We did not know. So I'll have to kick this out to the 31st, so we have the 2 weeks for a writ if she's going to be there.
Your Honor, she's on remand status, so it's my understanding that she's likely going to remain there till then.
Okay. Probable cause conference, July 31st, 2025, 9 a.m. Bond continues.
Thank you so much, Your Honor.
Thank you. Court does call the case of the people versus David Mariquin, 2 cases.
Your Honor, Alex Warren Green on behalf of Mr. Mariquin. You state your name?
David Mariquin.
Thank you.
Your Honor, at this time, we're asking the court to set both matters for preliminary.
All discovery is complete.
Discovery is complete, Your Honor.
People have their witnesses available the 22nd. Preliminary examination in person in these matters will be set for July 22nd, 2025, 9 a.m. 9 or noon?
It's actually at 12. Yeah.
12 noon
With you.
for me. Bond will continue.
Thank you, Your Honor.
Court does call the case of the people versus Todd Amerman.
I'm Lori Gacky, Assistant Public Defender with and on behalf of Mr. Ammerman, who is standing to my right.
Your name, sir?
Todd Ammerman.
Your Honor, I do apologize. I will 100% take responsibility. We do have a plea form. I know I should have submitted it yesterday. Mr. Ammerman was very diligent in calling my office, and we were only able to connect after. But we have agreed upon a plea. It's not a no contest. It's just a guilty plea to an added count 2 abuse. So I'm hoping the court will take this today.
Plea form indicates that the defendant will be pleading, that box was a check. He's pleading guilty.
Yes, I apologize.
That's what happens when we rush things at the last minute. The plea form indicates that he's going to be pleading guilty to the charge of use of methamphetamine. On his successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
Yes, Your Honor.
That's correct.
Let's have him sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Todd L. Ammerman.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Do you understand that?
Yes, sir.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in 14A4 District Court.
Yes, sir.
Understanding all of that, do you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
Has he signed any advice or rights form?
I
You're not ready. I'm not gonna I'm passing it.
Okay, I'm sorry.
Court calls the case, People versus Zavratko. Kitana, I think.
Good morning, Your Honor. Good morning, Your Honor. Roba Hamden requesting permission to practice pursuant MCR 8.120 under the supervision of Assistant Public Defender David Boundary.
Permission practice is granted.
Thank you. I am here on behalf of the Grappo Kitnell. Can you please state your name for the record?
Sure, Kitnell.
We are requesting a 2-week adjournment on this matter for negotiation.
Probable cause conference will be adjourned July 22nd, 2025, 9 a.m. Bond continued.
Your Honor.
Court calls case of the People versus Anita Barnes.
Assistant Public Defender Nicholas Bukovich on behalf of Ms. Bonds, who should be appearing via Zoom.
Anita Barnes.
Got her. Yeah. All right, what are we doing?
At this time, Your Honor, we'll be requesting a 2-week adjournment for a little bit of further negotiation, and so I can provide some documentation to APA Cook. And I do have a green sheet.
Probable cause conference will be adjourned July 22nd, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Ms. White. Court does call the case, People versus Anthony Alfaro Cajellas.
May it please the court, Your Honor, good morning. My name is Venu Yadala. I appear on behalf of Zachariah Bonham, who is the attorney of record.
Oh. Is he here?
I'm sorry, Your Honor.
He's in custody.
Yeah, how you doing?
Your name, sir?
Anthony Alfaro Callejas.
Thank you. All right, what are we doing?
Your Honor, my understanding is that counsel just submitted a substitution and needs time to give discovery review with the client. So I believe they're requesting an adjournment.
Your Honor, that is a fair and accurate statement. Negotiations are being continued. We would respectfully request a brief adjournment.
They didn't tell you anything about green sheets. You'll need to fill out the green sheets. I'll grant the adjournment. But will the 22nd be enough time, counsel?
Thank you.
Will that be enough?
That should be enough. Thank you.
Probable cause conference will be adjourned July 22nd, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court calls case, People versus Roderick Bates.
Assistant Public Defender Nicholas Bukovich on behalf of Mr. Bates, who should be appearing via Zoom.
Good morning.
Your name?
Roderick Bates.
So, Your Honor, the prosecution's recently provided some additional video discovery we were just able to get from Washington County, so I just need time to review that with my client, so I'm requesting an adjournment.
Probable cause conference. Do you have a green sheet?
Yes, I do, Your Honor.
July 22nd, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
Thank you.
Court calls the case of the People versus Molly Fox.
Good morning, Your Honor. Ellen Dennis appearing on behalf of Molly Fox.
Your name?
Molly Fox.
You're requesting, well, is she gone to inpatient treatment yet?
She hasn't gone, she's still in custody, Your Honor. You
I know.
signed the order yesterday, I think. And it has some contingencies in it that there has to be a bed. She believes there will be, but we don't know yet. Also, I could tell the court that she's been interviewed by Mr. Reyes with a review of whether she'd be eligible for recovery court. And I do not know what that decision is because I haven't received the email yet from him. That happened, was it yesterday? Day before yesterday? Tuesday.
Your interview happened day before yesterday?
Yeah.
Okay, they should be coming out, hopefully with a decision relatively soon. I can give you the 22nd or the 31st, counsel.
Pardon?
The 22nd or the 31st, which date would you prefer?
The 31st. Now, I assume that if the bed becomes available, she can go and still.
She'll be an inpatient and we'll deal with it, but I mean.
Okay.
I'm not gonna hold everything up on that. Probable cause conference, July 31st, 2025, 9 a.m. Bond continue. Thank you.
Your Honor.
Court calls case, People versus Elton Bell.
Good morning, Your Honor.
Kerma Dadush on behalf of Mr. Bell. Mr. Bell, can you please state your name for the record?
Elton Robert Bell.
And good morning, sir. All right, what are we doing?
Your Honor, I did submit a green form, but we are actually not going to be adjourning on this case. We are going to be waiving preliminary examination.
All right, Mr. Bell?
Yes.
You're gonna waive your right to a preliminary examination?
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes.
And you understand you'll not have that hearing, you'll proceed to circuit court for further proceedings?
Yes.
People also waive their right?
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over on a single count.
We waive formal reading of the charges and stand mute, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
August 28th, 2025 at 1:30 with Judge Slay.
August 28th, 2025, 1:30, Judge Slay.
Thank you so much, Your Honor.
Thank you, Your Honor.
Bond will, thank you, sir. Bond will continue. Court calls case, People versus Ardeen Henderson.
Hey,
everyone.
Kerma Dadush on behalf of Ms. Henderson. Ms. Henderson, can you please state your name for the record?
So my name is Ardeen Beatrice Henderson, Grand Rising. Thank you all for having me.
You're welcome.
Your Honor, we are going to be asking for an adjournment. We have just started a mitigation process. So we're going to be asking for an adjournment for that purpose and plea negotiations.
Your Honor, I would just remind the court, this Henderson does have a case in Wayne County. She's got a case at 35th District Court, where she's referred for competency in May. That court did not come in based on rush actions. And that court is for August 29th.
August 29th. So were you aware of that, counsel?
Yes, I was. She had told me that she started that process.
Okay, well, then I'm a bit reluctant to do anything prior to that competency report coming through. So
Are we able to adjourn further out?
I'm able to do a lot of things. Some of the things I will not do.
Whatever Your Honor prefers.
Of course, you're learning. Give me a September date.
September 11th.
September 11th.
Can she hear us?
I will adjourn. Yeah. Can you hear me, ma'am?
Yeah, I just don't understand what's going on. Can somebody please explain to me, please?
Okay, so I'm adjourning it out. Okay, my understanding is that there's a competency review in your other matter.
Okay.
Okay, so
Okay.
what we're doing is we're taking the safe course of this, putting this out till after there's a finding there, because that may dictate what happens here. We really can't get much done until that comes through.
Okay, well, my lawyers better explain to me later also again, I won't forget. Or can someone send me something or something if I can have someone read to me what's going on? Okay, never mind. The sergeant here said, Sergeant Perzon, how you pronounce your name? Horizondex said he'll help me. He explained to me.
Okay, and your attorneys will be in touch with you, okay?
I can talk to you next week, Ms. Henderson, okay, to explain all of this.
Thank you.
Okay.
I thank you all for having me.
Yes.
Okay,
We are so glad, and we will
Thank
have you
you.
back in September 11th, 2025 at 9 a.m., okay?
Take care, Ms. Henderson.
Bond
For
continues.
my birthday, and what day would, I'm
That's
sorry,
your
what day
birthday?
would that be?
September 11th.
September the
What-
18th, it's right before. Okay.
September
That's on a
18th, your birthday? Well,
Maybe
so I
Yes.
don't forget, happy birthday.
Thank you. I'm taking my grandkids to the water park before it gets cold. Thank you.
Okay, take care.
Thank you.
Court calls the case, People versus Orby Huffman.
David Burgess on behalf of Orby Huffman.
State your name, sir.
Orby Huffman.
Thank you. What are we doing?
Your Honor, we've received discovery in this matter. We're requesting an exam be scheduled.
People have their witnesses available the 22nd. Preliminary examination in this matter will be set for July 22nd, 2025 at 9 a.m. before Judge Barr.
Thank you, Your Honor.
Bond will continue. Thank you. Does call the case of the People versus Nathan Bell.
Assistant Public Defender Nick Bukovich for Mr. Bell, who should be appearing via Zoom.
Nathan Bell, do we have him?
No, I do not.
I was in contact with my client this week and he asked me to put in that Zoom request.
He did?
Yes.
I'm here.
So,
I'm here.
He goes by another name, Motorola. Sir, I
Yeah.
need you to turn on the camera, please.
Yes, sir. Yes, am I here? Yes, I'm here.
Okay, you have to uncover the lens. There you go.
there you go.
What's your name?
Nathan Bell.
All right, what are we doing?
I'll be requesting a brief adjournment. For Mr. Bell to obtain some medical documentation I can provide to the prosecution towards an offer. And I do have a green sheet, Your Honor.
July 31st, 2025, 9 a.m. Bond continued. Court does call the case People versus Jonathan Miles. Oh, there she is.
Good afternoon, I'm sorry, good morning, Your Honor. Assistant Attorney General Carissa Williams on behalf of the people.
Good morning.
And Alex Warren Green on behalf of Mr. Miles. Mr. Miles, can you state your name for the court?
Jonathan Dion Miles.
All right, what are we doing?
Your Honor, I had an opportunity to confer with the Assistant Attorney General. She did extend a generous offer, but at this time, Mr. Miles is asking for a preliminary examination.
I'm sorry, who in our office did you speak to?
I emailed you, Ms. Williams, and received a return email as well.
Okay. I don't recall that, but okay, I'll look through my emails.
All right. You want this set for exam?
Mr. Miles is asking for a preliminary examination, yes.
All discovery is complete?
Believe so, Your Honor.
Would the people have their witnesses available on the 22nd?
We should, Your Honor. I'm sorry.
All right.
What is the defense attorney's name? He's saying he sent this email. I don't remember having a discussion. Was this shortly after the last hearing about this case? I know we hadn't made an offer at the last hearing.
My name is
Yes.
Alex Warren Green. I
I'm not saying that you
received a
did.
Yep.
No, I get you. How much is owing on this?
Your Honor, I believe it's just north of $6,000.
And so the exam is gonna be over what's owed?
Your Honor, I might
Meaning the law that if it's charged, it's owed?
talk to my
That's
client.
okay.
I advise
We'll
I
set it.
advise him of the offer.
We'll set the exam.
Thank you.
Preliminary examination in this matter in person will be set July 22nd, 2025. That's at 12 noon, and that's before me.
Thank you, Your
If
Honor.
we set it for exam, Mr. Warren Green, you better come with something.
Thank you, Your Honor.
Court calls the case, People versus Daniel Bowe.
Assistant Public Defendant Nicholas Bukovich for Mr. Bowe, who is approaching.
Your name?
Daniel Bowe.
Thank you.
At this time, Your Honor, we're requesting a brief adjournment. The prosecution has extended an offer. It's just Mr. Bowe wants to confirm that this offer won't have impact on an outside matter before accepting it. So,
Probable cause conference, July 22nd, 2025, 9 a.m.
Mr. Bowe did want me to ask if we could do a possible further out adjournment because he'll be up north for work from July 19th to August 5th. I did explain to him I could ask that, but it's ultimately up to the court.
Yeah, I'll be up by Mackinac working for about 2 weeks. And I don't want to miss court and have anything come back on me because I'm 4 hours away. If I have to make that adjustment, I will, but I'm just asking.
Oh, I know. When are you coming back now?
August 5th, I'll be back.
Any objection from the people?
No, Your Honor. Thank you.
August 7th, 2025, 9 a.m.
Thank you, Your Honor.
You're welcome. Bond continue.
Thank you, Your Honor.
Calls case, People versus Noah Adamson.
Lord Yagi, Assistant Public Defender, with and on behalf of Mr. Adamson, who's approaching. Could you state your name for the court?
Noah Adamson.
Thank you.
Your Honor, we are respectfully requesting an exam be set in this matter. The only
All
outstanding.
discovery, go ahead.
No, I'm sorry. The 911 call has already been requested and should be here either today or tomorrow.
That's correct, Your Honor. And if we could address bond appropriate.
Preliminary examination in this matter will be set July 22nd, 2025, 9 a.m. That will be before Judge Barr. As to bound.
Your Honor, it's come to my attention that since arraignment, the defendant has made 37 calls to the victim in this case, and at this time we would be asking that his phone privileges be revoked.
Where'd you go? Oh, no. Response.
Your Honor, unfortunately, we don't have, the calls, we don't have the timings. I can't really respond without having the information underlying the argument. Mr. Adamson actually wanted me to make a bond argument today for his release, as this is the only case holding him, and he has to go back to work. He has a separate residence from the alleged victim. I will have a conversation with him about ensuring that he understands and will comply with the no contact order. I know he's been contacting his family and friends using the phone here, as he has a lot of kind of business to attend to on the outside, and his rent's coming up and all that. So I would ask for the court to reserve judgment until the exam date in terms of his phone privileges.
These are to the victim's number.
Your Honor, I believe so, Your Honor. Yes.
They are. So, Ms. Yagi, are you making a motion to reduce his bond? I mean, was that what I was hearing or not?
I am, yes.
Go ahead, response.
I would object, given the phone calls. I believe the defendant is also currently on probation for a previous conviction in circuit court for a GBH DV Act with the same victim that he was sentenced on, I believe, in February of this year. In this case, they had an argument. He grabbed her by the wrist, pushed her up against the wall. She was able to free herself, tried to use a roommate's phone to call 911. He takes the phone, hangs it up. She then tries to call 911 from another phone. He then takes that phone, hangs it up, and he entered the apartment to begin with without permission. I have concerns given that he is on height of probation for a DV offense with the same victim from this year and is engaging in that same behavior. Would ask that bond remain the same.
Anything else?
I just want to note that that there's no hold for that case, and we discussed the tether. He's in accountable choices. He's in contact with his probation officer and hasn't been violated yet. So, but nothing further, Your Honor.
Defendant's motion for bond reduction is denied. As to people's requests as to the revoking of his phone privileges, this time the court will revoke the defendant's phone privileges. Defense is entitled to and can request a hearing on that matter once they hear the calls.
Thank you, Your Honor.
Court does call the case People versus Kevin Burden.
The Assistant Public Defender Jay Zollinger on behalf of Mr. Burden. And Mr. Burden, can you please state your name for the record? Kevin Burden. And Your Honor, all mitigation materials have been submitted. We're just waiting on consideration of that. We would be asking for 3 weeks.
Probable cause conference will be adjourned July 31st, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Thank you.
Court calls case People versus DeJure Bond Sanders.
I was done on behalf of the people, Your Honor.
And Alex Warren Green on behalf of Mr. Bond Sanders. State your name, Mr. Bond Sanders.
DeJure Bond Sanders.
Thank you. Your Honor, we're asking for a preliminary examination in this case.
Discovery is complete.
I believe so, Your Honor.
People have their witnesses available the 22nd.
I believe so, Your Honor. And for the rest, we did request a 911 call in this case. It has not come in yet, but it should be here by Monday before it's
Preliminary examination in person, July 22nd, 2025 at 9 a.m. before Judge Barr. Bond continue. Court
Your Honor.
Court calls case People versus Andrew Burke.
And Alex Warren Green on behalf of Mr. Burke.
Your name, sir?
Andrew Burke.
Thank you.
Your Honor, today's date and time for probable cause conference. At this time, Mr. Burke does wish to waive his right to a preliminary examination and proceed to circuit court. I'm having him sign the waiver right now.
Mr. Burke, while you're signing that, you're waiving your right to a preliminary examination, sir?
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed.
Yes, I do.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
I do.
All right. People also waive their right. Preliminary examination having been waived, defendant found over to circuit court on a single count.
Your Honor, we acknowledge receipt of the information, waive its reading, and stand mute.
Defendant having waived from a reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
August 28th, 2025 at 1:30 with Judge Slay.
August 28th,
Yes.
2025, 1:30 before Judge Slay. Bond will continue. All right. Court calls the case People versus Matthew Fonseca. What's the deal on this one?
So he has a bond violation this one. Oh, I'm sorry.
That's Morning, Judge. Good morning. How are you?
Brian Bowling. on
I
behalf
don't
of-
know. What are you gonna do? No, go ahead.
Good point. Brian Bowling on behalf of Mr. Fonseca, just state your name for the record.
Matthew Fonseca.
Your Honor, when it comes to the PCCs, we were in the process of trying to reach a global resolution, but now it's come to my attention, there is a new charge that we
Yes.
will kind of throw into that pot to try to
That's-
put together.
Absolutely, and I'll arraign him on that charge. Mr. Fonseca, you're here on another case. If I
Your Honor.
find my complaint.
I was able to obtain a copy of the complaint this morning. I did review that with Mr. Fonseca, so for purpose of the arraignment on that charge, I would waive formal reading and stand mute.
Mr. Fonseca, you understand the nature of the charges in that case?
Yes, sir.
You understand the maximum penalties?
Yes.
And you do wish to be represented by counsel?
Yes.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. So in terms of setting the probable cause in this matter.
Well, Your Honor, this would be, I guess, now 2 felony matters, it looks like that would be pending.
How come this doesn't have to do a date? Okay. All right, go ahead.
We do have the bond violation as well.
Yes.
That is alleged. I guess obviously.
Which are different than the new charges.
Correct.
Right.
So, I mean, I guess if we just could keep everything together and have a
Yes.
couple weeks, I think that would be satisfactory. I should be able to get a discovery request submitted today, and hopefully we'll have those materials prior to the next.
I'll adjourn then everything. I'll adjourn the one that's set for PCC as well as the bond violation hearing. I'll adjourn that to the 22nd, 2025 at 9 a.m. Bond will continue on that matter. On the other matter, I will set the probable cause conference for July 22nd, 2025, 9 a.m. His bond in that case. What's his bond in the other one? So how many cases is he being held on right now?
It is just the bond violation, correct? Because you were out of custody, right?
Yes. Bond in this case will be set at a $5,000 cash surety at this juncture. I'll order standard conditions, including no assault behavior, possession of any weapons, no possession or consumption of any alcohol, recreational marijuana, or any illegal drugs. I will order that if the defendant is released, he is to report over to community corrections for 2 times per week drug testing.
Thank you, Judge. Your Honor, on the matter pending with the bond violation, was bond revoked?
It was.
Okay. Thank you, Judge.
So his bond will be revoked on that matter. Correct.
Okay, what time do I have to go back?
I'll be over to see you.
Pardon? Court calls the case People versus Antonio Williams.
You took the people? Brian Bowling on behalf of Mr. Williams. Oh, he's on the screen. Your Honor.
Mr. Williams, do you have somebody that can unmute? So you can tell us, can you unmute the device?
Judge, he can hear you, but he's basically blind. So
okay.
He won't be able to, move around within that room to.
All right, Mr. Williams, if you can hear me, if you can wave your hand so that I know that you can hear me. All right, thank you, sir. What do you want?
Judge, after meeting with Mr. Williams at the jail, I believe that a competency examination is appropriate in this matter, so there should be a proposed order in the court's file for that. I'd ask you to sign it.
All right, I will sign those orders for a forensic evaluation. Ordered. I'll set a competency hearing for 90, please.
October 9th, 2024.
October 9th, 2025, 9 a.m. Bond on this matter will continue.
Thank you, Judge.
Court does call the case People versus LaShawn Charles.
And Lori Yagi, Assistant Public Defender, with and on behalf of Ms. Charles. Ms. Charles, can you state your name for the court?
LaShawn Charles.
Got her.
Thank you. Your Honor, we're asking for an adjournment for further discovery in this matter.
Probable cause conference will be adjourned July 31st, 2025, 9 a.m. Bond continued.
Thank you.
Thank you.
Have a good day.
You do the same. Court calls the case People versus Darrell Frederick.
Assistant Public Defender Jay Bellinger on behalf of Mr. Frederick, who approaches.
Ms. Wyman.
Mr. Frederick, can you please state your name for the record?
Frederick.
Go ahead. And Your Honor, we've signed a waiver and I got my client's permission to sign that on his behalf.
Oh, sure have. All right. So you're waiving your right to a preliminary examination?
That's correct.
All right. You understand that's a proceeding where people would have
To whatever you were talking.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
That's correct.
And you understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
That's correct, Your Honor.
All right. People also waive their rights. Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Your Honor, we acknowledge receipt of information. We have formal reading stand mute at this time.
Defendant having waived formal reading standing mute, court will enter a not guilty plea. Pretrial will be set for
July 22nd, 2025.
July 22nd, 2025, 1:30, Judge Coffey.
We'll be in touch, okay? Thank you, Your Honor.
Thank you. Bond continue. Court calls the case People versus Bradley Chavez.
On behalf of Mr. Chavez, can you state your name for the record, sir?
Bradley Chavez. All right.
We are going to be asking for a brief adjournment so we can continue plea negotiations with prosecution.
Probable cause conference, July 22nd, 2025, 9 a.m.
Thank you, Your Honor.
Thank you. Bond continue. Court calls the case People versus Robert Gallet.
Kerma Dadush on behalf of Ms. Gallet on the case ending in 713.
Morning, Roger Kilwell, Judge. I'm on case 5612.
All right.
Your Honor, we were going to be asking for adjournment in our case and a chance to address bond, please.
You're also asking for an adjournment?
Yes, I'm sorry.
All right. Go ahead and address bond.
Thank you, Your Honor. First of all, Ms. Gallet here wanted to apologize for missing her last court hearing. Since the start of this case and since her last court date, a lot of things have changed. Ms. Gallet has, first of all, now she has a phone number, a phone that we can contact her on. She has gone back on her medications. She has bipolar medications that she has to take, as well as hormones. So all of that kind of, well, it can, no, I don't want, let me word this correctly. All of that is helping us reassure, we're using that to help reassure Your Honor that she is going to show up if she is released on her own personal recognizance. She has also, she has two different caseworkers helping her. She has a CMH caseworker and a PATH caseworker. She has been approved for Avalon Housing if she were to be released. So all of that combined, her having a more secure home, having a phone number and medications. We are hoping to get a personal recognizance for that reason. She will appear. She has no intent, and there is nothing else holding her. I believe she has a 15th District Court case, but that she has a PR for that.
How did she come back in custody?
On the 15th case, Your Honor, 15th District Court case. Which is just a parks violation.
When did that happen?
I believe on the 4th or the 3rd, July 3rd. Well, that was the day.
So between March 20th and that time, what was she doing?
She was, let me talk. She was unmedicated. Her husband also has bipolar and schizophrenia. They were both unmedicated. They were both homeless, doing quite poorly. Since then, all of that has changed. Her husband is in custody, but she is really trying to do her best. She, picks up debris with the Parks and Recreation program, Give 365. Again, her meds are a very big part of her ability to, come back to court and be more stable, have stable housing. And she hopes to even start classes with Washington Community College, wants to do linguistics, just wants to start becoming better. And her meds was the first step to that, Your Honor.
Mr. Killowald, anything?
I would just echo that argument, Your Honor.
Anything from the people? I really don't necessarily need it, but go ahead.
Two sets of concerns. I appreciate that it sounds like there's some progress being made. That case in the 15th district is an assault matter in Eddie Hospital. I understand that things have happened in the psychiatric environment there, but that everything is just June 28th. And I'm concerned about some of the behaviors there and wondering, it sounds like there's been a very dramatic turnaround within a very short amount of time. I don't know if Mr. Ducci has anything to provide proofs of some of the housing. The family is apparently in the California area, doesn't really have any ties to our county. So I'm not sure. I'm not sure that we'll see her, quite frankly. We do have.
So when I say I don't need it, what does that mean to you?
Well,
go ahead. No, go ahead. I'm listening.
I had options. You told me to add.
No, I did.
Although you don't need it. So, that's it.
Thank you. Motion for bond reductions denied. Bond will continue. I'll set the probable cause conference for July 22nd, 2025, 9 a.m. in both cases. Thank you. Court calls the case. People versus Deshaun Clifton.
Stephanie Cannon on behalf of Mr. Clifton.
Oh boy. Oh boy.
And Your Honor, we're simply asking for an adjournment. I'm sorry.
She did? She said her name?
I did.
I didn't hear it.
Oh, you want me to do it again, Your Honor?
No, really not.
Okay. Mitigation information has been provided very recently to the prosecutor in this case. We're just asking for some time, 2 weeks, Your Honor, for her to review it and see if an offer is forthcoming.
Will the 22nd work?
It will, Your Honor.
The 31st. All right. Probable cause conference, July 22nd, 2025, 9 a.m. Bond will continue. Thank you.
Thank you, Your Honor.
Thank you, sir. Court calls the case People versus Haruska Dennis.
And I'm acting on behalf of Mr. Haruska Dennis, who is approaching.
Again, Your Honor, Christina Costantino appearing on behalf of Mr. Haruska Dennis in the case number ending in 5076.
Oh, all right.
Thank
you.
We're respectfully requesting an adjournment in this matter. We AIM sent over a mitigation report last night, and the prosecution needs time to review it.
And I would join in that request.
All right. Will the 22nd work? I think that's what we set your last case, Ms. Constantino. Is that right?
Yes, Judge, I would ask for the 22nd, given he is in custody.
Probable cause conference will be adjourned July 22nd, 2025, 9 a.m. Bond will continue. And Ms. I will tell you, I miss you too. And Mr. Allen told me I wasn't very nice in saying what I said the last time. So I don't know what's going on there, but he was kind of yelling at me.
Well,
So-
thank you, Mr. Allen, and thank you, Judge. I appreciate you changing your mind. I hope to see you soon.
Yes, ma'am.
Thank you.
Thank you. Court calls the case, People versus Christopher Cummings IV.
Assistant Public Defender Chelsea Vergils with and on behalf of Christopher Cummings. Please state your name.
Christopher Cummings.
Your Honor, we are requesting an adjournment today. Since his last court date, we did receive discovery. We're asking for time to review that and consider the offer that's been made in this case.
July 31st, 2025, 9 a.m. Bond continued. Thank you. Court does call the case, People versus Mark Hubbard.
Alexander, on behalf of the people, Your Honor. And Mackie on behalf of Mr. Hubbard, who is approaching, Your Honor. Please state your name for the record.
Mark Hubbard.
Your Honor, at this time, we respectfully ask to set this matter for a preliminary examination, and all discovery is complete as far as we are aware.
People have their witnesses available the 22nd.
We'll do our best, Your Honor.
Preliminary examination in person will be set July 22nd, 2025 at
12 p.m.
12 noon before me. Bond will continue.
Judge.
Court calls case People versus Devon Julia Martinez.
Stephanie Cannon on behalf of Ms. Martinez, Your Honor, who's appearing via Zoom.
Devin, can you state your name for me?
Devin Julia Martinez.
Thank you.
Your Honor, Ms. Martinez was recently, I believe a week or two ago, evaluated by the Forensic Center because in her other cases, she has forensic order requested, the paperwork to get one filed in this one as well. However, we have not received the evaluation back. Upon receipt of that, my client is indicating she does want to waive. However, I don't believe the court will do anything.
I won't.
But I want her to hear that, won't be able to do so.
When is that other case set? Do you know?
She is set in front of Judge Hammoud. I believe her next court appearance is on July 28th.
All right. And you're filling out the paperwork because you want. All right.
I'm just gonna have the order placed in this file as well, Your Honor.
So I will order a forensic evaluation. I will set her comp hearing on this case October what?
October 9th.
October 9th, 2025 at 9 a.m. If the report comes in before then, certainly we can move that date up. All right.
And I will explain that to my client, Your Honor.
All right. Bond will continue.
Thank you.
Yes. And when they get that. Who's filling, thank you. Who's filling out the order? I can really? Oh, it's gonna be a minute here. Why is that taking so long?
Well, Your Honor.
Why, not you, her.
Okay.
What is she doing? What are you trying to help her? Just slowly though, right? Court calls the cases of the People versus Chad Jones.
Hannah Mackie on behalf of Mr. Jones, who's approaching. Please state your name for the record.
Chad Jones. Thank you.
Your Honor, we're respectfully requesting to adjourn this matter pending drug court eligibility.
All right. Has he already been interviewed yet?
Not yet, Your Honor.
Not yet?
The referral was sent in yesterday.
Of course it was. All right. I will adjourn these matters then to July 31st, 2020. And bond continue.
Thank you, Your Honor.
Thank you. Court calls the case People versus Sean Hardman.
Portable 8.120. During the supervision of Assistant Prosecuting Attorney Jennifer Hudson.
Good morning. What? Hold on. So why are you with Douglas? Wow. I asked the question. Actually, what I was gonna say, what Zenda do to you? Oh, okay. All right. No, I thought you might have requested a transfer. Permission to practice is granted. Go ahead.
Good morning, Your Honor. Sydney Rushing, appearing on behalf of Mr. Hardman. Mr. Hardman, can you please shake your hand, let the deputy know need to be unmuted and state your name for the record?
Oh, yeah, hold on to that blanket. Don't worry about it.
Okay, thank you. Your Honor,
That's him. We're good.
Your Honor, at this time, we are requesting a brief adjournment. There is some outstanding discovery that I will need to get and review with my client. So we are just asking for an adjourned PCC date.
All right. Probable cause conference, July 22nd, 2025, 9 a.m. Bond continues.
Your Honor, may I briefly address bond?
Sure.
I did tell the people I was going to be doing so. Mr. Hardman's bond is currently set at $1,000, 10%. So $100 is what would need to be posted. I'm asking Your Honor to consider reducing that down to a personal bond. This case the incident date is from November 2nd, 2023. The warrant on this case wasn't signed until September 26, 2024. And then the arraignment on this happened on 6/30/2025. He's actually currently in Judge Conkey's drug treatment court. So this is a new case. It's not a violation, or I guess I should say it wasn't a violation. It will be if he pleads on, but it's not new. So I'm just asking for Your Honor to consider reducing it down to a personal bond. He does have stable housing.
Is this the only thing holding him?
Yes. After this, Judge Conkey isn't addressing the bond on that case until this bond's addressed. So he has court on that on the 20, is it the first?
So
I believe on the 26th.
Well, is this a bond violation?
I think at this point, since it's been issued, yes, but she was waiting to see what the court was going to do on this bond before she addressed her bond. He had court earlier this week.
Okay.
She put it out for us to address it here first, and then she's going to address it in her court.
Okay, just so that I have the timing correctly. He was in drug court.
Yes.
This case, the allegations in this case occur.
They occurred prior to him going into drug court. So this case, it took a while for the warrant to get signed.
Gotcha.
When the warrant got
That's
signed.
what I was trying to make sure of. So
Yeah.
This case, I'm not clear how it would be a violation. Okay, I get you. That's what I was trying to figure out.
Yes.
Dates weren't matching up for him.
I think, and technically it can be, but I don't think it's going to be viewed as it since the incident happened prior.
Any response from the people?
It's usually that it's a mobile case, it's not assaultive, so we would leave it in the court's discretion. The incident does predate the other incidents in the circuit court cases, and XGL isn't showing any holds on.
Alan, doesn't she seem much nicer since she's not with Zenda? I say that out loud. I'm sorry, Miss Zenda, I didn't mean it.
They know your case or no?
All right. Here's what I'm going to do. I will, under the circumstances, and since he's in drug court, I will grant the defendant's motion. I'll reduce his bond to a $1,000 personal recognizance bond with all its conditions of no drug use.
Thank you, Judge.
All right.
2 minutes.
All right.
Thank you, Judge. I'll see you on the 22nd.
Thank you.
Have a great day, Judge. Have a
You
great
do the
staff
same.
as well.
Okay, he's all set. Court calls the case, People versus Nicole McCauley.
Hannah Mackey on behalf of Mrs. Colley, who is approaching.
So in there, you don't have.
Nicole McCauley.
Yeah, you're all set, sir.
We're requesting an adjournment in this matter, Your Honor. We are waiting for media discovery.
Probable cause conference will be adjourned July 22nd, 2025, 9 a.m. Bond continue. Court calls case People versus Stefan Wainwright. Why do I have so many down there? Jimmy.
And Alex Warren Green on behalf of Mr. Wainwright, who is on Zoom, Your Honor. Mr. Wainwright, can you state your name for the court?
Yes, Avon Dallas Wainwright.
Thank you. All right. Your Honor, I've completed an adjournment request form. We are asking for an adjournment to continue our negotiations with the people.
July 22nd, 2025, 9 a.m. bond.
Thank you, Your Honor.
Court calls case of the people versus Richard Morende. Morende.
Alexander on behalf of the people, Your Honor.
Good morning, Your Honor. Megan McDonald on behalf of Mr. Morandi, who was present on Zoom this morning, and we consent to have this hearing via Zoom.
Sir, can you please state your name?
Yes, good morning, Your Honor. My name is Richard Morandi.
Thank you.
Your Honor, for the purposes of the PCC today, we have not yet received discovery in this matter, so I would ask for an adjournment of this, please.
All right, he's out of custody. So
Yes, he's out of custody on bond.
seriously. I'll adjourn probable cause conference to July 31st, 2025 at 9 a.m.
31st, Your Honor. Okay, at 9 a.m. Thank you so much. That works for us.
Thank you. Bond
Thank you, Your Honor. Have a
continued.
great day.
Thank you. You too. Court does call the case. People versus Inbeatme Agbu Zulu.
Alexander on behalf of the people, Your Honor.
Stephanie Canna on behalf of Bititmi Guzulu.
Oh, Buzulu Alexander.
Your Honor, the E is silent in his name.
Okay.
Yeah, let you know. Oh, Your Honor, we are adjourning this case.
Why? You know what?
For mitigation purposes, I do
You only
understand.
deal with her one day a week.
You got lucky. this
One
week.
day.
You got-
One day. And then you were here 2 days.
You got lucky.
So I'm over it.
There you go.
And Your Honor, if we could address it on. Good.
And Your Honor, we understand that he also has a bond violation.
Yep. Go ahead, Ms. Senda.
Your Honor, this would be a further violation of his bond as he third parties from the jail, and I will just paraphrase one of these conversations. As long as she doesn't show up, then they'll just knock the case out. All right, do you want me to tell her not to show up? Well, she already said she's not. All right, I might shoot a text and say, hey, don't show up to that court thing. He says, no, I think you should drive there. Ain't nothing wrong with you going there. He says, all right, talk to her in person. So I have concerns he's calling third parties, having them talk to the victim, go to her residence, see her in person to tell her not to come to court. And I would be asking that his phone privileges also be revoked.
Any response?
Your Honor, I have talked to my client about that. I was informed that this did happen. I actually don't have a copy of those. However, I trust that the prosecutor's office will be sending me those. Your Honor, my client is understanding that he cannot do that. He will not be doing that. And he is asking that his phone privileges remain in place. As to the prior violation, Your Honor, my client works for the property management. That's how they have the apartment that they live in. So on that date in question for that particular violation, he did not go to the resident. He was not in the residence. He went to the shed,
Yeah.
we'll call it a shed, located on the property. He retrieved his tools and then he left. So
He could have done that with a civil standby.
he didn't go into the apartment, Your Honor.
Yeah, but I'm
Complex.
real concerned right
I
now
understand.
because the phone calls clearly indicate an attempt to get in contact with this victim, and then he's in the vicinity violating his condition. But you can go on if you wish, Ms. Kane.
No, Your Honor, I believe the court has all the information they need.
His bond in this matter is revoked based upon the bond condition, and his phone privileges are also revoked.
Thank you, Your Honor.
Thank you.
Oh, thank you, Your Honor.
Your Honor, what was the new date?
Was that it? I did not. You're looking for an adjournment. Probable cause conference, July 22nd, 2025, 9 a.m.
Thank you, Your Honor.
Thank you.
Court does call the case, People versus Ryan Piper.
And Alex Warren Green on behalf of Mr. Piper. Mr. Piper, can you state your name for the court, please?
Ryan Pieper.
Your Honor, today's date and time for a probable cause conference. In light of Mr. Pieper's restoration to competency, I would be asking for a preliminary examination in this case.
Discovery is complete then.
Believe so, Your Honor.
And would the people have their witnesses available the 22nd?
Yes.
Preliminary examination in person, July 22nd, 2025. That's Barr. 9 a.m. before Judge Barr. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the case, People versus London Daughtery.
Andrew Childers, on behalf of people.
Hannah Mackey on behalf of Mr. Daughtery, who's approaching to my right. Name for the record.
London Daughters.
Your Honor, we respectfully request to adjourn this matter for further investigation,
For what?
to look into the case a little bit more, into the police reports and everything.
It's like a movie. It gets better. Probable cause conference, July 31st, 2025, 9 a.m. Bond continue.
Thank you.
Right.
Cinda, I apologize for what I said. Mr. Allen is making me apologize to you also.
Can I have one?
So I'm sorry. Wow, the whole table? I like Gaddy. Court calls the case, People versus Farage Scott.
Andrew Childers, appearing on behalf of people.
And Assistant Public Defender Chinazi Kyriakin Rulu, Your Honor, on behalf of Mr. Faraj Scott.
I didn't know if you were going to do anything today other than that order that was taking forever. All right.
There's two things. State your name for the record, Mr. Scott.
Verizon Scott.
Thank you. You're welcome. All right, what are we doing on this?
Judge, I have a green sheet. We are currently working on mitigation for Mr. Scott, so we're asking for an adjournment to continue that.
All right, so you're working on the mitigation.
Yes, Your Honor.
What do you have as bonds? I can look at it, that's all right. I'm just trying to think, how much time are you gonna need to?
I think the 31st should be fine.
Should be okay.
Yes, Judge.
Probable cause conference then, I'm good, Ann. To July 31st, 2025, 9 a.m. Bond will continue.
Thank you so much, Your Honor.
Versus Devon.
Hannah Mackey on behalf of Mr. Haywood, who is approaching to my right. Please state your name for the record.
Good morning, Your Honor. Devon Hayward.
Thank you.
Your Honor, I believe we reached a resolution in this matter.
You have. And it's here.
Perfect.
That's right. This is the one that, hang on a second, this one, sure, this is the one that I looked at. All right. We have a plea form in this case that the defendant would be pleading to the charge of use of a controlled substance. I don't have, how come these forms aren't that hard to fill out?
Pardon?
How come I don't have the maximum penalty on here of what he's pleading to? Who did this? Mr. Childers? Mr. Childers, type. Childers, you know what? No, you know what? It's typed. Did you type it?
No, I did.
You didn't. Who did?
It was a group effort, but I'll take that.
I appreciate Ms. Mackey because she provided me with basic love. I think we're both at fault here.
I It just felt,
Provided me with a mostly typed out plea form. All I did was look at it, sign it, and send it back to her.
because if it was up to me,
I fill these out myself. I
Correct.
appreciate it, Ms. Mackey doing my work for me. I'm not gonna, stop there.
Well, she half did it.
I did, yeah, and so we will.
I wasn't gonna put a max penalty for my client.
What?
It felt wrong to like do that part. So I was like,
That hurt. I just couldn't write that. I couldn't type that part. What is the maximum penalty on the one that, pardon?
1 year.
1 year, 2,000? It was a group effort. I like how they all sat there and tried to protect each other. All right. May I have him sworn?
Solemnly swear to affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name.
Devon Haywood.
All right. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of use of a controlled substance. That's a misdemeanor, punishable by up to 1 year incarceration and $2,000 fine plus court costs. Do you understand that, sir?
I do, Your Honor.
Do you understand what a no contest plea is?
Yes, I do, Your Honor.
All right. Two things about it I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
I do.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
I understand.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
I do.
All right. Basis for the no contest plea?
civil liability, Your Honor.
All right. And sir, to this charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
I do.
You signed an advice of rights form, is that correct, sir?
Yes, sir, Your Honor.
Do you have any question regarding any of those rights?
No, sir, Your Honor.
All right. Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
I am. I'm on probation for. Explain the case.
Well, were you on probation at the time of this offense?
No, Your Honor.
All right.
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Has anybody threatened you or coerced you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
All right. The court has been provided Washington County Sheriff's Office report, and I've also reviewed that report for their case number 24-42704. Any objection to the court having reviewed that report?
Okay.
None from us, Your Honor.
All right. Sir, you also understand that if between the time I accept your plea, if I accept your plea, and the time of sentencing, if you commit misconduct as defined by the court rule, two things would occur. You would not be entitled to set aside your plea, and the court would not be bound by any sentence agreement and or evaluation of your case. You understand that, sir?
I do.
All right. Based upon a review of that report, the court does find that there is a sufficient factual basis in which the court could determine the defendant's guilt. Before I accept this plea, is counsel aware of any other promises, threats, or other inducements which have caused this plea?
Not yet.
None, Your Honor.
All right. Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
August 14th, 2025 at 10 a.m. in Judge Washington.
August 14th, 2025. What time?
10 a.m.
10 a.m. before Judge Washington. Bond will continue.
Thank you, Your Honor.
Thank you.
Thank you. Thank you, sir. Court calls the case People versus Derek Stevens.
Jacob, can we ask the people, Your Honor? All right, floor open.
Michael, he just.
How you doing, sir?
My apologies, Your Honor. Michael Gaddy, Assistant Public Defender for Mr. Stevenson.
Your name, sir?
Derek Stevenson, how you doing, Your Honor?
I'm doing well. Thank you, sir.
Yes.
Your Honor, we have submitted a green sheet in this matter. We'd ask for a brief adjournment so that we can obtain video discovery.
Probable cause conference will be adjourned July 22nd, 2025, 9 a.m.
Thank you, Your Honor.
Bond will continue. Thank you.
Thank you.
Court calls case People versus Michael Frazier.
Assistant Public Defender Jay Bellinger on behalf of Mr. Frazier, who appears via Zoom. Mr. Frazier, can you please state your name for the record?
My name is Michael Valentino Frazier.
Thank you.
Your Honor, I am just asking for a 2-week adjournment on this matter. An offer was just made to me. I'd like time to discuss that with Mr. Frazier to see what he'd like to do.
Probable cause conference July 22nd, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
Thank you, sir.
Court does call the cases of the People versus Bryce Valero.
Rhoda Handon on behalf of Bryce Valero. Can you please state your name for the record?
Bryce Valero, Your Honor.
Your Honor, we're requesting a two-week adjournment on this matter for negotiation purposes.
Probable cause conference will be adjourned July 22nd, 2025, 9 a.m. Bond in each of these matters will continue.
Sorry, am I done, Mr. Simpson?
Oh, yes, sir. You're good, Mr. Frazier.
Okay.
Thank you
appreciate
for
it.
waiting and asking.
Yes, sir. Thank you.
Your Honor.
Thank you.
Thank you.
Court does call the case People versus Serrano Johnson.
Assistant Public Defender Chelsea Vergils with and on behalf of Cyrano Johnson. Mr. Johnson, please state your name.
Cyrano Johnson.
I mispronounce your name every time, sir. Okay. I apologize.
Thank you, Your Honor. Today is the time and date set for a probable cause conference. Regarding that, we are asking for an adjournment to show compliance with his bond conditions. I understand he's had a violation that we are prepared to deal with today.
All right.
Mr. Johnson is prepared to plead guilty to violating his bond by consuming alcohol on July 7th.
And I'll accept that. Before imposing any sentence regarding that, I'm going to ask this question. He presumably, he has indicated that he had O'Doul's. So my only question is, does your client wish to stick to that story, or does he wish to tell me the truth?
I believe that he would not be sticking to that story, that he would be stating that he consumed beer.
That is correct, Your Honor.
And why'd you tell everybody O'Doul?
I had O'Doul's first, but I needed beer.
You had O'Doul?
Yeah. I don't look like what I'm going through.
No.
I had O'Doul's.
Are you
I had
tell me that? So did you tell them that?
Yes.
That you had O'Doul's first and then had beer?
Maybe I omitted the beers, but yes.
What?
I omitted the beers.
Hold it. You know what, sir? Don't play fast and loose.
I got
the story.
I consume alcohol.
I know that. You lied to them. Did you even have an O'Doul's that day?
Yes.
How many?
6.
And then how many beers?
2.
So why didn't you tell them that you had the beer?
I just omitted.
Pardon?
I just didn't. I was afraid of what might happen. I thought I could pass.
Yeah, I would be too, because you're violating your bond condition.
Indeed.
So, first of all, we did the calculation because the only story you gave is that you had duels. To get to the level that you were at, you would have had to have 25 duels in an hour.
No, I didn't have
in
that.
order to reach that level.
Sure.
And could not have used the bathroom because you couldn't eliminate in order to get to that level. That's how stupid your story was. And now you can't bring yourself to say that you were intentionally lying to them and attempting to mislead them. It was not just a simple omission. Counsel, what did you want me to do with this case?
In regarding the probable cause conference, we're asking for a 2-week adjournment so that he can show that he's going to comply with the court's orders. I
Well,
understand.
I don't think he's going to have a choice on that, quite frankly, Mr.
Your Honor,
Allen.
we are asking for him to remain out of custody today. This would be his first bond violation. He is here to be honest with you, although the truth doesn't always make sense.
Really?
He is.
Really?
He's here.
No, he was not being honest. I asked him the question and then asked him the question of why didn't he tell them? And he couldn't even be honest about that. I'll let you go ahead with your argument, but I'm not buying any of that.
Your Honor, he is honest about the fact that he consumed alcohol, and he is very open to treatment. He understands that he has a substance issue and he wants to get help for that. Your Honor, he's a business owner. There's a lot of pressure on him. He provides for himself and his family. He also does volunteer work, not court ordered, just out of the goodness of his heart. He is open to treatment, substance abuse, counseling. He plans to seek that regardless of whether the court orders it or not. We're asking you to keep him out of custody with a scram tether. Again, this would be his first violation. And he is asking for the opportunity to show compliance while out of custody.
Anything from the people?
Your Honor, we do have some concern about Mr. Johnson's ability to comply with the bond conditions. As stated, this is his second offense. His scandal, I think it's just a couple of years. We would note that in this case, he allegedly was found not awake in a vehicle that was in the street with 2 guns on him. Although he's only charged with 1 CCW. So we do have some concerns about whether he's able to comply with those bond conditions.
Anything else?
Yeah, I just think that he would have a better opportunity to get the treatment and help that he needs out of custody.
He first has to admit that he has a problem.
I do.
The way that he does admit that is he stops lying. Defendant's bond at this time is revoked. Defendant's remanded. Court does call the case, People versus Fred Willis.
Your Honor, we're going to go to the people. And Alex Warren Green on behalf of Mr. Willis. Mr. Willis, can you state your name for the court, please?
Fred Willis. Thank you.
Your Honor, today's the date and time for probable cause conference in both of these matters. I have completed 2 adjournment request forms. We are requesting to adjourn both cases. We need to complete discovery in the discharge at a building case.
Got it.
Thank you.
July 22nd, 2025, 9 a.m.
Thank you, Your Honor.
Thank you. Bond continued. Now,
Mr. Carroll's case, I will file that to his date to the 17th.
Yes, sir.
All right.
Court does call the case of the People versus Stephen Johnston.
Laura Yagi, Assistant Public Defender. Hopefully with on behalf of Mr. Johnson, who indicated to me that he was on Zoom. Okay, Mr. Johnson, can you unmute and state your name for the court? Thank you. Your Honor, I am asking for an adjournment in this matter to continue conversations regarding the next step in the case.
Probable cause conference will be adjourned to July 22nd, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Your Honor. Thank you. Sir. Court calls. Ms. Weidling, if you could let Mr. Gilles know. All right.
And Assistant Public Defender Nicholas Bukovich on behalf of Mr. Jones, who should be appearing via Zoom. I did see him earlier.
I see him, but, well, I see the A.
Mr. Jones, you can please turn on your camera and microphone and state your name for the court.
Bukovich.
As my client is, I did see him on Zoom and it's been indicated by the court he is on Zoom. I would ask for a brief moment to pass this to see if I can help him get his technology working, because I did see his camera on earlier.
Okay.
Alvin Jones.
How are you gonna do that? Oh, is she calling? Can't things.
I will call him myself.
Okay, good enough. Just saying. Court calls the case People versus Anushka King.
Great introduction, Your Honor. Cannon on behalf of Ms. Anushka King, who is appearing to my right. And Your Honor, this is a plea agreement.
Yes, it is. Your name, ma'am?
Anushka King, Your Honor. Good morning.
The plea agreement that I have indicates that the defendant will be pleading guilty to the charge of operating with a high BAC second offense. That is a misdemeanor punishable by up to 1 year incarceration. There's further an agreement, and that's count 4. Then counts 1, 2, and 3 would be dismissed. The defendant is also agreeing to complete screening at the 16th District.
36.
Yes,
it's 30. It's 36. They made a mistake on paper.
No, I didn't. It's 16.
It says 16.
36 would take the transfer.
Oh, okay. Thank you. Okay.
Your Honor, she will complete one, yes.
Yes.
What?
She will be completing the one at the 16th District Sobriety Court.
So we're all in agreement to 16.
Yes, we are.
All right, 16th District Sobriety Court, including submission of all required documents, participation in all required interviews and assessment, contravention of acceptance or denial must be forwarded to the APA. That is the court's full understanding of the agreement. I am going to check box 5 on this form, which is the sentencing judge waiver. Did she read that over, counsel?
Correct. Yes. Yes.
Okay. May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Anushka King.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of operating with a high BAC second offense. That is a misdemeanor punishable by a $200 to $1,000 fine plus court costs, 5 days to 1 year in jail. Court could order community service and any rehabilitative programs the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that?
I do.
All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Washington in the 14B district. You understand that?
Yes.
All right. Now, understanding all of that, you still wish to plead guilty.
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights.
Understand?
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe that you are indeed guilty of this offense?
I do.
March 3rd, 2024, at the location of I-94 near Wired Road in Ypsilanti Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
I was.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
I did.
What did you have and how much?
A couple of shots. I don't remember in some coolers.
Pardon?
A couple of shots. I don't remember exactly how many. And I had 2 coolers.
Shots of what?
Tequila.
Were you stopped by the police or was there an accident?
I was stopped.
All right. Why'd they stop you?
I went around a semi truck. I get panicky around semi trucks. I sped up and I went around him to get ahead of him because it was construction in the area. And I was
Okay,
on my
so
way. Speed violation.
there was some type of erratic driving?
Speed violation. Yes.
Okay, you're not disputing the right of the police to stop you in this case?
I'm not.
All right. After they stopped you, were you ultimately arrested?
Yes, they took me to the hospital.
And there was a blood draw?
It was blood draw.
And what was your
Your Honor, if I may,
results?
the prosecutor and I have agreed to stipulate to the findings of the Lansing Forensic Laboratory forensic report, laboratory number TX 24-3306, whereby it was found that.
I just need a number.
Oh, sorry, Your Honor, 0.216 grams of alcohol per 100 milliliters of blood. Well, we were stipulating to the findings, Your Honor. My apologies.
No, it's okay. I was gonna let you go, but
Okay.
I ain't got all day. All right. Ma'am, do you have any reason to dispute those results?
I don't.
All right. Had you previously been convicted of operating while impaired on or about April 5th, 2022 in the 23rd District Court and or of operating while impaired on or about February 16, 2021 in the 43rd District Court?
Yeah.
Yes?
Yes.
All right. Counsel, are you aware of any other promises, threats, or inducements that have led to this plea?
None, Your Honor.
All right. And ma'am, I do have to advise you that if I do accept your plea and you commit misconduct as defined by the court rules, any evaluation of your case, the court would not be bound by that, any evaluation, and you would also not be entitled to set aside your plea. You understand that?
I do.
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
You have, Your Honor.
Court will accept the defendant's plea to count 4. Counts 1, 2, and 3 are dismissed. Pre-sentence investigation and report is ordered at 14A or 14B probation. Sentencing in this matter will be
August 14, 2025 at 10 a.m.
August 14, 2025, 10 a.m. before Judge Washington. Bond with its conditions will continue. Thank you.
Thank you.
Thank you, Your Honor.
You want me to fill out a sheet for that?
That was nice of you. You usually don't share. Court calls the case, People versus Romeo Smith.
Rachel McDuffie for the people.
Assistant Public Defender Jay Bellinger on behalf of Mr. Smith, who appears via Zoom from the jail, Your Honor.
Yes.
It looks like he's muted.
He is.
Mr. Smith, can you please state your name for the record?
Muhammad Martez Smith.
All right, thank you.
Your Honor, we are here for a competency review hearing today, and I suppose I can let this serve as information to the court and everyone around me. I reached out to a couple of contacts at the CFP, And they responded back to me with the following, and that due to limited bed resources and increased demand throughout our hospital system, there are extended delays in our admission process. As a result, we anticipate that Mr. Smith will be admitted for competency restoration treatment in approximately 1 to 2 more months. I contacted them about several other clients and they gave me the same exact response. So I wanted to let the court know that. It's very unfortunate, certainly, but that's what they gave me.
Okay. Let's. My last date in August is what?
August 19th.
I'm not here the 28th. Thank you. What I will do is I will adjourn the competency review hearing to August 28th, 2025, 9 a.m. If we get something before then, certainly we can move that date up, but that's going to be our best shot at this point.
Thank you, John.
Thank you. Case People versus Darien Rhodes.
All right. 14A, District Court for County of Washington, State of Michigan, now back in session, the Honorable Judge Jason.
You may be seated. Court does call the case People versus Don. Is it Godoyne?
Yes, it does for the people.
Morning, Your Honor. Alvin Fick. Good to see you again.
Good
It's
to
been a
see
while.
you, sir.
I'm standing in for attorney of record Murray Duncan. We have a substitution of attorneys in the file.
Yes, I do see that. All right. Very good, and I've signed off on it.
And we would like to adjourn the probable cause.
All right. Those folks over there will help you with the green sheet. I'll do it, but so they have that in the file.
I'm sorry, I didn't quite hear you.
How much time is he looking for?
Maybe 4 weeks.
4 weeks. Really? All right. Since I haven't seen you, I'll do that. August 7th.
Okay. And she's prepared to waive the 21 day.
All right. And she.
I'm sorry, what day?
Is that correct, ma'am?
Yes.
Yeah, okay.
You say August 7th?
August 7th.
Okay, yeah.
2025. I'll set it at 9 a.m., but you'll get your time block via email. All right?
All right.
Bond will continue. Thank you.
Thank you.
Court calls case People versus Brian Brown. Everybody's in. Oh, gotcha. All right.
Good afternoon, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Your Honor, good afternoon to your staff. May it please this honorable court. My name is Todd Russell Perkins, P55623, appearing on behalf of Mr. Brown.
Mr. Brown present?
Yes.
Yes, I'm Brown here. I'm here.
Oh, there you are. Okay, I got you. You guys are on opposite sides of the screen. Okay, what are we doing on this today?
Your Honor, I was in trial the last time, and I do want to thank your staff for accommodating us. I had asked my prior counsel or my associate at our firm just to set this for the exam. I haven't been able to requite any of the issues, and Mr. Brown remains in custody. But my position is that the amount should not be scored as to what it is, and that's the legal issue. I think we'll have to have an exam in order to vet that.
All right. Where is he located?
Bay County.
It's in Bay County. Well, if I have an exam on it, then it's in person. Okay, so you wish me to set this for an exam?
Yes, please.
All right. Timing wise, we're gonna have to go and get him, right?
That's correct.
he's likely to be remaining in custody. Is that correct, counsel?
In talking with his other attorney, she seemed optimistic about him getting a bond, but it hasn't happened. Hasn't happened yet. So I can't, right now I have to say that he's gonna be in bond, in custody and will need to be transported.
Well, I can do any Tuesday. So I don't know what schedules look like. If it's gonna be before me, my next one isn't until really August 19th. But
That is, the problem. I have a trial that starts on the 19th, Your Honor. And then I have one that starts on the 25th. So,
well,
we would be, I think
there are judges available any Tuesday, so you guys give me a
Okay.
Tuesday.
Okay.
I mean, I just have to have enough time for the transporting of the
Okay.
defendant.
All right.
Your Honor, my office typically, even if I cannot attend, we typically can have someone to participate in most of the hearings. So it depends on what the defense counsel needs. Sometime in August would be, or thereafter would be probably best. I am going out on a leave, so.
Well, the only date I really do have available, Your Honor, is the 2nd of September.
That's off my chart.
September 2nd.
Set this for preliminary examination in this matter in person, September 2nd, 2025, 9 a.m. That's before Judge Perry.
Okay.
All right.
Okay.
Thank you, Your Honor.
Thank you.
Thank you. Bond will continue. Court does call the case of the people versus Desmond Hodge.
Ally Zend on behalf of the people, Your Honor.
Good afternoon, Your Honor. James Fifelsky appearing on behalf of Mr. Hodge, who is approaching. Please state your name.
Desmond Hodge.
Your Honor, we'd ask the court to set this for preliminary examination,
All
please.
discoveries complete.
Yes, Your Honor.
People have their witnesses available on the 22nd.
We'll do our best, Your Honor.
Preliminary examination in this case will be set for July 22nd, 2025, 9 a.m. That is before Judge Barr. Bond will continue.
Thank you very much, Your Honor.
Thank you.
Thank you.
Calls the case people versus
Ally Zend on behalf of the people.
Good afternoon, Your Honor. Dan Garrett on behalf of Mr. Perez Ovalle. Your Honor, discovery is complete. I'm asking for an examination, please.
people have their witnesses available the 22nd.
We'll do our best, Your Honor.
All right. Preliminary examination in person will be July 22nd, 2025. 12 noon, that is before me. Bond will continue.
Thank you, Your Honor.
Case people versus Gregory Bell.
Introduction to the people.
On behalf of Mr. Bell. Mr. Bell.
Good afternoon, Your Honor. Gregory Bell, approaching the court.
Thank you, Judge. Today is the date and time set for probable cause conference. I have spoken with the prosecutor on this matter. We are continuing plea negotiations, so we are asking for a brief adjournment in this matter.
Probable cause conference will be July 22nd, 2025, 9 a.m. Bond continued.
Thank you, Judge.
Thank you, Your Honor. Thank you. Court calls case People versus Carlos South.
On behalf of Mr. Self, coaching the podium. Please introduce yourself to the court.
Carlos South. I can see your shirt.
Oh, you're okay. Thank you, Judge. Today's the date and time set for probable cause conference. I was just appointed on this matter very recently, so we are in ongoing plea negotiations, and I'm still waiting on a little bit of discovery. I know the prosecutor's office is working on it, so asking for an adjournment.
And so that'll give you time not only to do that, but that I would expect him to wear all of his pants the next time.
We'll discuss.
July 22nd, 2025, 9 a.m.
All right, thank you, Judge.
Court calls the case People versus Tyrone Smith.
Alexander on behalf of the people, Your Honor.
Yes, Your Honor, Brandon Bird on behalf of Tyrone Smith. Mr. Smith, can you please take your full name?
Tyrone Smith the fourth.
Thank you. You're looking for an adjournment, counsel.
Yes, Your Honor.
July 22nd, 2025, 9 a.m.
Thank you, Your Honor.
Bond continued. Thank you.
Thank you.
Court calls the case of the People versus, is it Chancel Bragg Page?
Thank you, Richmond Deputy People. Mr. Greenwood. So is the
Yes, Judge.
Okay.
I'm turning on my camera too.
Yep.
But anyway, Your Honor, Emmett Greenwood on behalf of the defendant, P56556. There you go.
Oh, there you are. Okay. All right. And sir, could you state your name, please?
Chancel Bray Page.
Thank you. All right, what are we doing?
Your Honor, we're asking that this matter be set for in-person exam.
Discovery is complete.
I sent a request. I'm sure if you're setting your dates by the 22nd, I'm sure the people they're usually prompt on it.
Well, has discovery been sent? Because we're not going to adjourn if.
I believe everything should have been sent, but I think it would be best, Mr. Greenwood, if you can confirm that.
No, it hasn't been sent. I emailed Sarah my request. Sarah with my.
So you don't have discovery.
Basically not, Your Honor.
Probable cause conference. Has the request, can you see counsel has sent the request into you guys?
I'm looking in the file at this point. I don't see the appearance in our file, which may be the issue.
All right, counsel, you got to send in the appearance, and there's a certain email that you send it to. If you can put that in the chat, and then we can get that all taken care of. I'll adjourn the probable cause conference to the 22nd, 2025, 9 a.m. And then we'll see if we can have everything straight and then set the exam. Thank you.
Thank you so much. And okay. Ms.
Court
Williams
call.
already sent it to me. Thank you, Judge.
Thank you. Court calls the case. People versus, is it Tyrell Alex Casera?
Oh, maybe Richmond Deputy for the people.
And Assistant Public Defender, Chinaza Carey, I can relay your honor on behalf of Mr. Gassara. Tyrell, state your name for the record, please.
Yes, ma'am. Terrell Vox Jacera.
All right, I have before me a plea form. Is that what we're doing?
That is, Your Honor.
It's indicating that the defendant will plead guilty to the charge of attempted check no account. The 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. The defendant is also agreeing to pay full restitution to Huntington Bank, J. Keller Properties, and any other parties involved. That's the court's full understanding at this time. Is there an amount that has been determined?
The reason it's phrased that way is because I believe that the bulk of the payment was returned, but there might be fees that people encounter with the check, basically being an invalid check. So I put that on there just in case anybody had any remaining fees outside of the main amount. As far as we know, it looks like let me rephrase that. The amount on the invalid check was apparently returned to the individual whose check was stolen, but that was returned to them by the bank. So the bank may need the restitution for it. So that's why it's phrased that way.
So I guess for the record, we would just, we don't have the amount. We just know that there was a check in the amount of $1,900. I guess I would just need to make sure that there aren't other checks that you're speaking of.
Well, it's just that one check, but it could be other people's, fees for return check or not sufficient or whatever. So that's why if there is any remaining, it should be repaid. If there isn't, we're good. So I'll look that out.
Okay.
So I guess, Your Honor, I think we can reserve that issue for restitution, a restitution hearing if need be, but I guess I'm not 100%. Can we recall this matter, Judge? I apologize. I think I want to see if we can rephrase the way that that condition is written in the plea form. Sorry, Judge.
Yes, sir. Court calls the case, People versus Alexander Cronin.
And good afternoon, Lord Yagi, Assistant Public Defender with and on behalf of Mr. Cronin. Mr. Cronin, could you state your name for the court?
Good afternoon, Your Honor. How are you today, sir? This is Alexander Cronin.
All right, very well. Thank you for asking.
Your Honor, the people and I have been in discussions back and forth. I do think need a little bit more time to come to a resolution, so I am asking for an adjournment.
Probable cause conference, July 22nd, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls the case of the People versus Eric Coons.
Assistant Public Defender Chelsea Virgils on behalf of Eric Coons.
Eric Coons? We don't have him.
Your Honor, I haven't had any contact with Mr. Coons.
Is Mr. Coons in custody?
I don't know.
Not that I'm aware of. I did plan to ask for an adjournment. I would still ask you to consider that.
Okay. I considered it. No. Bench warrant will issue for defendant's failure to appear. Bond 10,000. As surety. That warrant will issue immediately. Can we just double check and make sure he's not in custody? Thank you. Court does call the case of the People versus Seth Latham.
And Mackie on behalf of Mr. Latham. I tried to get in contact with Mr.
That's
Latham.
Bellinger. Okay. Did you? No, Miss Mackey was like staring at the door thinking.
I was just having hope.
Oh, that was a hopeful look. Okay. All right.
We were going to request an adjournment in this matter. So if we could please still go ahead with that.
You mean your request or my denial?
The request.
And my denial. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000 cash surety.
Thank you.
You're welcome. That warrant will issue immediately. Court calls case People versus Shelby Lawson.
Good afternoon, Your Honor. Raymond Cook for the People. And Assistant Public Defender Nicholas Bukovich on behalf of Ms. Lawson, who is approaching the podium now.
Hello.
Hi,
What's your name?
Shelby Lawson.
All right. What are we doing?
At this time, Your Honor, would be requesting to set this matter for preliminary examination. To my knowledge, all discovery is complete.
People have their witnesses available the 22nd.
We should, Your Honor.
Preliminary examination in person, July 22nd, 2025, 9 a.m. That is before Judge Barr. Bond will continue.
Thank you.
Court calls the case of the people versus Austin. Is it Lowestone?
Assistant Public Defender Chelsea Vergils with and on behalf of Austin Lobosall, who should be appearing via Zoom.
Lobestall?
Yes, Your Honor.
All right, I need a camera also, please, sir. Oh, there he is. Go ahead.
Your Honor, I'm asking for a 3-week adjournment to continue a plea discussion that would require him to pay restitution. So the 3 weeks is so he can be ready to pay that.
The action probable cause will be adjourned to July 31st, 2025, 9 a.m. Bond continues.
Thank you.
Thank you. Court calls the case of the people versus Catherine Mercoy or Mercox?
Marku, Your Honor.
Mercu.
It's
It's very French. I don't speak French.
Roba Hamden, with and on behalf of Catherine Marcoux. Please state your name for the record.
Catherine Camilla Marcoux.
Your Honor, we are sending mitigation information to the prosecution for an offer consideration on an offer. We expect to have a resolution in 3 weeks' time. So we would be requesting an adjournment.
Probable cause conference without objection, July 31st, 2025, 9 a.m. Bond will continue. Thank you.
Thank you, Your Honor.
Court does call the case of the people versus Jody Merritt.
Laura Yagi, Assistant Public Defender with and on behalf of Ms. Merritt. Ms. Merritt, could you state your name for the court? Jody Merritt.
Thank you.
Your Honor, regarding the probable cause conference, we do need a little bit more time to get the paperwork together for the 14B recovery court. We have been in contact with them about the referral.
Probable cause conference, July 31st, 2025, 9 a.m. Bond continue.
Thank you, Your Honor. And I will be filing a written motion regarding the screen tether, but I don't have that for today. But thank you. All right.
They just attach. Okay. Court does call the cases of People State of Michigan versus Stephanie Melissa Minton.
Thank you for the people.
And Alex Warren, agreeing on behalf of Ms. Minton. Ms. Minton, can you state your name for the court, please?
Stephanie Minton.
Your Honor, today's date and time for probable cause conference in both of these cases, we are asking for an adjournment in both matters. Have completed the green sheet towards consideration. We need to continue our investigation.
Probable cause conference will be adjourned July 31st, 2025, 9 a.m. Bond continue. Sorry, your note.
Thank you, Your Honor.
Thank you. Court does call the case People versus John Michael Noack.
Good afternoon, Your Honor.
Assistant Public Defender Chelsea Vergils with and on behalf of John Michael Noack. Mr. Noack, please state your name.
John Noack. Take the hands out of your pockets. Thank you. All right.
Your Honor, we're asking for a 1-week adjournment And I believe we have a resolution in this case. We just didn't get the plea form settled in time, so we're just asking for a very quick adjournment. Next time we should be able to resolve.
July 22nd, 2025, 9 a.m. Bond continued.
Thank you.
Court calls the case People versus Brent Pearson.
Good afternoon, Your Honor. Raymond Cook for the people.
On behalf of Mr. Person.
Pearson. Sorry, I say Pearson.
Can you state your name for the record, please?
Mr. Person?
You have to unmute first. There you go. I think you have to speak up a little bit.
Your Honor, did you hear him or would you like to him to read it?
Repeat your name, please.
For the record, my name is.
One more time. Do you have headphones in? No.
No, no headphones.
One more time, please. What is happening? Got it?
I got it.
Thank you.
Okay.
This is all just for an adjournment. Your Honor, there is outstanding discovery that we need to review, so we're not going to ask for an adjournment for that.
Pardon?
There is outstanding discovery. We're going to be asking for an adjournment for that purpose.
Yeah, part of the outstanding discovery is trying to discover if your client's taking any drugs. He hasn't reported over to community correction.
Okay.
Is there a reason for that?
Well, he is in Battle Creek, correct? I did not realize, Your Honor, if I had, I would have asked him why beforehand. My guess is that it's because he is in Battle Creek. I will talk to him after court to find a way that he can report and test as needed in Battle Creek, or if needed to drive here and do that here.
He's got to report initially to do the intake.
Okay. Understood, Your Honor.
I'll put that defendant must report to community corrections and get that straightened out. I will adjourn the probable cause conference to July 22nd, 2025, 9 a.m.
Thank you, Your Honor.
Bond continued.
I'll talk to you, Mr. Person.
Okay. Are you going to be calling me or?
Yeah, I'll call you.
Court calls
Thank
case
you.
People versus Tyler Pittman.
Richard is appearing on behalf of the people.
Sure.
Herman Dadush on behalf of Mr. Pittman. Can you state your name for the record?
Thank you. He's waiving his right to preliminary examination.
Yes, Your Honor.
Sir, is that correct?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed.
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on all three counts.
Thank you, Your Honor. We waive formal reading and stand me to the charges.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
September 3rd, 2025 at 1:30 with Judge Conkey.
September 3rd, 2025, 1:30, Judge Conkey.
Thank you, Your Honor.
Thank you. Bond will continue. It's September 2nd.
September 2nd?
Yes.
Oh.
Does call the case People versus is it Ever Ramirez Martinez.
Herman Dadush on behalf of Mr. Ramirez Martinez. Mr. Ramirez Martinez, can you state your name for the record, please?
Ever Ramirez Martinez.
All right, Your Honor, we're just asking for a brief adjournment so we can go over the plea offer with the client.
July 31st, 2025, 9 a.m. Bond continue.
Thank you.
Thank you, Your Honor. Have a great rest of your day.
Thank you, sir. You too. Court does call the case People versus Alexis Russian.
Assistant Public Defender Nicholas Bukovich on behalf of Alexa Rushing. Ms. Rushing is paying via Zoom. Can you please unmute and state your name for the record?
Alexa Russian.
At this time, Your Honor, I'll be requesting a brief adjournment. We are working towards a resolution in this matter. However, Ms. Rushing needs to confirm with academic advisor what type of plea would not inhibit her from her future educational activities.
Got it.
I do know she has that meeting with the advisor on the 22nd, so if we could possibly get the 31st date, that may be beneficial so she can have time to meet with her advisor.
July 31st, 2025, 9 a.m. Bond continue.
Thank
you, Your Honor.
Court calls case People versus DeAndre Searcy.
And Assistant Public Defender Nick Bukovich on behalf of Mr. Searcy, who's now approaching. Mr. Searcy, can you please state your name for the record?
Yeah, how you doing, y'all?
I'm doing well, thank you.
At this time, Your Honor, we're requesting an adjournment for a little bit more time for some negotiations between the people and myself.
July 22nd, 2025, 9 a.m. Bond continue. Thank you. Thank you, Mr. Searcy. Court calls case People versus Leilani Smith. I know. So this is how it works, Ms. Smith. I'm gonna stare at that side until somebody moves.
That is, yep, Stephanie Cannon. I'm
We
so
knew
sorry.
it would be her, so.
On behalf.
So it's okay. It's okay. She just decided she didn't want to get up.
Nope, I love being here, Your Honor.
And we love having you here just as much. All right.
So, we're just asking for a 2-week adjournment to try and mitigate this a little bit.
Probable cause conference, July 31st, 2025,
Thank you, Your Honor.
9 a.m. Bond will continue.
So sorry, I'm sorry.
Why are you apologizing to them?
I was distracting her.
You didn't, who was distracting? Oh, somehow I knew you'd be involved. Court calls the case, People versus Kirby Snyder.
Michael Gaddy, Assistant Public Defender, appearing on behalf of Mr. Snyder, who's approaching judge. State your name.
Kelly Soda.
Here.
Your Honor, may we approach briefly?
Yes. Miss Robin, I don't. Record should reflect we've had a bench conference in this case. I will adjourn the probable cause conference to July 31st, 2025, 9 a.m. Bond will continue. All right.
Thank you, Your Honor.
Court calls case People versus DeAndre Weems.
Alex Warren Green on behalf of Mr. Weems. Mr. Weems, can you state your name for the court?
DeAndre Weems.
Your Honor, this time we're asking the court to set the matter for preliminary examination. I think he's saving his pants for the exam.
Is that what's happening?
I think so.
Okay. Discovery is complete.
I believe so, Your Honor.
People have their witnesses available the 22nd. Preliminary examination in person, July 22nd, 2025, 12 noon. That's before me. That way I'll be able to see these pants when they arrive.
Your Honor.
Thank you. Court calls the case, People versus Jelani Wright.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Wright, Your Honor. I believe he is on Zoom.
You believe he is? Jelani Wright? Is that him?
Sorry, I couldn't hear the court.
Okay, what's your name?
Jelani Wright.
Okay. Okay, what are we doing?
Your Honor, I'd ask the court to indulge us in one more adjournment. I need to go over his options with Mr. Wright and as to how he wishes to proceed in this matter. I have prepared a green sheet. The people have extended an offer to not object to HIDA with a waiver, and I need to go over that with him.
July 22nd, 2025, 9 a.m. Bond continue.
Thank you, Judge.
Thank you.
Thank you, Judge.
Thank you, sir. Court does call the case People versus Brian Butsick.
Ready, Your Honor.
Ally Zend on behalf of, Your Honor.
And good afternoon, Your Honor. Miles Drew on behalf of Mr. Ryan Busick, who is approaching to my right. Mr. Busick, once you get to the podium, can you please state your name for the record? Ryan Busick. And Your Honor, today is the date and time set for a probable cause conference in this matter. The defense would be requesting an additional adjournment to get some outstanding discovery. The prosecution has been working diligently to get us this discovery, but there's just still some work to be done.
You fill out a green sheet or no?
I did not, Your Honor.
Okay.
Happy to fill out whatever form you need, Judge.
I know you will, but okay, we'll just need it filled out. July 31st, 2025, 9 a.m. Bond will continue.
Your Honor, I would ask if we could do a different day other than the 31st. I am scheduled to be in New York that day.
Are you want more time or less? I mean,
More probably would be better, I'm thinking, Judge. I know the afternoon of the 7th is open for me. I do have an evidentiary hearing that morning if you're looking at Thursdays.
August 7th.
Thank you very much, Judge.
2025. I set it at 9 a.m., but you'll get your time block sent to you.
Of
All right?
course.
Thank you.
Thank you very much, Judge. Hope you and your staff have a great afternoon.
Thank you, Your Honor. Court does call the cases of the People versus Jamie Foxx.
Good afternoon. Mike Gaddy, Assistant Public Defender for Ms. Fox, who's here at the podium. She beat me, Your Honor. State your name, Ms. Fox.
Jamie Fox.
Thank you.
Hey.
Your Honor, and I am standing in for Mr. Friedman with Ms. Fox's permission.
Is that true?
Yes.
All right, go ahead.
Your Honor, I have had a chance to speak with Mr. Cook about this matter. There is some medical records that are outstanding. I also spoke with Ms. Landy. I believe that they are in the process of being prepared, and any items that the people believe are extraneous are being redacted. We're just waiting for that process.
And Your Honor, my understanding is that those documents were redacted. Those APAs, Emin and Landy, who are handling those, need to have them there in trial this week. That's why I couldn't get out this week. I do apologize.
All right, so the medical, you have the medical, it's been redacted, it's just a matter of getting it over to.
Yes, that's my understanding.
Is it, do you know if it's well, never mind. Here's what we'll do. July 31st, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Case people recall Volks Gisara. Were you ready on that yet or no? Pardon?
Yes, we are here.
Anna Mack,
If you're Richard.
Anna Mack on behalf of Mr. Volks-Sara.
All right. We agreed to. Okay, so what are we doing?
We changed the language in the plea form. And we have an agreement on that language. Me and the prosecutor.
Okay, so do I have the plea form? Is this a new one?
Your Honor, I thought that, Ms. Mackey was getting ready to read from the screen. She said it in front of us, so I can,
Well, okay, so.
we're essentially asking for the draw a line for some of the words that are already on the existing.
I can read it. I just wasn't sure if he wanted a new one completely or if he wanted us to just read it.
If you would prefer that we either retrieve that plea form and do that editing ourselves and return it to the court, or do a new plea form, we're happy to.
Let me think. Do I want you to do your work or do I want you to do your work? Hang on, I'm pondering that idea. Mr. Garen, do you have a suggestion as to what I should do? Yeah, all right. I'd have a suggestion for me. Are you shopping?
No, I'm sending you
Oh.
the plea form. Do you want anything?
What? Well, it is Amazon Prime Day, but okay, look, folks.
I think council is retrieving our existing plea form, so is that what you?
Yeah, I'm editing the old one with the new wording and sending it to you. Are we able to proceed with the plea in the meantime? No? Okay.
Oh, that was a question?
No.
Okay.
Thinking out loud.
Your Honor, I have a suggestion. If,
Oh, Lord.
this man, I think you're putting yourself in, you already had this like happen once.
Hold on a second. So at some point, you're going to redo this language. Has that language been explained, the redo of the language to your client?
We texted him.
Pardon? And he,
I am happy to take the form, make the changes, send it out to everyone.
this just should not be this hard. Here's what I'm gonna do.
Oh, here we are. I got it.
I am going to leave this here and call it up first case next block, give you guys time to do what you need to do. And then I'll be more than happy to hear this gentleman's case. But I gotta have everybody ready. I gotta make sure he understands what it is. And so we're gonna have to do it that way.
Thank you.
All right? You are so very welcome. And that way I don't have to take up time I don't get back. All right? Thank you. What's Simon doing?
Brightening your day.
Not so much. All right. Court's in recess. All right.
Talk to my wife. Apparently, you can imagine. So.
Fourteen District Court for County of Washington, State of Michigan is now back in session. The honorable.
You may be seated. Court does call the case of the People versus Anthony Hamilton.
You want him here? Yeah, he's supposed to be on this side. Go ahead, state your appearance.
Robert Egersinski for the prosecution.
And good afternoon, Judge, to you and your staff. Robert Burton Harris on behalf of Mr. Anthony Hamilton, who's standing to my right.
Your name, sir?
Anthony Hamilton.
All right. In this matter, there was a brief in-chambers conference, and there's been a request to adjourn this matter out, which I will grant. I will adjourn the probable cause conference to July 31st, 2025. I set it at 9 a.m., but you'll get your time block via email. All right. Thank you. Bond will continue.
Good to see you.
Good to see you. Court does call the case of the People versus Tiffany Pryor.
Andrew Trill is appearing on behalf of people, Your Honor.
Yes, Your Honor. Please, this honorable court, Brandon Bird on behalf of Tiffany Pryor. Ms. Pryor, can you please state your full name for the record?
Thank you.
I'd like to set this matter for exam, Your Honor.
Discovery is complete.
It is, Your Honor.
People have their witnesses available the 22nd. No. Because I'm just that way today. What do you mean you know? I think I've been exceedingly patient today.
Fine, 20 seconds.
It stops now. Fine. Okay, what says it, 29? All right, fine. Preliminary, any objection from the defense?
No objection, Your Honor.
Preliminary examination, July 29th, 2025, 9 a.m. before Judge Barr. Bond will continue.
Thank you, Your Honor.
Thank you. Oh, look there. Dewey and Louie. Court calls the case. People versus Andre Williams.
Good afternoon, Your Honor. Raymond Cook for the people.
Good afternoon again, Your Honor. Brandon Bird on behalf of Andre Williams. Mr. Williams, can you please state your full name for the record?
Andre Williams.
Thank you. And you're requesting an adjournment?
Yes, Your Honor.
Probable cause conference will be adjourned July 31st, 2025. Bond continued.
Thank you, Your Honor.
Yeah.
Your Honor, court, have a great day.
You do the same.
Thank you.
Court calls case People versus David Leland.
People, Your Honor. Good afternoon, Your Honor. Dan Garrett on behalf of Mr. Leland. David D. Leland.
Oh.
Your Honor, I'm asking for an adjourned probable cause conference.
Probable cause conference will be adjourned July 31st, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you, sir. Court calls case People versus Adam Bari.
Ready, Your Honor. And Your Honor, Joe Simon on behalf of Mr. Barry. State your name, man.
Adam Barry.
All right.
Your Honor, we need to make one little amendment to that. Since it's an HYTA plea, it should be, the box should have been checked guilty, not nolo, and that's something I should have caught.
It's a guilty plea. Gotcha, because I didn't have a police report, so. So I have a plea form that indicates that the defendant will be pleading guilty to 2 charges, added counts 3 and 4. Added count 3 of breaking and entering without owner's permission, the 90-day offense, and also count 4, use of a controlled substance, the 1-year offense. On a successful plea to those charges, counts 1 and 2 would be dismissed, and that there's a sentence agreement of treatment of defendant's pleas under the Home Truthful Training Act. Although I can't find the court, I do see the agreement. All right. That's the court's full understanding.
Yes, sir.
And that's accurate, Your Honor, yes.
May I have him sworn?
Raise your right hand. You solemnly swear to affirm the testimony about the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name.
Adam Bari.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to 2 misdemeanor charges. Is that your understanding?
Yes, Your Honor.
All right. So first of all, this court's understanding that you're going to be pleading guilty to the charge of breaking and entering without or entry without owner's permission. That's a misdemeanor punishment. 90 days in jail, $500 fine plus court cost. Do you understand that, sir?
Yes, Your Honor.
Also, it's this court's understanding you'll be pleading guilty to an added count 4 of use of a controlled substance. That is a misdemeanor punishable by up to 1 year in jail, $1,000 fine plus court cost. Do you understand that?
Yes, Your Honor.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A3 District Court. Do you understand that?
Yes, Your Honor.
All right. And understanding all of that, do you still wish to plead guilty?
Yes, Your Honor.
To the charge of breaking and entering or entry without owner's permission, how do you plead?
Guilty.
To the charge of use of a controlled substance, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
All right. You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are a part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will,
Yes, Your Honor.
and also because you believe that you're guilty of these offenses?
Yes, Your Honor.
January 31st, 2025, at the location of 404 Lincoln Court in the city of Chelsea, Washtenaw County, state of Michigan, did you have cocaine in your possession?
Yes, Your Honor.
All right. Had you used it?
Yes, Your Honor.
Did you know what you were using was cocaine?
Yes, Your Honor.
All right. And on that same date and at that same location, had you entered that dwelling or that building?
Yes, Your Honor.
Did you have ownership interest in that building?
No, Your Honor.
All right. Did you have the permission of the owner to enter that building?
No, Your Honor.
You did. All right. Sir, if I accept your plea, I do have to advise you that any evaluation or sentence agreement in this case, if you commit misconduct as defined by the Michigan court rules, that the court is not bound by any of that evaluation or that sentence agreement. You understand that?
Yes, Your Honor.
And you understand also that if you commit that misconduct, that you could not also at that point waive your or withdraw your plea. You
Yes, Your Honor.
understand that, sir? All right. Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
All right. And has the court complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
All right. Court will accept the defendant's pleas of guilty to counts 3 and 4. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A3. Probation sentencing in this matter will be
September 22nd, 2025 at 9 a.m.
September 22nd, 2025, 9 a.m. before Judge Freshour.
Yes.
Bond will continue.
Your Honor, regarding bond, one request. My client's been testing at community corrections weekly since his arraignment in early June without incident. This disposition enabled him
to keep a job offer in northern Michigan. He's starting his career Monday. And he's going to be relocated.
In northern Michigan?
Yeah, Traverse City area. And community corrections said that
it's cold there. Go ahead. I'm sorry.
that if his testing requirement is to continue, he will not be able to get here, so that he would have to have authorization from this court to find someplace local.
So you're asking that he's able to test in, when is he heading up?
I'm heading up to Sunday.
Sunday? All right. Any objection from the people?
It's not an objection.
Defendant may test in northern Michigan. I'd suggest that you arrange that with community corrections to find a suitable facility in the area. All right?
Thank you, Your Honor.
Thank you.
Wait with your. Okay.
Appreciate it.
Thank you.
What's up? This is Norwin Rouse.
Ready?
Alexander, on behalf of the people, Your Honor.
And Your Honor, Joe Simon, on behalf of Mr. Rouse. No one state your name.
Norwin Rouse. Right. Question and adjournment. Gotcha. Or how much time will that?
Your Honor, we have 2 or 3 weeks.
Your Honor, if the court is going to set the 31st, I can be here, but in the morning only, and I know that you don't like to do that. Otherwise, I'd request a different date. If you can do them in the.
Did I say I didn't like to do them?
Well, if you.
Or is he making a presumption?
I made a presumption.
It's Ann that doesn't like to do
In
We
the,
can do the 22nd.
will that work for you?
I'll make that happen. Is that enough time, Al? You think?
Yeah.
Great, great.
Probable cause conference will be adjourned July 22nd, 2025, 9 a.m. That will, so that you know on that date, Mr. Simon, that will be in the morning.
In the morning.
Because at some point, bond will continue.
That's a 2. Okay. I'll write you a note. You don't need to, only if you want to.
Court does call the case of the people versus Hannah Smith Sealy.
And Your Honor, Joe Simon, on behalf of Ms. Seeley, state your name, Hannah.
Hannah Smith Sealy.
Thank you.
My client, Your Honor, we adjourned to see if she'd be screened and accepted in the 15th District Court Sobriety Court. That happened. She's screened. She is accepted. The parties are not quite finalized with the exact plea that she's going to be rendering. We're asking for a brief adjournment.
All right. Will the 22nd be enough time for you guys to figure that out, or you want something after?
That's just a tough day for me personally. So,
yeah, just wait for my day.
Pardon?
You will have no sympathy for that.
I know.
The second is going to be painful for me. I'm usually very sympathetic to you, Mr. Simon.
I appreciate that very much, Your Honor. More than you know. If we could do the morning of the 31st or the very next available, either way.
Sorry, could you ask me that again? August 7th?
Yeah, that's probably smartest.
Thank you for stepping in there, Anna, because this was going to start spiraling downhill. August 7th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Thank you.
You do that for me, but if she wants to write it all up. Okay. Yep.
Court does call the case. People versus Charles Tingley.
Joe Simon on behalf of Mr. Tingley. He should be online, but I don't.
I do have his camera's not on.
Where he resides, his Wi-Fi is really bad.
Mr. Tingley?
Charles Tingley.
Okay.
I am
there he
Charles
is.
Tingley.
All right, what are we doing?
This time, Your Honor, people are requesting an adjournment.
All right.
I believe likely set this for the 22nd. So, just so you know, Mr. Simon will be here.
Will that be enough time to get, he said the 22nd is a bad date, not that we're accommodating Mr. Simon. But I can do that date or the 7th or the 31st, whichever suits the parties. You want to just do the 7th?
It would be best for me. Thank you, Your Honor.
Probable cause conference, August 7th, 2025, 9 a.m.
Thank you, Aaron.
Thank you, Your Honor.
Bond will continue. Thank you. Thank you, Mr. Kingley.
Thank you, Your Honor.
It does call the case of the people versus Adrian Braswell.
Thank you, Aaron.
Is that it for you, Mr. Simon?
I had one more, Your Honor.
Did you?
Maybe, nope, I'm sorry, Your Honor. I did transport Mr. Easto. Maybe that counts in my count. The one that, I'm just kidding. No, I was kidding. No, the other one was dismissed. So thank you. Thank you. Thank you.
Could you pull the car around?
Wow.
Good afternoon, Your Honor. Chris Eastup appearing on behalf of with Adrian Braswell. Mr. Braswell, would you unmute and state your name for the record?
Adrian Braswell.
You got him? You got him? Okay. All right.
Your Honor, Mr. Duffy and I are still working on the case. We need some discovery and time. I know based on my schedule, if
Told you.
I just got to come
You
out of
know,
the
I
block.
try to be nice to one person and somebody else steps in.
I know. I feel bad about this.
Yeah, I'm sure you do. I can tell.
We are hoping, I have two cases up today, Your Honor. We're hoping to put them both on August 7th if possible.
Any objection from the people that Mr. Eastup has picked his date?
I object because I specifically say we're seeking a longer adjournment. I say numbers.
Wow. And you just said.
I was just looking for court efficiency. That's
Probable cause conference, August 7th, 2025, 9 a.m. Bond will continue.
All right, Mr. Braswell, I'll be in touch. Thank you, Your Honor.
Thanks. That was a good look on Eastup's face as he just looked at my kid saying, he's right. He told me not to. Court then calls the case of the people versus Jamie Villalobos.
Panate.
Kelly's on behalf of the people, Your Honor.
Chris Eastup on behalf of Mr. Villalobos Panate, Your Honor.
All right. And you're requesting an adjournment. Any objection to?
No, Your Honor.
She's so nice.
They are. It's unbelievable.
You said they are? No, I just was talking about Allie.
Oh, sorry. Just Allie.
The rest have issues. All right, August 7th, 2025, 9 a.m. Bond continue.
Thank you very much. And Mr. Villalobos is
present.
He's present.
All
Thank
right.
you.
Thank you. See, did that quickly so that Mr. Simon, I have the car all right.
He's got the air conditioning.
He's right. Court calls the case. People versus Dennis Garvin.
Thank you, Richard. That's good people.
Tom Pietrowski on behalf of Mr. Garvin, who's standing to my right, and I have no special requests of the court today. Dennis
Whoever
Garvin.
they're hiding in the corner. What was that?
Dennis Garvin, Your Honor.
All right, he's waiving.
Yes, sir.
All right. So you're waiving your right to have a preliminary examination?
Yes, Your Honor.
All right. You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on count 1 with 2 following. Mr. Pietrowski.
As to bond?
Pardon?
I'm sorry.
You waive formal reading.
Oh, yes, sir. I'm sorry. Yes.
You waive formal reading. Client stands mute at this time.
Yes, sir.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
September 3rd, 2025 at 1:30 with Judge Thomas.
September 3rd, 2025, 1:30, Judge Kaplan.
Thank you very much, Your Honor.
Thank you. Bond will continue with its.
Thank you, Your Honor. Have a great day.
You do the same, sir. Court does call the case. People versus Alondre Smith.
Good afternoon, Your Honor. Sam Bernstein with on behalf of Mr. Smith. Mr. Smith, could you please state your name?
Laundry Smith.
Thank you.
Your Honor, we're asking the court to please set this for exam. Discovery is complete. I know there's been a lot of requests. I note that I haven't made a special request in like half a year at this point. Hoping for the 29th, Your Honor, please. I can adjourn something else.
That's not true.
Okay.
That's just not true.
It feels
We
like
keep track of every request you make.
I believe it.
We do. Had one in April. There's no objection to that from the people.
No, Your Honor.
Preliminary examination, July 29th, 2025. 9 a.m. That is before Judge Washington.
Thank you, Your Honor. Have a great day to you and your wonderful staff.
Thank you, sir.
Thank you.
Court calls the case of the people versus Vernon Fry.
Good afternoon, Your Honor. Good afternoon, your staff. Robert Gross, PA 2012, appearing on behalf of the defendant. We are consenting to appear via Zoom.
Sir Fry, can you state your name, please, sir?
Vernon Fry.
Thank you. All right. What are we doing today?
Your Honor, I had an opportunity to speak with the APA this morning. I believe we're asking to set this for an exam.
And you have all the discovery?
I do.
You need, sir. All right. People have their witnesses available the 22nd?
We'll do our best, Your Honor.
Preliminary examination in person will be set on July 22nd, 2025, 9 a.m. before Judge Barr. Bond will continue.
Thank you, Your Honor.
Thank you. That is an in-person proceeding. Court does call the case. People versus Cameron Hallam.
Good afternoon, Your Honor. Uwe Dawes with and on behalf of Mr. Hanlon. Cameron, state your name for the court, please.
Cameron Hanlon.
Judge, out of discussions with Ms. Douglas, we are setting course to mental health court in Ann Arbor, starting with a referral. We did submit the form along with an adjournment request for the PC.
All right. And I have signed off on that form. Do we know how fast they're doing?
I tried to find out in advance. I did not get a response from 15th. I was looking to come back here on the 31st of July. If that's not enough time, we'll deal with it then.
Figure it then. Okay. Probable cause conference, July 31st, 2025, 9 a.m. Richard. Bond continued. Thank you.
Very good. Thank you.
Court does call the case. People versus James Belleville.
Good afternoon, Your Honor. Edward Lucas on behalf of James Belleville, but not with.
Got it. Okay.
I'm asking for an adjournment today.
And there's got it. And we have the documentation that backs up your request. How much time do you want?
I asked for 4 weeks. I think that's what we adjourned it last time. I'm in contact with this family.
No objection from the people. Probable cause conference, August 7th, 2025, 9 a.m. Bond continued.
Okay.
Court calls case. People versus Clifford Gordon.
Edward Lucas for Clifford Gordon, who is approaching.
Your name, sir?
Clifford Gordon.
All right. I have before me a plea form. Is that what we're doing today?
Yes, Your Honor.
All right, plea form indicates that the defendant will be pleading guilty to the charge of disturbing the peace, the 90-day offense. Upon his successful plea to that charge, count one will be dismissed. That is the court's full understanding of the agreement. So, all right. Mr. Jerk, is that correct?
That's correct, Your Honor.
Very good. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
Sure, yes.
State your name.
Clifford Gordon?
All right. Mr. Gordon, it's this court's understanding that you're going to be pleading guilty to the charge of disturbing the peace. That is a misdemeanor punishable by up to 90 days in jail, a $500 fine plus court cost. Do you understand that?
Yes, Your Honor.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court. You understand that?
Yes, Your Honor.
All right. All right, hang on one second. All right. Understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty?
Now, you understand that by pleading guilty, you will not have a trial of any kind.
I understand it.
All right. You signed an advice of rights form, is that correct?
Yes, Your Honor.
You have any questions regarding any of those rights?
No, Your Honor.
All right, please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor.
Of your own free will?
Yes, Your Honor.
And because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
August 29, 2024, at the location of 550 Perry Street, City of Ypsilanti, Washtenaw County, State of Michigan. Were you at that location, sir?
Yes, Your Honor.
All right. And what did you do that makes you think that you're guilty?
Your Honor, if I may.
Yes, please.
Were you on the sidewalk at that location?
Yes.
And were you causing a disturbance to where other people would have?
Yes.
Or would have looked at you and potentially thought you're
Yes.
being disturbing the public
Yes.
by being too loud?
Yes.
Okay. And so you, being as loud as you were, you disturbed the peace and repose of the area that was immediately surrounding you?
Yes, Your Honor.
All right. Sir, if I accept your plea, I need you to understand that if there is misconduct as defined by the Michigan court rules committed between the time of my acceptance of the plea and the time of your sentencing, that any sentence evaluation or sentence agreement, the court would no longer be bound by. You understand that, sir?
Yes, Your Honor.
It's applicable in this case. And also, sir, you would not be entitled to withdraw your plea. You understand that?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements that have caused this plea?
No, Your Honor.
All right. And have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be
August 13th, 2025 at 10 a.m.
August 13th, 2025, 10 a.m. before Judge Barr. Bond will continue.
Thank you.
Thank you, Your
Thank you. Thank you. Court does call the case of the people versus Joletta King.
Good afternoon, Your Honor. Raymond Cook for the people.
Ed Rodriguez for Joletta King, who will be approaching.
Hello, your name?
Joletta King.
Thank you.
Your Honor, at this time, I'd like to set this for an exam. I believe the discovery is complete.
People have their witnesses available the 22nd.
We'll try.
Preliminary examination in person will be set July 22nd, 2025. Time?
At 12 p.m. with you.
12 p.m. That's before me. Bond will continue.
Thank you, guys.
Let's call the case. People versus Ray Nidgamo.
Good afternoon, Judge. Patrick Nineheist, P76343 on behalf of Mr. Gamble. Would you please state your name for the court?
Green Gamble.
Thank you.
Judge, discovery's been complete, and we're just asking you to schedule this for an exam.
People, other witnesses available the 22nd.
Can I request a morning time just because I have stuff in the afternoon? I don't know how.
You see what he did? He sat over there real quiet.
Yeah.
Paying attention to all those people. And now thinks he can just, right?
Well, Judge, I already tripped your clerk, and that was my fault.
Did you push her?
I distracted her enough to.
Push? No. Are you okay? Huh?
I didn't even fall, I just tripped.
He did that?
I did just.
Didn't he?
Yeah.
I was distracting her. I
Mr. Allen.
already told you. I already told her I took full responsibility for that.
I was about to. You'll get a morning time.
Okay,
So
thank you.
here's what
And can
I'll
I
do.
request the same prosecutor because he's been so nice to work with?
No.
Okay.
They send a whole other evil bunch.
No, I didn't say it like that.
Wow. Okay. Somebody took offense.
And I don't know her.
Preliminary examination will be set July 22nd, 2025, 9 a.m. That is before Judge Barr.
Judge Barr or Judge
Judge
Osho?
Barr.
Okay.
I'll let him know you don't know his name. Bond continue.
Just to make sure it's this courtroom or this courthouse?
It's in this courthouse.
Okay, thank you.
He'll be, I'm on that day, so he'll be next door in courtroom B.
Okay, thank you so much, Judge. I just want to make sure I go to the right place.
Thank you, Honor.
Thank you, sir. Court does call the case. People versus Donovan Sneak.
Judge Colin McLaughlin, P75096 for Donovan Sneak. I'm standing in for the attorney of record, Stephen Mamet, with his permission. Is that correct, Mr. Sneak?
Yes.
All right. And state your name, sir.
Donovan Sneath.
All right. And what are we doing on this today?
Judge, I think Mr. Mamet would just like, and Mr. Sneak would just like an adjourned PCC date to continue negotiations with the prosecutor at this time. If he has not already done so, he is agreeing to waive his 21-day right to an exam.
All right. Probable cause conference will be adjourned to July 31st, 2025, 9 a.m. Or as your invite indicates, bond will continue. All right?
Thank you.
Thank you. Court does call the case. People versus Jacqueline Buckle.
Good afternoon, Your Honor.
Good afternoon, Your Honor. Paul Stablin appearing on behalf and with Ms. Wachel, who is standing to my right.
It's Wachel.
Wait.
Your name?
Jacqueline Rachel.
Thank you. All right. What are we doing on this case?
Your Honor, I've had discussions with Mr. Cook
How'd
about.
it go? No, I'm kidding. Go ahead.
It went great.
Oh, it did? Okay.
In regards to some outstanding discovery, the last time we were before the court on Zoom,
Yes.
we had discussed that the prosecution does not yet have the cell phone extraction, which I wanted the opportunity to review before advising Ms. Wachel as to how to proceed.
Right. And that usually takes a lot of time.
So I got in contact with the OIC. He informed me that they would be able to create a copy of that flash drive and prepare it by next week. They already have the phone dump done. It's on a flash drive that you
Got it.
need. They just need to make copies for us.
Got it. Okay. Well, that's further along than where I thought it would be. Okay. And that would be next week, then that would get to you. And then if I set it for the 31st, will that be enough time for you, counsel, or you need?
It will be, Judge. Can I lock it in for the afternoon? Because I've been listening to the dates.
See what he did? Sitting back there and he did that. And he was really such a nice guy on Zoom. And then he knows how much that irritates me.
Oh,
People do that. He just didn't.
I have to-
He just didn't care. Just didn't care. See, and this is, I'm sensitive. Aren't I?
I apologize, Your Honor.
I'm not accepting it. No. You will be in the afternoon in any event as private counsel. So
Thank you very
you'll
much,
be-
Your Honor.
You'll be good. So probable cause conference, July 31st, 2025. I said it at 9 a.m., but you'll be in the afternoon.
Thank you very much.
All right, thank you. Bond will continue. Thank you. Okay, any more trouble we can cause, or is that it?
You've got a 3 o'clock block. Remember?
Yeah, I wasn't really listening. Okay, so I guess I'll stay in recess till that happens.
You're just setting for the.
I'm saying, well, I mean, you want the RO to follow that they just procedurally?
Let's let it follow.
Send data?
Yes.
Makes sense.
Yeah.
Okay. Yeah, I mean, I'll set it, you don't have to, call you, I don't care about that so much. It's an hour. So. Yeah, I'll just, set it over.
No.
Okay. Which, he does it a week from now.
Yeah.
I get that. I'm sitting here not standing and doing your talking. We're waiting on a case to call. Sometimes. I was here earlier because actually I had a matter at 9. And I, came back at 3.
I can work from home. And I can
Oh, okay.
kind of power it out, which will be nice.
Case notes on.
And then, so that we could put the witnesses for, RNO on standby. Because obviously the A witness come by and done, right? So this is coming to come.
Homework for myself. How weird is that?
So you know who you're doing.
Okay, I think we're ready. He's up there.
Kareem.
Yes, sir.
Hey, on the AWIM, I got retained on both. So
Okay.
I don't know, but I just want to make sure I can get your name, your approval to sign you for substitution of attorney.
Yes, sir.
Okay, I'm gonna have my office do that then. So.
All right. So
You may be seated. Court does call the cases of the people state of Michigan versus Anton Brooks.
Anton Brooks.
Regardless of the people?
Joseph and Bill also met the people.
Good afternoon, Your Honor. May it please this honorable court, David Burgess on behalf of Anton Brooks. Your Honor, I'm actually retained on both matters. My office is filing a substitution of attorney, even though I've received discovery in both cases. For some reason, the substitution on the assault with intent to murder case didn't go through. I just asked Mr. Johnson for his approval to sign that, and I believe that's okay. Obviously, he's still the attorney record judge, but I just want to put that
right. And Mr. Johnson, that's your understanding also, sir?
yes, Your Honor.
All right, very good. Then Mr. Brooks, you don't have any problem with regard to today if Mr. Burgess just proceeds on your behalf and then I can let Mr. Johnson go. Do you have a problem with that?
No.
Okay, very good. All right, thank you, Mr. Johnson.
Oh, yes, sir. Thank you.
All right. Okay.
Judge, procedurally, addressing the R&O case and the motion first. Your Honor, I did speak to my client regarding the DNA swab. There was some misunderstanding when he was asked to provide a DNA swab. He thought he didn't understand why I had to provide one because he had already provided one earlier in another time frame. He wanted time to speak to an attorney. Since that occurred, Judge, and I understand. I mean, a lot of people don't know their rights. And since that occurred, he and I have spoken. He understands that there's a court order. He understands that the people obviously have a pending motion, but he's at this point, he's spoken to me and he understands that they need a separate DNA swab for this particular case. So based on what we've discussed, Your Honor, he is okay with providing a DNA swab voluntarily. Is that correct, sir?
Yes, sir.
Okay.
All right, very good.
So there's no need to proceed on the motion, Judge. Your Honor.
People okay with that? Fantastic. Okay. Well, let me ask this. He's voluntarily going to do that. Are the people going to feel more comfortable? There's an order in place, at least, so that.
There already is the search warrant in place trying to accept counsel's representations. It's my understanding that counsel's intending to set up the A1 matter and the other matter for exam day. All it asks is that the motion be continued to that date. If the samples provided by then, we would just strike the motion.
Got it.
That's correct, Your Honor. That's how we plan to proceed because
then we can do that.
My next issue is, Judge, since I did receive discovery in both cases, obviously we're probably not going to proceed on the R&O to exam, but we were going to set them both for exam dates for your next available one, Judge. And obviously that's a placeholder more than anything on the R&O. So
got it. And you have discovery on everything.
Yes, Your Honor.
So let me just say this. What are the charges? I mean, I can set them for the 22nd.
That's fine, Your Honor. I'm here anyway. So
that's going to be a day. That's all I'll say.
Okay.
All right, but let me. What do you have as the count?
Otherwise, he's going to put it out further. I don't want to do that.
You're at 17.
All right, so I'll set these before. All right. Preliminary examination in person will be set in these matters for July 22nd, 2025, 9 a.m. These are before Judge Barr.
And Your Honor, if I may briefly address the issue of bond.
Yeah.
I'm sorry.
So that what I don't want to, I'm just in terms of judicial resources and judicial time. If the DNA swab is not provided that day, you can send the motion over to me since I am familiar with it. Okay, because I'll be on that day.
Yes, Your Honor. I think though that given my discussions with the defense counsel, I trust that.
Yeah, no, I got that. I believe that everybody has good intentions, but just in case some issue comes up regarding it, Judge Barr will be in B and I'll be in C, and so it'd be better off if I just deal with it.
Understood.
Okay. All right. Yes, that's about.
Thank you, Your Honor. Your Honor, we understand the serious nature of the charges in this case, and we understand there was some misunderstanding. I don't believe my client was trying to obstruct justice or do anything improper in any way. I think he was just exploring his options regarding his rights as it relates to the DNA. So I don't think that should be considered as an aggravating situation. Since I spoke to him today, he understands his rights at this point. Obviously, Judge, he's agreed to voluntarily provide that swab. So I don't want that looked on disfavorably as it relates to bond in this case, Judge. Your Honor, I understand the serious nature of the charges, sole intent to murder. However, my client obviously is presumed innocent in this matter. I believe the bond is currently set at 100,000 cash surety, if I'm not mistaken.
It is.
Okay. Your Honor, he does, when he's home, he does take care of his, I believe, 95-year-old grandmother. Is that correct? And I just want to make sure I get the age right. And Your Honor, his mother and significant other are present in court today in support of him. He does have large family support, Judge. I did meet with the family last week, and there are a number of people that he has family members in the community. He does live in Ypsilanti, Judge, but even though they're not all present here, Judge, they are in support of him. So he's not going anywhere as it relates. His whole family's in the area, Judge. Again, understand the serious nature of the charges. We understand a PR bond might not be appropriate, Judge, but at least the court, if it would consider a 10% provision. Again, he does help take care of some elderly family members, and he's not going anywhere. Again, his mother and significant other are present in court today in support of him.
Are there other case outside of these? Is he being held on anything else, or does he have anything else?
He does have he is on probation to Judge Conlon, Your Honor. That matter is still pending. He's about to be released from probation in front of Judge Conlon. But obviously they're going to wait to see what happens in this matter.
Right, and I guess that's, and I'll hear from the people, but I guess that's part of my concern. At the time these events occurred, was he on probation?
Yes, Your Honor.
From the people.
Your Honor, on our note, we would leave that up to the court's discretion. It does sound like maybe that's going to get worked out. Where people have their great concern is with the assault and murder. Your Honor, in this case, Mr. Brooks is accused of shooting at a stranger in public with no provocation. The allegation being that Mr. Brooks saw this individual at a gas station, started asking him questions, and the individual told him basically to leave him alone. And then Mr. Brooks allegedly followed him and then shot at him at a red light. It was a shooting that was witnessed by 3 people. Identification was not made by those individuals who were all strangers, but there was some surveillance. There was getting videos, security videos from the area. There was the pulling over of a vehicle that left Mr. Brooks' home with a bag. The officers saw taken into the home and then back out the home. And that's where the firearm in this case, that's how it was recovered, Your Honor. There was testing done, and the shell casings at the shooting matched up with the gun that was found in the bag that officers had seen taken into Mr. Brooks' home and then brought out of his home. And so, Your Honor, we do think that Mr. Brooks poses a great danger to the public. This isn't a situation where perhaps Mr. Brooks had an anger at a close friend or relative, and then you just perhaps put on each other, make sure they don't have contact. This is a situation with a stranger as the victim. Additionally, shooting outside in public, anyone could get hurt. The bullets or shots, they go somewhere. Unfortunately, in this case, no individuals were struck, but they could have been. And so, Your Honor, based on these reasons, we do believe that there is a danger to the public in general, a grave danger. We're asking for the A1 bond to stay the same. At arraignment, I did the arraignment. I actually had asked for a higher dollar amount. I had asked for $250,000. And so the magistrate decided to give Mr. Brooks a break and just ordered $100,000. I do believe it should not be reduced any further.
Your Honor, I would just indicate, obviously, the evidence obviously sounds like it's somewhat circumstantial. And again, I'm not sure that the people were somewhat remiss on if the weapon was actually allegedly fired. I don't know what the situation is, but whether the weapon was allegedly fired at someone in particular or just fired in general wasn't clear as to what that situation was. But again, Judge, I understand the nature of the charges, but my client does still enjoy the presumption of innocence, and I'm asking at least if the court could consider 10% provision. Regardless, Judge, he does have to address, I believe, the issue in front of Judge Conlon. I'm not sure what the status of that is at this point. So,
is his bond denied in the matter currently in front of Judge Conlon?
Do you know what your status? Did he remand you, or did he?
No, he was waiting to see what this was.
Did he set a bond though? Do you know?
No, I'm just hold.
Oh, okay.
Probation hold.
He's on a probation hold, but he doesn't believe a bond's been set. I haven't appeared in front of Judge Conlon.
The effect of that is that his bond is denied. That's how I would read it, that his bond would be denied pending resolution of that probation violation.
Yeah, right.
Otherwise, there would have been a monetary amount or a bond set. Given a number of different circumstances in this case, the representation, or at least the allegations in this case, and the nexus to the defendant, while it may be some of it may be circumstantial. The court does believe that in that instance, the defendant would pose a significant risk to the public. And further, in looking at it, the other issue that arises is that at the time of these events, the defendant is on probation to another court. So it would be this court's understanding that he may not be entitled to a bond in any event if these actions occurred while he's on bond. But irrespective of that, the court does consider given the allegations that the defendant is a danger to the public, would view the bond as reasonably set. Actually, in both matters, I'm going to leave the bond as set in the R&O as it is. He has an exam coming up in a few days, and certainly Judge Barr could be free to change those bonds after he hears the testimony in the case. So the defendant's motion to reduce bond at this time is denied.
The 14th District Court is now in session. All those having business before the court draw near. The Honorable Judge J. Cedric Simpson presiding.
Since I don't have the other camera, can we lock it, please? Good morning, everyone. Court does call the case of Covington Apartments versus Hussein Sanifer.
Good morning, Your Honor. Rebecca Austin for plaintiff.
Do I have a?
We do not have Mr. Sandberg.
Saying Sanifer? There is no response, counsel. If you'd like to take a default, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, go ahead with your claim.
Your Honor, this is a non-payment of rent case. Rent to repaid is $1,102.04. There are court costs of $173.20 for a total judgment of $1,275.24. I'd request a possession only default judgment. Upon information and belief, Mr. Sanifer is not a minor, is not in military service, and is otherwise within the jurisdiction of this court.
Judgment to the plaintiff. That is by default for possession. Redemption amount is in the amount requested. Writ to issue in 10 days.
Thank you, Your Honor. Have a great weekend.
You do the same.
Thank you.
Court calls the case CJK Capital LLC versus Alan Smith.
Your Honor, Attorney James Carey for the plaintiff.
Mr. Smith?
Good morning, Your Honor. Representing myself today.
All right. And what is plaintiff's claim in this case?
Your Honor, this is a non-payment of rent case. We would like eviction as well as money damages. The lease was extended. The original lease was between Mr. Smith and another party. The other party moved out and was excused from the lease completely. Mr. Smith continued under amended lease for an additional 3 months. He has made no payments under that additional lease. Rent is $1,600 a month and has not been paid for May or for June or for July. There are late fees.
So how much is the money part of your claim at this point?
The money part of the claim at this point is $4,300 for rent and late fees.
And that does not include your cost?
That does not include attorney costs or court costs, correct.
Mr. Smith, what's
Yes,
your
Your Honor.
position on this? What's your position on this, sir?
I haven't paid rent and I'm going to be relocating this weekend.
You're going to be moving out?
Correct, Your Honor.
All right. Okay, you have an opportunity to speak with an attorney to seek some type of assistance or do also go along that route if that's what you choose to do. So I will adjourn this matter out 1 week to
July 18th, 2025.
July 18th, 2025 at what time?
2 p.m.
2 p.m. That is an in-person hearing if you haven't vacated the premises.
Thank you.
All right. You'll need to appear in any event because there's a claim for money damages, sir.
Yes, Your Honor.
All right. Thank you.
All right, thank you.
Court calls the case of LIB WAG Associates versus Richard Town.
Good morning, Your Honor. James Jackson appearing for the plaintiff, Libweg Associates.
We don't have Mr. Tom checked.
Mr. Town is not checked in. Mr. Jackson, good to see you, sir. Haven't seen you in a while.
You haven't, Your Honor. The last time was in person because Zoom had not yet been invented.
Okay, we do not have Mr. Town. If you'd like to proceed, sir, please raise your right hand. Do you solemnly swear or affirm testimony you're about to get? Well, did you do a second service on this?
Services by
No.
posting, Your Honor.
Right, and there was not a mailing copy, so I will have to adjourn it out a week, sir. I'll adjourn it to July 18th, 2025 at 2 p.m. Okay, that's an in-person hearing.
Thank you, Your Honor.
All right, thank you, sir. Joseph Gregory versus Amanda Miller.
Phil Lloyd, Your Honor, appearing on behalf of Mr. Gregory.
All right, good morning, Mr. Lloyd.
Morning.
Amanda Miller?
Yes. Yes,
Okay, you're here. All right, this is a termination of tenancy action?
it is.
All right. There is no lease, is that correct?
Correct.
All right. And Ms. Miller, what's your position on this?
I need some time to speak with an attorney. I reached out to Mr. Lloyd this week and let him know that I received the paperwork. But I do need to speak with an attorney because we
All
do.
right, I will grant you 1 week to accomplish that.
Okay.
And so I will adjourn this matter to July 18th, 2025 at 2 p.m. That's an in-person hearing, ma'am. Make sure that if you get an attorney that they know of that. Okay?
Okay.
All right.
Thank you, Your Honor.
Thank you. Tracy Group LLC versus Jeffrey Rumbaugh or Rambaugh. Mr. Shimke, I think.
Good morning, Judge. Dan Shemke appearing on behalf of the Tracy Group.
All right.
Mr. Rumbaugh is present, but he is not connected to audio.
Okay.
I will try.
Can he? I can't pick it up on my screen. But.
I will try to send him a message.
Mr. Rumbaugh?
Still off.
It's still off. That's not him.
No.
All
Yeah,
right.
there's been no change for Mr. Rumbaugh.
All right. Mr. Shemke, I can do one or two things. I can just adjourn this out and we'll let him know in writing, but he's not responding at this point. Or what I can do is I can pass the matter and we can keep trying to
Judge.
contact him to see if he does anything.
I'm late for a date on Torch Lake, so I would be happy to stick around for a little bit because I'm going to be out of state next week. I assume you would put it over 1 week.
Yes, sir.
I'm going to be out of state next week, so if we could get him connected and get this resolved today, that would be ideal.
We'll give it a shot. Let my staff know by chat when you have to leave so we can get you called up. All right? But
Thank you so much, Judge.
Thank you. Elizabeth Zomalia versus Sharon Owens.
Good morning, Your Honor.
Good morning, Mr. Stewart. You disappeared on me, I think.
He muted himself and turned off.
Yep, you're muted, Mr. Stewart.
Is it okay now, Judge?
You're up. You're good now. All right.
Thank you.
All
Good
right.
morning, Your Honor. Joe Stewart.
All right. Sharon Owens.
Yes, I'm here, Your Honor.
All right. Okay, there you are. Okay, this is a non-payment of rent case. Counsel, what is the plaintiff's claim in this case?
The claim is that the rent is $2,500 a month, Your Honor. It's a large house. Rent has not been paid since April, so it's Mrs. Owens owes May, June, and July. And there is $100 late fee for each month. So she,
Okay, give me a total. What did she owe?
the total of that is $7,800.
All right.
And I have spoken with Mrs. Owens, if I may just tell you about that.
Yeah. Yes, sir.
And I proposed a consent judgment payment agreement with payments, and we did speak about it, and I forwarded her the agreement. My client is in agreement with that, and Mrs. Owens just wasn't sure about it. She's extremely nice lady. She was ill. That's how she got behind. She was always a very, very good tenant.
Okay. All right, Miss Owens.
Yes, Your Honor.
All right. Is all of that correct? Is there an agreement or something that you believe the parties have worked out?
First of all, I wanted to just reiterate, I had made the request that this not be live streamed on YouTube. Can that be honored?
I understand, but the courtroom is actually closed. It's Zoomed, and I have to have this public. So I appreciate what you're saying, but that's my rule.
Okay, thank you. Okay, yes, I am not going to deny responsibility for that. As the attorney stated, I have lived at this property for almost 2 years, never missed a payment, never been late. For most of 2024, I had to go through a very aggressive breast cancer treatment, which I didn't tolerate well. I had to come off work, so the rent got behind. What I've been trying to do is, instead of yes, the attorney is correct. He did present the consent judgment, but I have applied for assistance, and I have proof of that.
Okay.
And so I'm just waiting to hear back from that.
Okay, so you've applied for assistance.
From
Who did you
multiple
apply
organizations.
through? Pardon?
From multiple organizations. I have two commitments. And I'm waiting. I have an appointment Monday with SOS Community Services of Washtenaw County, and they said that they could pay up to $3,000. And I have another waiting for a decision. Another one said they can pay from $2,000 to $3,000. And then I have a commitment of $500. I have a commitment of $300. And one of the people who committed the $500, they're going through their parish council president is seeking contributions from other parishes. So I'm hoping to put that amount together without having to go through the consent judgment, because that'll be on my public record.
I understand that. Okay. So here's what would happen. I will adjourn this out to the 18th, 2025 at 2 p.m. Okay. There's a form that came in your packet called a rental assistance form, Miss Owens.
Yes.
You'll have to fill that out if you've got tracking numbers or something like that indicating that you applied for assistance and where. Okay. That needs to be filed with the court by Wednesday.
Okay. Now, when I looked online, it said that it could be paused for 14 days to allow for my application to be processed. Is that possible? I just want to give enough time to hear back from.
Ma'am, that's why I need the form.
Oh, okay. I'm sorry.
All right. So I need the form into the court indicating that you applied. And then come the 18th, we will be looking at that. But I need to have that form by the Wednesday before. You have to file that 5 days from today.
Okay.
Basically. Okay. So you get that into the court, and then we'll do that. At this point, I'll adjourn it out to the 18th at 2 p.m. Yes. At 2 p.m. Okay.
Your Honor, is that by Zoom or in person?
That is in person. Okay? Thank you. Ms. Owens, be well, please.
Thank you.
Thank you, Judge.
Thank you. Barnes and Barnes versus Alex Holtzclaw.
Ellis Friedman for the plaintiff.
Alex Holtzclaw, there's no response. If you'd like to take a default, raise your right hand, sir. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
Go ahead, sir.
I'm Ellis Friedman. I'm the attorney and agent for Barnes and Barnes. I believe we have personal service on this.
Yes, you do.
The amount of rent that's past due is $857.76 plus $230 costs for a total of $1087.76.
Judgment to the plaintiff, that is by default for possession as well as money. Judgment amount, redemption amount, any amount requested with a writ issue 10 days.
Thank you.
Thank you. Red Arrow Motel versus Roderick Reuter.
Ellis Friedman for the plaintiff.
I think Mr. Reuter's here.
Oh, yes, thank you. Yep.
Mr. Reuter, you're at our access point. Can you unmute? You're gonna need to send somebody in. Oh, there you go.
Okay. Okay.
All right. Okay, so we got Mr. Reuter. This is a termination of tenancy action. There's no lease.
Correct.
No.
Mr. Reuter, what's your position on this, sir?
I've been moved out for about 2 or 3 weeks now. I've been living in my car. I have been during this time going back and removing all my stuff from the place. I had about 2 bookcases, about 40 boxes of books. I bought a carpet cleaner and redid all of her carpet, and I gave her $2,000.
So you're gonna move out, correct?
I am out. I've been living in my car.
You are out?
I was sleeping at the bus terminal last night and sleeping in my car wherever for the last 2 or 3 weeks.
Okay.
The only
Have you
thing-
turned over the keys or anything, or you
No,
still
no.
got stuff in there?
I moved everything out. There's not a thing of mine in there. I had to
Okay.
take storage. We threw a bunch of books away, about $4,000 or $5,000 worth of books I threw away.
Okay, so did you give the keys to the landlord?
There were no keys.
There were no keys.
I don't lock anything, my car or whatever.
Okay.
So I don't know if
Um,
he wants more money or you want money. And you want.
We just
so
need-
sir, you're surrendering possession of the premises?
Oh, yeah. Now, does that mean I couldn't have gone back and get my stuff? Or does that mean I can't go back and she has to get rid of it? She didn't want to get rid of it, I know. She would have to have a dumpster to get rid of all the stuff I took out of there.
Okay, so, well, that's what I'm trying to be clear on. Is all of your stuff out
Oh,
or
yes,
not?
everything's out. All the drawers are
Every-
empty, floor is clean, everything's gone.
Okay, so you're giving up possession of the premises, is that correct?
Yes,
Okay, so if I were to order that the plaintiff can take possession of the unit, you're not gonna have any problem with that, is that
oh,
correct?
no, I haven't had any problem with that at all.
Okay,
Like she evicted me when I was in the hospital.
all right.
And
So what I'm gonna do is I'm gonna indicate that the defendant is surrendering possession of premises and plaintiff may take that back based upon his representations in court.
Thank
Okay.
you, Your Honor.
All right.
Are you?
Thank you.
That's it.
Thank you, sir. You're
Okay.
all set.
Thank you.
All right, Barnes and Barnes versus Darius Bell. That matter is dismissed on plaintiff's motion without prejudice.
Thank you.
Is that it for you this morning, Mr. Freeman?
It is, Your Honor. Thank you. Have a good weekend.
All right. You do the same, sir. Red Line Apartments versus George Bennett. Mr. Pantera?
Mr. Pantera is present, he just hasn't unmuted.
Yeah, I do see Mr. Pantera. Mr. Pantera, can you hear me?
Oh, I think he's doing two things at once.
He is doing two things at once because he thinks I'll wait.
Mr. Reggie, can I put you back in the waiting room for a second till we've got Mr. Pantera back again?
Yes, that's fine.
Okay.
Good morning, Your
All
Honor.
right. Good morning. I've called the George Bennett, the fourth case.
I apologize. I was doing Zoom somewhere else.
All right.
All right. Your Honor, David Fantera on behalf of Red Line Apartments. Mr. Bennett has a current balance of $2,470, including court costs.
All right. And Mr. Bennett, how are you intending on getting that paid?
I'm hoping to get the money together soon, but I don't have it right now.
Okay. Are you seeking assistance or what are you intending upon doing?
I just kind of found out from this hearing that the assistance was available, so I think I'll apply for that. Yeah.
Okay. So you'll need to apply for assistance. The rental assistance form, which was in your packet, if you do apply for assistance, you'll need to file that with the court with the requisite or necessary information by Wednesday. I will adjourn this matter out to July 18th, 2025 at 1 p.m.
Okay, thank you.
That's an in-person hearing, so you'll have to come down to the courthouse, sir.
Okay, thank you.
Thank you. Walkabout Creek Apartments versus Beth Sherfield and Barbara Sherfield.
Good morning, Your Honor. David Fantera on behalf of Walkabout Creek Apartments.
Beth or Barbara Sherfield? I have no response. If you'd like to take a default, raise your right hand, sir. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
Go ahead.
I'm David Fantera. I'm the attorney for Walkabout Creek Apartments, and as such, I'm familiar with the books and records as they relate to this tenancy. In this case, there's rent owing in the amount of $3,328, court costs of $188, a total of $3,516. We'd ask for a judgment for possession with a written 10 days if that amount remains unpaid.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ issue in 10 days. YPF 16 LLC versus Kiera Fleming.
Good morning, Your Honor. David Fantera on behalf of the plaintiff.
Hello, this is Kiera. Go sit down, please. Thank you.
Hello. All right. And what is plaintiff's claim in this case?
There's a current balance owing of $4,298.39.
And Ms. Fleming, how were you intending on getting that paid?
I applied for assistance through state emergency relief from VHS. I'm just waiting for.
I'm sorry, you broke up there. You applied for assistance.
July 15th.
Okay, you applied for assistance where?
Through DHS, through the state emergency relief program.
Okay. All right. Just so that you're aware, how many people are in your house?
Me and my two children.
Okay, so 3. That will only help you if they give you the max for about $620.
Your Honor, may I ask something?
Go ahead, Mr. Pantera.
She said when we meet, she was going to help me with other resources to help out, more, because she only covered a certain amount.
Yeah.
She told me that.
What's that?
So you want what I just said?
What I was about to say was that I've been in touch with SOS because Ms. Fleming has rapid rehousing through them, so they pay a certain portion and she's responsible for the rest. They're willing to help her with something, but not the full amount. So
Yes, they are willing to hold something, but it's also other programs to help also. So I'm going to get help with other programs also.
All right. What I will do is I'll adjourn this to the 18th, 2025, 1 p.m. All right. And Ms. Fleming, there's a rental assistance form that's in your packet. You'll need to fill that form out, put the necessary information on, and file that with the court by Wednesday.
Okay, I'll get that filled out and sent by Wednesday because my meeting
All right.
is Wednesday, so I'll have everything by Wednesday.
Thank you.
Okay, have a nice one. Thank you.
You too. YPF 16 LLC versus Nakia Turner and Elise Turner.
Good morning, Your Honor. David Fantair on behalf of the plaintiff.
We think we have Elise.
Yeah, she's here.
Hello.
All right. Hello, Ms. Turner. All right. And what is plaintiff's claim in this case?
The current balance is $5,402.80.
All right. Ms. Turner, how are you guys intending on getting this paid?
We filed bankruptcy last month, so our bankruptcy attorney informed us to attend today, just I guess, I don't know, for a reminder or.
Okay. Have they supplied that information to the landlord? Do you know?
They should have, because we did already have our the meeting, the examination or whatever it was.
Who is your
Gotcha.
attorney?
What'd you say? I'm sorry.
Who is your attorney? Because if there's a bankruptcy, I need to stay this case.
Peter Behrman.
Spell that, please.
Behrmann.
Where is he?
Livonia.
All right, Your Honor, I'll reach out. If we could adjourn this, I'll reach out. If I can verify that there's a bankruptcy, obviously, I do an administrative closing.
Right. So, ma'am, what
Yes,
will
sir.
happen is I'm going to adjourn it out a week so they can verify the bankruptcy information. All right.
Okay.
So
Mhm.
no action is being taken until we can figure that out, just so that you understand that part of it. If they do verify it, they'll be filing what's called an administrative stay to close the case, usually temporarily. Okay.
Okay.
All right. So that's July 18, 2025 at 1 p.m. And what I would suggest, ma'am, that's an in-person hearing. I would just make sure to either have your attorney contact Mr. Fantera or the like to make sure if there's a stay, I don't need you down here.
Okay. Okay.
Okay?
Yes,
All right.
sir.
Thank you. Have a good
Thank you.
weekend.
You too. Bye-bye.
No, that's all for me, and I apologize that I wasn't there when my case was called the first time.
Not a problem, Mr. Fantera.
Have a great weekend, Your Honor.
You too.
Actually, I'll see you at noon, so I'll get to say it again.
That's true.
Okay.
All right. Group 5 management versus Burnett Turbington.
Good morning, Your Honor. Robert Weiss appearing on behalf of Group 5.
We don't have this tenant.
Burnett Turbington. No response. If you'd like to take the default, raise your right hand, sir. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
I do, Your Honor.
All right, go ahead.
Robert Weiss appearing on behalf of Group 5 Management. Ms. Turbington is a resident at Randolph Court Apartments, 3139 Randolph Court Drive. The amount owing, including court costs as of this point, is $1,438. Requested judgment for possession. Was there personal service, Your Honor?
There was not.
Okay. Judgment for possession with the issue on or after the 21st.
All right. Judgment to the plaintiff. That is by default for possession. Redemption amount is in the amount requested with the writ issue in 10 days.
Okay. Did
All
you
right.
get the dismissal on my other case, Your Honor?
We must have, because I don't have another case. So it
Okay.
got taken off.
I'll see you at 1.
All right. Very good. Thank you, sir.
Thank you.
Coachville versus Brian Vasquez.
Here comes Miss Matson for balance.
Oh, there she is. Okay.
Good morning, Your Honor. Casey Matson, P87729 on behalf of plaintiff.
All right. And Mr. Vasquez, he's here. What is plaintiff's claim?
Your Honor, this is a non-payment of rent case. We have rent to retain of $819.46, court costs of $174.00 for a total of $993.46.
All right. Mr. Vasquez, how are you intending on getting that paid, sir?
Yesterday I dropped off $600. So I only owe like $390 something, and I just planned on paying that when I get my next check, just in like 2 weeks.
In 2 weeks?
Mhm.
Okay, so here's what I'll do is I'll adjourn this matter out to the 18th, 2025 at 3 p.m. All right, if you can get it paid before then the case gets dismissed. But you're not gonna get another check until probably after that, so, but we'll deal with it at that time. All right, so I'll set it for the 18th at 3. That's an in-person hearing, so you'll need to be down at the court, sir.
All right, thank you.
Thank you. River Ridge versus Douglas Codger.
Casey Matson, P87729 on behalf of plaintiff.
Don't have Mr. Codger.
Douglas Codger? Or
Oh,
Codger?
Your Honor,
Yes.
we actually have information that this defendant is deceased. However, there is an open probate, and so we would request an adjournment to amend the pleadings to name the estate.
Pleadings. All right, very good.
And
I'll
there
adjourn
was,
it to, go ahead. I'm sorry.
sorry, Your Honor, there was also a payment dropped off. I just wanted to make the court aware.
Got it. Okay. I'll adjourn this to July 18th, 2025 at 3 p.m.
Thank you, Your Honor.
Okay. Thank you. Sile Farms versus Juan Real, or Real.
Casey Matson for the plaintiff.
Mr. Real? You got him, or?
He's here, but he's still muted and.
I see him. I see the. Juan Real?
Yeah,
Okay, I'll need you to turn your camera on. What is the plaintiff's claim?
Your Honor, this is a non-payment of rent case. I rent to retain of $6,412.44. Court costs of $190.00 for a total of $6,602.44.
And Mr. Real?
yeah.
How are you intending on getting that paid?
No, should have it paid 3 weeks.
So, all right. So what I'm gonna suggest is that you contact the plaintiff to see if you can work something out. But otherwise, what I'm gonna do is I'm gonna set this out 1 week to July 18th, 2025 at 3 p.m. That's an in-person hearing, so you'll need to come down to the courthouse, okay?
Okay. All right.
All right, thank you.
Have a good weekend.
You too. Spice Tree Apartments versus Kia Berry.
Casey Matson on behalf of the plaintiff.
Okay, there's Miss Berry. All right. What is plaintiff's claim in this case?
Your Honor, this is a non-payment of rent case. I rent to retain of $1,539.53. Cost of $169.00 for a total of $1,708.53.
And Miss Berry, how were you intending on getting that paid?
I did pay $1,000 on Wednesday. And I don't get paid till July 23rd next in 2 weeks. And I was gonna pay the
Gotcha.
rest.
All right, and counsel, I'm assuming you don't see the 1,000 yet on your account.
Your Honor, what was Thursday. I do see a payment from the 2nd. It was a check for $750, but I don't see a $1,000 payment.
I do have the
Got it.
receipt of
No, it's
$1,000 that I
okay. It's
paid on the
Miss Barry,
Wednesday.
Miss Barry, it's okay. I just want to make sure that the 1,000, that I'm looking at the right number.
Yeah.
All right.
I don't know. I
Okay.
totally understand, but I know I got the receipt for the 1,000 that I paid.
Gotcha. I understand. All right.
And I was in contact with Spice Tree Apartments and told them that I was coming to the Zoom meeting and letting them know of everything.
All right. So what I'll do is I suggest that you contact the plaintiff's counsel's office, see if you can work something out, but I'll adjourn it out 1 week to the 18th, 2025 at 3 p.m. Okay. And at that time, we'll figure out exactly where you are. Okay.
Okay. Thank you so much.
That's an in-person hearing, so you'll need to come down to the courthouse.
No problem.
All right. Thank you.
Thank you.
Spice Tree Apartments versus Warlene Foster.
Oh yeah, you guys excuse my voice. I'm kind of hoarse.
All right. It's all right. All right. What is plaintiff's claim in this case?
Your Honor, this is a non-payment of rent case. We have rent to retain of $2,395.58. Costs of $169.00 for a total of $2,564.58.
All right. And Ms. Foster, how are you intending on getting that paid?
I'm gonna pay something today, and then I'm gonna get paid in 2 more weeks, and I'm gonna
Okay.
pay and I can pay the rest.
Okay. So how much were you going to pay today, you think?
1,000.
About 1,000 today?
Yeah.
Okay. All right. So what I'll do is I'll adjourn this matter out 1 week to the 18th, 2025 at 3 p.m. And then with the hopes that then that's an in-person hearing, so you'll have to go down to the courthouse. So at that point, either you can call the attorney's office or you can come down and see if we can work something out that day. All right?
Okay, thank you.
All right. Thank you. Spice Tree Apartments versus Brianna Hutchinson and Michael Dealman.
Hello.
Hello. All right. What is plaintiff's claim in this case?
Your Honor, this is a non-payment of rent case. We have rent to retain of $1,526.13. Costs of $182.00 for a total of $1,708.13.
All right. And how are you guys going to intend on getting that paid?
Currently I'm ended up having to move out due to having my daughter a couple of weeks ago. And
Okay.
but I do plan to pay it or work
All right,
something out with the apartments.
Okay. So let me ask you this. Is
Michelle?
yes, is she still residing there?
Yes, she is.
Okay. So here's what I'll do. I will adjourn the matter to the 18th, 2025 at 3 p.m.
What
Okay,
time?
that's an in-person hearing. And so I will need both you and Michelle down here. I understand you moved out.
Yes,
But-
and she won't pay anything because she has this feeling of self-righteousness. So it basically is going to all fall on me.
Okay, don't worry about that self-righteousness. I get that with every attorney I run into. It's not that big a deal. All right, okay.
What
All
can
right, listen.
you repeat what day and time that was?
Yes, it's the 18th, next Friday. That's at 3 p.m.
Okay, thank you, Your Honor.
Okay, come down to the courthouse and we'll see if we can work something out at that point, okay?
Okay, thank you.
All right, thank you. I apologize to all the attorneys out there. I didn't mean that. Court does call the case of Spice Tree Apartments versus Brian Meeks. And
I'm here. Good morning.
good morning. And also, the Ciesa Mana?
She's not available.
Me? All right. I was just hoping I was
We are.
pronouncing the name even close. All right.
It's
Don't you say anything. Just leave it alone. All right.
oh, I was gonna say that we're actually divorced. She doesn't even live here, so this is just me.
Oh, okay. Gotcha. Okay. All right. What is plaintiff's claim in this case?
Your Honor, this is a non-payment of rent case. We have rent to retain of $3,225.20, costs of $182.00, for a total of $3,407.20.
All right. And sir, how are you intending on getting that paid?
I know that for June that was 1853.52, I believe, but I'm a realtor and I've had some slow closings, to be frank. So I should have a closing here next week, which means I'll be able to pay at least pay half of that the following week.
Okay, I got
and
you.
as it stands right now, it looks like I'm gonna have to go back to, getting a normal position again. I work in marketing for 20 years, so I'm gonna go back to do that and just see what I can do to catch up the rest here, unless I get some
All
more
right.
closings.
So here's what I'll do.
Okay.
Since we don't know that, right, I get the idea of the slow pay on the closing. I'll adjourn this out 1 week, sir, to the 18th, 2025 at 3 p.m. That's an in-person hearing. In the interim, you can either contact the plaintiff's office, the attorney's office, to see if you can work something out or appear here on the 18th. And if you can't work it out, we'll figure out what we're going to do. Okay.
All right. And one other thing too, Your Honor, I am going to try the rental assistance. I do have the packet here, so.
Okay. So if you do that, make sure to fill out the rental assistance form, put the requisite information on there, and file that report by next Wednesday.
Will do.
All right. Thank you, sir.
Thank you, sir.
Court does call the case. Spice Tree Apartments versus Fatma Musa. Musa? Do not have them present. If you'd like to take a default, I don't think I've had you sworn.
No, Your Honor.
Do you
Hello?
solemnly
Good
swear or
morning, Your
affirm? Hold it. Okay, who's talking to me?
Phone ending 340. Didn't give it.
Yeah, I tried to zoom in, but it's not, the password's not working. I'm not sure why.
I'm not understanding you, sir. What are you saying?
I said I tried to zoom in, but the password I was given is not working. I'm not sure why. So,
What is your name?
yeah. Abu Ibrahim, an occupant in the B7.
He's breaking up on
I
me.
didn't catch his name. Can you repeat it?
Can you repeat your name, sir?
Abu Bakr Ibrahim, I'm occupant of Fatima Musa's
Green.
B7.
I think he's.
He said Ibrahim occupant.
Is that what
Hello?
he said? You're gonna have to back up from the microphone on your phone, sir, because I can't understand you.
Can you hear me better now?
I can.
Hello?
What is your name?
Abu Bakr Ibrahim.
Okay, who is your landlord?
Spice Tree Apartments.
Okay, do you reside with Musa?
Yes. It's
Okay,
B7.
so you're an occupant in the premises?
Yes.
Do you know why Fatma Musa is not here?
She's out of country.
Pardon?
She's out of country right now. She'll be back in a couple of weeks.
Yeah, you say for a couple of weeks. When is she expected back?
I think on the 24th.
Okay, well, let's.
But I've been paying the rent on behalf. And I want to say, I don't know
Well,
what the balance that's.
Is the amount that's due and owing going to get paid in the next week?
Yeah.
Council, how much is
And then we
owing,
just paid,
including court costs?
Your Honor, including court costs, I have the balance is $3,085.42.
All right. Okay, sir, the problem that I have here is that you're not on the lease.
and that's something that the office was supposed to change. I'm not sure why they haven't updated that, but we did pay $2,100 in the last 2 days. So it's $995 actually that's remaining. I'm sure it's probably not updated yet, but that's the remaining balance.
You're saying you paid $2,100?
Yeah, in the last 2 days.
Your Honor, I do not have receipt of that payment.
I'm going to give a shot because she's not going to be back for 2 weeks. Rather than give a default, at least at this point, somebody has appeared. If the 21's paid, then there's a limited amount. I'm going to adjourn this out 1 week, the 18th, 2025 at 3 p.m. That's an in-person hearing, sir. So you or somebody on behalf of Ms. Musa must be here, but you won't technically be able to represent her because you're not an attorney.
I understand.
All right, but my suggestion is if you paid the 21, my suggestion is by that time before the 18th, if the rest of that gets paid, then it's likely the case will be dismissed.
Okay, so if it is paid, we don't need to appear.
All right. Thank you.
So if it's paid, we don't need to appear.
Pardon?
If it's paid, we don't need to appear.
But you have to make sure that everything is paid in full. Yes.
Okay.
All right. Thank you.
All right. Thank you.
Vice Street Apartments versus Raymond Stewart and Jaron Morgan. Oh, there's Mr. Stewart. Okay. All right. What is plaintiff's claim in this case?
Your Honor, this is a non-payment of rent case. I rent to retain of $1,911.46. Cost of $182.00 for a total of $2,093.46.
All right. And Mr. Stewart, how are you intending on getting that paid?
So I made a payment of almost $450 on the 9th, and my plan was to get it paid off in the next week.
In the next week?
Yep, by
So
Wednesday.
you paid $400. So can you get that paid by the 17th?
Yes.
All right. So what I'm going to do is I'm going to indicate in my file you're going to pay the balance by the 17th. I'll adjourn this out to July 18th, 2025 at 3 p.m. All right. If you get all of that paid, then the case will be dismissed, but you got to make sure that everything's paid in full.
Thank you. Will do.
All right. Thank you.
Thank you, Your Honor.
Thank you. Sylvan Crossing versus Aria Jones or Cumming Jones.
Don't have those tenants.
Vicky Mattson for the plaintiff.
Cummings Jones, there's no response. Now, if you'll raise your right hand, I think you can. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, go ahead.
Your Honor, this is the non-payment of rent case. We are requesting entry of a default possession judgment only. I have rent to retain of $702.34, cost of $194.00 for a total of $896.34. Writ to issue in 10 days, which would be July 21st.
Judgment to the plaintiff, that is by default for possession, redemption amount, in the amount requested with the writ issued 10 days. Sylvan Crossing versus Andre Marshall.
Don't have Mr. Marshall.
Andre Marshall, they are not present. You may proceed.
Thank you, Your Honor. This is a non-payment of rent case. We are seeking entry of a default possession only judgment. I have rent to retain of $2,137.66. cost of $194.00 for a total of $2,331.66. Writ to issue in 10 days, July 21st.
Judgment to the plaintiff, that is by default for possession, redemption amount, any amount requested, writ to issue in 10 days.
Thank
I
you.
think that's all I have for you this morning.
Thank you.
Thank you. All right.
Good morning, Your Honor.
All right. Good morning.
How are we doing this morning?
I'm fine. I don't know who you are.
Jason Pennington, Pennington.
I got his name. I don't know. I look. I don't know. Oh, he's early.
He's early. He's not till 10 o'clock. All right. Lynn King versus Nakia McDonald.
Judge Simpson, Your Honor, this is Lin King.
All right. And Ms. McDonald, you're present?
Yes, sir, I am present.
All right. And Ms. King, how much is owing in rent?
She owes 1,760 from May, the late fee, and June, the rent and the late fee, and July rent and late fee so far. And also, when she moved in, the security deposit was not paid because the cold winter and in the Christmas time. So I let her and her younger children move in. But so far, the half year has been passed, and the security deposit of $2,370 is still not paid.
Okay, I can't right now do anything because it's a non-payment case. And I'm reluctant to
Updated a little
order
bit.
at this time that. All right, Ms. McDonald, how are you intending on getting this paid?
So that is not the correct total. There's been 2 payments since then, and there will be a third payment today, and then I get paid within 2 weeks. So everything is, for the most part, current. If anything, it's just late fees. So I would like the correct amount.
How much do you think you owe?
I am paying for this month. I owe late fees and security deposit. I'm not sure how much. I want to say maybe 3. I'm not sure, but it's late fees. Is what it is.
How
It's
I
not the
counted.
rent.
$50 first initial late fee, and then $5 per day for the late fee from May.
$5 per day?
Yeah,
I'm gonna
very
tell you,
low.
that's ma'am, that's a questionable, maybe illegal late fee. So
Yes.
you may want to reconsider that. What I will do is I will adjourn this matter to July 18th, 2025 at time?
2 p.m.
At 2 p.m. That's an in-person hearing. Both of you will need to be down at the court.
Okay.
All right. And then we'll see exactly how much is owed at this time. All right. Thank you.
Okay.
Thank you.
All right. Thank you.
Jeff Lewis versus Michelle Kresnak.
Good morning, sir.
And
Julie are present.
all right. And Noah Frush. And that's
Yes.
Jeff and Julie Lewis. All right.
The 10.
Don't have the tenants here. Kresnak, Frush. There is no response. If you'd like to take the default, raise your right hand, sir. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
Yes, sir.
All right. What is the amount that's owed?
The amount that's owed is $12,103.57. And the fees and costs are $702. The total judgment or the total is $12,805.57.
And there was also a request for a money judgment. I do have in my file that personal service was made upon both of these individuals. So judgment to the plaintiff, that is by default for possession and money. Redemption amount is in the amount requested, as well as money judgment with a writ to issue in 10 days. And I will sign that upon its presentation. All right. Thank you, sir.
Thank you.
Tracy Group versus Rumbra. Recall.
Prompting Mr. Shuckey. And I no longer have that.
Judge,
Yes, sir.
do we have Mr. Rumbaugh or no?
No longer here. And I don't have a second mailing, so I'm gonna have to adjourn it out. I don't have a choice.
A second mailing
Of the complaint. So the new process, or the process is, I need a mailing. So it's actually 3 notices, because there's the service notice, court mails a copy, then that what we call now the second mailing would have to be done for me to be able to take a default today. And that was not done in this case, so I have to adjourn it out. Are you available? I know you said are you available by Zoom? It's an in-person hearing, but would you be available by Zoom for a hearing or no?
when, Judge?
Oh, you will be?
When would that be?
Next week. You said you were going to be out next week, but
Yes, yes, I can make that happen if I know the time,
okay.
yes.
All right. I'll adjourn this then to July 18th, 2025. I will allow plaintiff to appear via Zoom. That will be at what time? 2 p.m. At 2 p.m. So right around in there.
Thank you very much, Judge.
All right. Thank you. All right. Safe travels.
Thank you, Judge. Have a good weekend.
All right. You too. All right. That's it for that block. All right. Court stands in recess.
Court is now back in session. The Honorable Judge J. Cedric Simpson presiding.
Am I locked? Six Trails versus Paul Cox.
Good morning.
Mr. Borkin.
Good morning.
Hello, sir.
Christopher Borkin for the plaintiff.
Thank you.
Don't have a tenant check.
Paul Cox. There is no response. If you'd like to take a default, please raise your right hand, sir. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
Go ahead.
Plaintiff would respectfully request a default judgment of possession only. We have sent out a second mailing, I believe. Rent is $34.23. Court costs are $175, totaling $35.98. Plaintiff would request a writ to issue in 10 days if that amount is not paid in full.
Judgment to the plaintiff, that is by default. For possession, redemption amount is in the amount requested with the writ to issue in 10 days.
Thank you, Your Honor.
Good to see you, Mr. Borkin.
As well. Thank you very much.
All right, take care. Court does call the case. Ridgewood Apartments versus Rataj Abulawi.
Good morning, Your Honor. Mark Schlesinger appearing on behalf of plaintiff.
I do not have this tenant check.
Abulawi, no response. If you'd like to take a default, raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do, Judge.
Go ahead, sir.
Thanks, Judge. I'm going to preface this with a quick question. We don't have a proof of service in our file. The court officer, I think, did the service. Can Your Honor verify that there's proof of service and if it was personal or posting? Because we are asking for money judgment.
It is service by attachment.
All right, very well then. Plaintiff would request, based on defendant's failure to appear, a default judgment for possession only. Current rent to retain, $3,237.29. Court cost, $224.50. Total to retain $3,461.79. Writ to issue after 7/21/25.
Judgment to the plaintiff, that is by default for possession. Redemption amount in the amount requested, writ to issue in 10 days. Thank you, sir.
Thanks, Judge. Appreciate the assistance with the proof of service. Have a great weekend.
All right, you do the same.
Thanks, Judge.
Glencoe Hills versus Yaritza Herrera.
Good morning, Your Honor. Jillian Engen for plaintiff.
Ms. Herrera?
Good
Oh,
morning,
there she
Your
is.
Honor. Yes, I'm here.
Good morning. All right, what is plaintiff's claim?
I have a balance including court costs of $1,354.85.
All right. And Ms. Herrera, how are you intending on
Yes.
getting that paid?
Well, last week I made a payment of $800. This past May, I had a loss in income with Social Security. I don't know what's going on. I've been to their office. They're advising me to request an appeal, so I'm waiting to get that process started. But in the meantime, with my voucher, Section 8, I was making payments to them because of this source of income that I had is really confusing, but they said that I was overpaid. And this was last year. I've been making payments to Section 8 of $100. And when I lost that income in May, I couldn't afford those payments plus my rent. So as of yesterday, I was told that I can file a hardship with them, pay $42. And as soon as I get that payment paid and the hardship form submitted to my worker, they will release payment to Glencoe Hills because they haven't been making payments yet.
Got it. Okay. Ms. Engine, you don't know anything about that, right?
I have a note from my client saying that there was the issue with the repayment agreement, and Ms. Herrera is working to get clarification on that.
Okay. So what I'll do, while we try to await and hopefully maybe get some clarification, I'll adjourn it out to the 18th, July 18th, 2025 at 12 noon. All right.
Your Honor.
And that's an in-person hearing. Yes, ma'am.
Okay. Yes, can I get that phone number that you stated in your greeting for the Veteran Services? This is where I'm issue my son.
For which one?
For Veteran Services.
Do you have that one?
I do. I can put it in the chat for her. Or do you want me to read it?
Can read it out loud. She's
734-973-4540.
Okay, I have it. Thank you.
all right. Are you a veteran, ma'am?
No, my son's father was,
Gotcha.
in
Okay.
2017, he was deceased, so all his children get benefits from
Correct.
him being a veteran. And that's the
Right.
issue we're having. My son, for some reason, was taken off, but all of his other children still have it. So we're trying to figure out what's going on.
Figure that one out. Okay. All right.
Thank you.
All right. Thank you. Does call the case of Gulfside Lake versus Paul, is it Kutzlag?
Jillian Engen for plaintiff.
Kutzlag?
Your Honor, he's here. I think he's muted right now. He's at the access point, I believe. There.
Is it?
Yes, Your Honor. Paul Kutzlag.
Okay, there you are. Okay. All right, this is a termination of tenancy action.
Yes, Your Honor. The notice to quit was sent for lease violations.
All right. And sir, what's your position on this?
Your Honor, I have submitted a written response. Is that in the case file, and may I add to it at this time?
I'm sorry?
I submitted a written response to the summons that summarizes my position. Is it in the case file? I've also asked for a jury trial
Yep,
my
I
name
do
is-
see that. All right. And
Your Honor, I don't think we have a
Counsel,
copy.
you don't have a copy of it. Did you send a copy to the plaintiff?
Your Honor, I'm not sure. I submitted the form and the $50 fee for the jury file.
All right, but did you send a copy to the plaintiff?
Not to my knowledge.
All right, you need to do that. I will adjourn this matter out to the 18th, 2025 at 12 noon. Okay, and then we'll come back. We'll try to sort out what issues there are and try to figure out where we go from there.
Thank you, Your Honor.
Thank you. River Drive Apartments versus Ann Marquette.
Jillian Engen for plaintiff.
Ann Marquette. They are not here. If you'd like to take a default, please raise your right hand. Do you solemnly
I'm
swear?
here,
affirm
Your
test-
Honor. Can you hear me?
Oh,
Your Honor, I'm
okay, there you
here.
are. We can hear you now. 649 or
Okay,
629.
thank you, sir.
Okay, what's your name, ma'am?
My name is Ann Marquette.
Okay. What is plaintiff's claim in this case?
I have a balance including court costs of $3,452.56.
All right. And ma'am, how are you intending on getting that paid?
Your Honor, I explained to the plaintiff, Miss June, the apartment manager, I have put in $2,500 into my car over the last 2.5 weeks is where that money went, so I could get to and from work. She told me I've been late on my rent before and she's always gotten paid. So I'm not sure why this is actually even happening. I told her I would have her money and she still filed. So I called the court to get some information and they told me to contact the plaintiff. I contacted Miss June and her response to me was, I'm not an attorney. So I contacted the plaintiff's attorney and I left 6 voicemail messages to try to reach out to them to explain that I have filed for an SER and I have filed for other assets and to explain for the situation with the car. 6 voicemail messages. They have not returned my calls to work things out with them. So this is why we're at
Okay,
this
ma'am,
point.
if you filed an SER, or other request for assistance in your packet, you'll see a rental assistance form. You need to fill that out, put the necessary information in and file it with the court by Wednesday. What I will do is I will adjourn this out to the 18th, 2025 at 12 noon. You'll need to appear at the courthouse in person and then we'll work through what the issues are.
Okay, what kind of paperwork, what kind of packet do I need to fill out, Your Honor?
In your packet, there's a form called a rental assistance form. I need that information filled out on there with the tracking number for your SCR. And you need to do that by Wednesday.
Okay.
All right?
All right, perfect.
And
Thank you.
We'll see you next week in person. Thank you.
Okay, thank you. Bye.
River Drive Apartments versus Jason Pennington.
Jillian Engen for plaintiff.
All right, what is plaintiff's claim in this case? Mr. Pennington's here.
Your Honor, I have a balance including court costs of $2,330.56. I did speak with Mr. Pennington yesterday, and it sounds like he has some an application for rental assistance in.
Is that correct, sir?
Yes, and the other reason why I fell behind, I was in jail from March 14th of this year to the 26th of this year, and my aunt and uncle had to pay $5,000 to get me out of bond, to get me out of court, and I am on home confinement and GPS tethering, so it kind of made it hard to find work.
Got it. Okay. So what you'll need to do is you'll need to fill out that rental assistance form with the information necessary on it.
Is this the correct one where it says rental assistance proof of application And,
Yes, sir.
okay,
Yes, sir.
in the
Oh, you'll need
meantime,
to fill that out, get that to the court by Wednesday.
okay, I'm gonna continue making payments
All right.
so it shows that I still want to live here. I still want, all that fun stuff.
All right. Real good. So
All right.
get that to the court, and then
Okay.
I will set a hearing for July 18th, 2025 at 12 p.m.
You
That's
said,
an in-person hearing. I don't know
okay.
who that is. That's an in-person hearing. All right? And
Do you
we'll
have
see
a
where we go.
Do you have a reference number in case they ask for it?
Reference number.
Would it be the case number, Mr. Pennington?
I'm not sure what they said there had to be like either a reference number or a case number. I'm not exactly sure. What
Is that on the, are you talking about on the rental assistance form?
Yes, that's correct.
If you applied for did you apply for an SER?
No, I have not. That was
okay. So, sir,
yeah.
One of the things you need to do is call Hawk.
Okay.
All right, because there is the Rising Hope program. I don't know if you've got a voucher, but there may be some assistance for those that have been touched by the criminal justice system. Okay.
Okay. I will. Go ahead.
Oh, sorry, Mr. Pennington, you have an appointment with Hawk, don't you?
Yeah, on Monday, yes.
On Monday.
On Monday.
Yep.
So you won't, I don't think you'll have a tracking number for that. But Your Honor, I don't know how people have been filling out when they have a Hawk.
I don't either.
But Mr.
I'm
Pennington,
usually, if they've contacted Hawk, I've usually marked that in the file and I'll mark this one.
that's
Okay.
fine, Your
Okay.
Honor.
All right, I'll keep you guys on in the loop of everything. So that way, you don't think I'm hiding or anything like that.
No worries.
That's not my MO.
Thank you.
All
sir.
right.
Thank you
Okay.
guys.
Thank you.
Have a great weekend.
You too.
Bye.
The Haven versus Kiera Scott and Donnell Johnson.
Jillian Engen for plaintiff.
Ms. Scott is present. Time prompt.
Oh, there she is.
Hello. Can you hear me? Did it unmute?
Yes, I can hear you. We can see you. Okay. What's plaintiff's claim in this case?
I have a balance including court costs of $4,861.58.
All right, Ms. Scott, how are you intending on getting that paid?
Your Honor, so I filed through Hawk. I completed my application. But I just wanted to say for the record that on December 23rd, I slipped and fell due to untreated ice, and I have several spinal injuries. I understand that that's not what today is for, but I just wanted to say that that's the reason why I've been having difficulties paying. I've been staying at the Haven for 6 years, and it's only been one other time, and that was throughout the pandemic, and I was 1 month behind. This has been the issue. But
all right, why don't you go ahead?
No, I was just gonna say that's pretty much what's been going on, and I haven't been able to work all year.
Okay. Have you applied for any assistance, ma'am?
Yes, through Hawk, and I submitted all my information. I'm just waiting for them to get back with me.
Okay. Did you do an SCR?
I'm not sure what it was I did. They did an intake thing, and then they asked me to send in the information. I'm not sure exactly what it was.
All right. What I suggest you do is contact the plaintiff's attorney's office, see if you can work something out. I will adjourn this to July 18th, 2025 at 12 noon.
Okay, thank you.
All right, thank you. Court calls the case of Augusta Woods versus, is it Juline Ballard?
Good morning, Your Honor. John Capitan appearing on behalf of Augusta Woods.
Okay.
And this is Shelby Mink. Julie Ballard was my grandmother.
Okay. Are you residing at the premises now, ma'am, or?
Yes, I've been here since October 30th of 2023.
Okay. All right. Council, how much is owing on this?
Inclusive of costs, $1,282.94.
All right. And ma'am, how are you intending on getting that paid?
So I have reached out to Hawk, and they are agreeing to work with me. I'm also seeking legal counsel right now. Unfortunately, my lawyer is out of town, so he did ask me to ask for a week adjournment.
All right. I will adjourn this matter then to July 18th, 2025 at 1 p.m. That's an in-person hearing.
All right, thank
Okay,
you.
and then he did want me to also mention that my grandmother has passed. So
Yes,
I just want to put that there. Okay.
I get that. Okay. So let your attorney
All right, cool.
know that's an in-person hearing next week at 1. All right?
At 1.
Thank you.
Thank you so much. All right. Bye.
Augusta Woods versus Paul Reedy.
John Capitan appearing on behalf of the plaintiff.
All right, there's Mr. Reedy. Okay. How much is owing on this?
$679.03.
All right. Mr. Reedy, how are you gonna get that paid, sir?
I should have it paid by next Friday. Before I know it had to be before court. So by Thursday, working on it right now.
Okay.
If I
So
can
you're
get
gonna
this,
pay it by Thursday?
yeah, man, if I can get this, I'm like back a month. If I can just get this straightened up real quick, you won't see me again. I apologize.
No, it's okay, Mr. Reedy. You always, I see you. You always come through. I'm not worried about it. All right.
I appreciate it. It's
Okay.
embarrassing. Embarrassing.
Well,
What do you
life
do?
happens.
For
Life
sure.
happens, right? Okay.
For sure.
I'll adjourn this out July 18th, 2025, 1 p.m. All right, that's an in-person hearing, but you know the routine, Mr. Reedy. You get it
Yes,
paid, you
sir.
don't need to be here.
Yes,
Okay?
I appreciate it. Have a good weekend.
You do the same.
Thank you.
Bio Properties versus Jessica Bolden.
John Capitan appearing on behalf of the plaintiff.
Jessica Bolden. I do not have them present. If you'd like to take a default, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do.
Go ahead, sir.
We move for a default judgment of possession only. Rent to retain is $1,124.18. Cost of $175. Total is $1,299.18. Ask for the writ to issue after July 21st. No money judgment.
All right, judgment to the plaintiff. By default for possession, redemption amount, any amount requested, writ issue in 10 days. Bio Properties versus Jacqueline Poole.
John Capitan appearing on behalf of the plaintiff.
Jacqueline Poole. There's no response. You may proceed.
Move for a default judgment of possession only. Rent retained is $1,536.76. Cost of $175 for a total of $1,711.76. We ask for a writ to issue after July 21st. No money judgment.
Judgment to the plaintiff by default for possession. Redemption amount, any amount requested with the writ issue 10 days. Upland Green Apartments versus Ben Davidson.
John Capitan appearing on behalf of Upland Green Apartments.
Do you not have Mr. Davidson?
Ben Davidson or Davidson Benjamin? No response. You may proceed.
Move for a default judgment of possession only. Rent to retain is $3,990. Cost of $186 for a total of $4,176. We ask for the writ to issue after July 21st. No money judgment.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested, writ issue in 10 days. Woodview Commons versus Kevin McCullough.
John Capitan appearing on behalf of the plaintiff.
Do not have Mr. McCullough.
Kevin McCullough. No response. You may proceed.
Move for a default judgment of possession only. Rent to retain is $5,742.07. Cost of $175 for a total of $5,917.07. We ask that the writ issue after July 21st. No money judgment.
Judgment to the plaintiff by default for possession, redemption amount in the amount requested, writ issue in 10 days. Arbor Meadows versus Stone Ho.
John Capitan appearing on behalf of the plaintiff.
Ms. Ho is not checked in.
Stone Ho, they are not present. You may proceed.
Move for
We're
default.
here. I'm sorry.
Oh,
Yeah,
she's here.
All right.
we're here.
Okay, Ms. Ho's here. Does she need a interpreter?
She speaks pretty good English.
Okay,
Mm-hmm.
all right. And you are who, ma'am?
I am Kalila Horton. I'm the CHW here at Washtenaw County Health Department, and I'm helping her with her housing case.
Got it. Okay. I'll let you proceed on that, certainly. How much is owing, counsel?
Including cost of $175, the total is $2,402.28. 2402.28.
All right. And how is she intending on getting that paid?
Well, I reached out to Friends Indeed for funding. We called Hawk. Hawk denied her funding. They said she didn't qualify, and of course, you have to get approved through Hawk to get funding from SOS. So those three agencies are out. Friends Indeed said that.
Excuse me one moment, ma'am. There's a gentleman that's online on Samsung. You're smoking. You are in a courtroom. You need to put that out. Go ahead, ma'am. I'm sorry.
Friends Indeed denied her due to her income documents. Mrs. Doan, she works in a nail shop and she gets paid cash. And the letter that I got from her employer, they would not accept. I work with them a lot, and they just wouldn't do that. So that's part of their requirements. So she doesn't get Medicaid or food stamps, so she wouldn't qualify for an SCR. So at this point, I don't know. This is a lot. Her mom is in hospice. She's taking care of her mom, and she's not working because she can pass any day now. She does own the trailer. She just owes for lot fees, and so this is like really difficult.
All right.
Yeah.
So why don't you contact plaintiff's office and see if something can be worked out for Ms. Ho? Okay.
Can I have the number for that, please?
It should. Do you have Ms. Ho's paperwork? Do you have her court paperwork?
She doesn't.
The attorney's number is at the top of that. Do you have that or no?
I can provide it, Your Honor, if you
go ahead. Go ahead, counsel.
All right. It's 248-851-8000.
Okay. I would like to add that we did call legal aid to leave a message. We're just waiting on them to call back. So just want to.
Okay. How old is Ms. Ho? Do you know?
How old are you?
Is she over 60?
No. 52.
No.
52.
Okay. I was just thinking about other resources that might be out there. All right. What I will do is I will adjourn this to July 18th, 2025 at 1 p.m.
Okay.
All right.
I will call the number.
All right.
Thank you for the advice.
All right. Thank you, Your Honor.
Yes, sir.
I was going to say, have a great day or weekend.
Okay. Yes, you too. All right. And, I don't know why they wouldn't take proof of income from a nail salon. I have a daughter. They get a lot of money through there. I know it.
You know what? They want her to have actual pay stubs. And I feel like creating a pay stub will be fraudulent. If he pays cash, he should,
No, I get you. And that I understand their rules. They should know that the money's coming through there, though.
Exactly.
All right.
Okay.
All right. Thank you. Court calls the case of Lakestone Apartments versus Nicole Sanborn.
Good morning, Your Honor. Attorney Samantha Sprague, P. 1931, appearing on behalf of the plaintiff.
Nicole Sanborn?
She's here.
She is.
I am.
Okay, there she is.
Hi,
All
sorry,
right.
that took a sec.
No, it's okay. What is plaintiff's claim in this case?
We do show that there is past due rent in the amount of $1,520.85, with court costs the amount of $232 for a total due owing of $1,752.85.
All right. And Ms. Sanborn, how are you intending on getting that paid?
So I have applied for SER online, through DHS. I haven't gotten a verdict on that yet. I just checked in this morning on my MyBridges account online. It's not saying whether it was approved or denied. And then I also called Hawk. I have a meeting with SOS on Tuesday at 3 p.m. I think it's a virtual meeting to hopefully secure funding for that. I'm currently disabled right now and haven't been working for a while, like over a year at the moment. And unfortunately, my disability case, for reasons I won't bore you with, has just been taking a really long time to get through and get approved because mostly because my doctor and issues with my medical records not being complete, not being sent over to my disability lawyer. And I can't work in the meantime while I'm waiting for that to get approved. So that is the reason why I'm behind, but I've got
All
plans
right,
to get it
here's what
paid, hopefully.
here's what I'm gonna do. In your packet, there's a rental assistance form. You need to fill that out. You need to make sure that the tracking number for your SER is on that form. It needs to be filed with the court by Wednesday.
Tracking number
Okay?
for my SER. Okay, and then you said turn that on Wednesday?
Yeah, well, before Wednesday or before.
Okay, because yeah, my SOS virtual meeting is on Tuesday. So it wouldn't be any earlier
Okay.
than that.
So get that into the court by that time. And I will adjourn this out to the 18th at 2 p.m. All
Okay,
right, that's an
is there
in-person hearing, ma'am.
is there any way I might be able to get permission to do another virtual? Because I don't have transportation right now, and like I said, being
Gotcha. Okay,
disabled,
you
being
can
on the
submit
bus.
a form and then the court will consider it. Okay?
Which form? Sorry, sir.
It's a Zoom request form.
Zoom request form.
My coordinator is sending her email to you so that we'll get that form to you so you can submit it, okay?
Okay, thank you so much.
Thank you. Lakestone Apartments versus Lila Cochran.
Good morning, Your Honor. Attorney Samantha Sprague, the 81931, appearing on behalf of the plaintiff.
I have a caseworker signed in, Mandy DeBono.
Okay.
And I'm here. Hello,
Hello, what's your name?
Leela Cochran.
Okay, and your caseworker. Okay, got it. We've got two screens here. Okay. All right. What is the plaintiff's claim on this account?
Yes, Your Honor, we are here on a non-payment of rent in the amount of $837.31, along with court costs of $232 for a total due owing of $1,069.31.
Okay, Ms. Cochran, how are you intending on trying to get that paid? Mr. Bono, speak up if you have something also.
Sure, yes. So I helped Ms. Cochran apply for Barrier Busters funding. Now, this amount of $1,069.31 is more than I was aware of her owing. We went off of what the court paperwork, and did you guys
Okay.
receive Barrier Busters money for Miss Johnson? Or Miss
This is
Johnson?
Lakestone
Johnson?
Manager Saber McBride. And yes, we did. So I showed we just received 2 checks this morning from Barrier Busters, I believe.
And how much was that total?
Let me look here real quick. Sorry. I got one check for $572.48.
Okay,
And another, let's see, I believe there's another one in here for $730.44.
so,
So,
okay, so now I'm really lost because that would seem to me, has the total you gave me, counsel, did that take into account those checks?
I'm pulling up her file right now, Your Honor, so that way I can confirm. I don't believe that had the
Does
checks
not.
on there. Because as my client had indicated, it sounds like she just received those this morning.
Yep.
And with them being, is that correct, Ms. McBride?
Yes, it is correct.
So that means this case should be dismissed because
Your Honor, as soon as they
Well,
post,
the first check for 730.44, actually, I think that they got it a day or two ago because I came.
it doesn't matter. That is irrelevant to me right now.
Okay.
It just seems to me that the 1,069.31, if I have almost $1,300 that was received this morning, then her account's paid. So here's what I'll do, Ms. Cochran and Mr. Bono, so you know where we'll go. I'm going to adjourn this out 1 week to the 18th, 2025 at 2 p.m. That's an in-person hearing, but once those checks go in, you may not need to come down, and this case will likely be dismissed.
Okay, would I be able to request a Zoom meeting because I don't have any transportation?
Okay, ma'am, you'll have to submit the form.
Okay.
Those are in-person hearings.
Okay.
All right.
Okay. Thank you.
Thank
Okay, thanks.
Thank you, folks. Court calls the case of Lakestone Apartments versus Cheryl McCoy.
good morning, Your Honor, Attorney Samantha Pete, 1931, appearing on behalf of the plaintiff.
Don't have Ms. McCoy.
Cheryl McCoy. There is no response. I don't think I've had you sworn. So if you raise your right hand, do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
I'm
Go
here,
ahead.
sir. I'm here.
Okay, hold
I'm
on.
here.
Where is she?
Okay.
I'm here, sir. I'm on the phone.
Okay.
Hello? Hello?
What's your name?
Cheryl McCoy.
Okay. What is the plaintiff's claim in this case?
Yes, Your Honor, this is a non-payment of rent. We do show that there is a past due balance in the amount of $1,485.13, along with court costs in the amount of $232, for a total due and owing of $1,717.13.
All right, Ms. McCoy, how are you intending on getting that paid?
I have my social worker from the U of M said that they were going to take care of that for me. I think she said she emailed the manager.
Yes. Yes, Cheryl, I did get that information and I can confirm the manager, the social worker has reached out to me. And so they are working with Cheryl to figure out the balance, and I've sent them a ledger. Yes.
All right. So what I'll do is I'll adjourn this out the 18th, 2025, 2 p.m.
Yes.
2 p.m. That's an in-person hearing, but hopefully it can be worked out prior to that date.
Okay, Judge Simpson. I don't have a car neither. I have bad knees.
Ma'am, then typically my second hearings are in person. So you're going to have to, between now and then, attempt to try to arrange transportation.
Okay, so I can't. Okay, so when is it?
The 18th at 2 p.m.
I'm washing off
Yes, ma'am.
at 2 p.m.
Yes, ma'am.
Okay, because
thank you.
It should be, but if they receive the money before then, do I have to come in?
If everything is paid and they're going to dismiss the case, you don't need to be here.
All right, thank you.
But you
So
have
that's
to make
right.
sure everything's paid.
Okay, I sure will.
Thank you. Lakestone Apartments
you.
versus Lolitha Jones.
Attorney Samantha Sprague, P81931, appearing on behalf of the plaintiff.
And there's Miss Jones. She's right there. All right. What is plaintiff's claim in this case?
Yes, Your Honor, this is a non-payment of rent. We do show that currently there is past due rent in the amount of $2,435.20, along with court costs of $252 for a total due owing of $2,687.20.
All right. Miss Jones, how are you intending on getting that paid?
Yes, Your Honor. I was gonna pay 1,000 by next week, and I was gonna take the other half out of my 401k. So just waiting back the forms that I got to send in to Ford to get the money from there.
Okay. So you'll pay the 1,000 by what day next week?
Next week, 11th, I would say the 18th.
Okay. Can you pay it early in the day, please?
Yes, Your Honor.
All right. So I'm going to mark the file that you're going to pay 1,000 then. I'm going to adjourn this matter over to the 18th, next Friday at 2 p.m. All right.
Yes, Your Honor.
And that's an in-person hearing. Okay. And so you pay the 1,000 and then we'll see where we go with the balance. Okay. If the 401k is not in yet.
Yes, Your Honor.
All right. Thank you, ma'am. Lakestone Apartments versus Amanda Hentula.
Attorney Samantha Sprague, P81931, appearing on behalf of the plaintiff.
I'm here, Your
Yes,
Honor.
Okay, I need a camera, ma'am. And while you do that, what is plaintiff's claim?
Yes, Your Honor, we do show this as a non-payment of rent in the amount of $5,478.72, along with court cost of $252 for a total due owing of $5,730.72.
All right. And Ms. Hentula, how are you intending on getting that paid?
I'm going to apply for a hardship withdrawal through my 401k and also apply for assistance through SER and Contact Hawk. I feel like there has been a misunderstanding between me and Lakestone Apartments. I signed a lease renewal at the beginning of April, and the lease addendum that was attached to my renewal had a different rent amount than what Lakestone wants me to pay, and they want me to sign a new lease addendum with a different rent amount on it. So it's a little bit of a confusing situation.
All right. Well, you may want to contact legal services to see if they can help you regarding that lease addendum issue also, okay? I'll adjourn this matter out to July 18, 2025 at 2 p.m. And hopefully then you'll have submitted the hardship withdrawal forms. And have you applied for SER, ma'am?
I have not yet because I'm not sure exactly like legally what my lease amount is, because the lease addendum that I signed and gave to Lakestone has a different amount than.
Gotcha. Okay, I see what the problem
sure.
is. Okay, so here's what I'll do. I'll adjourn it out to that time. That's in person. Contact legal services. Bring all of your documentation with you. We'll try to sort at least that part out, okay?
Okay, thank you.
All right, thank you. Lakestone Apartments versus Aisha Frederick.
Good morning, Your Honor. Attorney Samantha Sprague, P81931, appearing on behalf of the plaintiff.
Aisha Frederick? Frederick, I don't have her. You may proceed, counsel.
Yes, Your Honor, at this time, we would respectfully request a default judgment. We do show that there is past due rent in the amount of $2,256.69, along with court costs in the amount of $200.
Hold on.
Hello.
Hello.
Hi, I'm here. Hello.
What's your name?
My name is Aisha Frederick. For some reason,
Okay.
the Zoom logged the password has not been working for me all day long. I think that's something that needs to be,
Okay,
I don't know.
so council, how much is owing on Miss Frederick Chase?
Yes, we do
Total?
show that there is past due went in $2,256.69 and court costs of $252 for a total due and owing of $2,508.69.
All right, Miss Frederick, how are you intending on getting that paid?
I am currently working with SOS. They are working with me, and in fact, that she said that they have limited funding. I applied for SER, which I was denied. So I'm just waiting for them to hear what they have to say.
Here's what I will do. I will, if you're waiting on SOS, I will adjourn this matter to July 18th, 2025, 2 p.m. 2 p.m. That's an in-person hearing. You'll need to appear at the court and we'll see where we go from there, okay?
Okay, thank you.
Thank you. Lakestone Apartments versus Maxine Mercier. Mercier or Mercier?
Mercier.
All right, Mercier, she's here. Thank you. All right.
You're welcome.
You pick it up.
Yeah.
8. All right. What is plaintiff's claim in this case?
Good morning, Your Honor. Attorney Samantha Pete, 1931, appearing on behalf of the plaintiff. This is a non-payment of rent. We do think there is past due rent in the amount of $6,045.47, along with court costs of $252. That does bring us to a total of $6,297.47.
And ma'am, how are you intending on getting this paid?
I'm currently working with Hawk right now, and I pulled a hardship on my 401k. I'm waiting on that check, and then I get a check next week of a grant that I should receive it next Wednesday or Thursday. And then Hawk, once I get it below 3,000, Hawk said that they would be willing to help me, but I had to get it below the 3,000 mark.
3,000. So, ma'am, so how much are you going to be able to pay next week?
I should have at least 3,500 to give them.
All right. So I'll mark the file and I'll say you're going to try to do that by the 17th. Okay.
Yes.
All right. So I'll put that in there. I'll adjourn this out to July 18th, 2025 at 2 p.m. That's an in-person hearing, so you'll need to come down to the courthouse. All right. But if you get that check
right.
on Wednesday and can get that into them, get that in as soon as you possibly can. Okay.
Okay, will do.
All right. Thank you. And
Thank you.
counsel, is that it for you?
I believe so, Your Honor. Have a great day.
Okay. All right. You take care. Darlene Morin versus Emil Tito.
Hello, I'm here.
Oh, all right. And Emil Tito.
I'm here,
All
Your
right.
Honor.
Okay, this is a termination case.
Yes, please.
And was there any?
Currently, he owes $2,225.
But you're seeking to terminate his tenancy.
Yes, please, and try to collect the money.
Okay, but this case, I don't know if you filed a case for the back rent at this point.
I did.
But you did file a supplemental complaint. I see it.
Yes.
Okay, but it's a termination. And Sir Tito, what's your position on this?
Yes, I was out of work for about a month and a half. Me and Miss Morin have had an agreement worked out to pay in about 200 a week or 400 every 2 weeks, and I'm paying on that. So my position is that an adjournment to just see if I continue to keep paying.
Okay, but let me just make sure I got it clear. I think Miss Morin, do you want him out?
Yes, please. Because he has lied to me at least 7 times. He promises that he's gonna pay 200. It started in December when he only paid 275, and then
All right.
March,
So,
April,
ma'am, I
May,
only
June.
asked the question because paying the rent won't solve the problem. She wishes that you leave the premises, sir.
All right.
So here's what I'll do. I'm going to adjourn this out to July 18th, 2025 at what time? 2 p.m. That's an in-person hearing, so I'll need both of you here. We'll work out whatever details we need to work out. But you ought to be clear, Mr. Tito. She has filed a termination case and she wants you to leave the premises.
Yes, sir. Yes, Your Honor.
All right. Thank you. We'll see you then.
All right, thank you.
Thank you both.
No.
14A stands in recess.
14A, Department County, Washington,
You may be seated. Court does call the case of Onyx Real Estate Solutions versus Jennifer Smith.
Good morning, Your Honor. Attorney Hamza Sob on behalf of the plaintiff.
Your name?
Jennifer Ruth Smith.
All right, where are we on this?
Your Honor, we entered into a consent agreement. Currently, the rent to retain is $4,000. Court costs are $175. The total outstanding balance is $4,175. Under paragraph 10 of the proposed order, it states defendant shall pay $835 starting July 21st, 2025, and then every month moving forward on the 1st till the balance is paid. Defendant must also stay current with rent moving forward, and then Ms. Smith has signed the proposed order as well.
All right. And so it's $835 plus rent.
Yes, plus the $925.
All right.
I'm finally back to work.
Pardon?
I'm finally back.
Finally back. Great. All right. And you have any questions regarding this consent judgment, ma'am?
Just if something comes up, what happens to me?
Okay. What do you mean?
I was dealing with cancer.
Yes.
And I had to take time off work for that.
Okay.
So I'm still not 100% in the clear, but I'm doing everything that I can to maintain employment and hold on to my home.
All right. Well,
I apologize for the bad handwriting, Your Honor.
Pardon?
I apologize for the bad handwriting.
Yeah. I don't think.
I do believe
I
that
don't
the
think there's
amount is
enough.
below.
I'm sorry to make this up, but anyway, if you don't pay this, they can seek to get an order of eviction.
Okay.
Okay.
So communication.
Yeah, I would think so. I would say this, that under your circumstances, I would hope they're obviously working with you. But it seems to me if you get through, or as you're working through this, if for whatever reason something happens, I'll put it this way, I would hope that plaintiff would work with you as best that they can.
All right, thank you.
All right, so I'll have that message sent. And if not, then you can always file a motion with the court,
Okay.
Seeking some type of relief because of circumstances you couldn't anticipate. All right?
Thank you.
How's that for an answer?
Thank
Is
you.
that all
Your
right?
Honor. It alleviates some stress in my head right now.
Yeah, okay. And so I will sign this. Did you apprise her of the 3-day rescission?
I have not, Your Honor.
All right, ma'am, I've signed the judgment. You have 3 business days to think about this judgment. If you think that there's some legal reason, some right you didn't assert, or some other confusion on your part, you have those 3 business days to file a motion with the court to have the court consider setting this aside.
Okay.
Doesn't mean I will, but you have that time period to do that.
All right, thank you.
Okay? Good luck to you.
Thank you. I'm
Thank you,
going
Your
back to
Honor.
work.
Have a great day.
Court does call the case of Mrs. Haverkamp LLC versus Chase Hyatt.
Good afternoon, Your Honor. David Fainter on behalf of the plaintiff.
Name?
Hyatt.
All right.
Your Honor, Mr. Hyatt and I've come to an agreement. The amount of rent that's owed is $775, court cost of $175 for a total of $950. We've agreed that that amount has to be paid by July 21st, or he could be evicted. He says he's made some payments that I'm unable to verify, but he said he'll have the whole thing paid by next Friday. So I think the 21st works. And I'm getting old.
In form of a consent judgment.
Yes, consent judgment.
All right.
I don't remember whether I advised him of his rights under the court rule.
That's fine. All right. And do you have any questions regarding anything on this judgment?
No.
All right. I'm going to sign off on the judgment, and then by consent, you do have 3 business days to think about this. If you believe that there's some legal reason, some confusion, or some right you didn't assert, you would have to file a motion with the court within those 3 business days to set this aside.
Okay.
Understood?
Yes.
Have a great weekend.
Thank you, Your Honor.
Court does call the case of Sandy McFiddish versus Jamie Leslie. Hello.
I'm Jamie Leslie.
I have numbers first. Your Honor, David Faintier, on behalf of the plaintiff, I have a signed conditional dismissal in this case. The rent owing in the amount of $2,071.24, court cost of $175 for a total of $2246.24. Miss Leslie and I have agreed to a payment plan where she's going to pay $2,000 a month starting August 15th. Her rent is normally $1,465, so she's going to basically be paying $2,000 by the 15th. $1,465 will go toward the current rent and late fee. An additional $535 will go toward that balance. It'll basically take 4 months to get caught up. I think she's going to make partial payments. I told her I don't really care as long as the whole thing is paid. As long as when I look on the balance on the ledger on the 16th, I show $2,000 since the previous month. And so I think.
Oh, okay. So it's not part of the agreement, but you're thinking you may be able to have some extra money that you can put forward, try to get it done.
Yes.
Okay. All right. Is that your understanding?
Yes.
All right. Did you have any questions regarding this conditional order dismissal?
No, thank you.
All right.
She did ask for a copy.
Yes, sorry.
She asked me for a copy. She didn't just say it to you, but she asked in the hallway.
I don't make copies. What do you? No, we'll take care of it.
Okay.
All right. So I will sign off on the conditional order dismissal. You do have 3 business days to think about this. If you believe there's some legal reason, some right you didn't assert, or some confusion on your part, you'd have to file a motion within that time frame.
Okay.
You understand that?
Yes.
All right. Thank you. Just Weidling will get a copy for you just momentarily.
Okay.
Just have a seat. Court does call the case of YPF 16 versus Christina Morgan. And Terry Jones.
David Faintier on behalf of the plaintiff.
Your name? Morgan. All right. And where are we on this?
Your Honor, we had a chance to go over her ledger in the hallway, and we've got her balance is now down to $313, which she agrees is correct. She said she's going to pay that next Friday. So I've got to be here next Friday at 1 o'clock anyway. Can we adjourn this till next Friday? And then if we come to court and she's got it down to 0, I'll just be dismissing.
Okay. That sound good to you?
Absolutely.
Okay, so I just want to make sure logistically, so we're clear. When are you going to pay that? Are you going to pay that on Friday?
Friday morning. Just like
Friday morning.
But she pays it online through her
So
card.
you'll
through
be
her
able
card.
to see it.
She'll be able to show me and I'll verify.
Okay. All right. I was just trying to see if there's a way to do it where she didn't have to show, but I get it. We'll do it that way. All right. So I will adjourn this then to July 18th, 2025 at
1 p.m.
At 1 p.m.
Thank you.
All right. Thank you. Have a great weekend. Court does call the case of YPF 16 versus Marla Borders.
We don't have any.
Good afternoon, Your Honor. David Faintier on behalf of the plaintiff.
Your name?
Marla Borders.
Thank you.
Your Honor, I've got a conditional dismissal in this case also. Her current rent is $3,285, court cost of $175 for a total of $3,460. We've agreed that starting August 5th, she's going to pay a total of $1,527.50 per month. And the reason we're doing it that way is her lease actually goes through next March. So we spread the $3,460 over that 8-month period.
Got it.
So she's going to pay $1,527.50. $1,095 will get applied towards her current rent and late fees, and then the remainder will be applied towards her arrearage. And I think that'll work out just fine.
All right. Is all of that correct, ma'am?
I agree.
All right. Do you have any questions regarding anything on here?
None at this time.
All right. And just also to apprise you, you do have, I've signed the conditional order of dismissal. You have 3 business days to think about it. If you believe that there's some legal reason, some confusion, or some right you didn't assert, you'd have to file a motion with this court within that time frame. You understand that? All right. Very good. I've signed that. Thank you, ma'am.
Now I'm done with your honors. Have a great weekend.
You do the same, sir. And Mrs. Haverkamp versus Decker, that matter's dismissed on blame.
Sorry, I forgot.
No, it's okay.
Mr. Decker is in.
Oh, is it? All right, Mr. Decker?
Hello, sir. Can you hear me?
Okay, yes, we can hear you. They dismissed the case. You have a problem with that?
Dismissal? Not at all, sir.
I didn't think so. You don't have to smile so much. All right.
Hey, it's a good thing, man. It's a blessing. I don't have too many stress and problems anymore, boss.
All right. All right. You take care. Have a great weekend.
You as well, sir. Thank you.
Thank you.
Thank you.
Arbor Meadows versus Karen Contreras Hernandez.
Front, take a look.
I think there she is. All right. Your name?
Karen Contreras Hernandez.
All right. Where are we on this case?
This is termination of tenancy matter based on failure to maintain the residence.
All right. I don't think you were here at the last hearing.
I was not. I was very much.
And she's overseas serving our country. You're aware of that?
Attorney Landman did indicate that she had said that. We don't have any proof of that other than her statements, but I'm not.
I can look in her background. I also saw some uniform and military paraphernalia at the last hearing, and I'm gonna tell you, she's overseas. She's,
I'll take her word.
all right, I mean, I'm not gonna even question that part of it. But given that fact, my understanding is there's something that has to be moved from the unit, from the property.
Outside the unit,
Pardon?
the trailer, just assorted things need to be relocated.
Okay, and my understanding, I think the gentleman that was here the last time, was that Mr. Contreras, ma'am?
Correct.
That-
My
Okay, he had indicated that they were basically waiting for her to come back stateside. That's my understanding.
Correct.
And when is that anticipated to occur, ma'am?
Okay, so I should be back. I want to say within like a month, maybe a little bit longer. But
All
that's
right.
now. Mhm.
All right.
I don't have an exact date.
Pardon?
I don't have an exact date.
Gotcha. Yeah, I understand. So, although there's the condition that's there, is anything regarding that condition a significant health hazard or life threatening in any
No,
way?
Judge.
All right, because and I stated this to Mr. Landman, I am not going to, unless forced, issue a judgment against military personnel that's overseas serving. It's just not going to happen. I think I made that clear. If you want to take it to another judge to do it, that's fine, but I'm not doing it. That's bottom line. So what I'm going to suggest, if she's anticipating being back, then you're going to, I'm going to say, put it out a month, let her get back, or at least a month, and let her get back, and then assess the situation and try to figure out what to do.
That's understandable, Your
All
Honor.
right. All right. And what branch did you say you were in?
Army?
Oh, that's right. So maybe I'll change my mind. No, I'm kidding. All right. Why don't you give me a date? About 35 plus days out.
August 15th at 3 p.m.
All right. I'm going to adjourn this to August 15th, 2025. You said 3 p.m.?
Yes.
At 3 p.m. Okay.
And this will be an in-person, correct?
This will be an in-person hearing. If for whatever reason you're not back, then what you can do is you can sign in, or somebody can let us know that you're not coming back at that particular point in time, and we'll figure something out.
Okay. sounds
Okay?
good. Yes, thank you so much, Your Honor.
All right, ma'am, thank you very much for your service. Do appreciate it. It's because of people like you that I get to do what I get to do every day, and I'm grateful, always. All right?
Thank
Take
you.
care and please be safe.
Thank you. Bye-bye.
Bye-bye. Court does call the case of Beagle Properties versus Carlos Hicks.
Printing.
How you doing? What's your name?
Carlos Hicks.
Gotcha. Thank you. All right. And what are we here on? We are here on a.
Defendant's motion to set aside the default judge. Your Honor.
All right. And what's your basis, sir?
Huh?
What's your basis? Why do you want this judgment set aside?
Because I'm literally just got relocated to a condemned spot.
Say that again, please.
I got relocated to a condemned.
Okay. So we back up. You were at Arbor One.
Mm-hmm.
Then you went. They relocated you to
the
villas
townhouses
across the street.
And that's even worse. I haven't had no hot water since 2 months, 3 months.
Okay. And so did you sign a new lease with them?
I never signed a new lease. I still have the old lease from last apartment I was in before they relocated.
Okay. So the only lease you have is the Arbor One lease.
Yes.
Okay. All right. So Mr. Hicks, when they moved you to the villas over across, right? To your understanding, what was the arrangement of what your tenancy would be?
When they moved me, I was still active going to a court with y'all before. So I was still active in court with y'all. So when they relocated me, I was still active going to court with y'all. So I still got another court date with y'all.
And that was when they were before me, and I was telling them they needed to relocate people.
Yes.
And so then they moved you over there.
Mm-hmm.
Did you sign anything saying that you were going to pay rent?
No, I never signed nothing. They just said you're getting a relocation. They gave me my keys and told me my apartment, and I was moved in, and they moved me in. I don't have no lease or nothing like that.
So I'll hear from you in a second, Ms. Kim, but
And then they only want $800, and I've been living there for like 3 months, so the math don't add up. They only want $800, and I've
Well-
been there for like 3 months, and the math don't even add up.
no, so I hear you kind of on that. They took a judgment for 1909. Council, and you may or may not know, was there something signed as to what he was gonna pay?
No, but obviously he's still gonna be obligated to pay rent if he's moved to another property. If he's not, he can't just live there for free. And the fact that he has moved over to the other side was because of the repairs that needed to be made to the 14A side.
I got you, but so when he didn't appear on June 27th, somebody, hold on a second. Somebody came up with a figure for the judgment of 1909.69. So if he didn't sign anything, or there was some other type of agreement, I'm trying to figure out where that number came from.
It was the rental obligation that he would have been under if he was still in other property. So he's moved over to the new property, he still has to pay rent.
Okay. So they took what his rental amount was when he was over at Arbor One, and that's what he was supposed to pay.
So
That's my understanding.
Yes, go ahead.
So, Brent's, other counsel, I'm sorry, I forget, Ingram, Mr. Ingram, and I just had a conversation regarding Ms. McGuire's case, and it sounds like Mr. Hicks' case is in the same posture, Your Honor. It was supposed to have been filed in 14B and not 14A if they're residing in the villas, and it's a non-payment of rent case for the villas. Mr. Ingram agreed to transfer, we agreed that they would transfer the case.
That's a good.
But I
So-
don't think I mean, I understand this is a motion to set aside the judgment, but I don't think that case should have been filed here.
I would agree.
I don't
Are
disagree.
you talking about this case now?
Oh, hold on. Don't talk, you're winning. Okay.
And I apologize to Mr. Hicks. He tried to talk to me when I was speaking with Ms. McGuire, and I didn't get a chance to get it. And Judge Washington has several of these cases before her next week regarding the same issue.
So here's what I'm gonna do on this one. I'm gonna grant the motion to set aside the case because venue was improper. This case is to be transferred to 14B. All costs associated with that transfer of the case will be borne by the plaintiff. All right? So just so you understand, case doesn't disappear. If they file all the paperwork and do everything, it's just gonna be heard at 14B.
All right.
All right?
Okay.
Okay, good luck to you.
Thank you.
And you did a good job being quiet when you were ahead. Beal Properties versus Rika McGuire.
I'm sorry, Your Honor, was this Ms. McGuire?
Yes, there she is. Come on.
And yeah, I think you're already apprised.
Yes.
Your Honor.
We'll oppose rent in this case.
Min Kim on behalf of Ms. McGuire, and Ms. McGuire is here today as well. Do you want to discuss it? The parties had time to discuss the matter and have agreed to transfer the case to 14B District Court.
Case is transferred to the 14B District Court. All costs associated with that are to be borne by the plaintiff.
Thank you.
Thank you. Take care, Ms. McGuire. Beal Properties versus Jason Mitchell. Hello, what's your name?
Jason Mitchell.
All right, where are we on this case?
Your Honor, this is a notice payment case. Right now, the outstanding balance is $30,660.03. There is cost of $335.97 for a total of $30,952.
Did you say 30,000?
It's a commercial property.
Got it.
We have been in communication with the defendant. We're willing to work with him. However, at this time, my client still would like to move forward with a judgment. And after that, then we're going to work with him because I believe his business is winding down.
Well, we did come up with an agreement. It was given to me yesterday about 3:30, 4 o'clock. And some of the things were not what we verbally agreed on.
Who were you talking to?
Was Hunter with Beal. We kind of came up with some terms. It's different terms. And the biggest problem I have is a few of the terms put me in a position in order to, I guess, complete the terms, I have to break federal and state laws. So I don't feel comfortable doing that. And if they would work with me on that, I'd be happy to.
Do you know anything about the agreement?
He's referring to an attempt at a conditional dismissal, and it has to do with the transfer of the liquor licenses That's not our position at that time, at this time, rather. Right now, we're just looking for an actual judgment. However, as I said, we are willing to work with him as far as actually winding down.
Can I show you the agreement, please?
Well, hold on. Well, this is kind of odd because the plaintiff or representative of the plaintiff gave him a proposal. He's what, and just so that I'm just transparent on the record, I don't, he can't go along with the agreement because in part, he believes that part of that agreement is illegal.
I'm not privy to that agreement. All that I know is that
Okay.
indicated that he did attempt to settle it, however, because of the defendant's objections, we backed off of a settlement in whatever terms they were doing. And that now they would like.
Well, I'm not gonna grant a judgment because obviously there was an agreement. He's saying, and so you correct me if I'm wrong, I can go along with this agreement. I just can't do these illegal things.
Yes, that is correct.
And if that's the case, I'm not gonna allow plaintiffs to say, well, you can agree with me, but you have to do something illegal in order to keep your,
Nobody's trying to get him to do anything illegal. I think it's just a misunderstanding. It's not his part. If you want, we can pass this and I can speak to him outside.
well, you can speak to, I'm gonna do this because I think you should probably look at the agreement and make sure that what they're asking of this gentleman is the proper thing. I'm gonna adjourn this to the 18th.
Thank you, sir.
2025 at 1 p.m.
Yeah, I'll want counsel to look over the agreement first.
There you go. All right.
All right, thank you.
What was that time, Your Honor?
1.
Thank you.
BO Properties versus Melissa Daly
Trying to think of it.
and Carla Hardman and Cindy Hardman.
Judge Dominic Camden appearing on behalf of the defendant, Ms. Daly. Judge, she can stay in the back. It's okay. He's probably not going to want to arrest her. The other two individuals named Judge are my client's children, I believe. So.
Okay, so this is Miss Daly.
Yes.
And then Carla and Cindy are children. Are they minors?
Yes.
Okay. All right. Right. Okay, where are we on this case?
Determination, Your Honor, based on unauthorized, and only.
An unauthorized.
Correct.
No, the second thing you said unauthorized occupant. What was the other thing?
An unauthorized pet as well.
And a pet. Okay.
Your Honor, I was just retained in this case earlier this week. My client, I think, did request a previous adjournment from 2 weeks ago to today. I was gone last week with my family, and she reached out to me at the first part of this week. So I am going to be asking the court for a bit of an adjournment to give me an opportunity to talk to her. We are also contemplating filing a counter complaint in this case based upon the condition and status of the property. I would also note that this is the third attempt to evict my client. The first attempt was dismissed by this court summarily for failure to give proper notice under the 30-day rule. The second one was dismissed, I believe, by Judge Washington for improper venue. So this is the third attempt to file this matter, and my client is contemplating filing a counter complaint for both the violation of quiet enjoyment and not keeping the property in habitable condition.
All right. I'll give you an opportunity to look at that. I will adjourn this to the 18th at 1 p.m.
Court would just oblige me 1 second to make sure my wife didn't schedule me anything.
Wow.
1 week, Your Honor.
I was gonna say, come on, Andy, you know how, but if it's
1 week
scheduling,
with 1 week, Judge.
yes.
Okay.
1 week, and at least let you figure out exactly where you are.
The other item, Judge, which I think is procedural, is there's been no written response filed in this case. So I think I'm still within the court rule in order to file the counter complaint. I do not believe I need leave.
I don't think you do either.
I don't think so.
All right.
All right.
All right.
The time, I apologize, Judge.
1 o'clock.
I'll adjust my schedule accordingly. Thank you, Your Honor.
Sir.
All right.
Thank you. Court calls case Westridge Mobile Home Park versus Jacob Veneer.
This here is it.
Pardon?
Laura Vernon, after Jacob.
Okay. There you are. Everybody's cutting out. I don't know.
It just started really pouring rain, so it might be the weather.
Okay, gotcha. All right. What's the claim in this case?
Judge, I'm sorry, attorney had been speaking.
Yeah, this was Veneer.
Yes.
Payment case, I've got 1451.46, 183.97 of cost for a total of 1635.43 as of today.
1635.43 as of today, ma'am.
I have yet to hear anything from SER. I can give Hawk a call again now that it's a greater amount because I know SER is not going to cover that entirely.
Did you file the rental assistance form?
Yes, I did. I emailed it to Ann,
She
I think.
did.
it was.
Okay, we've got something that indicates she did. I see what you did. Okay. So she's gonna be entitled to another adjournment. There's no decision yet, ma'am?
No, there is nothing. I have case history. It literally just shows it's submitted.
I'll
Um,
adjourn this to, I'll adjourn,
with the
ma'am,
greater,
I
I
suggest,
can get a hold of Hawk as well. And hopefully.
yes, you should get a hold of Hawk. I'm going to adjourn this to July 18, 2025, 1 PM.
Alrighty, thank you.
Thank you. Court does call the case of the people, West Ridge Mobile Home Park versus Jessica Holloway.
Renting.
Oh. And Billy Hubbard.
Yes, sir.
That's probably you.
Yes.
Okay, all right. Okay, where are we on this case?
Right now I have rented 760 for a cost of $237.94 for a total of $1,006.98.
1,698. All right. Sir, how are you guys gonna get this paid?
I've been making payments on it every week, but I just talked this morning to start up a payment plan for the amount that's overdue right now. Because every month that I pay it, I only have a week after that to pay the next month's rent. So it's been kicking in with late fees and court fees. So I'm trying to work out something right now to get the amount that I owe right now placed to the side and put a payment plan in order. So every month I can pay like $200 more than what my rent is to knock that down until it's paid off. So I'll know more probably within a day or so. I got to turn in the paperwork to my office today. But I have another
which
payment.
office?
The office of the mobile home park, where they told me if I submitted to them in writing with dates on the dates that I'd be able to pay, they can place it up to their boss and let me know if that'll work for them.
Gotcha. Okay, that's, I now I get what you're trying to explain to me. You took that agreement that you just explained.
Yes.
You explained that to them. They
Yes.
want it in writing.
Yes.
That just hasn't happened yet. And so you
Exactly.
don't have a yes or no.
Don't have a yes or no, but I still will be able to make payments on this every week.
You don't know anything about it, do you? Or do you?
I saw it indicated that he had applied, but other than that, no.
All right.
I'm the property manager of Westridge Mobile Home Park. I'm Cindy.
Yes.
I spoke with Jessica today. They did not give me any details of what the payment arrangement would be. I told them that they needed to put exactly what they could pay and when they could pay, but I could not tell them if our corporate office would approve it. And then I would submit it to find out if they could make payments. But so far, they haven't given me any actual details.
That's exactly what Mr. Hubbard was saying.
Yeah,
He was
perfect.
saying he's got it kind of laid out in his mind, but that it had to be in writing with specific dates.
Yes.
And
Perfect.
he's gonna do that. Can you get that
I'll
done
get
by
that
Monday?
today. That'll
or-
be done today.
All right, so here's what I'm gonna do, given that's where we are, I'll go to the 18th, 2025 at 1 PM, give you a chance to do that, and see if we can get it up to change. See.
Thank you.
Sound good? All right, have a good weekend.
Thank you.
Is that it for that month? It is? Oh, that was quick. I am efficient.
Yes, you are.
Thank you for signing on to that, Ann. 14 days.
So Westridge lady, what her name is?
Ma'am, the manager from Westridge.
Yes.
You Westwood women. What can you get? What's your name?
Cynthia Walentovich, WALENTOWICZ.
Thank you.
You're welcome. Have a good day.
All right, take care. Court now stands in recess. You may be seated. Chelsea Hospitality Group versus Carla Giovanni.
Good afternoon, Your Honor. Jose LeBron on behalf of the petitioners on this matter, Chelsea Hospitality Group LLC. I believe we were up this afternoon based on the fact that the second note or request for mailing hadn't been entered previously by the company. However, I do have that was submitted that first week of July and entered, I think, July 3rd.
Yes, there was a second mailing. Well, hold on a second. What day? Why did they do that? Okay, I see what they did. It really, let me just tell you, it isn't, it's for naught in a lot of ways. What I was explaining, I don't know who appeared the first time on this.
Yeah, the company.
That had they originally filed it with the second mailing, I could have given a default last time.
Yep.
The fact that I can give a default today, regardless of whether or not there was a second mailing.
Okay, excellent.
Okay, so I guess thanks for the cash.
That works, yeah.
If you'd like to take it to Paul, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
All right, what is your claim?
Your Honor, so since the date of the notice, what was owed was 1,765. That was May 27th. Since then, it's been approximately 45 days. The fee is $59 per day. So since then, it's accumulated about 2,655. And then within court costs, it's about $110.10, Your Honor.
Counsel, we got another problem.
Certainly.
Now that I look at this, my file and cover sheet is marked that this is a termination case based upon the complaint, and that is true. The complaint that's filed.
And yeah, Your Honor, I believe my clients too, in the end, are seeking more so an in rem judgment for possession of the property. If they're not able, I don't think this.
Well, okay, so let me just tell you that, well, who did all this? Okay, so your complaint and your notice don't match.
Okay.
So the demand or the notice to quit is for non-payment of rent.
Correct.
The complaint is for termination of tenancy. So here goes the other problem. You can correct by filing an amended complaint and then serving that amended complaint for non-payment of rent because I have the notice as a non-payment.
Mm-hmm.
It doesn't work the opposite way because you can't give 30-day notice to allow me to proceed on that complaint. Or I can dismiss the whole thing out and it can start all over.
Yeah.
That was just my option.
Yeah, no, and when I discussed it with the clients, that was my original option. But I think, Your Honor, if you're saying that we're able to amend the complaint without having to redo the notice,
yes.
Then as far as time efficiency, I believe that's to the best benefit of my
So I think if you try to get that out today, it's going to have to be served, or at least there has to be a mailing, but it has to be served at least 3 days before the next hearing. So I can set this for the 18th. I do not have the 25th, correct? So I can set it for the 18th or August 1st.
It would have to be the 18th from Your Honor.
18th, very good. Then I'll adjourn this matter to July 18th, 2025 at 2 p.m.
And Your Honor, are we able to appear by Zoom for this one?
No.
In person. Thank you.
Why? Where do you have to drive from?
Actually, now just Michigan, but I also work in Chicago, so I'm actually back and forth quite a bit.
I don't care. No, I'm just kidding. If you submit the form, I'll take a look at it.
Thank you, Your Honor.
Make a decision. All right, thank you. You do the same. Court does call the case of Carl Schultz versus Sadie George.
Not George.
Yeah, but well,
Sorry.
I know I have to go by what it's under.
Where would you like me?
You're on that side. Go ahead, Counsel.
Good afternoon, Natalie Benici, appearing for plaintiff.
All right, and your name?
Sadie Gore.
Okay. All right, this is a termination case, and where are we on this?
Your Honor, you adjourned this 2 weeks. The defendant said she had some documents to submit to the court and myself that we were not served with. I have been provided a copy of the documents that she wanted to submit to the court. I don't believe the documents have any relevance to termination of a tenancy. So I asked that we proceed today with termination.
Go ahead, ma'am.
Sadie Gore. I moved into the house with Mr. Schultz about 2.5 years ago or so. I worked and I paid rent. I worked with a friend. I was never late. I ended up getting sick last year. I had cancer and I was recently diagnosed with a rare neurological disorder. Him and his father both told me I could stay until I got my disability or I was able to pay. During that time, and there's been trouble since the day I moved in, Your Honor, I wrote the paper. I don't want to get too big, but the defendant has a lot of issues with mental instability and psychosis, and I've helped him through that. Even when I was a paying tenant, he would come to my room and ask to look for hidden cameras. His sister can vouch for that. She's his lawyer. She is his family. I broke my phone that had that information on it. However, during that time too, he did take another tenant by the name of Chelsea Pritchell, and I inquired with him because I couldn't walk at the time. I wanted to move to the upstairs room, and he said she was moving in and she's crazy and she doesn't know how long to stay. Since then, there's been nothing but loud arguments, fights, alcoholic bottles everywhere. This recent fight that they got into, she was screaming and yelling that I was a horrible, disgusting human being with diseases and that she should push me down the stairs because I'm going to die anyways. And he messaged me saying, I'm so sorry, and I turned that into the court, that he said, I'm sorry that she treated you this way, everything for the last year, but he did nothing about it. When she was saying those things, he was loudly coming to my door, loudly.
Okay, ma'am,
Sorry,
ma'am,
sorry,
there is no lease, is that correct?
correct.
All right. So the real, go ahead.
Oh, I did file with the Disability Determined Services. They said it could be any day now. I did submit information that I've done that. I'm here with this. My doctor has to fill in a few more papers. I see him in a couple of weeks, and I was going to ask him about that. But for right now, I literally have no place to live, 2 dogs, and a neurological disease that I'm waiting on disability papers or information from. I don't bother them since we've been in this litigation. It's been very quiet and peaceful. There was only one fight, and when I asked them to stop, they did, and they did not bring my name up.
All right. So let me ask this. Are the parties able to work out a move out date or no?
I think that's completely up to the defendant when she can move out. I mean, she hasn't paid.
No. But I mean, she's got, from what I can understand, certain circumstances where it's going to be difficult for her to move immediately. And I don't know if there's any leeway on the plaintiff's side to give additional time regarding a move out.
She told me in early May that she was expecting her disability in about 2 weeks. So that was in the middle of May. We're now into the middle of July. So, you know, these things take time. If she just applied for it, I don't anticipate her getting disability within a few months. Those take a couple of years.
I didn't just file. I filed in September of 2025. They told me I'm on the last leg, and they're waiting.
September of 25?
September 25, September 20th of 25. Yes, and I have a letter here from May saying that.
Well, hold on. That can't be right unless I just went into a time.
24, I'm sorry.
Thank you. All right, go ahead.
And they said they're just waiting on a few more things from my doctor, another one of my doctors. I never told her 2 weeks. I told her, they've told me 2 weeks, 3 months, January. I've heard all kinds of things from them, talking to them, but I have been keeping up with them. I have told her that I don't know, 3-4 months would be wonderful if they would give that to me. He told me that he can't let me stay because his girlfriend, the one that is in question, told him that she will leave. That is what he has told me several times, that she pays rent, so she gets to stay.
Okay. So here's the question. How much time are you asking for?
4 months would be great.
4 months? Okay, I'm just gonna take realistically, that's not gonna happen.
90 days?
That there isn't, and just let me finish, I don't see in here a legal basis by which you can stay. Okay, so it's gonna come down to a point of you having to leave. And I usually prefer it if the parties can work that out, but if they can't, then I just make the call. So I try to ask the parties, how much time let's make certain assumptions, okay? Let's make the assumption that your disability doesn't come through anytime soon. You may not have in your mind what exactly you will do, but you'd basically be having to try to figure out some contingency plan in case it doesn't happen. Okay.
And I have been, but it's been really hard to do anything with this court case because I've been trying to defend myself. So I haven't even, he went so far as to turning the Wi-Fi off. I can't even do surveys to get dog food money anymore or to look for places to live. If this wasn't going on and he had come to me and given me 2 months maybe, I would have been able to figure.
Were you guys just renters?
Yes. I just
Okay. Okay, so why all the animosity?
I don't know. I have no idea. It's been in
Okay,
an insane house since I moved in.
Okay. Is the Wi-Fi off?
I changed the password of the Wi-Fi because
Okay, so why?
I figured I gave her a month's notice to leave. She didn't leave.
Okay, but really, let me just ask you, where does that get you? I mean, you're gonna shut the Wi-Fi off to force her out?
I don't know. I'm not going to make it comfortable for her to stay if she hasn't paid rent in 9 months.
For Pete's sakes. So you're gonna just try to force her out? You're just gonna make it uncomfortable and
I didn't try to force anything. That's why we're here.
Okay, so here's gonna be the problem, and maybe counsel, you can talk to your client. At certain points, regardless, well, she's got a legitimate tenancy for whatever it is, to the extent it is. When he begins to interfere with utilities and other things, that creates other problems for your client, which could amount to a lockout claim. I don't understand why he changed the Wi-Fi password. That makes no sense to me.
Can I say one more thing?
Your Honor, she sent him harassing text messages in the middle of the night. It was.
I accidentally
excuse me.
clicked a smiley face on a message from years ago, and then he turned the Wi-Fi
This is
off.
a month-to-month tenancy at will. He's asking her to leave pursuant to MCL 554.134, it's paragraph 1. He will be willing to allow her to stay for 30 days. He will turn the Wi-Fi back on.
He's also unscrewed all the light bulbs, so I have to be in the dark downstairs and I have to stand on ladders in the dark. I have a neurological disease. I should not be standing on anything. Every day they come down and unscrew the light bulbs.
That's a complete lie.
Did you do anything with the lights?
His girlfriend Chelsea does.
Huh.
And I have proof from him messaging me saying that.
Can you get out in 30 days?
No, 60 days, 90 days. I mean, I don't know. I don't know about 30
Okay,
days. I don't-
remember what I said. There would be a time period. You're gonna have to figure out some contingency plan in case what you're hoping to happen
Yeah.
doesn't
Well,
happen.
my only plan is to have to move to Florida, and then I would lose all the doctors that I just became. You know, I have a group of doctors that are helping me. I have to move to Florida with my family. I would just, if I could just have a couple more months of not having stress on me. I've been sick for 2 years. It would be great to just not be harassed and just have a few moments to think. I can come up with a logical situation if it doesn't go through.
How long's the Wi-Fi been off?
2 weeks, I think, maybe a week and a half, 2 weeks.
We can have.
He will turn the Wi-Fi back on and give her 30 days if the court was complained.
So here's what I'm gonna do. I'm gonna issue a judgment for possession. I'm gonna give her a little bit longer than 30 days. I'm gonna make it August 29th. And part of the court's rationale in doing that is take the 30 days, plus you just shouldn't have been shutting off the Wi-Fi. You should not, part of this process, that being the court, is to let that process work. You should not resort to any type of self-help. Am I understood?
Yes. Your Honor.
So I will grant a judgment finding no tribal issue. The court will grant a judgment to the plaintiff for possession of the premises. A writ would issue after August 29th, 2025. What's the setup of the premises so that I can sort of be clear on this?
It is a residential home, and she lives in the basement. He lives upstairs on the main floor. It's I guess a 1-story home.
Gotcha.
A few bedrooms on the first floor, and then there's a basement with a bedroom that the defendant lives in.
With huntsman spiders, I have an infestation right now, about 5, 10 of them. I woke up with one by my side of my bed.
Okay. What I'm gonna do is I'm going to do that. So the only portion of the premises that she occupies is the basement. Is that?
The bathroom at the top of the stairs.
So I will sign a judgment to that effect, granting judgment for possession. With a writ date of August 29th. All right. So ma'am, that gives you the time in terms of your trying to find your contingency plan. It also admonishes you and puts you on fair notice that should a motion come back before this court that there is any type of self-help, then the court will take whatever remedies it deems necessary to protect what is in effect still now a tenancy. Understood?
Yes, understood, Your Honor.
I'll sign the judgment when you submit it.
Thank you very much.
Gary Wrigley versus Men on Move, Inc.
Your Honor, Joe Lloyd, appearing on behalf of the defendant.
Good morning or afternoon, Natalie Benici.
Oh, you're back? No, I'm kidding. What is this? It said, geez, one case, she's out. No, go ahead.
Yes, I'm filling in for John Dean this afternoon from the same firm.
All right.
To my left is the plaintiff.
All right. All right. Where are we on this case?
Your Honor, this is a termination of tenancy, and we have a subsequent civil action going on that was filed recently regarding the business. So my client owns the building. He's a silent partner, 50% interest in the business that rents from his building.
Got it. I think.
So,
He's a 50%, so he's a 50% owner,
correct.
basically of the building, but,
He 100% owns the building and the
Okay.
business that rents from him, he's a 50% silent partner.
got it.
Yeah, so there's an issue.
So he's, half of him has to go to this side. No, I'm kidding.
I'm not his lawyer.
Oh, my, okay. Oh, this would be fun. All right, okay, got it.
Yeah, so what we're requesting today, I did have a chance to speak with brother counsel. We are requesting a pretrial in about 90 days. The parties would like some time to conduct discovery regarding the civil action and hopefully come to a global resolution.
Okay, so let me ask you this. Where is the civil action?
Washington Circuit.
Okay,
Yes, in business court.
got it. So, so you're trying to work out some of that through the business court, which ultimately potentially could resolve some of what's here or all of what's here.
Correct.
Is that?
I believe.
Okay.
Oh, sorry, and one more thing, we are requesting.
See, I was gonna say that was so easy and I knew she was gonna say something. No, go
I'm
ahead.
just, we are also requesting that escrow be paid through the court, through the defendant's prior attorney. He represented that the defendant was holding escrow of $4,500 a month. That is the fair rental value. And we just ask that in the interim that the court enter an escrow order.
If I may address that, Your Honor.
Certainly.
One, Mr. Reach was the previous lawyer. I called him here and there is no money actually in escrow with him. And the second thing, there's not a money claim in this. This is purely a possession claim. So I'm not sure that escrow.
Well, certainly, even if it's a possession case, escrow can be ordered. It's just, I mean, the remedy, if it's not paid, I don't know if that gets you folks to the point that you would want to be in any event, but go ahead.
I'm going to make a proposal. What I don't have is, I don't know if my client even wants to contest the escrow. What I was going to suggest is if you wanted to enter an order, I'd want to reserve the right to come back and revisit the merits of it in a week or 2 weeks, but you shouldn't have to come back if the client agrees. I just haven't been able to address the question with my client. So.
Right, and I guess I also have the business. This is a little bit complicated, or maybe I'm making it more complicated in my head. If the plaintiff is a 50% owner of the business, then go ahead.
Because what happens, I think, I mean, the business is a separate entity. It's an LLC.
Right.
So I'm exploring that as a possible defense, but I haven't given it serious thought at the moment. I understand the conundrum, and if I raise it, I will raise it with authority in mind.
Okay, well, part of what I'm thinking, despite his ownership, to what extent your client's ownership was, the company was the one that paid the rent. Is that
Yes.
correct? Okay.
Yes, and the rent was $2,500, or excuse me, yes, $2,500 a month. And then as of January, the two partners agreed that they would pay an extra $600 a week. They were converting payroll into rent. So the rent price went up.
Doing what?
Sorry, to keep it short, the business was paying for rent. The proceeds came from the business.
Got it.
Your Honor, I am confused now. I'm in over my head in terms of the facts of the case, because I'm not handling the circuit court case.
Oh, you're not.
I am not. So I'm a little.
And you're not.
No.
Oh, it's beautiful.
We're just here.
I thought you guys were the ones in circuit, but no.
Okay.
We're just
Got it. Okay. So here's what I'll do. I will give you the. So, counsel, what was then your understanding then of? It was $2,500 per month, but then it changed.
Correct.
To.
They changed to the $4,900 in February.
4,900.
Correct.
Per month.
Yes. And they paid that for 1 month and then completely stopped paying rent. So the last payment was in February.
Okay. That's a significant change. And I guess I'm trying to figure out motivated that change? Whoever can explain it to me.
My partner wanted to buy me out. And I agreed, it's time for me to get out. He sent me an offer which basically said, give me the business. I turned down that offer. Then he said, I'm not paying you. And I said, that's crazy. He goes, I'm just not paying your salary, I'm not paying your rent, I'm paying nothing. And they just stopped paying.
Okay, no, I get, well, I don't get, but the reason for not paying, what I'm trying to figure out is the rent was at 2,500 per month. At some point goes to 49, basically doubles.
I had a salary of 600 a week. And he asked me, can we roll the salary of 600 a week into the monthly payment? And I said, okay, since we're gonna be trying to work out a buyout. And then they just stopped paying me. They made one payment 1 month. So
Got it. So the reality is the additional 2,400 really isn't rent.
Right.
It really is your salary. Right? I mean, I get what you guys may have been calling it, but that's
what they asked me to do.
I hear you, but so that you understand, sir, I get what you're saying. For my purposes, in determining escrow, someone's salary would not be included in what I would set escrow.
I understand. And the rent was significantly below market value, and partially because he was, an owner of the building. But I do have the email from the prior attorney saying that the defendant was placing an escrow of sum of $4,500 a month. So they agreed that that was the price of escrow. And I can provide
$4,500.
So that's
but rent was 49
as of February, but we're asking for $4,500 a month in escrow.
When you say that it was okay, but part of the reason it's significantly below is because of the relationship of the parties, one to the building owner and to the business, right? I mean,
may I make an observation, Your Honor?
Yes, sir.
It seems like this rental thing is really something that's going to be going on in the circuit court in terms of what's salary and what's rent. And there has not been a request in this case for money damages. It seems to me that the right thing to do is to either make a formal motion with lots of explanation in it, or leave it for the circuit court, which is what I think would be the appropriate thing. Because I can't imagine that circuit court people aren't talking about money damages. So,
Your Honor, may I respond?
Sure.
MCR 4.201 for escrow orders does not require that it be just rent. You're allowed to ask for escrow in possession to recover property. So we're asking that the court exercise its powers and grant an escrow.
Right. Here's what I'm going to do, folks, and it's not by any stretch of the imagination exact, but I've taken into account what everybody is indicating regarding what the value of the property is, kind of formulating in my mind the relationship of the parties as to why that occurred, taking out what part of that is salary and doing in that. So what I'm going to do is I'm going to order escrow in the amount of $3,600 per month. The defendant would need to pay $2,400 for July and then $3,600 per month thereafter. I need a date. What's 3 months out?
October 10th.
All right, at 8? Oh, we did, okay. So what I will do is I will set this at October 10th.
Yes.
October 10th, 2025. The time that I'm going to give you at this point is 8 a.m. It will be, but we'll have, because our docket isn't set out that far yet. And then we will be able to give you a more specific time there.
That's
Okay?
for the pretrial, October.
Yes.
At 8:30?
I said it at
Or
8.
it'll be-
At 8, but you'll get a clarification. Yeah. Okay?
thank you, Your Honor.
Thank you, folks. Okay, is that it for you, Council? You got
That is
more?
it.
Okay,
Not-
all right. No, have a good
Very nice
weekend.
to see you. You too. Thank you.
Group 5 Management versus Sequoia Graham.
Good afternoon. Once again, Your Honor, Robert Wise appearing on behalf of Group 5.
Graham?
Good afternoon, Your Honor.
Good afternoon. All right. And where are we on this case?
What's owed as of this point in time, including court costs, is $940.
How much is monthly rent?
Monthly rent, well, agency pays part of it.
$775.
775.
Is your portion?
Yes.
Okay.
And
So,
the-
so basically, when you say 940, basically what I have owing is July plus court costs.
Yes, but I made a
Basically.
payment, so it's not 940. I'm sorry. Sorry.
I mean, she did what she said she was gonna do when she was here in June, and that is basically try to get the balance paid, but then July kicked in.
Yes.
Still had the court costs. Okay.
Yeah, she made
So-
she made a payment of 475 on the 10th. I think that's the last payment we're showing.
I'm sorry. I made a payment this morning. It might have not kicked in, so it should be
Okay.
maybe $890 now.
Okay, how much did you pay this morning?
Just $50.
Okay, you paid what you could.
Yes.
Okay. All right. So that 940, that's inclusive of court costs, Mr. Weiss?
Yes, yes, Your Honor.
Okay. So let me ask you this, Mr. Graham, when can you get that paid, you think?
So my plan is to make another payment of $100 this on the 19th of this month, and then on the 25th is the next time I get paid. I plan on paying off the balance of the rest
On the
that's left.
25th?
Yes.
Okay, let's do it this way then. You don't have to keep coming back and forth, and I can lock in the figure for you, okay?
Okay.
So I'm gonna find that there's no tribal issue after hearing. I'm gonna grant a judgment for possession for the total amount of $940, okay?
Okay.
So hold on. And so normally the writ date or the date they could seek eviction or you have to pay by is the 21st. You get paid on the 25th?
Yes.
Deal? Okay. So what I'm gonna do is,
I'll do you one
Writ
better,
date.
Your Honor. I'll give her to the 29th.
I was gonna give her to, you're giving her to the 29th?
Yes.
Well, I'm always better than you. I'm gonna make her writ date the 30th.
You do that to me all the time, Your Honor.
I know. I'm not gonna let you show me up.
Thank you, Your Honor.
All right, so you get it paid by then. And either way, quite frankly, at the end of the month, but the 30th is good because that way you can get it paid. You'll be done, then you can start working toward this.
Thank you.
All right.
Would that
Thank
be-
you. Here,
Thank you.
Your
Have a
Honor,
great
would that be
weekend.
after hearing or consent?
That would be after hearing.
Okay, thank you.
All right.
fax it
Thank you.
over,
Have a you too.
And I'm gonna hit the road.
All righty, sir. Take care. Safe
Okay.
travels, please.
Thank you.
Onyx Real Estate Solutions versus Yasser Detzler.
Good afternoon, Your Honor. For the record, Neil Chanis appearing on behalf of the plaintiff.
Detzler, is there a
I'm here.
reason we may? Okay, no, he's over here. Okay. Say again, Mr. Detzler?
Yes, sir, I'm here.
Okay, I just had to have you come up on my screen. Okay, how much is owing at this time, counsel?
Your Honor, we have presented and already submitted to the court a consent order for conditional dismissal that's been signed by the parties. We've agreed
Yes.
to convert the case to a termination of tenancy, and Mr. Detzler is going to vacate the premises on or before July 31st, 2025. I explained and checked box 4B as well as Michigan Court Rule 4.201J. And again, Mr. Detzler has actually docu-signed the document.
All
as
right.
indicated.
Sir, is that all correct?
Yes, but I do have a question as far as the
Okay.
dismissal. Does the termination is that basically an eviction? Or
No, what will happen is that this case is what's called conditionally dismissed for the court's purposes. As long as you fulfill the terms, which is to vacate the premises on or before July 31st, then it will be converted into a permanent dismissal. If you don't, then what will happen is they will file a judgment plus an order of eviction, and that's where it will show as an eviction.
Okay, understood.
Does that make sense to you? Okay,
Yes,
did
it
you
does.
have any other questions regarding this?
Nope, that was it.
All right, I will sign off. Mark this file as conditionally dismissed, and folks, thank you for working it out.
Thank you, Your Honor. Have a good All day. right, have a good one.
All right, have a good weekend. Lori Anderson versus Armani Lyman.
Where do I stand, sir?
You can stand at the podium at this point. Your name?
Lori Anderson.
All right. We have a note at 1:20 from Ms. Lyman indicating that she called for the Zoom password. The clerk looked at the ROA, our Register of Actions, and regarding her Zoom request, which was denied, and I recall doing that on the record and indicated that both parties needed to be in person. She says in the notes, as I should say, that she cannot make it and is requesting an adjournment. So here's what I'm going to do. Prior to allowing you to state proofs and take a judgment on this case, I'm going to pass this matter briefly. I'm going to call you up in my next block. I want to go back and review exactly what I said to make sure that if I let you have a judgment, that I recall saying that you both had to be here.
Yes, sir.
I want to make sure that that's exactly what I said.
Yes, sir.
Okay, so have a seat. I'm going to take a recess. You were my last one in this block, and then I will call you up in the next block.
Okay.
Okay, thank you. You may be seated. Court recalls the case of Lori Anderson versus Armani Lyman. State your name, please.
Lori Anderson.
I went back and reviewed the record, and what is clear in this case is I specifically indicated to both parties that they needed to be here in person. And she is not here, and the like. Did receive an answer. What is your claim? This is for termination of tenancy.
And a judgment, sir. Do you want me to read my
How much are you claiming is owed?
$1,139.94 as of today?
Hang on, 4,000.
$139.94.
All right, and that is for?
That is for July rent.
The amount of how much?
$330 plus late fees, which are $25 a day. So I calculated.
Can't do that.
No late fees?
All right. I can't let you assess late fees at $25 a day. Okay. First of all, I think under case law, it would be an illegal late fee. Late fees have to be reasonably calculated to the cost of collection. That's not an exact science, but they certainly cannot be what would be called liquidated damages, which those would be. Okay. So, what months does she owe for?
July. I got a calculation. July, that would be 3,300 for July.
3,300?
Yes, sir. And
That's the rent?
yes, sir.
Okay.
And then I got the water bill, the water charges.
And how much was that?
Oh, let me see. I had it all prepared and I'm just,
How my day goes.
what'd you say, sir?
I said that's pretty much how my day goes.
I
have it prepared and then
I had it all in order. Now. Find it. Oh, God, hold on. Okay, thank you. Okay.
got it. Okay.
Okay, here's an order. Okay, court cost of $33.59. That's to get her served. Lawn care service of $35. She didn't pay. I had to pay for the lawn care service. Water bill for May of $207.29.
207.29.
Water bill for June of $230.32. And then extrapolated water bill for July 1st through July 11th today of $84.45.
Okay.
Then 2 cashier's checks that I had to get done because she, I don't know if you'll approve that, but that's $20.
Okay.
Background checks of $54.29 for her uncle, Augustus Lyman,
Why'd you have to do?
because he's occupying my house and he's a criminal.
Okay, I can't let you have that. All right, go on.
And then, well, late fees, you said I couldn't have late fees.
Well, how much are your total late fees that you're charging?
I calculated based on today of 175, so whatever the court will allow.
175 for July?
Well, to the, I calculated to July, to today's date.
Today's date?
Yes, sir.
Okay, so I'll allow you $50. Well, your monthly rent is $3,300.
Yes, sir.
I'll allow you $100 in late fees.
Okay.
Okay.
Thank you.
So what you need to do, and I will approve that judgment. Why don't you raise your right hand for a moment? Do you solemnly swear or affirm all the testimony that you have given and will give is the truth, the whole truth, and nothing but the truth shall be God?
Yes.
All right. And was there a lease on the premises?
Yes, sir.
Okay. But you're terminating the lease based on.
Okay, can I read my little
Well,
spiel?
hold on, no. You can, I'll just look at it. You're terminating it based upon the misrepresentations and also violations and fraud that you've stated to the court previously, in this case, as well as a misrepresentation you believe as to identity,
Yes, sir.
and the person's in home, and then there is rent that is due. So based upon that and the defendant's failure to appear in this case, court is going to grant a judgment for possession to the plaintiff with that's her? Okay. All right. She's here. All right. Come on up, ma'am. What is your name? All right. Ms. Lyman, it is unacceptable to be effectively an hour and a half late to court.
I submitted something for Zoom because I can't be late for work class. So I just came straight from school.
And I got off the bench and I specifically looked because I specifically indicated to both parties that you needed to appear in person.
I didn't receive an email of a denial of Zoom either.
When you guys were here on the record, I specifically stated that both parties needed to appear in person.
Okay.
So whether or not you filed a Zoom request or did anything along those lines, it wouldn't have mattered because I told you to be here in person. And Ms. Anderson, I'll have to stop the inquiry that I'm making now that she's here. What's your position on this case, Ms. Lyman?
She asked me to sign a 3-year lease after I already signed a 2-year lease, and then this is when everything kind of went downhill.
Do you want to stay there?
No, not really. I already told her if she gives me my $6,000, I've been stated that I will leave.
Is that the security deposit?
There's a cleaning fee and security deposit, but she never said that she would leave, sir.
So how much is the security deposit?
It's a lease. And this is the first time I've seen her since she signed the lease on May 5th.
I don't care.
Okay. Oh. 5250.
And there's a cleaning fee, which is a non-refundable cleaning fee, I'm presuming, of how
Yes, sir.
much?
I have on video that she said that I could get my cleaning fee back.
What's the lease then?
Well, it's non-refundable, but I said if she leaves it really, really clean and, just like I had it, that I would be willing to, refund her that based on, being
understand.
clean.
Okay.
Because
But the lease itself says it's a non-refundable.
yeah, because I think by law it has to say that. So that's why it says that.
It doesn't have
Well, I don't know. I'm not
a lawyer.
I'm not a lawyer.
All right. So otherwise, well, two things. First of all, with reference to the I understand the oral representations that were made regarding the cleaning fee, but the lease would indicate that it's a non-refundable cleaning fee.
Yes, sir.
So,
Because I thought that's what I was.
and then with reference to the security deposit, that security deposit is can be used to pay rent, can be used for utilities and other things that may be outstanding. My understanding is that there are a number of water bills that still need to be paid. There is July rent that still needs to be paid. So, and I would have no way of assessing whether or not there were damages to the premises. So I don't know that that's a negotiation, but you say that you don't want to be there.
Well, yeah, because she has neighbors watching me, and it's very uncomfortable coming home, and there's people watching me.
All right, Ms. Lyman, let me ask you this. What do you want me to do on this case?
But really, I just want everything to be over. It's just the random people watching me, the false police reports.
So what do you want to do?
Say, I can move out in August,
When?
at least the 1st or the 6th.
Okay, and what about July rent
I was gonna put the rent as well.
with the court? And that's $3,300? There is, as I was totaling and going through this, There's approximately, I have about $500, give or take, for the water bills.
I just want water bills are supposed to come every 3 months.
I sent a,
I see one almost like every, and from the first water bill, I was only every 27.
can I make a comment, sir?
Sure.
I sent an Excel spreadsheet to the court and to the defendant that shows the water bill history for the last 3 quarters. I mean, 4 consecutive quarters, and it calculates a water bill based on my usage versus Mrs. Armani and her family's usage. And there's a significant difference. And I presented that to the court as well. That showed that she's using 3 times the amount of water with her family than I ever used. So, well, the police report indicated that there was a.
Just because the people over there don't mean people.
There's really no reason for me to be here with you two, is there? Because you're just gonna talk over each other. And when you talk over each other, I'll be honest with you, I'm not even listening.
Can I make a statement, sir?
You have, go ahead. What is the statement?
This is the first time I've seen her since May 5th because an older woman who says she's Armani, she's at least 40, has been telling me she's Armani, but I think it's her mother, Joanna Lyman, and I've never been able to speak with her or see her. So I can't even talk to my tenant. I would have liked to have tried to work something out, but I'm not able to ever talk to her.
Yes.
That's a lie. She's seen me on multiple occasions. She doesn't even know anybody else she's ever met my mother. She's only met with me every single time. The witness saying about mail, I've never met that man. The mail has always been inside the mailbox. I've never met any of the neighbors because I don't even go confront people. I just go on by my day. So of course, none of them ever seen me, but her.
And the fraud about the address that she said she lived at. In fact, she was living at a place on Maplewood that she was actually being evicted from. And she told me she was living at Mr. Diop's house that's on her driver's license that he's lived in for 3.5 years. So that was the fraud and misrepresentation of the truth. She was actually being evicted when she moved into my house. And I didn't know this.
Well, there's a difference. Did she represent that she wasn't being evicted?
Well, she said that she was living at Mr. Diop's house, who's been there for since 2021 and says he's never rented to her. So that's
What
fraud.
do you people want me to do? You guys just want to argue with each other. And quite frankly, I don't have the time today to hear all this. Because this is just a mess. You guys can't get past your personal animosity toward each other to even look at this whole thing rationally.
Judge, the phone number on her application was disconnected. I've not ever been able to call her and talk to her. For 2.5 months, it's been another lady talking to me on the phone and in person. I've never been able to talk to my tenant. We could have worked this out if she was actually talking.
Not the way you two are acting right now, because you're both acting like juveniles toward each other. You guys can't talk to each other.
I want to talk to her, not her mother, sir, respectfully.
Yeah.
She asked for a past address. 9090 is a past address. I never told her that I rented from the lease.
Why do I care?
The application has 9090 on it.
You're just gonna keep showing it to me, so I gotta try.
I just want honesty.
She's only been talking to me.
You guys can't even resolve this, can you?
I don't even have her number, sir. I don't have a number. You don't talk to me, sir. You don't talk to me. I've
You
never.
know what? Both of you go sit down. These other people, I'm not gonna have them waiting through your mess. Go sit down. I'm gonna pass this tape. No, I'm not even gonna pass it because I don't want you back up here right now. I'm gonna set this thing for a final settlement conference before trial. I'm gonna set it for this Tuesday. Oh joy. And then I'm inviting her back. So go ahead. What time is 9 o'clock this Tuesday? The 15th? Final settlement conference, July 15th, 2025, 9 a.m. That's in person. You need to be here. I will be waiting in courtroom A to hear your case and other cases with bells on.
The rent, since the mortgage is due, can
9 a.m. on the 15th. I am not making a decision today. You are to put the $3,300 in the court escrow. Thank you.
Thank you, sir.
She just said something. Anybody comes up and gives me a problem, you're gonna be. I see. What'd you say? Not working. Court just called the case of Barbara Woods versus David Pitchford and Helen Cummings. Yep, you knew it was you, didn't you?
Good afternoon, Your Honor. Keith Johnson on behalf of plaintiff.
Good afternoon. Your name, ma'am?
Helen Cummings.
All right. And where are we on this case?
Your Honor, we had adjourned this at the last hearing. I have the total balance. Well, the rent retained is rent retained is $149.83, cost of $242.00 for a total of $391.83. We had adjourned at the last hearing so she could seek some assistance.
Did that work for you or no?
Well, I did go and get some help,
Okay.
but the help that has been offered to me, they only want to pay what I owe, and that would be $243. Now, I paid my rent on time.
No, I remember you told me.
And I have proof.
No.
So that $391 is not what I owe, Judge Simpson.
Okay, so who said they're willing to pay?
The assistant.
Oh, who's it? Oh, come on up. You're the money person. Yeah, come on. Who are you? Could you state your name?
Mine's Madeline Linton with Housing Bureau for Seniors. I'm our eviction prevention coordinator.
You're with the Bureau.
Housing Bureau for Seniors. So we're Michigan
Yes.
Medicine, University of Michigan. Yeah. So we've applied for funding for her, and
Okay.
she's a good candidate, but she does have check from June and July that she paid on time, and they're charging her for $75 for those months. So we just don't want to pay Barbara Woods.
Right. So here's what's happening. There was a shortage at one point.
Yeah, in May.
In May. So the problem that happens and why I was trying to get to it so fast and trying to get it done is because that back balance exists, she gets charged a late fee, even though she's paying her rent on time. And the problem also in this case, or what can seem like part of the unfairness in this case, is that the balance that's owed is so low that when you then click the late fee in, it like doubles what you owe, right? And so I get all of that. And so what I was trying to express to Ms. Cummings the last time was if we can get somebody to just get it paid, because the reality is if we can just get her back to zero, she's gonna be fine. And that's the only thing that I wanted to happen. That's why.
I agree, Mr. Simpsons. And so we can apply for that whole amount. I just ask going forward that her checks be implemented the day she pays. Because right now her ledger, so it implements it a couple days after she pays it. So then it shows a late charge.
Well, it shouldn't, that shouldn't be happening. But hold on a second. If it's getting there, the late fee in this kicks in at what, day 5 or day 6, I guess?
On the lease, it says day 5.
Yes.
Yes.
The late fee that hits after the 5th, and then there is a second late fee that hits, I believe it's after the 21st or the 20th.
Right. So as I'm recalling, Ms. Cummings, the last time we were here when you were yelling at me.
I'm sorry.
She just needed to.
You want to know what?
Just got
It would be
excited.
so nice. She could have said, "No, Judge, I didn't yell at you." I appreciate the fact you acknowledged.
And I did. I got excited.
Okay. All right. So as I recall,
Yes.
you receive a check each month.
Yes, I get paid the 3rd of every month.
Okay. And so customarily, what do you do? When do you then pay your rent?
I was online paying it by the 5th.
By the 5th?
Yes.
Okay, so let me ask you this. Part of the way of avoiding that, okay, is if you get your check on the 3rd, can it get paid by the 4th or the 3rd?
Yes, but that was only because when I went online, it was more money that was in my account. That was for May. So you can't, they wanted 1177 and some change. I didn't have a 728, what I'm used to paying. So words was exchanged. Okay, I own up for May, but then I paid my rent for June and July on July 3rd and for June 5th. And I'm getting charged late charges.
Okay, so, right.
They're logging it in late.
Your Honor.
That's
Wow.
my fault.
It's probably clicking over on the portal late. Yes, Counsel.
Your Honor, she's going to continue to accrue those late fees until she has a zero balance.
And
So
Simpson
because
said-
she still has a balance
So, okay, so
regardless of when she pays the rent.
Right. So I just want to make sure, because I think we may be talking about two different things at this point.
Ah.
And that's because even though you,
Paid the rent.
how do I want to say this? Even though you paid your rent timely, let's just take June, okay? You paid it on the 3rd, you said, right? And then at some point, a late fee clicked in.
Yes.
Okay. That late fee doesn't have anything to do with your June payment. Okay? It has to do with the fact that you had a balance coming out of May that didn't get paid. And so then the late fee comes in.
Okay.
Okay?
That's how-
So it wouldn't matter.
If I paid it on the 1st, if I owed it on.
Right. Even if you had paid it on the 1st of the month,
Yeah.
it wouldn't matter because there's that balance coming from May.
Yeah, I see.
So what I'm hoping to avoid is a circumstance where if you pay your rent on the 3rd or the 4th, okay, it gets tricky on the 5th because of cutoff time
Right.
and that kind of thing.
Right.
That a late fee won't click in. If they don't put it on your ledger till then, there's no late fee.
Right. And once I get a zero.
Right. A late fee won't click in.
Exactly.
You just never got it to where it
Well,
hit as a 0.
Exactly.
Okay.
Yes.
So we're now back to where I was.
Yes.
And that is, can we get this back balance paid?
They're not willing to waive any of those late fees, even though she paid on June and July and the amount was so little.
Now
to
she's
pay.
gonna be a lawyer and everything. She's gonna start yelling.
It's
at
just
me.
frustrating.
She's gonna start yelling at me like Miss
But-
Cummings.
but-
Right,
but-
Miss
but
Cummings
yes.
yelling at me.
But
Miss
We
Cummings,
can ask the
she
whole-
yelled at me on Zoom, then was gonna
I'm
yell at me in
sorry.
person.
But I mean,
And then
can we ask the
hurt my
attorney?
feelings
We
because
at
I'm
least
sad.
They got the right to
And
say.
nobody seems to give you still
I-
talk.
I'm sorry. I mean, I
Okay,
saw them.
hold on, just hold on. Counsel, if
Yes.
I kick this out a week, can you talk to your client about maybe waiving something so that it can all just get paid? And then, maybe even there's like 2 late fees that are on there, I think.
Yes, two. Because what
So
made, okay, I'm sorry. I'm sorry. I just trying to figure it in my head.
This is like
know.
It's like when you're riding around in a car with kids.
And they won't.
Except that I had to say, don't make me come off this.
I know.
No. She like that.
I know that.
Okay. Would you at least talk to your client about waiving one of the late fees if we can get everything paid?
Your Honor, I can't discuss that with my client. However, I have discussed it with them previously and they're not willing to waive any additional late fees because they already did waive a late fee in May. There was a $55 late fee that was waived initially. And so
Really? What was that for? You know? Because I hadn't heard that before.
I didn't either.
Your Honor, there was a credit on her account. The late fee, $55 late fee was charged on May 6th. And then there was a credit to her account on May 13th
On May, really?
of $55.
They took the late fee off for me. That's true.
Pardon?
That's true.
They already waived one in
May,
May?
yeah.
Okay.
Okay. Can you just
And
give us some time? to-
Dana
yeah.
said she would, because I've never been late. So I just.
I know. Well, they did it. I didn't
didn't
think that.
see
I didn't know that they had already
And I
done
didn't,
something.
I didn't see that.
Okay, no, it's okay. We all now know it, right?
Yes,
The request
yes.
is made, we all know. How much time can you,
I need 2 weeks.
2 weeks?
Yeah.
All right. I don't have a date in 2 weeks. When's the second late fee click in?
Your Honor, the second late fee, I believe, clicks in the 21st.
Okay, so look, I'm gonna tell you what. What's her current balance right now?
Her current balance right now is $391.83. That includes court costs.
Yes.
If you didn't want to set another date, I mean, if they gave me 2 weeks to get the check to them, I could.
Yeah, but I don't want to go.
Okay.
I got it.
Okay.
I've been doing this for a minute.
Yes.
So here's what I'm gonna do. Here's what I'm gonna order. I'm gonna order something a little bit different in this case, but I think it's fair and equitable. The defendant is to pay $391.83 by July 29th, 2025. Because, and based upon the representations in court, here in Bureau for Seniors has committed to make sure that that's paid. And I'm gonna take that commitment. I'm gonna order that the plaintiff is not to charge the second July late fee if that balance is paid in full by the 29th. But if it's not paid in full by the 29th, that second late fee will click in and you'll accumulate the late fees. I will adjourn this then to August 1st, 2025 at 3 p.m. Now, here is what my hope is. You get that paid by the 29th, right?
Yeah.
And because that's before the end of July, and that gives you your 2 weeks plus a couple days, they don't charge the other late fee. Technically, then nothing is owed. Come the first, this case can be dismissed. And then you can make your August payment as you normally do.
Okay.
That is what I'm trying to get to. I'm doing that, both parts of this, over the objection of both parties, but the court is doing it because I believe that it's fair.
Thank you.
Thank you, Your
I
Honor.
appreciate
Okay.
it so much. Thank you.
Your Honor. Yes, for the
It's
record.
12, that's at 12 p.m. I'm sorry, that's at 12 noon.
So August 1st.
Pardon?
I said, thank you, Your Honor, and for the record, we do object to another adjournment.
I knew you would, but you do it so nicely. All right. Okay.
I appreciate you.
All right. Miss Cummings, you take care.
Yes.
All right.
Yeah.
And go find somebody else to yell at.
Okay.
Okay.
That 13-year-old.
You got to go yell at them. Why are you yelling at me? All right. Take care. Northville Crossing versus Jillian Davis. Oh, really? Hold on. You know her? Do you? Okay. Just between me and you like her? That is not what I was expecting to hear. All right. Bye. Jillian Davis and Jocelyn Diamond.
Here.
Okay, there you. All right. And what's the claim? What's plaintiff's claim in this case?
Your Honor, we have rent retain of $1,155.39, cost of $246.00, for a total of $1,401.39. Your Honor, at this time, we would be asking for entry of a judgment today. They stated that previously that they could have the remaining balance paid by July 22nd.
I think that's what you guys had indicated before, right?
Yes.
Because you paid my last note in June, you were gonna pay that $750, and then you must have paid something else, right?
Well, what we had talked about was paying the $750, and then we were gonna pay our rent on time, which
For
we
July.
did for July, and we did both of those. And
Okay.
we were waiting for someone, because last time we heard they were supposed to contact us and let us know if they approved it for us to pay the balance by the 22nd.
Okay,
Your Honor, that was approved.
that was approved.
By my
Oh.
client.
Okay,
Oh, okay.
so you can get this 1401.39 paid by the 22nd?
Yes.
Okay, so here's what I'm gonna do. I'm gonna find no tribal issue after hearing. I'm gonna grant a judgment to the plaintiff for possession. Judgment amount in total, including costs, of $1,401.39. And I'm gonna make the writ date the 23rd
Okay.
in case it's a hiccup, but just get it in there and then you're gonna be good, folks.
All right. Thank
Okay.
you.
Thank you.
All right, you are more than welcome. Take care of yourselves. Have a great weekend.
You do the same.
You too.
Northville Crossing versus Jose Gonzalez Ramos. Probably Ramos. Oh, and then I'm sorry, Christina Gonzalez.
Kate, so remembered Gonzalez is no longer there.
I cannot keep track of everybody's divorce. All right. Okay. All right. What's plaintiff's claim in this case?
Your Honor, we have rent retain of $3,081.49, cost of $246.00, for a total of $3,327.49. Your Honor, at this time, we are requesting entry of a judgment with a writ date in 10 days.
All right.
It will be paid today after 5 o'clock.
So that total amount?
Yes.
Because I think the last time we were here, but we were here in June,
Yes.
she had indicated she was gonna pay the entire balance by the 11th.
Right.
Okay, so, all right, so here's what I'll do. I'll grant a judgment for possession to the plaintiff, finding no tribal issue. And that total amount, counsel, was $3,300.
$27.49.
Okay, so I'll enter a judgment for that total amount.
Yes.
And that would have to be paid by the 21st.
Okay.
Okay, so get that in, you'll be all set.
All right.
Miss-
Thank you.
Hold on.
Gates.
Gates.
Gates. G-U-E-I-T-S. Gates.
Oh, then you don't even spell it.
No.
All right. All right, Ms. Gates, you have a great weekend. Everybody's just trying to confuse me. Scio Farms versus Shannon Rousseau.
Casey Matson on behalf of plaintiff.
Good afternoon. Name?
Shannon Russo.
All right. And how much is owing on this account?
Your Honor, I have rent to retain of $3,013.76, cost of $190.00, for a total of $3,203.76. Your Honor, at this time, we are asking for entry of a judgment with a writ to issue in 10 days.
Sir, when are you going to be able to get this paid?
Okay,
You take your hands out.
yeah, I'm sorry. Hopefully by the 22nd, I be planning with help from family and also just my work and by putting in the extra hours, I will be able to pay that on this 22nd.
Pay everything by the 22nd?
Right.
All right, so here's what I'm going to do. I'm going to find no tribal issue, and I'm going to grant it after hearing. I'm going to grant a judgment for possession in the total amount requested by the plaintiff. I'm going to extend his writ. I'm going to extend it 2 days to the 23rd. So a writ issue to 23rd, but you need to get that paid by the 22nd.
Yep.
Okay.
Right.
All right.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor. We do object to that extension.
Yeah, you're okay. So noted.
Thank you, Your Honor.
Yes. Scio Farms versus Maria M. Lotha. Where is she? Oh, she's in Zoom. Mr. Lotha?
Yes, I'm here.
Okay. How are you today?
I am doing well. I can't complain. And how are you?
I'm great, thank you. Except everybody keeps objecting to what I'm doing. Just thought I'd throw that out there. All right. What is the balance, counsel?
Your Honor, I have rent to retain of $1,485.08, cost of $190.00, for a total of $1,675.08. Your Honor, we did receive confirmation that a check was mailed yesterday from Faith in Action for $1,160.25. However, that has not been received yet. So we are requesting.
Okay, how much was the check, you said?
The check is for $1,160.25, but we have not.
But you haven't gotten it yet. Okay. Ms. Lotha, where is she?
Yes, I'm here.
Okay, there you are. Okay, I just couldn't see you on the screen. All right. That's gonna leave you about 500 short.
Yes.
How are you gonna get that paid?
So far, I found out for July, I should be paid on the 23rd of July. That's the fourth Wednesday of the month. So previous I said 28 because I wasn't sure, but now the date for July, they said it's 23rd. That's when I will get paid. So
you're gonna get paid that day?
That day, yes.
Okay. And is that a what kind of check is that? Is that a work check?
That's the Social Security survivors benefit.
Oh, okay. So they switched your date, but now it's earlier?
Yeah, every month is different dates.
Gotcha.
Whatever falls on the fourth Wednesday of the month, that's my date.
Oh, okay. I see. That's right. I think you did tell me that. Okay, so it's the fourth Wednesday. So this month it's the 23rd.
Yes.
Okay. All right. Okay, Mr. Lotha, here's what I'm gonna do. Okay, because I don't have another, after next week, I don't have another Friday, because otherwise I'd adjourn it, because you always get this paid somehow or another. But what I'm gonna do is I'm gonna issue a judgment for possession, finding no tribal issue. Okay?
Okay.
For the total amount of the 1675.08.
Yes, Your Honor, 1,600.
Okay. And what I know is that one check is coming, so we got about $500 or so that needs to be paid. I'm going to extend the writ date to the 25th.
Okay.
Okay, that Friday, because I'm not sure what's happening with some Social Security checks. I just want to make sure it gets to your account and you can get it paid, okay?
Yes.
All right, and then we'll do that and see if it gets paid. All right, Ms. Lotha?
Yes, thank you so much.
You're very welcome. All right. You have a great weekend.
Thank you. And when do I come back to court?
I know you want to come back and see me, but no, we're gonna be done. Okay?
Thank you so much.
I like it actually when you come to court.
God bless you.
All right, Mr. Lothar, you take care.
You too, thank you.
Thank you, Your Honor. And just for the
Thank you.
record, objecting to that extension, but
Yeah, I get you. I mean, so noted. I think that's a professional. Yeah, all right. Sile Farms versus Craig Gallagher. He had a guardian, that's right.
yes, Your Honor. I don't believe his guardian or Mr. Gallagher himself is intending on appearing. However, we would be seeking an adjournment just because we did
Okay.
receive the confirmation that there is a check coming from the payee for Mr. Gallagher, and yes,
Okay. Will 1 week be enough? I only have the 18th left this month, but
yes, Your Honor. 1 week will be sufficient.
okay. July 18th, 2025 at 3 p.m.
Thank you, Your Honor.
Thank you. Sile Farms versus Paula Clark and Anthony Clark.
Hi.
Hello. What are your names?
I'm Paula Clark, my son
Clark.
Anthony.
Okay. I only want to hear from Paula. Anyway, no. I'm kidding. All right. What's the claim in this case?
Your Honor, there is rent retain of $860.42, cost of $230.00, for a total of $1,090.42. At this time, we are asking for a judgment with a writ to issue in 10 days.
All right. And you paid $1,400 on the third? Is that what you
I paid $1,396 on the 9th because they wouldn't take a counter check. So I had to go get a
Gotcha.
cashier's check.
Okay. And so what was your plan on getting, just 1,100 basically, getting that?
So this is for July.
What's your monthly rent?
It's $870 in the water bill and the trash.
Okay, so this is basically then gonna be July plus some, plus the court costs. So you're at 1,090.42.
It'll be paid by Friday, next Friday.
The 18th?
Yes.
Okay. What time on the 18th will it be paid?
Well, I don't get out of work till 3.
So it's gonna be late on that day.
It'll be there. It'll be in office by 5.
Okay, here's what I'm gonna do then. I'm gonna find no tribal issue after hearing. I'm gonna issue a judgment for possession for the $1,090.42. That's the total, okay? And you say you can pay it by the 18th?
Yep. Yes,
And if
sir.
I put a standard writ date of the 21st, which is that Monday?
Yes, sir.
You'll have it paid.
Yes, sir.
Why'd you sign on? What?
Because that's my son.
You know, I know. He's like, yeah, he has said nothing the whole hearing.
They usually don't want me saying nothing.
What?
They usually don't want me saying nothing.
Yeah.
I said that?
No,
her.
I'd rather he just be quiet.
See, I knew that when you were walking up. Didn't I say I only wanted to hear from you? Then I don't know why he said yes. Anyway, I don't care. All right.
Yeah, it'll be in the office by 5.
All right, with the writ to issue the 21st. All right, so get that in, then you'll be all set.
All right. So I won't have to come back.
Well, don't look so happy about it. All right, you don't have
Never
to come
happen
back.
again.
You'll be all set. You
Thank
guys
you.
have a great weekend.
Have a blessed day.
Thank you, Your Honor.
Sile Farms versus Alex Corser and Alyssa Proctor. Corser, Proctor. They are not here. You'd previously been sworn. You may go ahead, counsel.
Thank you, Your Honor. We're requesting entry of a default possession only judgment. Rent to retain is $2,172.18, cost of $230.00, for a total of $2,402.18, with a writ to issue after July 21st.
Judgment to the plaintiff, that is by default for possession. Redemption amount is in the amount requested with the writ to issue in 10 days. Thank you, counsel. I think that's all I have for you.
That is
right.
all. Thank you. Have a great day.
All right. You have a great weekend, and Patty, take care.
Thank you. Have a good weekend, Your Honor.
All right. Court will stand in recess.
All right.
Call your name for the 3 o'clock block and speak up that you're here. Kaya Goins. Jason Amons. Quandria Dabney.
Here.
Thank you. Markayla Jones. Here. Thank you. Tiffany Cryer. I'm sorry, Tiffany Cryer. Kiera Morgan. Here. Thank you. Kayla Randall, is she here? No. Okay, thank you. Derek Moore?
Yeah.
Thank you. Nicholas Hoyt? Thank you. Shayna Williams, I see you in Zoom. Willie Williams?
Yeah.
Thank you. Anaje O'Hearn? Latanya Pupow? Here. Thank you. Justin Willis and Karina Holmes, I do see you in Zoom. Laisha Slayton Mitchell or Nazir Mills? Michael Perwee? Chinny Strip? Thank you. Victoria Bolton? Thank you. Jacqueline Taylor? Tisha Williams, I'm sorry, Tisha Wilson? Takima Reader? Here. Thank you. Shayla Cole? Here. Thank you. Denisha Davis? Tanika Ward? Alyssa Darling? Alana Armstead?
I'm
Karina
here.
Jones? Ms. Armstead?
I'm in Zoom.
Okay, thank you. Karina Jones? Janice Gardner, I do see you in Zoom. Carly Kenny? Sandra Moore, I see you in Zoom. Regina Agnew? Thank you. Alana Lindsay? Charles Ellison, I do see you in Zoom. And Sierra Moore, I also see you in Zoom. I do see you, Ms. Moore.
14A District Court, County of Washington, State of Michigan, not accepted beyond. They said it.
You may be seated. Court does call the case, Baker Street Properties versus Kaya Goins.
Good afternoon, Your Honor. Jillian Engen for plaintiff.
Kaya Goings. No response. You have previously been sworn. If you'd like to proceed, you may proceed.
I think I started to get sworn in and then the defendant appeared.
Oh, we didn't
I
finish?
don't think it.
Okay, well, we'll try to. All right, raise your hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the true self?
I do.
All right, go ahead.
Thank you. This is a case for non-payment of rent. Rent to retain possession is $3,600. Court costs are $175 for a total of $3,775. Plaintiff wishes to take a default judgment for possession only with a writ issued after 10 days.
Judgment to the plaintiff does not default for possession, redemption amount, any amount requested with the writ issue in 10 days. Court does call the case of Evergreen Apartments versus Quandria Dabney.
Jillian Engen for plaintiff.
Hello,
Hi, Your Honor.
what's your name?
Quandria Dabney.
All right, where are we on our case?
Your Honor, I have a balance of the court costs of $4,422.93.
All right, how are we gonna get this paid?
I am going to be able to pay that full amount by July 18th.
July 8th,
July 18th?
18th, next
Yes.
Friday,
Yes,
in the morning?
by 5 p.m.
Okay, so you're gonna pay it by 5 p.m.
Yes.
All right, well, I don't have another date before then. Counsel, I could take a judgment and give her the time to do that. Or what I can do is, my next date would be August 1st. If she gets it paid, then she's done.
I think, Your Honor, I'm hesitant to put it out to August 1st.
Because of
But-
the amount, and it would click August in if
Given-
it doesn't get paid.
Given that the next, that would be well within the 10 days, we could set it aside if it's paid in full.
Okay, very good. Find no tribal issue after hearing, I'll grant a judgment for possession to the plaintiff for their total amount, 4422.93. And so you're gonna get a check or something on the 18th to be able to pay it, is that
Yes.
what's happening? Okay, I would make the writ date the 23rd, just so that we're,
So make the redemption date the 23rd,
yes,
Wednesday.
instead of the
21st.
1st. You have a couple more days than that.
Thank you, Your Honor.
Okay, we all set then.
Okay,
You
have a
take care.
good
Have a
night.
great weekend.
You too.
Does call the case people of Evergreen Apartments versus Michaelia. Yeah. Jennings.
Jillian Engen for plaintiff.
There's a lot of K's. So, hello, what's your name?
Markayla.
Okay. I made it too complicated. All right. What's the claim in this case?
I have a balance including court costs of $3,450.70.
Okay, she paid the 1,000 that day. I wrote it a 2. And you were gonna pay 1,300 by the 11th
Today.
today.
Mhm.
Did you do that?
Yes.
Okay. You don't show that, however, correct, counsel?
Yeah, I don't see that. It probably just hasn't.
What was this morning?
This morning?
Mhm.
Okay, that's okay. That, I believe you because you paid the other 1,000, which is partly why the balance isn't so high. So that would bring you around 2,100 that would be owing. How do you intend on getting that paid?
I get paid every 2 weeks, so the 25th, I'll be able to pay 1,400.
Okay. So we're still gonna be about 700 short. What's your monthly rent?
I think 1164.
1164. And 2050. So how much were you said you were gonna pay on the 25th? You said 14.
1,400.
So that's gonna bring her into $2,000. Right, but she paid 13. So if I ballpark it, she's gonna have about 700 that she can do nothing with until the 8th, but 1,100 is gonna click in. And on the 8th, that would be your next check. You can only do 1,400 at a
Right.
time, 13 to 14.
Every time I can pay a little extra, I do. I paid 1350 today, but if it's extra, then I always pay extra.
Okay, right, but
Like 1,400 is minimum what I can pay.
okay, that's a minimum.
Well,
Okay,
maximum.
maximum. Okay, I was gonna say, okay, so the problem, okay, so let me just tell you, the problem that I see is that if we click over into August, which is really your next check after the 25th, then that 1,100 is gonna kick in.
Right.
Right.
So August rent.
Pardon?
That's August rent.
Yeah, your August rent. So what I'm gonna do in this case is this. I'm gonna grant a judgment for possession to the plaintiff, finding no tribal issue for the 34, 50, 70, realizing that the 13 that you paid isn't counted in that. So that number is gonna drop, right, to the 21, to about 2150. You're gonna pay 1,400 on that date. Okay, this is gonna get a little bit complicated, but just follow me here. What I will do is I will indicate that a writ will issue. You said you get paid on the 25th, right? Writ will issue July 25th. However, if defendant pays 1,400 by that date, then the writ is extended to the August 8th, 2025. Now I'm gonna do it that way. And here's what I'm just gonna tell you. This is not including your August rent.
Okay.
Okay, so here's what I'm hoping happens. Okay, you pay the 1,400 on the 25th.
Mhm.
I'm gonna give you time then to get this judgment satisfied, get this full amount till August 8th, which is your next check.
Right.
All right, if you can pay the 13 to 1,400 at that time,
August 8th.
yeah, then what will happen is you will have paid off the judgment, you'll have paid part of August.
Mhm.
Then by your next check in August, which would be the 22nd, you can get your August rent and late fees and everything paid.
Right.
And be done. Okay?
Okay.
You follow what I'm trying to do?
Yeah, I get it.
Okay, all right. So
Thank you.
that's the way that I'm gonna do that, and hopefully it'll work out for you.
Okay.
Okay, you have a great weekend.
I think I got it, Your Honor.
Okay, all right.
My hand hurts now.
Yeah. Fantastic. Court does call the case of Evergreen versus Tiffany Cryer. She's here. Hello,
Good afternoon.
what's your name?
Tiffany Cryer.
All right. And what is plaintiff's claim in this case?
Your Honor, the balance between court costs of $2,607.96. I also want to note that Ms. Cryer has been approved for Hawk, and I think that a check is going to be cut and mailed sometime today or Monday. So it should be
So for the full,
there within 10 to 14 days.
for the full balance.
Yes, sir. Full balance.
Fantastic. So what I'll do in this case is I'll adjourn you to the 18th, 2025 at 12 noon.
Okay.
Hopefully the check will be in. If it gets there, then we can dismiss this.
Hope so. Thank you. You guys have a good day.
All right, you take care. Court calls case of Evergreen versus Kira Morgan
Jillian Angus, the plaintiff.
and Tyler Randall. Hello,
Hello,
what's your name?
Kira Morgan.
Okay, what's the claim on this case?
I have a balance including court costs of $3,934.18.
Okay.
All right. She paid the 1,000, last time we were here in June, she paid the 1,000. She's gonna pay another 1,000 today.
Yes, I had to pay it after I leave here.
Okay, so you haven't paid that?
No.
So that would take us down in the $2,900 range. Okay. And so how are you gonna get this paid?
Well, I'm going to return my phone call to Faith and Action and see if I can get some. I'm sorry, I'm going to return my phone call to Faith and Action and see if I can get help there. If not, then when I get paid on the 25th, I can do 1,200 because I'm getting paid every 2 weeks.
So you're gonna pay 1,000 today.
Yes.
So if I work off of that figure and I'm at 4 and I go down and it becomes really 3. Then on the 25th, you think you could pay how much?
1,200.
How much is your monthly rent?
Last time I loaned it was $11.99.
So it's about, you think it's about 1,200 a month?
Yes.
Somewhere around there. Okay.
I have it as, I'm sorry, Your Honor, I have it as $12.29.
Okay, so
Okay, so right around there. Okay.
Plus utilities.
Okay. Ooh. Not clear how we're gonna get you caught up. Faith in Action, what, did they tell you anything about?
They just told me to give them all my information about what I owed, and they will give me a call back. And they called me earlier. I just haven't returned the call yet.
They called you earlier today?
Yes. I just didn't get the call because I was at work.
You got a cell phone?
Yes.
You got it on you?
Yes.
I'm gonna pass it. You go call them, see what they're gonna do for you right now.
Okay.
Okay? Because that may be the key to trying to try to allow me to do something that help keep you in, okay? So go call them, okay? And then we'll call you back up, okay? Evergreen versus Derek Moore.
Billion.
Afternoon. Afternoon. Your name?
Derek Dwayne Moore.
All right. And what's the claim in this case?
I have a balance of, including court costs of $1,755.16.
Okay. Sir, how are you gonna get that paid?
I'll get paid next Tuesday. I know I was supposed to do something, but I tried to help somebody, my daughter out, and I ended up getting messed over. But I get paid next Tuesday, and I'll be able to pay 500.
500 on the 15th, this Tuesday coming up. And then that's only gonna bring you down to about 1,200. Then how you gonna?
I can't hear you, sir.
Oh, okay. Did you need some? Let's get some equipment for you. Yeah, better?
Yes.
Okay. I tried those one day. Those are nice. All right. So if you pay, you can pay 500 by the 15th. Right?
Yes.
Okay.
I think it's the 17th, I think.
Pardon?
Tuesday, I think it's the 17th. No, it's the 15th.
It's the 15th.
Okay.
Okay, so if you pay 500 by then you're still gonna be at about 1,300 that you owe, or 1,255 that you owe.
And then I get paid every 2 weeks. I'm right down the street at the McDonald's.
Okay. So you got one more check coming this month on the 29th. How much is your monthly rent?
It's 413. And then plus.
Hold it. It's 413?
Plus the other stuff they add in,
Okay.
like 100 and something, 25 or whatever.
So it's about 500 and something, or
Yes.
what do you have, Miss Angie?
I do have rents 413, and then there are utilities that, yeah, at about 100.
Okay. So it's gonna be about 500. Okay. So if you pay 500 on the 15th, then you got one more check this month. So if can you pay 500 on the 29th also?
Mhm.
All right, that'll be 1,000. Then you'd have, that's the 29th, you have the 12th and the 26th. So the 12th, that's not gonna clear us. But he'll have 5, and then he'll have another 5, but he might be slightly behind, but okay. Okay, here's what I'm gonna do, because you done exactly what you said you were gonna do the first time you got here. You paid your 500, okay, and then you've got the other one coming up on the 15th. So I'm gonna, no tribal issue after, I'm gonna issue a judgment for the 1755-15. Okay, so here we go. Here's the tricky part. I'm gonna indicate that the writ date is July 29th, 2025. However, if defendant pays $1,000, then the writ, and this one's going to be long, and I'm doing it over plaintiff's objections, but I think Mr. Moore will come through. Writ is then extended to August 26th. That doesn't, now, that doesn't include your August rent.
Okay.
Okay, but what I'm hoping, I don't want to go into September, and I'm not going to. So what this does is you're going to pay 1,000. That'll get you down to about 755 plus a late fee. Probably kick in, so you'll be about at 800. But then it's going to take you those next two checks to pay off that 800. But if you pay the 500, then you'll have 200 of your August rent paid.
Okay.
And then you're probably going to still be behind going into September. But we'll do it this way to try to get that part paid.
All right.
But you won't be, if they file again, you won't be that far behind.
Okay.
You see what I'm trying to do?
Yes, I appreciate you.
All right.
What was the date that it was gonna be extended to? When
It'll be extended to the end of the next August 26th.
August 26th?
Yeah. But if you get some extra hours at McDonald's,
Catch up on it.
then put it toward it, because then you're gonna be wherever it is.
Okay.
All right. I'll send Alan up there to buy a cheeseburger or two.
Okay.
All right.
Yeah.
Okay.
Thank you so much, sir.
Huh?
Thank you so much.
Thank you. You take care of yourself. All right. Court calls case Evergreen Apartments versus Nicholas Hoyt. Hello.
Good afternoon, Your Honor.
What's your name?
Nicholas Hoyt.
Okay. And what's our balance?
I have a balance sheet court cost of $3,400.48.
3-4.
3,451 and 48.
Okay. And sir, how are you intending on getting that paid?
If they'd be willing to work with me, I can set up a payment plan.
Have you tried to work anything out with the landlord?
Not yet, just because it's taken me some time to get my hours right at work. We got new management, my hours got cut, so I had to talk to them.
Okay. And you have that now set with your hours, and
Correct.
hopefully you can get yourself back on track?
Yes.
Okay. Will they work with him on this, or you think, or?
Your Honor, it would just depend on the dates and the numbers and how long. Do you know how long if you did and how long you would be asking for? Get caught up.
I have it in my notes, but I don't remember off the top of my head.
All right, let me do this, Shanger. I'm going to adjourn this one out 1 week.
It can be,
Let you try to get the numbers, and you can call the attorney's office. All right, and propose something to them and see if we can get something worked out.
Okay.
Okay, so it'll be the 18th at 12 noon. Okay?
okay, thank
All
you.
right, thank you, sir. Court calls case of Glencoe Hills versus Shayna Williams.
Hello.
Okay, oh, there she is. All right, I'll need a camera.
One moment.
Hang
I'm
on
trying
one
to-
moment.
I'm trying to go into personal at work.
Oh,
Hello.
there she is. Okay, we got you. Hello. Okay, this is Shayna Williams and Jacqueline Murphy.
Thank you.
Okay, and how much is owing on this?
Your Honor, it looks like a payment of $1,450 was made earlier today, so I have a total of 1,647.
1647. Okay, young lady, how are you gonna get that paid?
So you were really busy last time, and I was in the
I
middle
was?
of work. Yes, it was a lot going
Okay.
on. last time. And I was in the middle of working, so I told you that I would get everything paid today. I was trying
Yes,
to
you
think that
did.
the reason why I wasn't able to pay everything was because I just had to buy a car. But I can have everything paid by the 25th.
By the what date?
25th, when I get paid.
Okay, so
again.
you can have the balance paid by the 25th?
Yes.
Okay, so here's what I'm gonna do. I'm gonna issue a judgment for possession, finding no tribal issue in the case for the 1647, and the redemption date or pay date will be the 28th of July. All right, so that way you'll get that, pay it, then you'll be all set.
Thank you.
You're welcome. You have a great weekend.
You too. Thank you.
Glencoe Hills versus Willie Williams. Hello.
Hi,
What's your name?
Willie Williams.
All right. And what do you have owing?
I have a balance including court costs of $2,296.86.
All right. Did you were gonna pay or 1,000 today?
You had asked me to pay 1,000 today. I don't have 1,000. I do have $800.
Okay. All
And
right.
then I get paid again on the first of all, I didn't think that what I owed was 2,000 and something. I thought it was less than that because the last time here,
The last time here we were in June.
okay, I paid 1,000.
And you paid 1,000 on that date, June 27th.
Yes.
Okay. You told me that. And then your July rent then kicked in.
Okay.
Okay. That's how we kind of arrive at this figure.
Okay. Well, like I said, I have $800 today.
Okay. So you can pay 800 today.
Yes, sir.
And then when's your next payment? When's your
Next payday is the week of the 21st.
so the 20 you get paid on Fridays or?
I have a second job and
Okay.
it's once a month through the state of Michigan.
Okay.
And so normally I get paid on the 17th, but the manager will be out of the country and she said it would be in my account on the 21st.
All right. And so on the 21st, so what can you pay on the 21st?
I'm hoping to pay $1,000.
Okay.
So what would
1,000? Hang on. That'd be by the 21st. After that, when would your next payment be? Would it be the 2 weeks from? Go ahead. I'm sorry.
My regular job, I think I get paid on the 25th.
On the 25th.
Yes.
Okay. And how much of that check can you do?
What would be the remaining balance if I come through with what I
With the 1,800?
Yes, sir.
500, Your Honor, a little under 500.
A little under 500.
I can do that.
On the 25th?
Yes, sir.
All right. So here's what I'm going to do. Rather than lay all of that out, I'm going to find no tribal issue. I'm going to grant a judgment for possession. All right. And that was 2296.86.
Yes.
All right. I'm going to grant a judgment for that amount. Instead of the 21st being the date, I'm going to give you to July 28th to pay it.
Okay.
Okay. That'd be that Monday after that
Okay.
weekend. Okay.
Yep.
And that way that all should work out for you and you'll be caught up.
Yes.
All right. But that's okay. In life, we just all catch up, fall back behind. Right?
No, it's
Yeah, okay.
Thanks a lot, sir.
All right. You take care of yourself. Court does call the case of Gulfside versus Anijah O'Haron. Okay. Hello.
Hi,
Your name?
Anaya O'Hearn.
Okay. And what is the balance on this?
I have a balance including court costs of $4,529.33.
Okay. And how are you intending on getting this paid?
I can make a payment today after I leave here of 500, and then I was wondering if I can get up on a payment plan.
Okay. Have you talked to them at all?
Yes.
And what'd they say?
I didn't get an email back, so I had emailed them, but I didn't get an email back regarding that.
Okay. How much is your monthly rent?
$13.99 plus utilities.
Right.
So Corinne, how long do you think is it going to take for you to get caught up?
I'll say to I want to say the beginning of August, because I lost my job. That's how I got all behind. So it's kind of hard to get back caught up with that much rent. So
Okay. So you think you can get caught up when?
I'll say August, like August 1st or around that time.
So hold on a second. Because I want to make sure I'm hearing what you're telling me.
Right.
You're telling me that.
Because I could pay 500 today after I leave, but a payment plan, I would need a couple more weeks to pay the remaining balance.
So hold on a second. Are you telling me that you can pay this 4,500 by the end of, basically the end of this month?
Yeah, for my family, if they come through for me, but I feel like I might need a little longer. Honestly, I don't know, but I don't.
Okay, hold on, take a breath. All right, slow down, because what you're trying to tell me is something that you think I want to hear.
No, I'm not.
Okay, you're not?
Mm-mm.
Okay, because what I want to make sure that you're telling me you can do something that you think you can do.
Yeah.
Okay, you follow me?
Mhm.
Okay, because that's a bit quick to try to come up
Yeah,
with that amount of cash.
Honestly, okay, let's be realistic. 500 today. Shoot, I'll say like, honestly, I don't know.
Okay, and just listen, that's okay sometimes to have that answer,
Mm,
okay? Because sometimes trying to think it through, you get yourself all tied up, you think you
Yeah.
can do whatever, and then you start saying I can do X, and then you have to explain why you couldn't do X,
Right.
and right?
Yeah.
And that's what I was getting at when I said you were trying to tell me what you,
Right.
okay?
Right.
So here's what I'm gonna do for you. You got to try to work this out in your head. I want you to call the attorney's office.
Okay.
I'm gonna adjourn it out a week,
Okay.
okay? I want you to think about, what funds you have, what you think you can do,
Right.
and talk to them and see if they can get their client to get you into a payment plan or something that'll work for you.
Okay.
Okay, fair enough?
Yes, fair.
Okay, I'll adjourn this to July 18th, 2025 at
Oh, yeah.
12 noon.
Okay. Thank you.
Okay, thank you. Gulfside Lakes versus Latanya Pugh Powell.
Julian Angus for plaintiff.
Hello,
Hello.
what's your name?
Latanya Pubal.
Okay, and how much is owing on her?
I have a balance including court costs of $3,800.36.
3.8, I'm sorry.
$3,836.
Okay, that's what I thought you said. And I said, no, I missed some numbers. All right. How are you intending on getting that paid?
Well, I'm gonna pay like 500 after I leave here.
Okay, so you're gonna pay 500 today.
Yes, and then I can,
Maybe around 33, and then how you gonna get that?
and then I can make weekly payments of whatever I have. I get paid every Friday.
Okay, and what do you think you're gonna have each Friday?
Probably about that amount, maybe
About 500?
Yeah.
Okay. Have you talked to the landlord about trying to work something out or no?
Like she's working with me on like, keeping her updated on like, oh, I need time, but as far as like,
Okay,
uh,
I got you.
yeah.
Because if you make it weekly, you only would hit 1,500 of that amount, and then you're still at about 2,300 that you would owe. And then your August rent would click in,
I don't know.
and then, right?
Right.
Okay, so I want you to at least, have you tried to get assistance at all, or?
Yes, I tried to do the SER, but they only helped out with the utility. They
Okay.
said I have to be facing eviction to get help with the assistance.
Have you called Hawk at all?
I'm not familiar with that.
Okay, so you haven't called over to Housing Access for Washtenaw County?
No, just only DHS.
Gotcha. Okay. All right. Do we have can you write down the number for Hawk? 961-1999. All right, what I'm gonna do, ma'am, is I'm gonna adjourn your case out 1 week to the 18th at 12 noon. Okay?
Okay.
We're gonna give you a number for Housing Access in Washtenaw County. I want you to call them. Try to call them on your way. If you got your phone with you, try to call them now.
Okay.
All right, let's see if they can maybe try to help you out. Pay the 500, because if they can help you out to the max, you gotta get this under 3,000. But if you can do it this month, but then it won't be if we hit click in the next.
Right.
month, right? Okay, so let's see if we can try to do some of that. Okay? And
Thank
we'll
you.
see you next week.
Okay. Thank you so much.
Court does call the case of Gulfside Lakes versus Justin Willis.
Julian Angus for plaintiff.
Yes. Oh, I'm sorry. I didn't mention the important one, Karina Combs. All right.
Yes.
All right, how much is owing on this?
I have a balance including court costs of $5,662.75.
Okay, how you guys gonna get this paid?
I talked to Melissa Duke yesterday from Gulfside. She's their financial person, and spoke to her about a payment plan. She had told me it was okay with her, depending on the court's approval. But right now I'm back to work. I make between $1,700 to $2,000 a week. So by the 25th, I'd be able to give them $3,100 plus the $740 that I get from the SER. And then on 8/1, I get another check. I give them another $1,782, and that should catch up all the arrears. And then I would be able to pay my August rent on the 8th.
But the next check,
Yeah.
right?
Yes, sir.
Okay. When I saw the number, I didn't think you had a plan, but you got a plan.
Yeah,
I
I
like
do.
it.
I do. Yeah.
Okay.
Yeah. No, I have a solid. It's just I lost a job, and I had gotten another one, and it was just not enough to pay. And I'm finally back to what I was making 6-7 months ago.
Doing.
Yes.
Gotcha. Okay, so here's what I'm gonna do. I'm gonna grant them a judgment for possession.
Okay.
Finding no tribal issue, okay? And for their full amount of $566,275.
Yes.
And you get paid, you said that last check is gonna hit the first
Yes, sir. Yeah.
of August?
Yes, sir.
Okay, so I'm gonna have the writ date on this. I'm gonna trust you that you're gonna come through with everything. I'm
Yeah.
not gonna make it contingent upon interim payments. I'm gonna have it. So I'm gonna have your writ date be August 4th,
Okay. That's great.
2025. This doesn't include your August rent.
Right. Yes.
But
I
what
know.
this is
Yeah.
doing is extending out the time so you can get this
Yes,
paid.
sir. Yes, sir.
All right?
Yep.
And then you'll be all set. You pay
Yes.
your August rent in those next few days on the 8th.
Yes,
You're
sir.
in the clear.
Yes. Thank you.
Sound good?
Yeah. Thank you so much.
you.
Karina, does that meet with your approval?
Yeah,
It does?
yeah.
Why'd you let him do all the talking?
I don't know. I just kind of sit by, I guess.
Next time you just jump in. I told you I'd rather talk to you than him, but he was talking some interesting stuff there.
Try to tell
All
him.
right.
He's good with numbers. I'm not.
Oh, okay. I see.
Yeah.
All right. You guys have a great weekend. All
Thank
right.
you, sir.
Thank you.
Thank you. Bye bye. Oh, thank you.
For calls the case of Gulfside Lakes versus said Aisha Clayton Mitchell. There's letters missing. Go ahead.
I don't.
Clayton Mitchell, they're not checked in. You may proceed.
Your Honor, there's also a Nazir Mill.
Oh, yes. And Nazir Mills.
Your Honor, this is a case for non-payment of rent. Rent to retain possession is $1,435.41. Court costs are $214 for a total of $1,649.41. Plaintiff requested default judgment for possession only with a writ issue after.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested, writ issue in 10 days. Gulfside Lakes versus Michael Pirguido, Pirguidi. Not here. Pirguidi, no response. You may proceed.
Your Honor, this case for non-payment of rent. Rent to retain possession is $653.03. Court costs are $172 for a total of $825.03. Plaintiff wishes to take a default for possession only with a writ issue.
Judgment to the plaintiff, that is by default for possession, redemption amount, any amount requested. Writ issue in 10 days. Gulfside Lakes versus Shanice Tripp.
Lillian Engen for plaintiff.
Hello, what's your name?
Shanice Tripp.
All right. And what's the claim in this case?
I have a total of $2,726.57.
All right. Told me you were gonna get the balance paid by the 10th. Well, what happened?
I'm gonna move.
Huh?
I'm moving. So I'm gonna
You're
pay-
moving?
Yeah, I'm gonna pay $1,000 on the 25th. My lease is up at the end of this month anyway.
Okay.
So I wanted to see if they would work with me with the remaining balance after I
To
pay.
get that paid?
Yeah, so if they
Okay.
would give me to like the 30th, I would be out. I'll have all my stuff out.
Okay, so you're gonna be moving by the end of this month when your lease is up?
Yes.
Okay, all right, so let's do this. No tribal issue, judgment for possession. For the 27, 26, 57. Get them paid. I will just have the writ date be July 30th.
Okay.
All right. Okay, thank you, ma'am. Good luck to you.
Thank you.
Cross case, or Hamilton Crossing versus Victoria Bolton.
Lillian Engen for plaintiff.
Hello, what's your name?
Victoria Bolton.
All right. And what's the claim in this case?
I have a balance including court costs of $2,674.
Okay, Bolton, how are you intending on getting that paid?
I just put 440 in escrow with the court.
You did?
Yeah, I got my receipt.
Okay.
And then I get paid weekly. I reached out to Friend in Action because Hawk told me that I'm over the income limit, so they can't help me. And then Friends Indeed said I need to bring it down because they could only pay 500. So I'm trying to get my balance down. But Friend in Action said they'll reach out to me next week to try to help me reduce my balance so I could get caught up. So
Okay. All
I
right.
just been trying to pay what I can pay weekly.
Okay. So you put 400 in escrow here,
Yeah, 440.
440.
Mhm.
Okay. So let's do this. Let's see what Friends Indeed have to say. I'll adjourn this out to the 18th, 2025 at 12 noon. Okay. And we'll have an answer on that. And then whatever else you can put into escrow. So we've got the money there, and let's take a look at where we are.
Okay.
Okay.
All right, thank you.
Have a good weekend.
Thanks.
Before I go on, did you get an answer? Of course they did. Come on back up. I give you a chance for them to call you back on Monday. This is the case of Evergreen versus Morgan and Randall. I'll adjourn this out to the 18th, 2025 at 12 noon.
Okay.
Okay. All right.
Thank you.
Thank you. Here on Vista versus Jacqueline Taylor. And Tania Tolliver.
I'm here, Judge Simpson. I'm here.
Oh, who is that? You're on the phone.
Jacqueline Taylor.
Okay, gotcha. Okay,
Submitted a COD to the court.
let's see. Oh, there is. All right, I have a conditional order of dismissal. And Taylor, you read that over?
Yes, sir.
Do you have any questions regarding it?
No.
All right. And both did sign it. Is that what happened here? Yes. Okay. All right, then I've looked it over. And it looks acceptable to the court. I will sign off on that. I will then indicate to you that you have 3 business days to think about this. If you believe that there is some legal reason, some confusion on your part, or some right you didn't assert, you could move this court to set this aside, okay?
Okay, thank you.
It doesn't mean I will, but you can move to set it aside. This case is conditionally
Okay.
dismissed. All right, you
Thank
take
you.
care. Have a good weekend.
You as well. You too. Thank you.
Here on Vista versus Tisha Wilson. Tisha Wilson, they are not present. You may proceed.
Thank you, Your Honor. This is a case for non-payment of rent. Rent to retain possession is $4,141.50. Court costs are $176 for a total of $4,317.50. Plaintiff wishes to take a default judgment for possession only with a writ to issue after 10 days.
Judgment to the plaintiff. That's by default for possession. Redemption amount in the amount requested with a writ issue in 10 days. Here on Vista versus Takima Reader. Hello.
How you doing?
What's your name?
Takima Reader.
Okay. And how much is owing on this?
Your Honor, I have a balance including court costs of $1,416. Your Honor, Ms. Reader was participating in the forgiveness program.
Okay.
I am waiting on some guidance from my client to see if they're still willing to offer a COD. There was a payment that was short.
It was I made a
Huh?
$800 payment, but I was $122 short.
Oh,
So, I don't
okay.
know
So
where
you
that- I don't know where that comes from. Yeah, I
you
made,
didn't, but you didn't get the full up. You didn't
Yeah.
get the,
And I just don't know how strict they're.
they're gonna be, okay, that, I get you. You just fell a little short, right?
yeah.
Okay, just listen, here's what I'm gonna do. I'm gonna give them time to check that, so I'm gonna adjourn it out a week. Hopefully, we can get a good answer for you on that. Are you gonna, by chance, that was for the July rent, is there, or when did you pay the 8th?
The 4th,
On the 4th? And that, you were supposed to pay your full
it was
July,
like 922, yeah.
you were supposed to pay your full, okay, so you were 122, sir.
Yeah, but I just dropped that off in the mailbox earlier, so
Hold on a second, you dropped what off?
122.
You should have led with that. Okay, because that may change, no, it's okay, but that may change how they look at it. Okay, and that's something we needed to know. Okay. Then I'm gonna adjourn it out, see what they have to say and see if they can keep you in that thing, okay? But it's probably gonna require that you not miss the next one, so.
Well, I don't even know how that's gonna go either, so
Pardon?
I don't even know how that's gonna go either.
What
Cause
do you
she
mean?
just gave me
the paperwork redoing my rent, because I work in, well, all my jobs with the school system. I work in our public schools and travel and food service. We use off in June. Yeah,
Gotcha.
so I don't know what type of,
So,
Yeah.
hold on a second, hold on. So your check in August is gonna be kind of weird, right? And it's really not.
no, it's not gonna be, I don't have income.
That's it, that's what I meant,
Yeah.
really.
So she was supposed to
So
extend the ink or whatever, how much, I don't know what the change.
you don't have an income coming in until September.
Yeah, school.
Okay, so it's also good to know that. So what I'll do, I'll turn it over to that. They'll communicate with their client and see if we can get something different, because the timing of it's just because of what
I
you
don't know
do.
what
doesn't
July
count.
rent is, so I don't know what July rent is. I don't-
So there might be a recertification
Yeah.
that adjusts your.
Yeah.
Oh, that's true. Okay. All right, real good. We'll try to figure this out next week.
Okay.
All right, you take care.
What day is it?
It'll be Friday at noon.
Is it possible I can do Zoom?
No, you're not working. You can come down here.
'Cause I start Monday, so.
You start Monday?
Yeah.
Send in a Zoom request. I'll consider it, but I may make you come down. Everybody else has to come down and see me before summer's over.
Okay.
All right. Huron Vista versus Shayla Cole.
Jillian Egan for plaintiff.
Oh, there she is. Hold on, there's my friend back there. Hello, what's your name?
Shayla Cole.
All right. And what's our claim in this case?
Your Honor, I have a balance of $2,340. I do know that a conditional order of dismissal has been drafted and it's been sent to Huron Vista for review. And so if they approve, they can present it to Ms. Cole, or I can get an email address from you and then we can send it as soon as we get approval.
Wait, okay.
Don't
repeat
put
that.
it, okay.
That was a lot for her.
Yeah, it was.
She just started staring at you like, I don't know what to say. What it is that was part of the forgiveness program. You got into that?
Yeah, I paid my July.
Okay, so what has to happen is paperwork has to be drafted, which is called a conditional order of dismissal for the court signature.
Okay.
Okay, they drafted it. They've got to send it to their client to get approval of what it says.
Okay.
And then they're gonna get it to you, hopefully sign off, and then we can close this case out with those terms.
Okay.
You follow me?
Yeah.
I said it much better, didn't you?
Yeah.
Okay. Yeah, oh, is that what it was? Okay. So here's what I'm gonna do, Ms. Cole. I'm gonna adjourn it July 18th, 2025 at 12 noon. Okay?
So look, I am in school, medical school, and I don't get out until 1.
She's gonna be a doctor?
So.
Are you a doctor?
No, nursing. So.
Oh, even
Yeah.
better.
So I don't.
Where are you in nursing school?
Ross.
At Ross?
Free though, but yeah.
So what are you trying to tell me? You can't get out of class to come down and see Judge Simpson?
Well, after 1, yeah. So,
But you can't zoom in either.
I can Zoom.
Can you?
Yeah.
Okay, if you, I don't know where she went.
Over here.
Oh, hi. All right. We'll give you a Zoom form, fill out. If you're in school, then
Okay.
I'll excuse you probably, okay?
All right, thank you.
Here on Vista versus Denisha Davis. Swipe right back here. Denisha Davis? All right. You may proceed.
Thank you, Your Honor. My client is willing to offer Ms. Davis the forgiveness plan and the COD. I just, my preference, Your Honor, would be to take a default today and then.
Then work it out. Okay, go ahead.
With that, plaintiff to take a default judgment of rent retained possession of $2,838, court cost of $176 for a total of $3,014. Plaintiff wishes to take a default judgment for possession only with a writ issue after 10 days.
Judgment to the plaintiff, that is by default. For possession, redemption amount is in the amount requested with the writ issue in 10 days.
Yes, that's the amount of risk.
Fairwood versus Regina Hampton. I just didn't want her sitting back there because by herself, like to the end, because she would have just yelled at me. Hello.
Hello, Your Honor.
How are you?
I'm hanging in here trying to get better. I have problems with my asthma, causing my voice.
Oh, okay. Let's see if we can get you out of here.
If Ms. Agnew is okay with it, I can do the talking.
All
So,
right. She's
I
not,
won't do
she's
it
not
as well.
okay with that, but she'll let it happen.
Your Honor, I spoke to Ms. Agnew and the repairs issues have been resolved. I think we are okay with the court releasing escrow to plaintiff. And as Ms. Agnew did pay through June, before July hit to an escrow to the court, I think we can dismiss this case with
Okay.
escrow. I don't have a dismissal form prepared, but.
Got it. Agnew, is that okay with you? You can just give me a thumbs up so you don't strain your voice. Okay. So what I will do is I will indicate release escrow to plaintiff and dismiss case. All right. All right. Ms. Agnew, you have a blessed weekend. You take care of yourself. All right. God is good. Yes, indeed. Every day. Huron Vista versus Tanika Ward.
Jillian Engen for plaintiff.
Ward? No response. You may proceed.
Your Honor, this is a case for non-payment of rent. Possession is $3,726. Court cost of $176 for a total of $3,902. Plaintiff wishes to take a default judgment. Possession only with the issue.
Judgment to the plaintiff by default for possession, redemption amount, any amount requested, writ issue 10 days. Huron Vista versus Alyssa Darling. Alyssa Darling? No response. You may proceed.
Thank you. Case for non-payment of rent. Rent to retain possession is $3,866. Court costs are $176 for a total of $4,042. Plaintiff wishes to take a default judgment for possession only with the writ issue after 10 days.
Judgment to the plaintiff, that is by default for possession, redemption amount, any amount requested, writ issue of 10 days. New Park Ridge Apartments versus Alana Armstead. She's in Zoom. Miss Armstead? Alana Armstead? You prompted her. I'll pass it briefly and we'll just see if she. New Park Ridge versus Karina Jones. Yep, she's in Zoom. Miss Jones, you unmute. There you go. How are you?
I'm good. I'm okay.
Okay. I set aside the default. Well, no, we did that. Okay, where are we on this case?
Your Honor, it sounds like my client received a check from SOS today. The remaining balance is $419.
$419?
Yes, sir.
All right. And Miss Jones, how are we gonna get that paid?
I just what was that? The day before yesterday, I just paid $429. So next week I get paid on Thursday, and I was gonna pay the rest.
You're gonna pay it by next
Thursday,
week,
next week.
Thursday?
Yes.
All right, then let me adjourn this out to next week, the 18th, 2025 at noon. Get that paid on Thursday, so hopefully we can dismiss this case out for you, okay?
Okay, I will. Thank you.
All right, take care. Have a good weekend.
You too.
Peninsula Place versus Jacqueline Gardner.
Hi.
Hello, Gardner. Okay, and what's owing on this?
I have a balance including court costs of $3,291.16.
All right, Ms. Gardner, how are we gonna get that paid?
I spoke with Jill this morning from Legal Services. The people you told me to contact in regards to me being on maternity leave. She told me that to tell you that my application went through today, and so she should be hearing something back from a program within 2 to 3 weeks to help me. She didn't say if they're gonna pay the full balance or not, but she told me to let you know that she did give me assistance.
Okay, Miss Bauer told you that?
Yes.
Okay, so let's do this. I'm gonna adjourn it out a week to the 25th at 12 noon. The 18th, I wrote the 18th, said the 25th. I don't know what I'm doing. All right, it's late. So July 18th, 2025, 12 noon. All right, and let's see what they have
Okay.
to say at that point, see where we are. Okay?
Okay. Thank you.
Is that the little one?
Yeah.
Oh,
He's sleeping.
look at that. So cute. All right, you two have a great weekend. Okay.
Thank you. You too.
That made my day. Okay. Peninsula Place versus Carly Kenny.
Jillian Engen for plaintiff. I think that there was a motion to stay.
Stay, yeah.
I haven't seen it, but we submitted a CSJ.
Yes, and looks like it's satisfied by party. Yeah. Carbon Asset Management versus Sandra Moore.
For plaintiff.
She's in Zoom. Sandra Moore?
Yes.
Okay, there she is. Okay. If you got a camera, that would be great.
Yes.
Okay. And how much is owing on this?
Your Honor, I have a balance including court costs of $2,605.55.
Okay. Yep, that's about where we. So did you get your July rent paid?
Yes, I did. July.
Okay, that. Okay. So how are we gonna get this balance done?
I spoke to Hawk and they were supposed, she told me I was approved, so I'm just waiting to see what happens with that. I already spoke to them and I told them that I paid July. I sent them a
Okay.
copy.
Okay, so they told you were approved? When did they tell you that?
She told me they got, what was it? Last week I spoke to her. She said they have fundings.
Okay, so who's your worker?
Caitlin Ota?
Okay. All right. Here's what I'll do. Let me adjourn it out a week. Let the attorneys see if they can catch up to them. You may want to that's the 18th at noon. All right.
Okay. All right.
Contact your caseworker and let her know that, it looks like the landlord hasn't received notification of this either.
Wow. Okay.
Okay, don't panic. Don't worry about it. We'll get it worked out.
Okay.
All right. You have a blessed weekend.
You too.
Court calls the case of Strong Future Homes versus Cedra. I don't know.
She's in Central.
Miss Moore.
Cedra.
I'm
Hi.
sorry. It's been a long day. And
You
also I'm
butcher
looking
it
at it,
every time.
but I know. But I'm looking at it, I'm thinking, don't mess this up. And then I just start dividing it and I mess up. State your name, please.
Cedra Moore.
I was gonna say that. I know, well, I need to just break it apart in 3 and not try to make it 2. Anyway. All right. Okay, where are we?
I have a balance including court costs of $741.
Okay, Miss Moore, how are we gonna get that paid?
I paid $500 today. I have a new ledger.
Oh, you did?
Yep. So the balance is now $200, and they're willing to work with me. I had a lot to pay this week, so but it's only $200 now.
Okay, so if you paid 500, when are you gonna get the rest of it paid?
Probably like 2 weeks. It's only $200, so the
Right,
next time I'm paid.
241. Pardon,
Yeah.
the next time you're paid?
Yes.
So you got paid today?
Yes.
Okay, so you get paid on the 25th. Okay, let's do this way because I don't have a date. Well, it's only 200 and some odd dollars. Get that paid on the 25th. I'm going to adjourn your case to August 1st, 2025 at 1 p.m. Okay? If you get everything paid.
Okay. So, just so you know, because I got paid. So the way, because I'm in pharmacy school, so I got paid early. So, I just wanted to make sure the dates is right, but it's only $200, so it's fine. Just the 25th is fine.
Okay, let's do this. Here's what I'm doing. I'm adjourning your case out to August 1st. That balance that you had, the 200 and something, if you can get it paid on the 25th, get it paid on the 25th. And whatever you'd have to do, get it paid before the 30th of July. That way the case can be dismissed and you don't have to show up on the 1st. Okay? Did I lose her there? I don't think so. You got that, Ms. Moore? All right, you're breaking up on us, but I think we got it.
Yes,
Okay.
you said, I'm sorry. Yes, thank you.
All righty, you take care.
Uh-oh.
Strong Future Homes versus Alana Lindsay. Lindsay, no response, you may proceed.
Thank you, Your Honor. Case for the rent possession is $310. Court costs are $176 for a total of $486. Plaintiff wishes to take a default judgment for possession only with a writ issue after 10 days.
Judgment to the plaintiff, that's by default for possession, redemption amount in the amount requested with issue in 10 days. Strong Future Homes versus Charles Ellison.
Hello, Judge.
Okay, he's here. Mr. Ellison?
How are you?
I'm doing well. All right, and what's our claimant this time on this case?
I have a balance including court costs of $2,139.
All right. Mr. Ellison, how do you intend on getting that paid?
The leasing office told me to ask you for a COD so I can set up a payment plan with them. And I also talked to Hawk. I've already had my my interview and everything with them. I spoke with my worker earlier today, and she said she's just waiting on funds. And I also talked to Friends in Need a couple of weeks ago, and they're just waiting right now.
All right. I'll adjourn this out to July 18th, 2025 at 12 noon.
Judge,
All right.
Is there anything? I've already been here 4 times. They're willing to set up a payment plan with me. Can I just do that?
Well, you're the one that fell behind in rent. I know, but I got to have the paperwork.
Okay. What paperwork?
I don't like to call the case that many times, but you're the one in trouble. If you want me to give them a judgment, I'll give them a judgment, but I don't think you want me to do that.
I don't. I just got my ledger. And we were waiting on HUD for forever, so I just got my ledger yesterday.
Okay, but I can't do anything with it today except give a judgment, but I don't think that's what you want me to do. So I don't have a choice but to put it out another week.
Okay.
Put it out another week. You should contact on your paperwork. You'll have the attorney's office number. You should contact them because they're the ones that create the COD for you to sign.
Okay.
Thank you. And Evergreen versus Hammonds and Gulfside versus Davis. Those matters are dismissed. I have one that I passed. Alana Armstead. Alana Armstead. She's not responding. I don't think she's there.
She was earlier. Verbally.
Okay, but ever since I've been calling it. What would you like to do? Take it to phone?
Your Honor, Ms. Armstead, my client received a check from Michigan Works
Okay.
on July 8th, and I think she's working with SOS. Her balance is currently $432.
Got it.
If you want to adjourn it for one.
Okay. 432. I'll adjourn this to July 18, 2025, 12 noon. All right. Thank you. That's it. Wow. 14 stands adjourned. And yes, Felicia, I have new glasses. All right.